ಕೋರ್ಟ್ ಆಫೀಸರ್ ಹೈಕೋರ್ಟ್ ಪ್ರೊಸೀಡಿಂಗ್ಸ್ ಮ್ಯೂಟ್ ಆಗಿದೆ.
of 2022. Accordingly, subject
Number 54, service report may kindly be awaited, my lord.
After 3 weeks.
This impleading business, this court finds it very difficult.
Oh. May I please, Your Lordship? Item number 14 and 15, my lord.
Yes.
My currently pass over for the day. Due to demise of my father, I was not able to prepare the case, and I have also to file.
You are for the petitioner?
In 15 I am petitioner, in 14 respondent.
No, but in 14 who is for the petitioner? Because this has been listed today for dismissal.
Yes, sir.
Alright, in item 14, you say that since on the last occasion there was no representation on behalf of the petitioner, comma, this matter has been listed today with the remark for dismissal in the cause list. Stop. However, today Mr. M. Sharma, learned counsel for the petitioner, is present. Stop. List this matter after 3 weeks on a date to be fixed by the registry. In item 15, you say, as prayed for by Mr.
S.U. Ahmed.
S.U.
Ahmed.
S.U.
Ahmed.
Ahmed, learned counsel for the petitioner. Petitioner?
Yes.
Comma. List this matter after 3 weeks on a date to be fixed by the registry.
Obligement.
May I please, Your Lordship?
Along with also you can say or whatever.
May I
Yes.
please, Your Lordship? I beg to mention item number 8, Lordship. Kindly
Item
pass-
number?
8,
8.
Lordship. Kindly
Yes,
pass-
what do you want?
Lordship, kindly pass over the matter for the day.
As prayed for, list this matter after 1 week on a date to be fixed by the registry. As prayed for by the petitioner. Your name?
D. Datta.
MSD Datta, learned counsel for the petitioner. Yes.
May it please, Your Lordship, with due consent of the other side, I beg to mention item number 2 of the daily list, my lord.
2.
2, my lord.
Yes, what do you want?
We are awaiting of instructions in this matter, my lord.
You are for
I am for the respondent, finance and
petitioner?
taxation.
This item 2 will just be called. Why are you making a mention? Yes. Any more mention?
Yes, may please, Lordship. Lordship, I beg to mention, Lordship, I'm praying for a listing, Lordship.
Listing.
It's a
When?
listing. It's a part-head matter, Lordship. Supposed to come on 18/4, but it has not been listed. I submitted an application before the registry, but it's
Part-head matter.
Part-head matter, Lordship.
What was the subject matter?
It's a criminal appeal, Lordship.
That quashing. No.
No.
Appeal.
Suspension. Yes.
Right.
Correct.
Then after the vacation,
16 on maybe.
we are reopening. Kitya hai sir?
It's Monday, Lordship.
Hobo?
Sorry, Tuesday. Lordship.
All right.
Hearing me.
All right.
Obliged.
May I please, Your Lordship, I beg to mention item number 34. Kindly the matter may be fixed after vacation.
34.
Yes, Lordship.
Yes. 34 you are for?
I am for the petitioner.
On the last occasion you were absent.
Lordship, in this case, I am appearing for Revenue Department. Lordship, that case, the budget has been already sanctioned.
All right.
Lordship.
You wait for your turn.
Yes, Lordship. That can be disposed of, Lordship.
You wait for your turn. We may pass a favorable order on.
Your Lordship, the respondent side had filed the affidavit, but we need some time to file the
No,
affidavit. in
Lordship,
reply.
their prayer has been already
Miss
complied,
Counsel, please don't come like a puppet before the court and say what you are being asked to say. Also be attentive of what the respondent counsel is saying. Have you heard what she said? That there is some progress in the matter and the matter can be disposed in your favor. So in that case, why do you want unnecessarily another date if something in your favor is going to be given? Yes, Mr. Mondal?
Yes, may I please? My lord, one matter, my lord, the main petition is posted for my lord, motion hearing tomorrow, my lord. One IA has been filed today for implementing party respondent. Now new party has come.
What do you want?
Let it be, my lord, listed tomorrow, my lord. That must
Along with that?
Along with that, I oblige,
Okay.
Lord.
Yes, call the list. Mr. R. Dekal, learned counsel for the petition. Mr. S.I. Akan, learned counsel for the petitioner, heard so and so, and also heard Mr. A. Bhattacharya, learned standing counsel revenue, Mr. M.S. S. Borwa, learned government advocate for the state respondent, and finance. Anyone from the finance? And Mr.
H. Borwa, on
H.
behalf of
Borwa, learned standing counsel finance.
and on behalf of B. Gogoi, my lord.
On behalf, then I'm giving B. Gogoi's name. B. Gogoi, learned standing counsel finance. Stop. Mr. S.I. Akan, learned counsel for the petitioner, submits that he has received instructions from his client, the petitioner, not to press the instant petition. Stop. Accordingly,
Matter has been infractious.
as the matter has become infractious. Dismissed for for withdrawal. Disposed of. $65 to
May I please, Lordship?
Yes.
Lordship, instruction was sought for regarding the representation filed by the petitioner before
Yes,
the registered
Corporation
property.
Department.
My lord, I have not received. Lordship may issue notice, my lord, short notice, my lord, after the petition.
Notice not yet issued. All right, issuing the notice so that things can move. Heard, Mr.
S.H. Raman.
S.
H.H. Raman.
H.S. Raman, learned counsel for the petitioner. Stop. Also heard Mr.
S.K. Talukdar.
S.K. Talukdar, learned standing counsel,
Corporation
Department.
1, 2, and 3, my lord.
Within bracket, respondent number 1,
2, 3, my lord.
1, 2, 3. Anybody else?
There are other respondents, my lord, Cooperative Apex Bank.
So that has to go by steps by my registered post.
My lord, I think there are standing counsel.
Anyone appearing? No.
Mr.
All right. Issue notice. Returnable 2 weeks. Mr. So and so accepts notice for respondent number 1, 2, 3. Steps by registered court. Respondent number 4 and 5.
My lord, there are other respondents also, 6,
4,
7, and
5,
8.
6, 7, 8. Within a period of 2 days from today. Extra copies during the course of the day. Okay? A list after return. I have given 2 weeks. List after 2 weeks on a date to be fixed by the registry.
Obliged.
Yes. What were you submitting in item 2?
My lord, our instructions are being awaited, my lord. I'm praying for 3 weeks time to file our affidavit, my lord.
Then I'll issue notice.
Yes, my lord.
Heard MS N. Gogoi.
Yes.
Learned counsel for the petitioner. Stop. Also heard Mr.
H. Borwa.
H. Borwa, learned counsel for Mr. B. Gogoi, learned standing counsel, Finance and Taxation Department for the respondent numbers 3 to 6. All right, B. Gogoi. Just put B. Gogoi's name. You don't have to put. I'm recording your name, Mr. Gogoi. Anyone else? Anybody from GST?
Yes.
And Dr. B. N. Gogoi, learned counsel.
1 and 2.
Learned standing counsel GST for the respondent numbers 1 and 2. Stop. Issue notice, returnable 2 weeks. I think extra copy already been served.
Yes, I have
Yes, isn't it? Since the respondents are represented and have already received the extra copies of the petitioner, no formal notice is required to be issued. Stop. Let affidavits be filed by before the returnable dates. List after 2 weeks on a date to be fixed by the registry. Obliged.
Obliged, my lord.
May I please, Lordship? A senior is on leg, my lord. Matter may be taken after some time.
Instruction has received, Lordship, and the investigation going on. I have received the report.
You file an affidavit then?
Then it's
Investigation is going on.
going on.
MS S.
And
Purva,
alternative
learned government advocate, submits.
Lordship, alternative remedy also available under CRPC 156. Sakri Basu said if proceedings are not going on, then they claim every person can apply before the SP.
Alright, then let his senior be there.
Yes.
At all of the piece of matter. Keep that provision ready. And Sakiri Basu.
Yes.
Last occasion instructions sought for my lord. Some demarcation is directed to be two dumb numbers, 202, 205.
Yes.
Yes, I have received telephonic instruction. A demarcation has proceeding has already completed, and demarcated land was demarcated on the presence of.
So that means the relief sought for has been met with.
Yes, but I have not written instruction.
Then you do one thing. You file an affidavit. You get the complete instructions.
Yes.
In the meantime, let me issue notice.
Yes, that's
Right.
Yes, my lord. Another direction is there. To record correction, my lord. Page 72, 71, 72. But I don't know that was done or not. So logical end, and that way logical end should be this. So they will ensure that until then notice is issued.
No, let me issue notice and
Yes.
let them file their return.
Yes, But my lord, why I filed this repetition? Because they started construction in disputed land, and page 82p, DC has says only 205 you restrain, 202 not restrain. That is my anxiety, my lord, and that nature.
What was page 82?
Yes, because there is two tag numbers, your lordship. One is 202, 205. They mentioned only 205. We said that our 205, then 202 is they are owner of 202, but they encroach 205. That is why demarcation is. So here.
So here the stop ongoing construction is relating to 05. Oh.
But 202 is not mentioned.
202? So there were two DAG numbers involved.
Yes, that should be mentioned. That is why.
202.
Yes.
Alright, then we will mention 202 and say that
yes.
Even in 202 there should not be any construction because your own order is there 82. Yes, yes. See page 82.
Yes, on the last occasion when the petitioners approached the Honorable Court, page 40, page 70, it starts from page 65.
Yes.
Page 66 is the petition filed by them.
This is another petition.
7184.
This is another petition.
Earlier petition. There is a question of title involved. There is a dispute between two parties regarding 202
then we are not going into all this.
What I
Rising out of DAG number 202
and 205. There is
205.
Yes. Now the difficulty this Honorable Court find that in a 226 proceeding that declaration cannot be done. Therefore they were relegated to civil court. Now if they have approached the civil court and finds an injunction, that can be done, whether they have filed a civil suit or not. Pursuant to the order of the Honorable Court. Because they are coming in again and again, my lord.
Before that, the demarcation should be there, and we know
that's
who is
a different issue,
who is.
In terms of the order dated 19/6/2024, MSS Borwal and Government Advocate for the respondent numbers 2 and 3 submits that she has received verbal instructions to the effect that the demarcation proceedings have been completed. Stop. Let written instructions in this regard be placed on the next date of listing. List again on such and such date. After vacation, did Nothing. Next. What is this?
Lordship, her petitioner parcels a plot of land from his father by executing registered deed. And thereafter, Lordship, in the year 2022, that parcels.
In the year
2022. And thereafter, Lordship, in 2024, he intends to sell the property, Lordship. And accordingly, he intends to apply for NOC, Lordship, in the online system. And there he found there is an objection filed by someone.
Alright, I'm issuing notice.
Yes.
Heard Mr.
AZ
Ahmed, Learned Counsel for the petitioner. Stop. Also heard MSS Borwal, Learned Government Advocate for the state respondent. Respondent number 1, 2, 3. Stop.
1, 2, 3.
I think one.
I am one.
Respondent number, you will be for 2 and 3?
2 and 3.
Respondent number 2 and 3. And Mr. A. Bhattacharya, Learned Standing Counsel, Revenue Department for respondent number 1. By filing the instant petition under Article 226 of the Constitution of India, the petitioner is seeking is assailing the order dated 17/5/2024 passed in objection case number 15/2024 by the respondent number 3, whereby NOC for sale / gift / transfer of the subject land was denied to the petitioner. Stop. Let notice be issued, returnable 4 weeks. Mr. A. Bhattacharya, Learned Standing Counsel, Revenue, accepts notice on behalf of respondent number 1 and MS S. Borwal, Learned Government Advocate, Assam accepts notice on behalf of respondent number 2 and 3. Registered post AD in respect of respondent number 4 and 5. Steps as indicated above shall be taken within a period of 2 days from today. List after 4 weeks on a date to be fixed by the registry. Yes, Mr. Kataki.
Yes, ma'am.
Land settlement.
Rejection of my prayer for Basundhara, my lord. 20.
Prayer?
My prayer for settlement, my lord, under Basundhara scheme, my lord. That was rejected on the ground that I have not been residing continuously for 3 generations. But the fact remains that way back in 98, my lord, I purchased the petitioner and the sons while residing for 3 generations.
All right, issuing notice
Notice.
at this stage.
And we apprehend that there is a possibility that we may be evicted, my lord. That, so, in terms of no eviction may be done without due process of law, my lord.
Eviction order was not passed.
Not passed. We are apprehending because...
All right. Heard Mr. P. Kotoki, Learned Counsel for the respondent, for the petitioner, stop. Also heard revenue is not there.
Yes, one.
For also heard Mr. A. Bhattacharya, Learned Standing Counsel, Revenue, and MSS Borwa, Learned Government Advocate for respondent numbers 2 and 3. Stop. By filing the instant petition under Article 226 of the Constitution of India, the petitioner is assailing the orders of rejection dated 21/9/2023 issued by Mission.
Circle officer,
Issued. What is of Mission Basundhara?
That's a scheme, man. There's a scheme for
orders of rejection dated so and so in relation to the Mission Basundhara 2.0 scheme of the petitioner.
No petitioners. Separate orders were passed, my lord. 1, 2, and 3, 31, 32, 33. The petitioner and the sons, my lord, they filed their petition.
Really pertaining to the petitioner and his family.
Family.
By the respondent number 3. Stop. Issue notice. Let notice be issued. Returnable 4 weeks. Mr. A. Bhattacharya accepts notice on behalf of respondent number 1. And MSS Borwa accepts notice on behalf of respondent numbers 2 and 3. Extra copies within a period of 2 days from today. In view of the apprehension projected by the petitioner as regards eviction from the subject land.
Yes, ma'am.
From the subject land, let no coercive steps be taken till the returnable date. All right?
Yes, ma'am.
Let no coercive steps be taken in this regard till the next date of listing. List after 4 weeks on a date to be fixed by the registry. Yes, illegal sealing of your shop.
Milord.
Why was your shop sealed?
Because, Milord, the Lordship will find at page number 16, Milord, in Extra 3, because somebody lost an FIR, Milord, and subsequent to that, Milord, the petitioner was arrested on the allegation that, Milord, some of the stolen properties, Milord, was recovered from the shop of the petitioner. I was arrested, I was in jail, Milord. And
all right, and then?
Then, Milord, when I came back from the jail, Milord, I went, Milord, because the impugn order directed me to produce documents.
All right, I'll issue notice. Nothing more at this stage.
But subject to, my lord, subject to the concurrence from the other side. Since my shop is, my lord, sealed, my lord. So therefore, my lord, if your lordship is pleased to dispose of the representation that was submitted therein, on perusal of the documents, if that those are found.
Where is your representation?
Yes, my lord, I have connected.
Mr. Nayak?
Yes, one representation is there, but in the meantime, his trade license has also expired. Lordship, one representation is pending. Lordship may direct the authority to dispose of them.
Dispose.
Yes.
Which page is the representation?
It is page number 28,
13.3.
20?
28, last page.
So this direction for disposal has to be issued to the GMC.
Yes, Commissioner GMC.
Respondent number?
Respondent number 2.
2 million.
2
All right. This is item number
7 million.
7 for disposal. Heard Mr. A. Ali, Learned Counsel for the petitioner. Stop. Also heard Mr. P. Nayak, Learned Standing Counsel, GMC.
All the 3 respondents, Lordship. GDD plus GMC, Lord. 1, 2 and 3.
For respondent number 1, 2 and 3. Anybody else? No.
No.
By filing the instant petition under article, this is under 227.
26 million.
Please be mindful when you draft the petitions. It is mentioned 227. By filing this petition under article 226 of the Constitution of India, the petitioner is assailing the order dated 22/1/2024 within bracket annexure 1, whereby his shop within quotes Krishna Guru Jewellery at Sharmakata Biharbari has been sealed by the respondent number 3. Stop. The brief facts of the case is that pursuant to an FIR being lodged before the Bokhista police station, after the petitioner was arrested in connection with Bokhista PS case number 823/2023 registered under section 457/380 IPC. Stop. It is alleged in the said FIR that on the base no, don't say you say like this.
Lordship, kindly say page 25.
Page
25.
25.
Lordship. In the same case, Lordship, a search was conducted at his shop, Lordship, and following metals were recovered.
25.
Page 25.
No, where is the FIR? I was trying to
FIR
find out.
Annexure 2 million.
What is the allegation in the FIR?
The allegation is that Milord 1.
Page?
Case number Milord 16.
16.
Annexure.
In the FIR you are named.
No Milord.
Not
Can you read that sentence? No, on before that. Wait. No, person, just delete that. I'm going to give you once again. Brief. An FIR was filed being Bokhista PS case number 823 of 2023 registered under section 457/380 IPC, wherein it has been alleged by the informant that the accused mentioned therein has taken some jewellery ornaments worth rupees 5 lakhs and a cash amount of rupees 50,000. Stop. Thereafter, it appears that on the basis of the statement of one Tej Bahadur Chetri, the petitioner's shop was raided. Where from?
Is number 25.
Where from the stolen gold and the cash of rupees 50,000 and of rupees 18,000 was recovered. Stop. The petitioner was accordingly arrested was also arrested. Stop. In the meantime, respondent number 3 issued notice dated 22/1/2024 asking the petitioner to produce requisite documents pertaining to his shop within 3 days. Stop. However, since the petitioner was in custody, he could not submit the aforesaid documents, whereupon the respondent number 3 sealed his shop. Stop. The petitioner, after being released on bail, submitted application dated 13/3/2024 before the respondent number 3. However, the same was not accepted. Stop. It is submitted at the bar that the aforesaid application dated 13/3/2024 Annexure 7 being pending, this writ petition can be disposed of with a direction to the respondent number 2 to dispose of the aforesaid application in accordance with law. Stop. As such, this court is of the considered view that this writ petition can be this court disposes of this writ petition with the direction to respondent number 2 to dispose of the application dated 13/3/2024 filed by the petitioner within a period of 1 month from the date or receipt of the certified copy of the order in accordance with law. Stop. Disposed of.
Obliged.
Lordship,
yes.
This matter may be fixed along with writ petition number 1229/2000.
More writ petitions are pending.
Yes, my lord. Similarly, so my lord, writ petitions are pending, and my lord, there is already interim orders are passed, my lord. This is one of the order, my lord.
You are aware?
Yes, my lord. No coercive action.
So I can issue notice and pass a similar order?
Yes, my lord. Other cases are fixed on 22nd.
Notices have been issued there?
Yes, my lord. And my lord, there is interim order also.
Alright, then I shall also issue notice here. Okay. Heard Mr.
A.K. Gupta.
A.K. Gupta, learned counsel for the petitioner. Stop. Also heard
M. Deka.
MS N. Deka, learned.
Lordship for CGST Lordship.
Learned learned standing for learned standing counsel CGC.
Representing CGST on behalf of SC KL Lordship.
Learned counsel on behalf of SC KL and Mr. SC KL, learned. What is the designation? Learned
CGST Lordship.
DYSDI.
Yes, Lordship.
DYSDI and Mr.
Lordship, it will be CGST.
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 Learned standing counsel.
Yes.
SC CGST. And Mr. B. Chaudhary,
For 4 and 5.
learned standing counsel, finance and taxation, for respondent number 4 and 5. Anybody else?
No.
By filing this writ petition under Article 226 of the Constitution of India, the petitioner have assailed the notification number 9/2023 central text dated 31/3/2023 issued by the respondent number 2 extending the period for issuance of order under section 73 within bracket 10 of the CGST Act 2017. Stop. assailing inter alia. Huh? Has a name. Issue notice returnable. On 10/5/20, 10/5 is already gone.
22/7 is the next date, madam.
The next date is 22/7. The other matters.
Returnable 2 weeks. Stop, Mr. MS, your name?
M. Deka.
MS M. Deka for Mr. S.E. Kyle accepts notice on behalf of respondent numbers
2 and 3.
2 and 3. Stop. Mr. B. Chaudhary, Learned Standing Counsel for the State GST,
4 and 5.
accepts notice for respondent number 4 and 5. So, who is for 1?
One lordship CGSC will apply.
So she will apply. 1, 2 and 3 then?
No, lordship.
Or CGSC? Anybody there? No. As MS S. Borwa for respondent number 1. And what a 4, 5? It is submitted at the bar that the issue involved in this writ petition is also that it is submitted at the bar that similar writ petition where the same issue is involved is pending adjudicating before this honorable court, being WPC 1845 of 2024, wherein interim measures to the effect that the recovery of the amount assessed against the petitioner shall not be enforced. Stop. In view of the above, comma, it is directed that as final order has already been, and taking note of the fact that you say, in view of the above, let the recovery of the amount assessed against the petitioner not be enforced as an interim measure. Stop.
22/7/2024.
22/7/2024.
Obliged. My lord, item number 10 and 13 are also same, my lord.
Item number
10
and
13.
Okay,
Also
same order in item 10 and 13.
Obliged.
I'm for Union of India, my lord.
You are for the petitioner?
Union of India.
Union of India.
Yes, my lord.
I've already, S. Borwa was there. Alright. Naam to Lulu. Alright.
Obliged.
I'm here as a social worker. I have preferred an application through RTI, and the RTI replies at page 19, where I got some information where somebody has acquired the land, which is a government land. Let's see, with reference to the cited, it is page 19. Let's see, next time. It is an RTI reply. So,
yes,
where it? So and so, with reference to the above
government municipality.
Yes, Lucy.
Okay.
So the horizon community because
yes.
So somebody has acquired the land, then I have preferred application to evict the land from the.
Let notice go first. Heard Mr. H. Hetri, Learned Counsel for the petitioner. Stop. Also heard MSS Borwa, Learned Government Advocate for the state respondent. Stop. By filing this petition under Article 226 of the Constitution of India, the writ petitioner is seeking inter alia directions to the respondent authorities to take appropriate action against the respondent number 5 so as to recover the government land measuring 14 lecha covered by DAC number 1580 and 1581, which has been wherein
it is
illegal construction, wherein they have illegally constructed a pakka structure.
Yes.
Correct?
Yes.
Stop. Let notice be issued, returnable 4 weeks. MSS Borwa, learned government advocate, accepts notice on behalf of respondent number 1, municipal 1, 2, 3 and 4. Steps by registered post AD in respect of R5 within the period of 2 days from today. Extra copies also within the during the course. 2 days.
Tomorrow.
During 2 days. List this matter after 4 weeks on a date to be fixed by the registry.
Obliged, highly obliged.
Regarding illegal eviction passed by the conducted by the this application has been filed for the illegal eviction has been conducted by the respondent number 456 on 8/6/2024, Your Lordships, this month, Your Lordships, without producing any prior notice to the without prior issuing any notice or intimations to the writ petitioners, though they have been bona fide possessor of the land.
What documents have you annexed to show that you are a bona fide?
Yes, land revenue receipts, Annexure 1. The
land revenue is not.
And the Jamamandi.
That shows your possession.
And Jamamandi, Your Lordships, wherein the Jamamandi, wherein my father's name has been appeared, and the land has been settled in way back in 1985.
You've been in possession since when?
1985, Your Lordships. But the thing is that
which is the order that you are challenging?
No, order is not.
There is no order of eviction.
That is why
already been evicted, Your Lordship. Evicted.
We have already evicted.
Without prior any notice, Your Lordships. And
similar matter came up yesterday. It's fixed on 15, Your Lordship.
On 15.
Similar, 15 of July.
What order has been passed?
Notice only issued.
No, there is a direction to furnish the instructions on 15. Till then, no coercive action will be taken against the.
So I'll pass the same order
on 15.
Where is that order?
Lordship?
Where is that order?
The order has not been uploaded yet. That is this one of the decisions.
Okay. Anyway, this is item number 12.
Lordship.
Heard Mr. H. Borwa, learned counsel for the petitioner. Stop. Also heard Mr.
R.R. Gogoi.
R.R. Gogoi, learned
Forest Department.
Standing Counsel Forest. Mr. A. Bhattacharya, learned Standing Counsel Revenue, and MSS Borwa, learned Government Advocate for the state respondent. By filing this petition under Article 226 of the Constitution of India, the writ petitioner is challenging the alleged illegal action of the respondent authorities in evicting them from the land where they have been residing since 1985. Stop. Let notice be issued, returnable 4 weeks. Mr. R.R. Gogoi, learned Standing Counsel Forest, accepts notice on behalf of respondent numbers
1, 2, 3, 4, 5 and 6.
1, 2, 3, 4, 5 and 6. MS Borwa for respondent number 7 and 8 and 9. So revenue is not there. 7, 8, 9. You remove Mr. Bhattacharya's name on top. Actually, in the cause list, it was mentioned. Okay. Till the returnable, till the next date,
15,
comma, let no coercive steps be taken in respect against the petitioners as regards the subject land. Stop. List this matter on 15/7/2024 along with WPC number
3211/24
and 2024
and
WPC
222
of
24.
222.
Obliged.
Obliged.
Supplementary list, item number 66.
Lordship, there is a direction by this Honorable Court, page 11, my lord. On 31/7/2023, there is a
Is a
specific
contempt
direction
case?
to
It's a contempt case?
Yes, ma'am.
Direction is where?
My lord, page 11, my lord. There is a direction to complete the demarcation process within a month of 2, my lord. Till that, nothing has been done, my lord.
All right, I'm issuing notice.
Yes, ma'am.
In item number 66. Heard Mr. S. Amaria, Learned Counsel for the petitioner. Stop. By filing the instant contempt petition, the petitioner is drawing notice of this court of the alleged willful violation of the directions contained in the order dated 31/7/2023 passed in WPC number 4284 of 2023 by the respondents. Stop. Let notice be issued, returnable 4 weeks, steps by registered post AD within a period of 2 days from today. List this matter after 4 weeks on a date to be fixed by the registry. Yes.
May I please, Your Lordship? The petitioner before Your Lordship, they are members of a, and after dissolution, the board approached this Honorable Court, and this Honorable Court granted some time, 3 months' time, liberty was given to them to hold the election. But that election actually could not be held because of lack of quorum. Then, my lord, the one-man committee has been appointed. In the meantime, the period already expired. The one-man committee was appointed. Then, my lord, the meeting was scheduled to be held, and that was not also not done. SGM could not be held. Now, my lord, they are going to hold the SGM on 7th of July. Tomorrow is the last date for applying for the nomination, my lord. My lord, our limited...
Who are you?
I am the board of earlier member of the board of directors.
Now, what is how can you be?
My lord, that is
at your instance, we delay this process.
My lord, in earlier occasion, my lord, I approached. We are given time, but we could not hold the election. Actually, disqualified.
See, I can issue notice, but I am not inclined to stay this election.
No, I am not praying for stay of the. I may be allowed to participate in the election, my lord, subject to, my lord, the result of this writ petition, my lord.
My lord, in fact, there is a statutory bar. The embargo created by the statute cannot be lifted by judicial order, and there are some orders, my lord, annexed. My lord,
I can simply issue notice and also say. That's all, nothing else. I'm not inclined to pass an interim.
Well,
and if you want, I can issue notice in the interim prayer as well, and keep the interim part open.
That is correct.
If you want, I can do that, or otherwise, I will hear you on the interim and decide it right away.
Just tomorrow is the last date for filing nomination.
I'm not inclined to do it. You had your chances.
And your lordship will see order is of 8/11.
You had your chances.
That 8/11, my lord, subsequently, my lord, another.
Sorry.
And similar secret.
If you sit silently and don't do anything, later
that
on
is,
now.
My lord,
yes, that is the lectures on your part, and this is a discretionary relief that you are ultimately seeking. Correct?
Only to participate.
Only because of that, this court is not inclined to grant you the interim.
Only to participate in the election, my lord. And I may be allowed to, my lord, file nomination, my lord.
Where is that embargo?
Yes, my lord.
Section 40.
40, my lord.
That is correct.
Then I am deciding the interim.
40.
Or if you wanted, I could have kept it open. But
44A and E, my lord. Unless there is the expiry of 5 years, they are debarred from participating in the election, my lord.
40?
40 subsection 4, A and E.
A and E?
E, A and E. Both are two, my lord. A is related to AGM, E related to election, my lord. These are settled positions, my lord. These are mandatory provisions, my lord.
So after 5 years, he can
after
participate.
5 years, they can participate.
And if there is an automatic dissolution under subsection 4 of 41.
Yes, my lord, yes.
Heard Mr. Heard Mr. N. Hawk, Learned Counsel for the petitioner. Stop. Also heard Mr. A. Talukdar.
SK Talukdar.
SK Talukdar, Learned Standing Counsel, Corporation Department. Stop. by filing the petition, the instant petition under Article 226 of the Constitution of India, the writ petitioner is challenging the impugned order, challenging the order dated 8/11/2023 within bracket annexure 5, issued by the respondent number 3, whereby the prayers of the petitioner to submit nomination papers for participating in the ensuing AGM/election for the year 2024-25 of Rangapani number 1 SS Limited scheduled to be held on 7/7/2024 was rejected. Stop.
Tomorrow is the date of nomination, not will mention it.
Issue notice returnable 4 weeks. Mr. S.K. Talukdar, Learned Standing Council Corporation Department, accepts notice on behalf of respondent number 1, 2, 3, 4, 5 and 6. Stop. Registered post AD in respect of respondent number 7. Stop. Heard the parties on interim prayer. Stop. The petitioner, who is the ex-board director, the petitioners who are the ex-board directors of Rangapani number 1 SS Limited, they were of the previous, no?
Previous.
Former ex-board, then I'll say, ex-board directors of the previous, what is it called? Previous board.
Well, in fact, the language is not correct. They were members of the earlier board.
That is what I thought.
Exactly.
That the petitioners were the members of the earlier
board of
directors of the
Rangapani number 1 SS Limited.
Of the Rangapani number 1 SS Limited.
Well.
In view of the fact that the election is scheduled to be held on 7/7/2024, that is tomorrow, 7/7/2024, the petitioner is seeking an interim direction that the petitioners be allowed to participate in the ensuing election scheduled on 7/7/2024. Stop.
Nomination date tomorrow.
Tomorrow nomination. It is also submitted that the nomination date is scheduled for tomorrow, i.e. 27/6/2024. Stop. Mr. S.K. Talukdar, Learned Standing Council Corporation Department, submits that Section 40 of the Assam Cooperative Societies Act 2007 cast an embargo for participating in the election by the ex-members of the board unless a period of 5 years has elapsed from the date of such member ceased to be a director for the reasons mentioned in subsection 4 of section 40. Stop. Admittedly, in the instant case, the period of 5 years has not been elapsed, correct?
Correct.
Elapsed. And therefore, the interim prayer sought prima facie cannot be allowed.
But we will add only one thing, 5 years from the date of their default.
5 years from the date of the default. Admittedly, from the default. As such, the interim prayer sought for is rejected. List after 4 weeks on a date to be fixed by the registry. Yes.
68.
Yes.
This is regarding non-payment of area malot against the land acquired for the purpose of national highway malot.
When land was acquired when?
In the year 2021 malot.
2021?
Yes malot. Part payment has been made malot.
Some payment has been made. How much left?
66 lessons, my lord. 3 katha 6 lessons.
How much payment is, how much is the outstanding?
Outstanding amount has not been informed to me.
But some amount you have received.
Yes, my lord. Page
Yes.
19 will reflect, my lord. Page 19 will reflect, my lord.
Page?
1919, my lord.
Alright, you take instruction.
My lord, Lordship may look into it, my lord. 3 and 3D notification under ANS Act is issued by the Ministry of Road Transport and Highways. Ministry of Road Transport and Highways not made a party. Work is executed by the NSIDCL. NSIDCL is not made a party. Land acquisition is made by the Kala.
Then how, if you do not make the appropriate
My lord.
authorities a rate respondent
My lord, Karbi
whose
Autonomous Council
presence
is
is
also made a
necessary
party.
for the
My lord,
effective
I have made the-
adjudication.
I have made the principal secretary National Highway, my lord, party. my
No,
lord.
National Highway itself has to be made a party.
I have made party. my lord.
Where have you made them party?
One, my lord. National Highway is 2, my lord.
That is National Highway Authority of India.
Yes, my lord.
Ministry of Road and Transport should be made. No, he has made NHAI a party.
NSIDCL, my lord. National Highway Authority.
NHAI
Road is constructed by
Mr. Council, it is
I will
for
make them party,
it
my
is for your benefit that the proper respondents are arrayed, correct? Otherwise, any order passed by this court will have no meaning if the concerned departments are not before this court. So you make the appropriate correction. You file an application. Now you have to file an application, and after that, we'll issue notice. There's no point of issuing notice at this stage.
Another Karbi Autonomous Council is also not by the represented by the principal secretary, by the chief executive member. So he should correct it also.
Just hear out the order. Please tell me the authorities that you think is necessary. It is submitted by Mr. J. Chutia Leonard Standing Council, KAC.
My lord. And also Kala, my lord. Kala is not by the party.
In this, you are appearing as Standing Council.
That's for number 6, my lord.
As SCKAC for respondent number 6. For respondent number?
6.
6 only? For respondent number 6. That. Yes, now tell me one by one.
My lord, the Ministry of Road Transport and
Ministry
Highways.
of Road Transport and Highways.
Government of India issued
Government of India
issued notification under section.
No, just tell me the names.
One. Second is the national.
National.
NSIDCL Highway Infrastructure Development Corporation.
Karbi Anglong.
No, National Highway Infrastructure Development Corporation.
Pala. National Highway Infrastructure Corporation Department.
My lord, third by the Kala, Competent Authority for Land Acquisition appointed under National Highway Act. There is Joint Secretary, Department of Revenue, KAC.
Please, Mr. Chute, can you ask one of your junior to just give the names? Otherwise, they'll be confused.
And the Karbi Autonomous Council represented by should be represented by Principal Secretary.
Represented by the
Principal Secretary.
Principal Secretary are the necessary parties in order to effectively decide the issue in hand. However, the said authorities have not been arrayed as party respondent in the instant writ petition. Stop. Let petitioner obtain instruction in this regard and do the needful within a period of 3 weeks from today. List on a date after 3 weeks fixed by the registry. Please give those. Yes, Mr. Bora.
May I plead the lordship?
What is this?
Petitioners all are residents of a particular residential area, my lord, before your lordship, against the setting up of a IMFL offshore within the in violation of the, my lord, provisions of the Assam excise rules, my lord. My lord, the violations we have stated at paragraph 5, my lord.
I can issue notice, but at this stage,
my lord,
stay will be difficult because...
no, my lord, what I pray that, my lord, because the allegation, that is specific. Because as per the provisions of the rules, my lord, if there is a temple or a temple which has a structure, a pakka structure of more than 200 square feet, here specifically I have stated that within 71 meters from the wine shop, that particular...
Mr. Bora, what is the status now? What is happening?
My lord, they are...
you must have filed a representation.
Yes, but that has not been considered.
Correct. And till now they have not issued the trade license?
Trade license issued, my lord.
Trade license issued?
Yeah, after filing of this writ petition, they have issued the trade license.
No, because one of your interim is
yes,
not to issue. So that they have.
They have
now,
issued...
you don't want it to be started.
Yes,
That is what you are saying.
Yes, ma'am. Status quo as on today, they are preparing.
If we dispose of this petition with a direction to the authorities to look into the grievances of the...
and only thereafter they can start.
Yes. Are you satisfied with that?
Submit one thing, Your Lordship. There was an inquiry conducted against which I have received the copy. If I may submit, Your Lordship.
And
this is an inquiry as regards
the shop of
grievances.
yes, the shop of the petitioner, because the excise department always conducts an inquiry before opening of the shop or issuing any license. In fact, surprisingly, there is another IMFL off shop which is only 800 meters away from the present shop, Your Lordship, and there have been no objection in that.
800 meters. That is not 800 meters. That is
just
not
near
in
the 800.
See, this inquiry otherwise has been done by the inquiry officer, and where the petitioner has not got any chance, correct?
Yes, sir.
Now, since the petitioners are the, you all are the residents of that locality.
Yes, madam. In fact, we have the NOCs from the local residents, Your Lordship.
Hear me out, Mr. Gogoi. What I am thinking is, why don't you give them an opportunity of hearing,
very well,
and thereafter you pass your whatever order you want to pass. Until you do not complete that exercise, you don't start that shop. It is up to you how soon you want to complete that hearing, provided they cooperate. I think that would be fair enough.
Yes, my lord.
Because otherwise, no point in keeping this matter or grant a stay order. That will also go against you.
Yes,
correct?
Yes, my lord.
Mr. Bora, you are okay with that?
Yeah.
Where is the representation?
Representation at Annexer...
Page 24, Your Lordship.
Annexer 2, page 20. It starts from page 20. There are three representations filed before.
Do you want to file a fresh representation?
Yes, my lord. Fresh representation.
So I will say that you file a fresh representation within a period of 1 week from today.
Yes, ma'am.
And after receiving within a period of 2 weeks.
2 weeks, Your Lordship.
2 weeks, you dispose of that representation in accordance with law by giving them opportunity.
Yes, my lord. And till such disposal. Yes, my lord.
Item 69, at a disposal. Heard Mr. D.P. Bora, Learned Counsel for the petitioner. Stop. Also heard Mr. K.K. Mr. R.R. Gogoi, Learned Standing Counsel.
Yes, Your Lordship.
Learned Standing Counsel, Excise Department, and M.S. S. Bora, Learned Government Advocate for the State Respondent. Stop. By filing the instant petition, under Article 226 of the Constitution of India, the petitioners are seeking directions inter alia to the effect directing the respondent authorities to consider the objections, representations submitted by the petitioners, praying for not allowing the respondent number 7 to set up his within quote IMFL OFF. This whole thing should be within double quotes, right?
Within double quotes.
Within double quotes. Shop at NSCB Road, Krishna Nagar, Municipal Holding Number 36, Ward Number 9, Hojai Town. Stop. The brief facts of the case is that the petitioners who are, where have you described, the petitioners are about 25 numbers, no? Where have you described them?
My lord, the side.
The petitioners, where have you described? Yes, alright. The petitioners who are residents of Krishna Nagar, Hojai, within a radius of 75 meters from the site proposed to be set up for the IMFL off shop of the respondent number 7. Stop. It is the specific case of the petitioners that the said IMFL off shop is being set up in the aforesaid location in violations of the provisions of the Assam excise rules. Stop. Paragraph 5 of the petition is reproduced hereunder for ready reference. Paragraph 5, correct?
Yes, my lord.
Mr. D.P. Bora heard the parties at length and perused the materials available on record. It appears that the petitioners have filed an application, have filed a representation to the respondent authorities for reconsidering the issuance of IMFL shop to the respondent number 7.
Yes, ma'am.
To the respondent number 7, comma. However, no response whatsoever has been received till date. Stop. Mr. R.R. Gogoi, Learned Standing Counsel, submits that an inquiry has been conducted by the Inspector Excise, Hosai Excise Circle, whereby it is seen that the grant of IMFL of license to the respondent number 7 is justified. Stop. Next. Be that as it may, next paragraph. Be that as it may, this court is of the considered view that since the residents of the locality has certain grievances as regards the setting up of the IMFL off shop in the proposed location, comma, to which representations has also been filed, which has not been considered till date, comma, deems appropriate to dispose of this writ petition at the motion stage itself, directing the respondent number.
That would be your lordship.
Respondent number so and so.
Three, your lordship.
Respondent number 3 to dispose of the application which shall be filed by the petitioners within the period of 1 week, comma, after receipt thereof in accordance with law within a period of
2 weeks.
2 weeks from therein. Stop. Alright, I think it is sufficient. Till needless to clarify that till the respondent number 3 disposes of the application filed by the petitioners in this regard, comma, it is respondent number 7, but he is not here, no?
He's not
R7.
here, respondent number 7 is not present, your lordship.
The proposed IMFL off shop shall not be started. Stop. It is further made clear that that all the stakeholders involved in the matter shall be duly heard before considering the application filed by the petitioner.
And let the speaking order be passed, your lordship. That will be better.
No, because you see R7 also has a right.
Yes, your lordship. After hearing both the parties, speaking order will be passed.
It is made clear that after hearing the parties involved in the writ petition, a speaking order shall be passed. I'll edit this later.
Yes.
Highly obliged, lordship.
Deeply obliged.
May I please, Your Lordship? My Lord, it's eviction matter, my Lord. Impugned notice, Lordship will find page 35.
Page?
35, my Lord. Annexure 7, my Lord.
Yes.
My Lord, may I read, my Lord?
Yes.
It is observed that you are encroaching government land measuring 0 visa.
This is eviction?
My Lord, eviction. Covered by Doc number 119, Revenue Village, Bongaigaon, Town Part 1, under Bongaigaon Revenue Circle. As per directions of District Commissioner Bongaigaon, so and so, you are hereby directed to vacate the aforesaid plot of land and remove your structure and establishment with immediate effect. Further failures. Now, Lordship will find, I have annexed the my Lord Sita copy, that Lordship will find at page 26.
Page?
26. Annexure 2, my Lord. My Lord, impugned notice, it is mentioned as Doc number 119, my Lord. Now, Lordship will find Doc number 119 is, my Lord, railway land, my Lord. That in vernacular, Lordship, I have also annexed that vernacular Sita copy, my Lord. It's a remarks column, it is railway land, my Lord. And now, Lordship will find page 29. 29, my Lord.
Hey, Rupak, it RR Gogo did you go? 29 is what?
This is, my Lord, certificate issued by the, my Lord, authorized officer, my Lord, NF Railway, my Lord. That Lordship will find that may I read, my Lord. This is the certified that the...
What is your prayer?
My Lord.
What is your prayer?
Prayer is, my Lord, I am challenging that impugned notice because, my Lord, the circle officer has no jurisdiction and authority, my Lord, because it is the, my Lord, railway land, my Lord. So, my Lord, the circle officers cannot, my Lord, issue that notice, my Lord.
Yes.
And
the first thing is that whether the petitioner has been able to make out a case for interference by this court. He has already admitted it is a government land. The Sita, the Jamabandi very clearly shows that it is a Sarkari land. So the meaning of Sarkari land is the government land. So he is saying that he has been allowed to be in possession by the railway authority. I don't know what kind of right he has accrued by way of such certificate being issued by officer. I don't know whether they are authorized officers of the railway.
As of now, he is in possession.
Yes, that is what he is claiming. But that apart, these are the certificates that is...
Mr. Borwa,
yes.
You obtain the I'll issue notice, and till that next date, you don't. If he is in possession, let's status quo. Because if he is in possession, why to? Because he's been there since.
No, the possession doesn't give him the right to be
I'm
there.
not declaring his right, correct?
Yes.
But instead of depossessing him right now,
yes.
I'm not even staying this order. I simply say that you don't take. Let status quo be maintained till the next date. Simple order.
Page 30 is the certificate issued in the year 30, my Lord. 2017, my Lord, wherein the circle officer himself admitted that.
See, because this is otherwise he's staying there only because of that. On the next occasion, you file your affidavits, and if something is there, this court will not extend the stay. Status quo only till the next date.
Page 30 is the, my Lord.
This notice
this
is
certificate is what? Issued by
circle officer himself,
revenue circle officer.
Yes, my Lord. Wherein, my
has
Lord,
possessed a plot of railway land.
My Lord.
Now, how have you... See, you have to prove your possession, because Mr. Borwa has raised a very pertaining question at how did the railway settle this land on your...
Railway allotment has been given, my Lord.
Huh?
Railways, my Lord, the government has allotted because the Sita copy itself says that it is allotted to the railway, my Lord.
Anyway, today is for motion, so... Heard Mr. R. Sharma, Learned Counsel for the petitioner. Stop. Also heard Mr. S. Borwa, Learned Government Advocate for the state respondent, and Mr. A. Bhattacharya, Learned Standing Counsel, Revenue. Stop. By filing this petition under Article 226 of the Constitution of India, the petitioner is assailing the impugned notice issued under memo number capital BNGC-14/2012/448 within bracket A, dated 14/6/2024, issued by the Circle Officer Bongaigaon, Revenue Circle Bongaigaon, within bracket Annexure 7. That is the Annexure 7 is that eviction, no?
Yes.
Stop. Let notice be issued, returnable 4 weeks.
15 days.
Mr. S. Borwal, Leonard, Government Advocate, accepts notice on behalf of respondent number 2, 3 and 4. And A. Bhattacharya accepts notice on behalf of respondent number 1. Correct? Extra copies within the period of 2 days from today. It appears from the, that certificate is at page 30.
My lord.
That certificate is page 30.
Certificate of Circle Officer?
Yes.
Yes, my lord.
It appears from the certificate dated 22/11/2017 and enclosed as Annexure 4 to the writ petition that the petitioner is possessing the subject plot of railway land prior to 1997.
My lord.
Prior to 1997. Stop. In the interest of justice, let status quo as regards the subject land be maintained till the next date of listing. Stop. List after 4 weeks on a date to be fixed by the registry.
One thing, they have made 5 petitioners. What is petitioners? We do not know.
Yes,
because if it is a registered Sangha, the Sangha is registered in a different name. Krihi Bikash Sangha, not Bongaigaon, and the petitioner's name is Ahom Krihi Bikash Sangha. If I take it to be the same, then who are these 4 other
So
petitioners?
I'll say
secondly, the entire case is based on
the certificate talks about this Assam Kristi Bikash Sangha, right?
Yes.
So I will say status.
Certificate of registration is different, man.
Yes.
A little different.
Page 11, my lord, I have specifically stated that.
Alright, on that returnable date, you file your returns and bring everything.
And I pray the railway may be paid party because their entire claim is based on the railways.
Make them a party. Why to unnecessarily
I have no any, my lord, grievance against the railway.
But if there, you see, the railway has at Korea, it appears that the presence of the railway is essential for effective adjudication of the matter, as the subject land has been alleged to have been given to the petitioner by railway.
Yes.
Correct?
Yes.
Stop. Let petitioner obtain instruction and do the needful in this regard.
Oblige.
Before the next date of listing.
Oblige.
Item number 3.
Yes, Mr.
My
Mahmood.
husband was brutally killed by the private respondents. My husband was killed by the private respondents.
Your husband was
killed
by
the private respondents, and they kept his dead body in a pit, and my lord, in that dig they kept a cow, so that people may consider it as a case of accident. Later on, I went to one local outpost, Boribazar police outpost, in the district of Borigaon. But police told that it is a matter of accident, so he compromised take rupees 2 lakhs. So it appears that the police is very much interested with them. So under compelling situation, I approached the SP. Lani SP sent the FIR to the police station, and police station thereafter, Wikivita police station thereafter registered the case and asked the police to investigate. But after some time also, we didn't know about who the police officer.
Will issue notice.
No, they were asked to take instruction by the last order. And if
Yes, Mr. Borra, you have the instructions. I think Ms. Borma in the morning was there.
Unfortunately, I don't have the file, so that's it.
I think she has it. She was mentioning something has come.
If I rightly remember, is it something relating to the non-registration of taking appropriate actions against the FIR?
Yes.
So in that case, the petitioner has an alternative remedy.
That's right. That is what she was submitting.
Yes. Sudhi Bhaskar Tambe and Sakira Basu.
Alternative
remedy is very much available.
Section 1.
Mr. Borma, you see on 12/6/24.
In many such cases, this honourable court also have dismissed those cases.
Yes,
asking them to approach the appropriate.
That is one thing. Dated 12/6/2024, whereby the government was directed to obtain instruction as regards the status of investigation.
There she comes.
Ms. Borua, in view of the judicial order that was passed on the last occasion, whereby you were asked to obtain instructions as regards to the status, have you got it?
Yes.
Yes. Investigation appears to be going on, Mr. Mahmood.
Investigation is going on. The
Statements have been recorded.
accused person regularly coming to police station. Kindly see page 22.
No, but you see, in such a situation,
Page 22.
there is nothing otherwise. Which is the decision you were referring to?
Yes, Lordship.
Some photos I have annexed of the dead body.
Which
Page
is
20.
Sakiri Basu.
Sakiri Basu is one, and there is another one you said. Show me.
Wait. On my photo.
I have also so many judgments. Lolita Kumari, then my lord, I have also studied
One
here.
second, Mr. Mahmood, just 1 second. You do one thing, Ms. Borwa.
Yes, sir.
You file an affidavit.
Yes.
You give chance to the other side to rebut and say whatever they want to do. After that, this court can always pass. This matter is still at the motion stage. Notice has not been issued. So I am issuing formal notice and let them file the...
A short date may fix, otherwise
All right.
they will vanish the witnesses.
I will bring this report on record.
MS S. Borwa, learned government advocate, in terms of the order dated 12/6/2024, has placed the status report in connection with
Mikirivita PS case number
in connection
70
with
Mikirivita PS
Yes, I got it. In connection with Mikirivita PS case number 70/2024, registered under section 302/34 IPC. Stop. Issue notice, returnable on, give a date after vacation, on such and such date. Let the aforesaid instructions be placed by way of an affidavit before the next date of listing. List this matter on such and such date. Return the instructions.
Kindly last week of July, Lordship.
All right. Because there is vacation in between, Mr. Mahmood. I'm returning these to you,
Yes,
huh?
Lordship, always.
Item number
16.
Item 16.
You want some accommodation?
No, my lord. I am basically, I have a simple prayer, my lord. At page 50, your lordship will find an order passed by the department.
Page?
50.
Yes.
There is an order of demolition issued against the respondent number 5 here in Miller. It says, Miller, whereas Honorable Guwahati High Court, by its order dated 18/1/2018, in connection with review petition number so-and-so, clearly held that building permission issued by NOC number so-and-so dated 14/11/2002, granted to Sheikh Nur Alam based on a false affidavit submitted by him was not a valid permission, and the building constructed by Sheikh Nur Alam on the strength of NOC dated 14/11/2002 is invalid in law and unauthorized. Whereas all the petitions submitted by Sheikh Nur Alam were disposed of, and a notice under section 88 of GMDA Act was already served to Sheikh Nur Alam, directing him to demolish the building of height number so-and-so dated 30/6/2015. Therefore, I so-and-so, Chief Executive Officer, Guwahati Metropolitan Development Authority, to hereby direct Sheikh Nur Alam, Ulugadi Bazar near so-and-so, Ashram Road, Guwahati 7, to demolish the unauthorized construction which is in violation of provision of GMDA Act 1985 zoning regulations and building bylaws made there under in pursuant to order of Honorable Guwahati High Court within 5 days from the date of receipt of this order. Failing which GMDA will be free to proceed with the demolition or sealing. Well, this is the order issued against the respondent number 5. Well, I am the petitioner herein residing in the adjoining land, my lord. Well, basically, respondent number 5 and the petitioner are brothers, my lord. They have a joint property out there. Well, there are long civil suits are pending before the court, my lord, regarding their partition. In the meantime, he obtained, the respondent number 5 obtained a NOC by forging the signatures of various brothers and obtained that NOC hiding, my lord, all the facts which has led to the various cases in various courts, my lord. After all, my lord, the GMDA, after perusing all the records, issued a revocation order by which the NOC issued in favor of him.
Your prayer in the writ petition is to demolish the illegal construction
Yes,
of
my lord.
R5.
Yes, my lord. And this is the order, my lord.
But there is a dispute pending.
Well, there is no dispute pending with regard to this, my lord. The NOC obtained by the respondent number 5 is a forged one.
You are challenging that NOC.
My lord, that NOC, they have challenged, my lord. The petition, the respondent number 5 filed a writ petition challenging the revocation order issued by GMDA. Well, the writ petition, in the writ petition, your lordship will find.
No, in the writ petition, your prayer appears to be directing the respondent authorities to demolish the illegal construction.
To comply the order, basically. The order they have issued, my lord, after
order
considering.
At page 50.
Yes, my lord.
Yes, Mr. Bora.
But I need to get instruction. There is a provision of section 71 of the GMDA Act, my lord.
Section?
There is a provision 71.
You have not filed your
I have
affidavit.
not filed, my lord. That instruction I will get it, my lord. If there is an appeal is pending, because against that order there is a provision of section 71 appeal. The appeal will be recorded district court.
71 is, my lord, is on a different footing, my lord. 71 is an order passed against a person who is.
My lord, I am not holding the GMC Act, my lord.
Alright, we are posting it after vacation.
Because I will get the instruction.
In the meantime, you get your instruction.
Lordship.
Mr. S. Bora, Learned Standing Counsel, GMC, seeks some accommodation in the matter to obtain instruction as regard whether any appeal
under section 71 of the GMDA, 71 of the GMDA Act 1985
is pending.
There is no appeal pending, my lord.
Mr. Your name?
S. Biswas, my lord.
Mr. S. Biswas, Learned Counsel for the petitioner, however, submits that no such appeal is pending. Stop. He is saying no appeal is pending, then?
And the appeal will be before the district judge, my lord.
No, my lord. This is an order, my lord.
The petitioner, if appeal would have been filed, who would file?
The person against whom this order has been issued. He will file an appeal under section 71.
That is respondent number 5.
Respondent number 5.
Well, he already filed a writ petition was dismissed. Then they filed a review petition was also dismissed.
Be that as it may, 2 weeks' time is granted to the parties to apprise the court as regard if any such appeal is pending. Stop. List this matter after 2 weeks on a date to be fixed by the registry. You have it. If you can also file your affidavit saying that it is not there. Yes. I shall resume in 5 minutes.
by consuming rat poison because of your harassment, wanting to discipline the child?
Lordship, there was
What
no,
sort of discipline is this?
Your Lordship, there was no
Why a girl should not talk to a boy?
there was no harassment as such.
What
Your Lordship.
harassment?
Coming to the question
Yes.
of the statement of the complainant herself, I'll take your Lordship to page number 32 of the petition, Your Lordship. That's a typed copy of the complaint.
Yes.
31 last pair. 31 last pair.
31, Your Lordship.
I have seen.
So the complaint discloses the fact that the allegation was mainly towards the accused number 1, Your Lordship. That is the petitioner number 1, the drawing sir. The drawing sir called the parents of the deceased, and
There is no question of disciplining the child. You have not attempted to that. You only wanted to harass the girl. Only because you wanted her to stop talking to boys.
Your Lordship, there was a misunderstanding right there, Your Lordship, initially, even admitted
And
by
you
the...
you called her parents also to the...
No, he
Called-
did call.
yes,
He
Your
did
Lordship.
call. What he does, my lord, he speaks to other students and tell the other student not to talk to this girl. And therefore, this girl complains to the mother. And then mother comes and asks the teachers, and why are you doing that? If there is an issue with my child, you tell me, why are you telling it to others?
These two should face.
Your Lordship, as far as that particular portion is concerned,
Do you even know you have killed a child?
Your Lordship,
You have killed a child.
there was an attempt just because the petitioner did not say sorry to the to the accused, Your Lordship, to the victim
Sir,
deceased.
at the age of 14 or 15, the girl's mind is so tender that the psyche gets affected by all these things. It is not, you must know, and you're 45 years old.
Your
You
Lordship,
must know how to teach the children.
there were rumors.
Drawing teacher should restrain for drawing purposes.
But Your Lordship, as far as allegation against accused number 2 is concerned, none of it finds places in the complaint, Your Lordship. As far as the accused number 2, just because he told that as far as the CCTV footages can be checked, as far as if at all you have made any attempts is concerned, only to that extent, a statement was given by the deceased victim in her statement, in her statement, Your Lordship. Statement recorded on the 8th of February. Thereafter, dying declaration was also recorded on the 8th of February, where the petition number 2 does not find any place. The name of the petition number 2 does not find any place. Your Lordship, the reason why a drastic step like this was taken, which is very unfortunate, was because on the preparatory examinations for SSLC, her scores were very low.
Whose scores were low?
The deceased victim.
So?
Yes, Your Lordship, as far as since there
You
was
wanted her scores to go high and adopt this
she
method.
made the same disclosure in the dying declaration, Your Lordship. I will take Your Lordship to the portion of the dying declaration at page number.
Sir, this is a civilized society.
Page number
Everybody is accountable and responsible. Male chauvinism has no place here. Don't try to impose your male chauvinism on girls or women.
Your Lordship, there was
That
no
is not the case. That
was
cannot
no
be
attempt.
permitted.
The page number 55 may be looked into, Your Lordship.
Yes, sir.
ನನ್ನ ಬಗ್ಗೆ ರೂಪೇಶ್ ಸರ್ ಅವರು ಕೊಟ್ಟ ಅಭಿಪ್ರಾಯ ಹೇಳಿ ರೂಪೇಶ್ ಸರ್ ಇಸ್ ಪೆಟಿಷನರ್ ಮೂವಾನ್, Your Lordship.
Yes.
ನನ್ನ ಬಗ್ಗೆ ರೂಪೇಶ್ ಸರ್ ಅವರು ಕೊಟ್ಟ ಅಭಿಪ್ರಾಯ ಹೇಳಿ ನನ್ನ ಗೆಳತಿಗೆ ಮೆಸೇಜ್ ಮಾಡಿ ವಿಚಾರದಲ್ಲಿ ಹಾಗೂ PT ಸರ್ ಸದಾನಂದರ್ ಅವರು ಟಾರ್ಗೆಟ್ ಮಾಡುತ್ತೇವೆ ಎಂದು ಹೇಳಿದ್ದು, ಇದೇ ಕಾರಣದಿಂದ ನನಗೆ SSLC ಪೂರ್ವಕ ಪರೀಕ್ಷೆಯಲ್ಲಿ ಕಡಿಮೆ ಅಂಕ ಬಂದಿದ್ದು, ಮುಂದೆ SSLC ಪರೀಕ್ಷೆಯಲ್ಲಿ
Dying declaration after consumption of rat poison.
Yes, Your Lordship.
Right?
Yes.
We'll answer.
This particular statement was her statement given to the police, Your Lordship. Dying declaration was recorded before the Tahsildar thereafter. ಪರೀಕ್ಷೆಯಲ್ಲಿ ಕಡಿಮೆ ಅಂಕ ಬಂದಿದ್ದು, ಮುಂದೆ SSLC ಪರೀಕ್ಷೆಯಲ್ಲಿ ಕಡಿಮೆ ಅಂಕ ಬರಬಹುದೆಂದು ಮನನೊಂದು ವಿಷಪಾತ ಸೇವಿಸಲು ಕಾರಣರಾದ ಡ್ರಾಯಿಂಗ್ ಸರ್ ರೂಪೇಶ್ ಹಾಗೂ PT ಸರ್ ಸದಾನಂದರ್ ಅವರ ಮೇಲೆ ಸೂಕ್ತ ಕಾನೂನು ಕ್ರಮ ಕೈಗೊಳ್ಳಬೇಕಾಗಿ ಕೋರಿಕೆ. So, Your Lordship, yes. There was no direct. There was an unfortunate step taken by the deceased victim.
So, how do you punish these people if they have taken unfortunate step? There should be some accountability.
Your Lordship,
there should be some accountability for having committed these acts.
Your Lordship, the petitioner number one did not take matter in his own hands. He followed the procedure.
What procedure?
The interaction was done before the HM, the headmaster itself.
All right.
It was decided that thereafter, henceforth, if at all there was an attempt or there happens any allegations against the deceased victim, as far as this is concerned, it will be brought to the parents' attention. Your Lordship, this was also recorded by this was also noted by the.
What was the date of that interaction?
The interaction happened on the 6th of February, Your Lordship.
Date of death?
Death of. She consumed poison on 7th February, succumbed to the same on 8th.
Perfectly justified. Yes.
8th February, Your Lordship. Your Lordship, I'll take your kind attention to page.
All judgments. Yes, come on, sir.
The last judgment that I have provided is.
Geo Varghese.
Yes, Your
Geo
Lordship.
Varghese.
Geo Varghese, yes.
Disciplining the child would not amount to abetment to suicide.
Yes, Your Lordship.
Yes.
As far as that is concerned, I have produced the judgment.
Yes, sir.
The attempt was made. The statement of the complainant herself at page number 32, Your Lordship. That interaction is been testified by the complainant herself in her complaint. I would read the particular portion, Your Lordship.
Yes.
ದಿನಾಂಕ 6/2/24 ಮಧ್ಯಾಹ್ನದ ಸಮಯ SDM ಪ್ರೌಢಶಾಲೆಗೆ ಹೋಗಿ ಶಾಲೆಯ HM ನನ್ನು ಭೇಟಿ ಮಾಡಿ ಮಗಳು ನನ್ನ ಜೊತೆ ಹೇಳಿದ ವಿಚಾರ ತಿಳಿಸಿತ್ತು. ಆಗ ರೂಪೇಶ್ ಅವರನ್ನ HM ಕರೆದು ನನ್ನ ಮಗಳು ತ್ರಿಷಾ, ಮಗಳು ಡಿಸೀಸ್ಡ್ ವಿಕ್ಟಿಮ್ Your Lordship, ಹಾಗೂ ಹರ್ಷಿತಾಳನ್ನು ಕರೆದಾಗ ನಾನು ರೂಪೇಶ್ ರವರಲ್ಲಿ ಏನು ವಿಚಾರ, ನನ್ನ ಮಗಳ ಬಗ್ಗೆ ನೀವು ಹರ್ಷಿತಾಳಿಗೆ ಮೆಸೇಜ್ ಮಾಡಿ ಯಾಕೆ ಕೇಳಿದ್ದು, ನನ್ನಲ್ಲಿ ಅಥವಾ ನನ್ನ ಮಗಳಲ್ಲಿ ನೇರವಾಗಿ ಕೇಳಬಹುದಿತ್ತಲ್ಲ, ನೀವು ಅವಳಲ್ಲಿ ಕೇಳಿ ನನ್ನ ಮಗಳ ಬಗ್ಗೆ ಕೆಟ್ಟ ಅಭಿಪ್ರಾಯ ಮಾಡಿರುವುದು ಯಾಕೆ ಎಂದಾಗ ರೂಪೇಶ್ ಅವರು ಶಾಲೆಯಲ್ಲಿ ಮಕ್ಕಳು ಡಿಸೀಸ್ಡ್ ವಿಕ್ಟಿಮ್ ಬಗ್ಗೆ ಕೆಟ್ಟದಾಗಿ ಮಾತನಾಡಿದ್ದರಿಂದ ನಾನು ಹರ್ಷಿತಾಳ ಮುಖಾಂತರ ಮೆಸೇಜ್ ಮೂಲಕ ವಿಚಾರಿಸಿ there was an attempt to ask ಇರುವುದಾಗಿ ತಿಳಿಸಿದರು. ಅಲ್ಲದೆ ದ ಡಿಸೀಸ್ಡ್ ವಿಕ್ಟಿಮ್ ಡಿಸೆಂಬರ್ 31 ಧರ್ಮಸ್ಥಳದ ಅಮೃತ ವರ್ಷಿಣಿ ಹಾಲ್ನಲ್ಲಿ ನಡೆದ ಕಾರ್ಯಕ್ರಮದ ಸಮಯ ನಮ್ಮ ಸಂಬಂಧಿಕರ ಜೊತೆ ಮಾತನಾಡಿದ ವಿಚಾರವನ್ನು ನೆಪವಾಗಿಟ್ಟುಕೊಂಡು ಸ್ವಯಂಸು ಸರಿ ಇಲ್ಲ ಎಂಬುದಾಗಿ ಹೇಳಿದರು. ಬಳಿಕ ನಾನು ಅವರಲ್ಲಿ ಹಾಗೂ HM ಅಲ್ಲಿ ಮುಂದಕ್ಕೆ ನನ್ನ ಮಗಳ ಬಗ್ಗೆ ಯಾವುದೇ ಕೆಟ್ಟ ಮಾತುಗಳು ಬಂದಲ್ಲಿ ನನ್ನಲ್ಲಿ ನೇರವಾಗಿ ತಿಳಿಸುವಂತೆ ಹೇಳಿ ಮನೆಗೆ ಬಂದಿರುತ್ತೇನೆ. ನಂತರ ಮಗಳು ಕ್ಲಾಸಿಗೆ ಹೋಗಿರುತ್ತಾಳೆ. The next day she goes to a medical store, gets a rat poison, consumes it, finds herself in 9th week class, taken to the hospital. Thereafter, it's the 8th of February, statements are recorded and she succumbs to the same.
Harshita is not a mother. If there is an issue with
Harshita is another student.
If there is an issue with a child, the teacher should speak to the parents. Instead of speaking to parents, he is spreading rumors to the classmates. And he expects the child of 14-year-old or 15-year-old to understand all these things and bear the consequences of spreading rumors with other children. And when mother makes a phone call to him, he cuts the phone call and directs her to come to the college. It's not that he called her for having a conciliation. Mother volunteers to go and understand what's happening. And then he says that I accept that and I inform that Arshita because people are speaking about. If there is something if he needs to discipline, he can bring it to the parents and then there's a method to understand all these things. He can't be.
Your Lordship, before the parent calls the petitioner, there was an attempt by the deceased victim who approaches the drawing sir. He tells her to get her parents. Thereafter, the parent calls and the conciliation is.
What crime did the girl do?
Your Lordship.
What crime did the girl do?
There was an inquiry made, Your Lordship. As far as he messaging Harshita, her friend, was to only concrete his findings. Only after that he wanted to go ahead with the complaint. He never spread rumors or anything as such. He just wanted to made an inquiry. But unfortunately, the said friend told that so-and-so was asked, and she was very mentally upset about it. And thereafter, the whole process happened, and then unfortunately, she consumed the rat poison and thereafter succumbed to the same.
Yes. Ashala. Heard reserved. Yes, next.
Your Lordship, an interim stay for the same may be sought, Your Lordship.
Will grant.
Your Lordship.
Pronounce it in 2 days.
Yes, Your Lordship. Much obliged.
ಇದು ಮಾತ್ರ ಬಿಡಲ್ಲ. Police machinery is being wasted in this.
Look at the
ಇದರಲ್ಲಿ
language.
ಏನಿದೆ ಹೇಳಿ?
Look at the language used.
What language? Come to the language.
Page 15. my lord.
ಏನೋ ತಲೆ ಕೆಟ್ಟಿದೆ, ಸರಿಯಾಗಿ ದುಡಿಯದೆ, so and so, so and so. What language?
Language have some, should have some.
Arts. ಆ ಕಡೆ ಪವರ್ಲಿದ್ದಾಗ ಇದು, ಈ ಕಡೆ ಪವರ್ ಬಂದಾಗಿದು. An eye for an eye and tooth for a tooth will render the world blind. ಅಲ್ಲಿಗೆ ಹೋಗ್ತಾ ಇದೆ. Yes. The petitioner is before this court calling in question registration of a crime in crime number 8 of 2024 registered for offences punishable under section 153A and 505(2) of the IPC. The allegation against the petitioner is that he has put up a post on the Facebook account that reads, so and so. This, in the considered view of this court, would not meet the ingredients of section 153A or 505(2), albeit prima facie. Permitting further proceedings against the petitioner would run foul of the judgments of the apex court in the case of Javed Hajam versus so and so 2024 4 SCC page 156, and the subsequent judgment of the apex court in the case of so and so 2024 SCC online SC page 132. Therefore, there shall be an interim order of stay of further proceedings against further investigation against the petitioner till the next date of hearing. List the matter on 25th in the fresh matters list. 153 ಏದೆಲ್ಲ ನೀವು ಹಾಕಿರೋದೆಲ್ಲ ಕೊಡಿ. ಒಂದೇ ದಿನ will finish everything. ಇವರು ಈ ಕಡೆ ಇದ್ದಾಗ ನೀವು ಬರೀ 153 Now the protagonists have changed in the government, so things are changing. Next. ಅದು 132 ಅಲ್ಲ, 322. Next judgment.
Notice.
Learned additional SPP is directed to accept notice to the respondents. Ibru.
ಅಲ್ಲ.
Complaint idara?
ಹೌದು.
Correct. Emergent notice to the complainant returnable by 25th. Yes, next.
Let's 409, 420, 465, 477A of IPC.
Sanction ilva?
Let's illa idu investigation alli.
Investigation.
Under investigation. Let's a chief accounts officer and financial advisor who conducts the inquiry regarding some the misconduct of the officers and prepares a report and make a recommendation to the managing director to hold the further inquiry and punish the culprits. Where
is the report? Page 46?
Page number 51.
Hello, 46 is the report.
The 46 is the, based on my report, the managing director writes to the government saying that, take action against this particular, I'm a whistleblower.
Heard the learned counsel.
Sought for a paper, investigating papers, my lord. Have it next week, my lord. Let the notice also go to the complainant and come.
Why? ಕೇಳೆ ಕೊಡಬೇಕು ಅಂತಿದೆಯಾ ಅಷ್ಟೇ ಮತ್ತೆ?
The issue of 11 crore of misappropriation.
Against him?
Yes, in this case.
No, against all.
Yes.
Not against him. That is what he has highlighted. Kodi anyway, give it. List day after tomorrow. Fresh matters list. Give the papers. Yes, madam.
341, 323, 504 and 506. The complaint is at page number 16, your lordship.
Wound certificate ಕೇಳಿದೆ ನಾನು.
Please, madam. They have furnished, my lord.
ಇದೆಯಾ wound certificate? Yes, madam.
So that is the additional document that we have filed.
You have produced the wound certificate?
That is not with respect to this case, your lordship. A counter case was filed. Initially, that case came to be registered, wherein accused number 1 in this case was the de facto complainant. Subsequent to registering of that crime, this crime was registered.
Criminal petition is preferred by them also?
No, your lordship. In that, they have subjected themselves to the medical examination. They have produced medical certificate also.
In
the
this case,
petitioners
where is
here-
the medical?
I'll secure, my lord. 230.
Secure, the head
230.
of the charge sheet ನಲ್ಲಿ there's no mention. Your lordship.
Charge sheet ಅಲ್ಲಿ ಇಲ್ವಾ?
ಇಲ್ವೇ ಇಲ್ಲ, your lordship. Head of the
ಚಾರ್ಜ್
charge
ಶೀಟ್
sheet,
ಇಲ್ಲದೆ ಇರೋದೇನ್ ತರ್ತೀರಾ ಈಗ ಮತ್ತೆ?
page 17. your
ಚಾರ್ಜ್ ಶೀಟ್
lordship.
is filed.
Charge
Charge sheet
sheet
is filed, my lord. Page number 19.
Page 17
Heard the
has,
learned counsel Abhinaya K appearing for the petitioner. The learned counsel for the petitioner submits that the present complainant is an accused in a crime registered by the petitioners for
not
offences
petitioners, your lordship, other accused.
by other accused. Then how are you connected with that?
That is the problem, your lordship. They were not even present at the spot, but just because there are some civil disputes pending before each of them, these people have been arrayed as accused.
Charge sheet ಅಲ್ಲಿ own certificate ಇಲ್ವಾ?
ಇಲ್ಲ. Head of the charge sheet, page 17.
Yes,
List of
that
documents.
is at page 19.
That is head of. the
Your
case.
accused numbers?
4 and 5.
ಜಗಳ ಬಿಡಿಸಿ ಬಂದಾಗ. Yes, a perusal at the summary of the charge sheet. The present petitioners accused number 4 and 5 would not indicate the meeting of ingredients of section 341 of the IPC as is necessary under section 339. While the allegations could be sustained against the other accused, not against the accused 4 and 5. Therefore, there shall be an interim order of stay of further proceedings where the petitioners accused number 4 and 5 till the next date of hearing. 1 HCGP 2 emergent notice 19th. Yes.
3.
Appear for the petitioners, my lord.
You implemented the.
Yes, my lord.
He is here. Yes.
Second response.
Who is the complainant here?
Your lordship may kindly turn to page 67, annexure C.
67.
Please. The complaint starts from page.
A complaint by the ROC.
By the ROC.
By the ROC.
Then you should not, why you would not make the complainant a party?
My lord, I have preferred an appeal. This is setting aside the order of the Sessions Court, my lord. I had filed an application initially under 451 for release.
Or
then
this is
there was
defreezing, is it?
defreezing, my lord.
Okay. Yes, sir. Yeah, tell me.
My lord, I am not accused in this matter, my lord. There was originally a complaint given by the respondent number 2 to investigate into the affairs of the company which are dealing with unauthorized financial and loan transactions. One such company, SHRI Technologies Private Limited. SHRI Technologies Private Limited.
All right. Yes.
My lord, the petitioner number 1 is a limited liability partnership firm. Petitioner number 2 and 3 are financial consultants or chartered accountants.
All right.
During the course of my profession, a reputed law firm approached me seeking my assistance with incorporation of a company. There is a consultancy agreement which is executed. My fees is decided on monthly retainership basis. Subsequently, I incorporate the company. As per their instructions, I hand over the company, towards which I have received a sum of rupees 6 lakhs. That fees is already intimated to the RBI as well. Except for the fees, I have not received anything else. The matter has been pending for 2 years. I have not been arraigned as an accused, nor there is.
Why have you bought these children?
My children accounts are also frozen.
Children account is there?
Yes.
6 years and 11 years you opened an account?
Our joint SRL ittu Swami. Ella nandu.
Joint account.
Joint SRL. Andre minor. No.
Don't project that children of 6 and 11 have their own accounts.
The minor account handled by me. That's the whole thing, my lord. Towards the professional capacity,
how much money is transferred to the account of the children?
Children account ಏನು ಹೋಗಿಲ್ಲ. Whatever is linked with my PAN, it has been frozen.
All right.
One small example, I am a treasury of a residential society. That society's bank accounts was also frozen.
No, that's all right. See, if there is money trail leading to some, accused or whatever, and the money has been dropped into your account by the accused in a crime, that trail is enough for the freezing of the account. Let me hear the other side.
My lord, one more point I needed to add.
Yes.
6 lakhs I had received. After I visited the investigating officer and submitted all the documents, a lien has been imposed and couple of accounts of their choice have been defrozen. Not everything. And lien was in, I have received 6 lakhs. The lien is imposed for 6 lakhs. So that amount lies as a security itself, my lord. If my entire family's bank accounts is frozen for 2 years, how would I run my affairs, my lord?
2 years ago.
2 years ಮೇಲೆ ಆಗಿದೆ Swami.
The fact that you have survived for 2 years, you can go until the
My
trial
lord,
is
it is
over.
not about, I have been up knocking the doors of the court regularly seeking for the request. As soon as the concept of Chinese beneficial owner comes into the mind, the courts are little jittery about passing an order or a relief in my favor, my lord.
This is also a court.
My lord, but that should not be the contention, my lord. I have discharged my duties as a prophet. Similarly, like a lawyer, my lord, I may appear for a company and I receive the professional fees.
That's your submission.
Yes, ma'am.
Yes, sir.
Lord, for the time being, I have these instructions, my lord. I will place all the other instructions thereafter. If your lordship may kindly see, the petitioner number 2 and 3, initially,
No, first you tell me, why did the ROC complain against these people?
Lord, the reason is this, my lord.
What led the ROC
Lord,
to register a
the
complaint?
Ministry of Home Affairs issues a directions to the Ministry
No,
of
your
Corporate
ಹೆಸರು ಇದೆಯಾ
Affairs.
ಇದರಲ್ಲಿ? Your ಹೆಸರು ಇದೆಯಾ ಈ ಲಿಸ್ಟ್ ಅಲ್ಲಿ? No, the allegation in the complaint is they are all the faces of Chinese citizens who are wanting to operate in India.
Please,
So
exactly.
that is the complaint. I've seen the complaint.
Please.
But the names of these people are there?
The names of these people are not to be
Or
found.
the companies whom these people have allegedly dealt with?
That, my lord, I'm yet to
That's
get
all.
that.
Now
That.
you tell me.
If your
Yes.
lordship may kindly see, the petitioner number 2 and 3, initially, my lord, subscribed for a company by, on the share capital, they become an initial directors. The modus operandi of the petitioner is this, my lord. They become the directors of the company, thereafter resign from the company, and the company is transferred to an Hong Kong based company. Lord, this is the modus operandi of the petitioners. Lord, the information by the Ministry of Home Affairs was that under the secret reference matters, my lord, there were about 300 companies which were doing such a business of lending loans to the general public by virtue of these apps. My lord, under that, my lord, under the secret reference matters, the Ministry of Home Affairs directed the Ministry of Corporate Affairs to inquire with the matter and, if found, to lodge a complaint. Based on that instructions, my lord, these complaints have lodged. This is my first submission. Insofar as my second submission is concerned, my lord, if your lordship may kindly go through the following issues were observed in the instructions, my lord, on physical verification. This is my name.
No, that is
Much okay.
objections he will file.
ಅಲ್ಲ ನಾನು ಏನು ಅಂತ ನೋಡಕ್ಕೆ.
Yes, yes, tell.
If your lordship may kindly see, point number 2, the main object mentioned in the memorandum of association of the company is software development, technical consultants, computer design software. However, as per the information available on the public domain, it was found that the company was involved in illegal loan app business, and the statement of one of the directors so and
No,
so.
how are these petitioners involved in this?
Lord, that, my lord, I'll have to.
All right, then you will have to file.
Instructions I've
You will
got
have to
in
file your objections.
Please.
Because you are the complainant, you have to defend the complaint and the linkage to these people. Heard the learned counsel appearing for the petitioner. The learned counsel seeks to impress upon the fact that the petitioner is neither an accused, is not an accused in any, petitioners are not accused in any crime. But their accounts have been frozen for the last 2 years and has caused great jeopardy to the running of the business. The learned DSGI Shanti Bhushan, who was directed to secure instructions, has secured instructions and would seek time to place all the instructions by way of statement of objections. It is his submission that the complaint was in specific that the Chinese app, the creators of the Chinese apps which lent loan to all public are under scrutiny by the Ministry of Home Affairs. That's complaint.
My lord, one small submission. All this comes up because of the press note number 3.
We'll see. Yes.
I was detached from the company before even the press.
1 minute. Yes, so and so. Therefore, the learned DSGI shall file a statement of objections by the next date of hearing. 1 week?
Please,
1 week. Yes, list on 5th July in the fresh matters list.
Great.
Yes. Alla bada, 5th July at 3:30 PM for further hearing.
Great.
Yes. File your objections.
Please, please.
Let him also know what is against him.
Please.
We take back the mail.
ತಗೊಳ್ಳಿ, ಅದು ವಾಪಸ್ ಕೊಟ್ಬಿಡಿ ಮೇಡಮ್.
Petitioners in this case, 498 AM and your report. But there are no allegations as against the.
Yes, you are appearing?
I'm appearing for afternoon. I'll enter my appearance today.
Huh?
I'll enter my appearance today, madam.
You enter your appearance.
Lord, so far, there are no allegations as against the husband, my lords. The main.
Oh, this is
Yes.
on mother-in-law and father-in-law they are rallying.
No. Sister-in-law.
Only sister-in-law now.
Father-in-law is passed away.
Oh, sister-in-law, sorry.
Sister-in-law.
That is 2 and 3.
2 and 3, my lords. And that too vague allegations.
Husband is somewhere else.
No, my lords, he is in Bangalore.
How can there not be allegations against the husband?
Allah, I can read out the complaint, my lords.
What do you mean?
Yes, my lord.
I thought this husband was somewhere else.
No. He stays in Bangalore, but he rarely stays in Bangalore because he goes on a touring for Honda company.
It's all right.
The allegations is this, my lords. A vague allegations as against 2 and 3. Brother-in-law, nothing, my lords. 4, 5, 6, 5, 6 and 7, my lords, they are relatives. They don't stay with the complainant.
Now, 1 is husband.
2 is mother-in-law. 3 is
sister-in-law.
4 is brother-in-law.
Brother-in-law. 5, 6.
They are all, my lords.
5, 6, 7.
Our relatives.
Yes, madam.
Please.
1, 2 and 3.
1 to 4, my lord, are assigned together.
1 to 4 we will decide later. Others we will stay.
My lord, I have placed the investigation papers on the last occasion. I
ಎಲ್ಲಿದೆ?
placed it on.
ಚಾರ್ಜ್ ಶೀಟ್ ಆಗಿದೆಯಾ?
Charge sheet ಆಗಿಲ್ಲ.
ರೆಡಿ ಇದೆ.
No, my lord, charge sheet is not yet.
My lords, nothing happened still, my lords. File a divorce petition.
That's all. That ground don't tell here.
Until April 10, my lords, the husband and wife were talking. They were having chats on WhatsApp.
So,
lords, after immediately I file a divorce petition and the notice is served and injected.
WhatsApp chats and the divorce petition gotaita seeda.
Allala.
Then?
See, my lords, what happens is, my lords, in February, there happens a fight inside the home.
On WhatsApp?
No.
Then?
Andre Maneli, Sanda Putak Vandvishikke. What happened? That, my lords, that goes to Annapurneshwari police station. And there counseling happens, my lords, the complainant leaves the house. And thereafter what happens, my lords, the complainant herself messages the husband that, my lords, I want to live with you, I am missing you, I love you, all these messages. Till 10th, my lord, that same thing happens. On 18th April, my lords, I file a divorce petition.
So you are presuming that there is no allegation against you because she said so?
No, actually no allegations, my lords. My lords, on 19th,
My lord, 1 to 4.
5, 6,
1 to 4 correct agide ಹೇಳಿ. You are also appearing on this side in many cases.
1 to 4.
You should be correct.
Insofar as accused number 1 to 4 is concerned, my lord, there
2
are
and 3, I quite see definitely.
My lord, insofar as
Hello, 1, 2 and 3.
Alla, one melu, alla, you ribru compare.
Sir, you are the husband, sir. Don't tell that there is no allegation at all.
But insofar as accused number 1 to 4, my lord, there are allegations. I still want to go live with my husband. They are refusing to take me back, my lord. That even in the complaint, my lord, I've written what. My
So
lord,
you have no axe to grind against the husband.
my lord, my lord, if the
You want to go back to the husband. Then if you show a dagger to him, how can you go back to him?
my lord, if the complaint is looked into from the date of marriage, my lord, from
The fair counsel, wait.
Yes.
Doesn't, not like that, yes.
my lord, from the date of marriage, my lord, if the complaint is looked into, my husband has harassed me, my mother-in-law, mother-in-law, sister-in-law, they've accepted, they've demanded dowry from me, my lord. I was thrown out the house.
You file your objections.
Obliged.
1 to 4, we will consider later.
Obliged.
Others I will state today. Yes. Heard the learned counsel appearing for the petitioner and the respondent. You have filed entered appearance? The learned counsel, Srimati Raksha Kirtana, seeks to enter appearance for the second respondent complainant. A perusal at the complaint so registered against these petitioners would prima facie indicate not even sprinkling allegations against petitioners 5, 6 and 7, accused 5, 6 and 7, while the learned counsel for the complainant submits that she would substantiate that the allegations are there against petitioners 1 to 4, accused 1 to 4. The learned counsel for the petitioner insists that there are no allegations against the husband at all, and the complainant herself wants to come back to the husband. if that be so, the interim order insofar as the petitioners 1 to 4 are concerned would be considered on the next date of hearing. Objections, if any, by the complainant by the 23rd. List the matter on 23rd in the fresh matters list. Yes, we'll see.
Yes.
Bail ತಗೊಂಡಿದ್ದೀರಲ್ಲ? Next. Yes, sir.
Please, Your Lordship. Crime number 118 of 24.
Engineer.
Please, engineer.
You have engineered something.
No, that's what is being felt, Your Lordship, and I am told that Your Lordship's expressed that it should be investigated. Absolutely no problem on that aspect of the matter. What we are only asking is the two wills in the year 2002 and the will of 2005, coupled with the mutations in favor of the person who got the will property under 2002, all may be investigated. The only prayer to this honorable court is...
I will not enlarge the scope of investigation.
No.
Yes.
It is part thereof, Your Honor. Because what they are saying is, let the investigation be done by the investigating officer. Let their sphere of investigation not be curtailed, Your Honor. Let them check it up in thorough.
No, if I increase the horizons of investigation, then it's not correct. What is the crime? For that crime, let investigation be done.
Related documents. I am not asking them to go beyond it.
Let's see what the investigation is.
Related documents, let it be done. But only our prayer is that pending that, let this mother and son not be in trouble. Because admittedly, it came to their husband of the father of the petition. Admittedly.
We'll see.
Money.
I've heard him yesterday.
Please, to that extent only we are seeking. Rest all, let your lordships, whatever you need.
Anything else, Jans?
No, that's all. I have shown your lordships the documents and
purely civil in nature.
That is their argument.
That is the argument.
Not only that, suit is pending. It will take its logical course. They will take their logical course there, including whatever other reliefs they want to claim.
Any given fact can give rise to two circumstances: one, the civil, and the criminal. Let's see whether
that your lordship can always. We are not on that aspect of the matter at all.
Merely because something is projected to be civil, whether we should hold our hands, we'll see.
Our humble submission here is that since the court is already seized of the matter.
Which court is seized of them? Civil court.
There's an injunction suit
filed. There's a suit pending.
That is why, my lord, now that matter is also listed today. Of course, they mentioned it in
GMCPC.
GMCPC, where BBMP has been directed in a GMCPC matter to be made a party to find out as to how they've done this.
All that, let it be investigated. We are not nothing on that. Because we can't stop anything being investigated. And I will be fairly cooperative with them. Only protection to the petition. That's all is that.
They have filed an application for anticipatory bail that has not been granted. It is still pending. Now they want to come here, my lord, to try and get an order where anticipatory bail is not granted to them. And there I want to point out to your lordship, these documents.
At least we will move there, your lordship.
Bail move madi.
Pending. We'll take chances there.
Ali
granted,
No.
Listed tomorrow.
List.
Ali, they produced one document, which is that forged document which I showed your lordship. Then when we pointed it out, we of course appeared and opposed bail. Then immediately, my lord, they took an adjournment and got these three new ones, which was created on June 2024.
It's okay, lordship. What and how they moved the matter. It can't be viewed in the manner that which the respondents like to view it.
Right, so and so reserved. Yes. Next.
26.
Made these claims. 500 of IPC, my lord. 501. My lord, 1 and 2 are the publishers. Accuse them 1 and 2. 3 is the president of the bank. And 4 to 14 are the directors. Based on the report of the cooperative registrar, my lords, that there is fraud and falsification of accounts, private complaint is filed and referred to the police, FIR is registered, which is published in the newspapers. Private complaint is at...
You are who?
My lord.
ಯಾವ newspaper ಇದು?
ಇದು accused number 1 and 2 are Udayavani and Vijay Karnataka, my lords. Accused number 3 is the president of the bank who has filed a complaint. Accused numbers 4 to 14 are the directors of the bank. which has filed a complaint, my lords.
Bank
That
is-
complaint is.
Bank is not a party.
Bank is not a party. Complaint is referred to the police, FIR is registered. That is published in the newspapers. Then complaint is filed under 500 of IPC. That's stating that there is defamation, my lords. My lord, that FIR we are compelled to file.
Page.
The complaint, FIR, my lords.
Charge sheet is filed in that case?
The investigation is private complaint is filed immediately. Kindly see page number 72.
72.
Howದು. Crime number 99 of 2020, registered on 13/10/2020. That is based on the report of the Cooperative Department, page 85.
Now, against whom is the complaint?
Against this complainant, my lords.
Against the present complainant.
Complainant.
What happened to this crime?
That is investigation pending, my lords. And what he
ಅಲ್ಲ
does
ಅದ್ರಲ್ಲಿ
is
charge sheet ಹಾಕಿಲ್ವಾ?
pending. ಇಲ್ಲ. ಇದ್ರೊಳಗೆ immediately this FIR is registered on October, my lords.
What did you report?
December 2020, he files the complaint.
No, what did you report?
Report about the Assistant Commissioner of Cooperative Department said, my lords, that there is fraud committed by this complainant.
That was a paper publication?
Paper publication. Other newspaper 85, my lords. Detailed report he has given, and he has also that page 87, your lords, may kindly see. The relevant. Many fraud is committed, my lords. Page 87. In respect of our bank, the allegation is the very complainant has committed fraud, my lords, committed falsification of accounts and obtained loans. Page 87, Kelagade, Udupi so and so bank. And the assistant registrar says, my lord, that action should be taken. Pursuant to which we have initiated action against him.
Now, where is the order taking cognizance?
Order taking, please, my lords. That, my lord, be pleased to get it, page number 45.
Heard the learned senior counsel, PP Hegde, appearing for the petitioner. The respondent was served by way of hand summons. Less the matter. Our counsel ಇದಾರಲ್ಲ?
ಇಲ್ಲ ನಾವು ಇದು ಫಸ್ಟ್ ಟೈಮ್ ಬರ್ತಾ ಇದೆ ಸ್ವಾಮಿ.
so
500 of IPC ಇದಕ್ಕೆ
ಪೊಲೀಸ್ ಇಲ್ಲ ಗೊತ್ತು.
ಇಲ್ಲ ಕಂಪ್ಲೇಂಟ್ಗೆ 500 of IPC ತಮ್ಮ ಮುಂದೆ ಫಸ್ಟ್ ಇಟ್ಸ್ ಕಮಿಂಗ್ ಅಪ್ ಫಾರ್ ದ ಫಸ್ಟ್ ಟೈಮ್, ಮೈ ಲಾರ್ಡ್. ದೇರ್ ಇಸ್ ನೋ ಡೈರೆಕ್ಷನ್ ಟು ಸರ್ವ್.
ವಾಟ್ ಡೈರೆಕ್ಷನ್?
ಹ್ಯಾಂಡ್ ಸಮ್ಮನ್ಸ್ ಗೆ ತರುವಾಗ
ಈಗ ಕೊಡ್ತಾ ಇದ್ದೀನಿ.
ಪ್ಲೀಸ್ ಯು ಆರ್ ಲಾಸ್ಟ್ ಪರ್ಮಿಟಿಂಗ್ ಮೀ. ಐ ಆಮ್
directed to serve the complainant by way of hand summons.
I am so sorry.
List the matter on 19th. The learned senior counsel takes this court through the documents appended to the petition to demonstrate that what was the content of the crime registered against the present complainant was only published in the newspaper as it was a public document. Therefore, an offense under section 500 cannot be laid as ingredients of section 499 can hardly be met in the case at hand. The perusal at the records would vindicate the stand or submission of the learned senior counsel, albeit prima facie. Therefore, there shall be an interim order of stay of further proceedings before the concerned court till the next date of hearing.
Most.
Yes.
7.
For petitioners. What is the matter? 153, my lord, your lordship directed to my lord secure investigation papers. What had happened is, my lord, Bharat Mata ki Jai ಅಂತ ಘೋಷಣೆ
ಗೊತ್ತಾಯ್ತು. ಕೊಡಿ. ಭಾರತ್ ಮಾತಾ ಕಿ ಜೈ ಅಂದ್ರೆ ಪ್ರಾಬ್ಲಮ್?
ಅಲ್ಲಲ್ಲ, ಅದೆಲ್ಲ ಪ್ರಾಬ್ಲಮ್ ಆಗಿರೋದು ಇನ್ಸಿಡೆಂಟ್ ಆಗಿದೆ. This is the
went into the mosque.
This is a classic case, my lord, that 153A would have been invoked because it resulted in subsequent crime. This incident resulted in subsequent crime.
ಸುಮ್ಮನೆ ಇರಕ್ ಆಗದೇ ಇಲ್ಲ.
Lord, we got the CCTV footage also, where, my lord, they were shouting, my lord, slogan, and they were not riding the bikes. All of a sudden, my lord, the accused in the other crime, my lord, they assaulted them. And to cover up that, my lord, next day they register this FIR.
Lord, I'll look into the
In fact,
papers.
the 2 police constables who were posted there also given a statement to that extent to say what transpired on that day.
We'll
Subsequent to that, there was this incident.
List tomorrow in the fresh matter.
Then on that basis, they should have registered FIR then and there itself.
They should.
We'll see.
They should have registered.
Why, my lord, it is
same
registered
as the
next
last
day is the question, my lord, that they have to answer.
They'll have to think what provision to invoke ಅಂತ. Yes. ಅದಕ್ಕೇನೆ ರಿಜಿಸ್ಟರ್ ಮಾಡ್ರೆ ನೆಕ್ಸ್ಟ್ ಡೇ.
Interim order.
ಇದೆಯಾ?
Interim order. No coercive action.
The interim protection granted shall continue till the next date of hearing. We'll have it on Friday in the fresh matters list. Please. ನೀವು ಇರಲ್ಲ ಫ್ರೈಡೆ? ನಾಳೆನೇ ಇರಲಿ. Till a Tuesday. There,
Tuesday.
I will take it on Tuesday. List on Tuesday in the fresh matters list. But papers early.
Yes.
The split of case, my lord. Offense against accused number 1 is acquitted.
Split charge sheet.
Please, ma'am.
Yes, government.
A judgment copy I have produced.
The
Also,
petitioner is before this court calling in question continuation of proceedings in CC 960 of 2019 by drawing up a split charge sheet against the petitioner. The petitioner is accused number 2, gets embroiled in a crime on 9/1/2015, which later is tried by the Court of Session for offence punishable under section 307, 504 and 506. It transpires that at the relevant point in time, the petitioner was not available for trial. The concerned court draws a split charge sheet against the petitioner in CC 18519 of CC 960 of 2019 and tries the other cases as CC. CC 307 drop aita.
So SC agi SC 227 of 2000
SC
227 of 2019.
So and so. And tries the other accused in other accused ಎಷ್ಟು ಜನ ಇದ್ರು ಒಂದೇನಾ?
Accused
and the other accused, accused number 1 in SC 227 of 2019. The Court of Session acquits the accused number 1 in terms of the order dated 3/10/2022. Since the petitioner was not available for trial at that point in time as observed herein above, a split charge sheet was drawn and the petitioner is now sought to be tried in CC 960 of 2019. The order of a perusal at the order of acquittal.
Page number 62.
The perusal at the, what is the
68
307,
ಅಲ್ಲಿ.
na?
The victim itself doesn't support.
Turned
the case.
hostile.
68 ಅಲ್ಲಿ.
The
Bottom.
order of acquittal is based upon the statement, based upon the victim herself turning hostile and not supporting the case of the prosecution. Therefore, the concerned court draws up benefit of doubt and acquits accused number 1. The reasons so rendered, if the victim has turned hostile to the prosecution, qua accused number 1, it cannot be said that the victim would now support the case of the prosecution when it comes to accused number 2. Therefore, permitting further proceedings against this petitioner, who would eventually get acquitted, like how the accused number 1 is now, accused number 1 stands acquitted, will be a colossal waste of judicial time, which is too precious in these days. Therefore, I deem it appropriate to obliterate the proceedings against the accused number 2, as is done in the case of accused number 1. The view of mine in this regard, in which I clearly so split charge and really
Even in his deposition also, he clearly stated, nothing stated against it.
Reason. Paragraph order.
Yeah, that is 55.
Page alla, paragraph. Acquittal order, the paragraph.
That is 62. Please.
Paragraph page. Work code. Yes.
That's page number 66.
Page number? Ram Singh, correct ಹೇಳ್ಬೇಕು.
Point number 8. Number 65, 66.
Page number 65, 66. Paragraph?
Para number 8.
8. ಅದನ್ನ extract ಮಾಡ್ಬಿಡಿ. Next.
It is very clear in this. Even there is no allegation.
All right, we'll make it clear in this also.
Please.
Yes. Disposed, yes. For the aforesaid reasons, the Madi allowed first.
This is a case pertaining to Lord's.
Heard the learned counsel, Subramanya appearing for the petitioner. ಯಾರನ್ನೋ ಕರ್ಕೊಂಡೋಗಿ ಇವ್ರನ್ನೋ ಅಂದ್ಬಿಟ್ಟಿದಾರಲ್ಲ ಮೇಡಮ್. ಕಾವೇರಿ ಗಲಾಟೆ ಯಾವಾಗ ಆಗಿದೆ?
ಅವ್ರು ಹೇಳೋದು 700-800 ಜನ ಇದ್ದಾರೆ ಅಂತ ಹೇಳ್ತಾರೆ. ಅದರಲ್ಲಿ 15 ಜನ ಇನಿಷಿಯಲ್ ಆಗಿ they identify. So far as Milords, I am concerned, they don't mention my name in the original FIR. Even in Milords, in the charge sheet also, there is nothing against me. No allegation.
The petitioner is said to be one of those present in the riots when the Kaveri riots, as it is known, in the year 2000.
Lord, 16, Lord.
2016. To draw the petitioner into the web of crime, a photograph or a footage of the television is taken note of. The learned counsel for the petitioner submits that about 500 people were present and 15 people are identified. And in the identification, the petitioner was not the one at the time of registering the crime, but has entered into the scene only while drawing up the charge sheet. A perusal at the charge sheet does not indicate any particular act of the petitioner to be a part of the unlawful assembly or even criminal trespass as obtaining under section 447. Finding nothing against the present petitioner, there shall be an interim order of stay of further proceedings, quay the petitioner till the next date of hearing. Additional SPP 1, complaint Nivelva.
Please, Your Lordship.
Additional SPP 1 and 2. Yes, next.
30.
Petitioner, my lord. Petitioner and second respondent are landlord and tenant, my lord. The registered lease deed is there, my lord. So I issued a notice.
ಯಾವುದು vacational ಕೊಟ್ಟರೋ interim order?
Vacational ಕೊಟ್ಟಿರೋದು
7/5/2024 ಯಾವ interim order ಕೊಟ್ಟಿದೆ? Page
number 79, my lord.
Identical matter.
Serial number 38. ಅದು first complaint ಅದು. ಇದು second complaint.
Serial number 38.
Today it is listed, my lord.
Yes.
Page
The
number
learned counsel for the petitioner submits that in a complaint registered by the very complainant, this court, the coordinate bench of this court has granted an interim order of stay pursuant to notice pursuant to the notice dated 3/5/2024. The notice, by the time interim order is granted, crime is registered in the subject which is challenged in the subject petition. In the light of the interim order subsisting in the subsequent, in the aforesaid petition, there shall be an interim order of stay of further investigation, quay the petitioner till the next date of hearing, finding that the issue in the list concerns the dispute between landlord and tenant, which is given a color of crime. Yes, next.
Please, sir.
You have not taken any loan?
No, Your Lordship.
You have not taken any loan?
I have not taken any.
Heard the learned counsel for the petitioner, Paras Jain, appearing for the petitioner. The learned counsel for the petitioner submits that he is neither an applicant nor a beneficiary of any loan granted to the petitioner and is without rhyme and reason dragged into these proceedings. Therefore, till the appearance of the respondent complainant, there shall be an interim order of stay of further proceedings, quay the petitioner, list the matter on 25th. Yes, 1 HCGP, 2 emergent notice, returnable by 25th. Yes. Next.
32.
Petition. This Immoral Traffic Act which came yesterday, the judgment.
Where is the other judgment?
There are two judgments, not one. Let's say two judgments.
Good.
The one, my lords, was pleased to point out.
Delhi, Dalla?
Yes, my lords. That is the.
Some Indira Nagar,
Enterprises. Yes, my lords.
Indira Nagar commercial complex is because 2022 yeah.
That is that Corinco Enterprises Private
yes,
Limited,
correct.
Delhi. And there's one more decision, my lords, where 12 days prior to the raid, rental agreement which was entered into, the court considered that is in SHRI, my lords.
So now Prabhuraj, Jayashri and this.
Yeah, 3 judgments. And I'll just point out, my lords, in our case, 2015 is when I purchased that property, my lords. I put up, my lords, the sale deed, we have produced it. 2015 is the purchase of this property. 2020, a commercial complex put up there. Lease deed entered in 2020, my lords, with accused number 1. Then accused number 1, my lords, even in his GST, reflects this hotel which he is running and he's paying GST on that. And my lords, the incident in question takes place in December 2023, 3 years after I've entered into the lease deed. And my lords, when the incident takes place, it's the inspector, my lords, who comes and raids. He gives the complaint. In the complaint, he adds me also as an accused, my lords. Now, a charge sheet is filed with 34 witnesses. None of the witnesses speak about my role. The co-accused says I was only owner of that entire premises. That's all, my lords. My lords, I have proof of even the rentals that were being paid to me and the GST standing in there.
Close.
Yes, my lord.
Open and shut case. Yes. The petitioner has opened it, will shut it. Yes. Heard the learned senior counsel the petitioner is before this court calling in question proceedings in CC 52393 of 2024, registered for offences punishable under section 3457. Madam, I'll prayerly the accommodation. The petitioner is accused number, Allah heard so and so money. The petitioner is accused number 3. Where is a resident of?
My lords, he is a resident of Bangalore, my lords.
Purchases a property in site number so and so. For synopsis, first synopsis, madam. On 23/9/2015, then constructs a building and leases it out to one Madhukar Shetty, accused number 1, in terms of a lease deed. The accused number 1 is said to be running a hotel and boarding and lodging business in the said premises after obtaining a requisite trade license from the hands of the BBMP. On 19/12/2023, a search happens to the hotel and results in registration of a crime against the accused in crime number 370 of 2023 for the aforequoted offences. Since the petitioner is the owner of the building, is drawn into the web of crime. The police the police conduct investigation and file a charge sheet against the accused, including the petitioner, on 19/2/2024. Filing of the charge sheet has driven this petitioner to this court in the subject petition. The learned senior counsel would vehemently contend that the petitioner is no doubt the owner of the property, but has leased it out to the accused number 1. And what activities the accused number 1 has undertaken there was not within the knowledge of the petitioner, as it was the sole responsibility of who's accused number 2? A2 yaro.
He's also shown as owner, my lords.
No, he's shown as a owner, but he's not an owner, my lords. A3 is the owner. A1 is the person who was running this.
But A2 should not come co-owner anta. Yes.
ನಮ್ಗ್ ಗೊತ್ತಿಲ್ಲ ಯಾರಂತ.
The accused number 1. The search results in the hotel or lodging and indulging in the offences indulging in the acts which should become offences under the Immoral Traffic Prevention Act, with particular reference to section 3, 4, 5, and 7 of the Act, read with section 370 of the IPC. Submission in learned counsel for the take it back, man. Learned senior counsel would take this court through the documents appended to the petition to demonstrate that the petitioner, after construction of the building, leases it out to accused number 1 for a certain consideration. What the accused number 1 has undertaken as business in the leased premises is not within the knowledge of the petitioner. He would submit that unless knowledge is proved even prima facie, it cannot be that the petitioner, being the owner of the premises, can be hauled into these proceedings. He would further clarify that accused number 1 is the one who was the lessee from the hands of the petitioner, and accused number 3 is the only owner and not accused number 2. The learned HCGP would refute the submissions to contend that the petitioner, being the owner, must be aware of what is happening in the leased premises, and therefore knowledge is presumed as obtaining under section 3 of the Act. Since the charge sheet is filed, it is for the petitioner to come out clean, is his emphatic submission. I have given my so and so. The afore narrated facts are not in dispute. The link in the dates are a matter of record. The lease that takes place on the petitioner purchases the property on 23/9/2015, gives it on lease to accused number 1 on 26/10/2020. It is then the story of the accused number 1 would commence of running the hotel in the said leased premises. On the evening of 19/12/2023, a search by the respondent takes place and results in the impugned crime. The issue now would be whether the petitioner, who is the owner of the premises who had let it out on lease 3 years ago would have the knowledge of what is happening in the premises. For this, a perusal at the charge sheet is necessary to be noted. A summary of the charge sheet is necessary to be noticed. Page.
It's at column 17.
Yes, page.
My lords, it's at page.
Page 74.
74.
The summary of the charge sheet reads as follows. Page 74, Madam, mark portion. Except depicting the petitioner to be the owner of the premises, there is nothing that would indicate that he had the knowledge of what was transpiring what was happening in the hotel. The statements recorded, which are all appended to the charge sheet, also does not indicate that the petitioner had complete knowledge of what was happening in the premises. Section 3 of the Act reads as follows. Section 3 directs that whoever, where is 3 is, Madam Act Codings. No, Section 3 mandates that directs punishment for keeping a brothel or allowing premises to be used as a brothel. It mandates that any person who keeps or manages or acts or assists in so and so would become punishable under Section 3. Subsection 2 of Section 3 deals with the person who is owner, lessor, or landlord of any premises, having full knowledge of what is happening thereof and intended to use the premises as the brothel would also be hauled up in the crime. Therefore, knowledge is the soul of subsection 2 of Section 3. Knowledge would mean, knowledge would be at least a statement from any of the persons whom the investigating officer inquires that he had the knowledge of what was happening in the premises. None of these instances are present in the case at hand. Therefore, the petitioner, without the knowledge of the petitioner, if the accused number 1 has gone on indulging himself in the crime, in the acts that would become offenses under the Act, the petitioner cannot be hauled up to those proceedings. In the light of the aforesaid circumstance, the further proceeding being permitted against the petitioner would become an abuse of the process of the law and result in miscarriage of justice. For the aforesaid reasons, the following
judgment
that we will see. I'll quote it.
Please.
I will add those.
Yes, just out of context, my lords, my lords should recollect the NDPS matter, my lords, which is reserved. And we had made a submission, coordinate bench has allowed a matter, but the judgment was not ready.
I saw it.
Now the judgment is released. 3 paragraphs there would be of relevance here. Yes, my lords, where in 1 is no recovery, my lords. 2 is not being subjected to medical examination. So in our case, as my lords recollects, A6, it is only through A1's mobile number that they tried to trace A6 and a GPay of 17,000 rupees. Other than that, no
70,000.
17,000.
1
GPay.
Yes.
So, my lords, there was no recovery and we were not subjected to medical examination.
Even I was waiting for that.
Yes, my lords. Could I give that judgment order?
I've seen it. Yes.
I made a memo.
Oh, yes, I've seen it.
Please, my lords. Oblige, my lords.
It runs into 14 pages. Yes.
Probably, my lords, has a lot more to consider in the other matter, my lords. It goes to the aspect of jurisdiction and bail.
No, I want to write something more.
Please.
I was waiting for that, true. But
yes, sir. Deeply obliged.
Here for petitioner's counsel. Offence alleged is 420, my lord. Lord, it is a clear case of civil dispute, my lord, which has been given color of a criminal case. Lord, from 2007, they were, my lord, jointly, my lord, taking care of the property. In fact, in the year 2007, property was purchased, my lord, by way of separate 2 sale deeds by the petitioner as well as CW2. She is not a complainant. Some journalist files a complaint, my lord, saying, my lord, a crop partnership deed has been, my lord, created and the proceeds of the joint venture has been utilized. Not the fact remains is, my lord, this very agricultural, my lord, property which was, my lord, cultivated, and the proceeds were, my lord, given to the, my lord, joint loan account obtained by both the parties. Lord, no, my lord, loan has been
We'll
settled.
hear the complainant.
Please. But my lord, so far as the, kindly see page 41 is the charge sheet column, my lord. Absolutely, there is, my lord, nothing, my lord, except civil allegation, my lord. Therefore, my lord, sought for interim order till then. And in the earlier occasion, accused number 4 has lodged a complaint, my lord, filed a private complaint. That private complaint, my lord, has been stayed by your lordship, my lord, in
number
page 93.
Number
Is 0 of 2024.
Page number 97.
Page number 97. He files a criminal complaint saying, my lord, by way of this prop partnership deed, Lord, that the same has not been given effect, and he is not allowing to cultivate the property. For that, he lodges a private complaint, and that complaint is, my lord, registered after this complaint is filed. This is not filed by the complainant, my lord, or the person who has aggrieved. This has been filed by a journalist. Therefore, my lord, sought, my lord, interim
We'll
order.
take both.
Till then, my lord,
Day after tomorrow. ಏನೇ ಆಗ್ಬಿಡುತ್ತೆ ಅಲ್ಲಿವರೆಗೆ.
Lord,
Charge sheet is already filed.
Lord,
Charge sheet filed.
his son, my lord,
Charge sheet challenge ಮಾಡಿರೋದಲ್ವಾ?
charge sheet
challenge
that is why, my lord, the kindly see page 41 is the charge sheet column. The very reading, my lord, makes it very clear. It is a pure civil dispute.
I'll take it day after tomorrow along with that.
Please, interim order may be granted.
ನಾಡಿದ್ದು ಕೊಡುವ.
Yes. Fresh matter.
Fresh matter.
There is a visa interview for the petitioner's son,
When?
my lord. This is Friday. That is the urgency.
Visa interview. ಅದಕ್ಕೂ ಇದಕ್ಕೆ ಏನ್ ಸಂಬಂಧ? Where are you going?
Some declaration has to be given, my lord.
Then no criminal cases are pending. Stay ಕೊಟ್ಟ ತಕ್ಷಣ ಪೆಂಡೆನ್ಸಿ ಹೋಗಲ್ಲ, ಪೆಂಡಿಂಗ್ ಇದ್ದೇ ಇರುತ್ತೆ.
But declaration can be granted, my lord, saying there is no running case.
Running case ಏನು?
It will be stayed
No,
by your lordships.
if it is stayed, it becomes stagnant, but still runs. Yes, unless it is quashed. Tag this petition along with the page 97 lede, madam. Order. List tomorrow in the fresh matters list. Please. Friday alva visa interview irodu.
Please.
Yes.
The offences, blood 420, 406, 403, 109, 384, and 34. I am the wife and the mother-in-law of the complainant. The FIR is registered in Mangalore saying that I have extorted money. But this happens after the complaint 498 is filed here in Bangalore. Bloods. The relation is the husband, I mean, the wife and the husband is the relationship.
One investigating officer ಯಾಕೆ ಪಾರ್ಟಿ ಮಾಡಿದ್ದೀರಾ?
The state, he was, that was the state.
Learned HCGP is directed to accept notice for the respondents. They have not challenged that crime.
They have, my lord, stay has been granted.
Which is that number?
It is WP number 28591, my lords.
Tag this petition along with 28591 of
23, my lords.
2023. In the light of the interim order subsisting in the said case, there shall be an interim order of stay of investigation in the case at hand. Charge sheet ಹಾಕಿದಾರಾ?
Charge sheet is ready, my lord.
Ready.
Ready.
Investigation till the next date of hearing. List both on next Friday. Yes.
Yes.
35.
For the petitioners in this matter, my lord. Lordships, in this matter, we are challenging the maintainability of the charge sheet, lordships, in this.
Maintainability of the charge sheet?
Yes, lordships.
Why, sir?
Before, previously, we had filed a criminal petition challenging the FIR, lordships, in this. So in the FIR, there was a stay on the investigation which was granted, lordships.
All right.
Page number 15. Page the lordships.
What was the date of the interim order?
19/1/2022, lordships.
19/1/2022. 22.
Yes, and the charge sheet has been filed on the 22nd of February 2022, lordships.
22nd February 2022.
Yes, lordships. Further on.
When did you intimate, or intimation was not sent to the IO?
Please, my lord.
Intimation was not sent to the IO that it is stayed?
I'll take instruction.
ಅಥವಾ ಏನಾರಾಗ್ಲಿ ಹಾಕೇ ಹಾಕ್ತೀನಿ ನಾನು.
Further, the petitioners have Petitioners have already informed the police station.
Where is the evidence of information?
They have not acknowledged that.
Phone
Lordship.
ಮಾಡಿ ಹೇಳಿದ್ರಾ?
They have given the copies at the police station stating that the matter has been stayed, Lordship.
ಯಾರು ಕೊಡಲ್ಲ, ಕೊಟ್ಟಿರ್ತಾರೆ stay ಆಗಿದ್ದನ್ನು. The counsel for the petitioner submits that on 19/1/2022, at the time when the crime was in subsistence, this court had granted an interim order of stay. Despite the interim order of stay granted, a charge sheet was filed before the concerned court on 22/2/2022. The learned HCGP to secure instructions from the hands of the investigating officer as to how, despite the charge sheet being as a stay being granted and that being informed to the investigating officer, he could file the charge sheet against the petitioner. List the matter on next Tuesday.
Meanwhile, the interim order may be.
1 minute, sir. Next Tuesday. Interim orders, ಕೊಟ್ಟಿರಲ್ಲ ಈಗ? There shall be an interim order of stay of further proceeding before the concerned court solely on the score that in violation of the interim order charge sheet has been filed. In the event the learned HCGP would steer clear the problem, the matter would be considered on its merit.
Yes, grateful.
Next.
46.
Lord Pokso. Father of the complainant, my lord, father of the victim boy, my lord, is the complainant.
ಏನಾಗಿದೆ?
My lord, there is only, my lords, may kindly have page number 144, my lord. This is.
You are accused number 1.
I am accused number 1, my lord.
ಅದೇ boy.
Accused number 2 is the mother of the victim. My lords, may kindly have page number 144, my lord. The affidavit filed by the father of the victim.
144,
my lord. In the GNWC proceedings, my lord, which is
Yes.
much prior to filing of the
Really?
complaint, my lord.
164 statement secure ಮಾಡ್ಲಿಕ್ಕೆ
ಮುಗಿಸ್ಬಿಡ್ಲಿ ತಾಳಿ. ಬಂದಿಲ್ವಾ 164?
ಇಲ್ಲ, ಬಂದಿಲ್ಲ.
Why?
I'll secure it.
Yes, sir. Second time it is being adjourned on that score. Yes, madam, you tell me.
Page number 145, my lord, paragraph
40?
number 8, 145, my lord. Paragraph number 8. This is the affidavit, my lord, filed by the father of the victim, my lord, in the GNWC proceedings. My lord, some 6 lines, my lord, in the paragraph number 18, after 6 lines, my lord. The mediation agreement and decree in MC number and the start of the mediation agreement and decree in MC number 4121 of 2020 specified.
Complainant is the mother, is it?
No, my lord, father of the victim boy, my lord, is the complaint. My lord, there are three.
Who is the
complaints.
petitioner?
Petitioner means, my lord, is alleged to be the friend of mother, my lord.
Friend of?
Mother of the victim boy, my lord. Accused number 2 is the mother, my lord.
What is the allegation?
My lord, allegation, my lord, is at complaint, my lord. That I tried to, my lord, touch his private parts. That's the only allegation.
Yeah, you have touched the private parts of
The boy, my lord.
of the boy. How old is he?
11 years, my lord, at the time of
11
My
years.
lord, on the same day, my lord, 4/7/2022, there are 3 complaints against 3 different individuals, my lord, with the same allegations. My lord, this is only to lay, my lord, foundation for the GNWC proceedings, which were already pending, my lord. It is clearly borne out, my lord.
Get
from
the
his
one
affidavit.
first.
Please, madam. I'll get it.
And the complaint is delayed, my lord.
Day
for
after
2 months.
tomorrow in the fresh matters list.
So great.
Yes.
Seven.
Investigation papers.
My lord, I also understand, my lord, over the past week, my lord, the B report I understand has been filed, but I do not, my lord, have any.
B report ಹಾಕಿದ್ರೆ ಹೇಳಿ.
B report ಹಾಕಿಲ್ಲ, case and counter case, another case they have obtained.
ಇಲ್ಲ ಯಾವ್ದ್ರಲ್ಲಿ B report ಹಾಕಿದ್ದೀರಾ ನೋಡಿ. ನಾಳೆ ತಗೊಂತೀನಿ. ನಾಳೆ ಆಗುತ್ತಾ? ಇಲ್ಲ ನಾಡಿ ತಗೊಳ್ಳ.
ನಾಡಿದ್ದು.
Friday in the fresh matters list. Will not record anything. Yes.
38.
Filed along with the WP.
Now, tag this petition along with serial number 30.
Interim order to be extended.
Interim order subsisting shall continue till the next date of hearing. ಅದು ಯಾವತ್ತು ಹಾಕಿದೀನಿ ಅವತ್ತಿಗೆ ಹಾಕಿ.
For the petitioner, my lord. Lord, the allegations are under, for the commission of the offences under 498A, 506, 149, 323 and 114 of IPC. The complainant is the daughter-in-law of the petitioner number 1 and 2, my lord. Petitioner number 3 is the
daughter of petitioner number 1 and
The
2.
petitioners 1, 2 and 3. Hello, 1, 2.
8, my lord.
You, Yallaridara.
1 to 8, my lord.
1 to 8 are accused 1 to 8 in a crime registered by the daughter-in-law. The crime so registered is for offences punishable under 498 ಏನ? 498A, 506, 149 and 323 of the IPC. The petitioners 1 and 2 are said to have been harassed by the couple, i.e. the complainant daughter-in-law and her husband, the son of petitioners 1 and 2. These petitioners on the harassment have also initiated proceedings before the Assistant Commissioner under the Maintenance and Welfare of Parents so and so Senior Citizens Act. And a crime register ಮಾಡಿದಿರಲ್ಲ?
ಹೌದು ಸ್ವಾಮಿ.
And a crime in crime number?
301 of 2023.
301 of 2023,
my lord.
2023 against the harassment by the complainant and her husband, the son of petitioners 1 and 2. It is then the impugned crime comes to be registered for offence punishable under 498A, ostensibly to get over the allegations made by these petitioners against the son and the daughter-in-law, the complainant herein. Therefore, there shall be an interim order of stay against interim order of stay in favor of these petitioners in crime number so and so till the next date of hearing. 1 HCGP, 2 emergent notice returnable by 26th July.
Obliged.
Yes. Different affidavit?
My lord, due to sudden demise of petitioner's brother-in-law, I could not complete my instructions as he was not available for conference yesterday. I am seeking short accommodation till day after tomorrow.
ಬಾಳೆಗ್ರೆ ಒಂದೆರಡು ದಿನ ಟೈಮ್ ಕೊಡುವ. ಯಾವ Tuesday I'll take.
My lord, may kindly have it day after tomorrow. I'll complete my instructions I have spoken.
She has to get back. Where are you from?
Delhi.
Delhi. Yes.
Day after tomorrow.
Day after. List day after tomorrow in the fresh matters list. Yes.
Okay.
Direction.
ಇದರಲ್ಲಿ
Instructions. ಏನಾಯ್ತು? Complaint register ಮಾಡ್ತೀರಾ ಇಲ್ವಾ?
ರಿಜಿಸ್ಟರ್ಡ್ ಬಿಫೋರ್ ದಿ ಅನಂತಪುರ PS. ಅನಂತಪುರ ಪೊಲೀಸ್ ಸ್ಟೇಷನ್ ಅಲ್ಲಿ ಕೇಸ್ ರಿಜಿಸ್ಟರ್
ಆಗಿದೆಯಾ?
ಆಗಿದೆ. ಅಲ್ಲಿ ಆಗಿ ಅಲ್ಲಿ he has taken an saying that we will return the amount ಅಂತೇಳಿ ಬರ್ಕೊಟ್ಟಿದ್ದಾರೆ.
ಮತ್ತೇನ್ ಬೇಕು ನಿಮ್ಗೆ?
ನಮ್ಗೆ ಏನ್ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್ ಇಲ್ಲ ಸ್ವಾಮಿ. ಸರ್
ನಮ್ಗೆ reports
CCB ಬರಕ್ಕೆ CCB
ಅಲ್ಲ ಆಯ್ತು ಈಗ Anantpur police station ಮಾಡಿ there is undertaking by the accused that he will return the money. What else you want?
Crime number 121/2023.
Verify.
Yes. Learned HCGP on instructions would submit that a crime has already been registered before the Anantpur police station in crime number
121 of 2023.
121 of 2023.
I'll verify.
2023. Therefore, the petition would become infructuous. The learned counsel seeks a day's accommodation to verify.
2 days, ma'am. Monday. Monday.
List on Monday in the fresh matters list. Learned counsel of the petitioner seeks time to verify and make his submissions.
Sorry for petition. No, there is no allegation against the petitioner, my lords, in the entire complaint. Petitioner is a purchaser of the property, my lords.
Yes, government.
The order is passed.
Investigation papers I
Yes,
asked.
2 days time is required.
List on
It has
Friday
to
in the fresh
come
matters
from
list.
Tarikere.
Yes, please. 2017 CC, sir.
No, it's 2017, but the complaint is, if you have a look at the complaint, ingredients of 420 is not established.
It can't be that as and when a complainant or accused comes to you, you come to this court. 8 ವರ್ಷ ಆದ್ಮೇಲೆ I will not interfere. What is the stage?
NBW issued.
Please appear.
If, let notice be taken out, my lord.
No, you appear before the court and come. When is the next date?
23/8, my lord.
You appear before the court, we'll take it later. 7 years admel I am not, because the cup of woe has come to the brim, you are before this court. No.
My lords, if your lordships could have a look at the perusal of the.
No, sir,
it's-
I will not
it's
even
based
see.
on
I
a
will not-
rental agreement.
I
or-
will not see, sir.
There is no allegations of.
You should have
420
come in
made out.
2018 itself. It's a CC of crime of 2016.
Please, ma'am.
CC of 2017.
Please, ma'am.
And we are in 2024.
My lords, they became aware of it very recently.
Oh,
my lords.
seriously? Yes, when non-bailable warrant was issued.
My lords,
No, sir. Attend the court. Let it be. List after 4 weeks.
grateful.
Yes. Pendency of this petition will not come in the way of further proceedings before the concerned court. It's a case to be quashed, but I am not because of the attitude of the petitioner. Yes, next.
Please, ma'am.
Order. 44.
Here, I have filed wakalat for R2 today, my.
The petitioner, my lords.
ನೆನ್ನೆ ಇದು
Yes, madam.
ಅದೇ 376.
No, my
ಅಲ್ಲ ಇದು ಎತ್ತಿನ ಹೊಡೆ ತಾವು.
Oh, long
ಮಾಡಿ
back.
ತಾವೇ. Kindly be posted on 4th or 11th, man.
Learned counsel B.V. Pinto submits that he has entered appearance for
For R2.
for the second
Today.
respondent registry
Today
to
itself.
delete the name of Vittal Shetty and H.C. Shivram as appearing for the second respondent. List the matter on 19th. Yes.
Lordship, interim order.
Interim order subsisting shall continue till the next date of hearing.
19th is Thursday, man.
19th is Fridays.
45.
My lord, I beg to appear for petition on this matter, my lord. IA 1 of 23 was for early hearing. That matter is listed, it's in.
You have not engaged a senior counsel in this?
My lord, that was only client instruction, my lord. My lord,
And,
the petitioner herein is,
The most brilliant draft I have seen in the other case, not this.
my lord.
Yes. What is the problem in this?
The petitioner herein as arraigned as accused number 2, my lord, challenging the CC proceedings for offence punishable under 418, 420.
Office objection, same madam.
No, my lord, the only objection was that I hadn't served the respondent number 2 counsel on my IA.
Who is R2?
R2 is the complainant who's not entered appearances yet. And the IA
Why
was
should
for,
you serve him?
it was an IA for early hearing, my lord.
Yeah, madam. Government official, KEA.
Yes, my lord. It's the
Serve ಮಾಡ್ಬಿಡಿ
it's
ಎನ್ಕೆ
the
ರಮೇಶ್ಗೆ.
SCGP itself, but that IA was for early hearing. It's infructuous, my lord.
ಹಾಕಿದಾರ ಆಲ್ರೆಡಿ ಹಾಕಿದಾರಲ್ಲ. List the matter in the first time ಬರ್ತಾ ಇರೋದಾ?
For IA for hearing on stay, my lord, yes. Previously, it has been heard.
I'll post it tomorrow then.
Please, my lord.
Yes. Tomorrow in the fresh matters list. Then don't get a senior counsel for this also.
No,
Yes.
no, my lord.
Yes.
Great.
46.
If I affirm with the petitioner, lordship, we paid the PF today.
Counsel for the petitioner submits needful has been done, office to verify.
Lordship,
In the
date
event
may be-
needful has been done, list the matter on interim order ಇದೆಯಾ?
No, lordship.
List the matter on ಇದೇನ್ 13 7
7.
7 list on 11th.
Grateful.
Yes.
47.
Report the death of ಯಾರ death?
Complainant, second respondent here.
You have to take care. Yes. The learned counsel for the petitioner has filed a memo reporting the death of the complainant.
Now-
Therefore, the state charge sheet ಆಗಿದೆಯಾ?
Report our file ಮಾಡಿದ್ ನಾವು. It's
ಆಯ್ತು
not
sir.
from-
The learned HCGP has filed a memo reporting the death of the complainant. In the light of the charge sheet being filed by the police, the state will have to defend the action. This matter on 23rd, the 24th for admission. Interim order ಇದೆಯಾ?
Interim ಮಾಡಿದ್.
Interim order subsisting shall continue till the next date of hearing.
Problem.
Next.
48.
Petitioner.
Post immediately after service of notice upon the second respondent. Interim order ಇದೆಯಾ?
Please.
Continue. Yes.
49.
Same order.
Needful
Furnishing
is
PF.
done. Needful is done this
Learned
morning.
counsel submits needful has been done. Office to verify.
Interim order.
So and so. Yes. Yes, 51
51.
for settlement, 230. Yes.
52.
Post immediately. Second respondent here, complaint.
Complaint.
Same order. List on 11th. 7 13
7.
List on 11th. Same order. 15th, 11th ಅಲ್ಲ. Post immediately after service of notice upon the second respondent. Interim order continue ಮಾಡಿ.
54.
List the matter in the fresh matters list on Monday. ಓ ಇದು ನೋಟಿಸ್ ಆಗಿದೆ. ಎಸ್ ಲೆಸ್ ದ ಮ್ಯಾಟರ್ ಆನ್ ಥರ್ಸ್ಡೇ ಹಾಕಿ. 54 ಇದೆಯಾ? ಲೆಸ್ ದ ಮ್ಯಾಟರ್ ಆನ್ ಥರ್ಸ್ಡೇ ಬೇಡ. 2 weeks time is granted. Do the needful entry order granted earlier stands extended till the next date of hearing. Yes, next.
55. Lord, I undertake to appear for R2 in 55. Well, I have already filed wakalat in 55.1 and 55.3 and 55.4. The other matters, that's 55.5, 55.
What are these?
56 and 57.
420, 467 and 468, my lord.
You are the borrower.
I'm not the borrower, my lord. I'm the borrower as well as
Bank manager.
a guarantor as well as the bank manager.
11, yes.
I'm already on wakalat in 55.
Planet Council, Divya Purandar submits that she undertakes to enter appearance. You already filed wakalat?
For 55.1, 2, 1, 3 and 4.
Undertakes to enter appearance for the second respondent in serial number 55. In the light of the fact that she has already entered appearance in all the other cases.
Yes, and 56 and 57, my lord.
Oh, adu ashtena?
Yes.
Yes, ma'am.
56 and 57, same order.
Interim order may be extended, my lord.
55.5, madam. LL Divya Purandar Kanala nimge allige hakbidi. Yes.
Lord,
for
one
second
submission.
respondent.
In fact, my lord, R2 is in the name of, actually, he's representing the bank. It was, the complaint was filed by the then manager. He's already retired. I'll file the wakalat of the present bank
ಯಾರ್ಗೆ
manager.
ಹಾಕ್ಬೇಕು ಮಾಡಿ?
Yes.
Yes, ತೊಂದ್ರೆ ಇಲ್ಲ. Tag all these 55.55 ಗೆ 56, 57 also be tagged.
Yes.
Interim order ಇದೆಯಾ ಅದರಲ್ಲಿ?
Ide.
Interim order wherever is subsisting shall continue till the next date of hearing.
Please.
Yes, next. 58.
My lord, I am for respondent number 2, my lord. I engaged service of senior counsel, my lord, Ravi Shankar, my lord.
Yes, Lord.
Today, what
Kindly
happened-
pass over the matter.
But please-
Non-compliance of statement of
I
objection.
complained, my lord. Yesterday I complained, my lord. My lord, what,
pass
my
over. Okay,
lord, one
pass over.
submission.
Your lords may kindly pass over the matter.
But
There's
one
urgency
submission.
in-
Sir, I am also going for lunch, sir.
Yes.
My lord, one submission. Senior counsel, my lord, engaged senior counsel, my lord. Senior counsel office ಬೇರೆ father.
ಊಟ ಮಾಡ್ಕೊಂಡ್ ಬರ್ತೀನಿ ಸರ್.
ಅಲ್ಲ, ಅದು ಡೇಟ್ ಕೇಳ್ಬೇಕು. Charge sheet has already filed.
ಅದ್ ನೋಡೋಣ ಆಮೇಲೆ 2:30. Yes.
Yes.
You're not hungry?
Please.
Please eat.
Lordships, leave, my lord. ಈಗ ಬೇಕಾ? ಇದು 9 ಅಲ್ಲ? ಇದು 8 ಆ? ಇದೆಯಾ? ಹಾಕಿದಾರಾ? ಮೇಡಮ್
My lords, serial number 66, my lords. My lords, serial number 66, I'm a, please, my lords.
I approve the response.
Page wise career, madam.
58, my lord.
1 minute.
58, my lord. I am for the de facto complaint, my lord. In this case, charge sheet has been filed, my lord. Charge sheet
Charge sheet?
has been filed, my lord.
Ah.
Point, second point, my lord, I engage the senior counsel, my lord, Ravi Shankar, my lord. In his office, my lord, office bearer.
Is challenge matter then crime, huh?
Crime challenge.
Who appears for the
I'm for the
petitioner?
petition, your lord.
Challenge the charge sheet.
It's not yet filed. No.
Yeah,
it's-
File
File
agate.
agide.
File agate. Already filed, my lord.
Challenge the charge sheet.
Seek instructions, your lord.
Challenge the charge sheet. I'll take it whenever you want. Yes. Liberty to challenge the charge sheet. Yes. He'll stay idea.
ಇಲ್ಲ my lords, ಅದ್ರಲ್ಲಿ ಏನಾಗಿತ್ತು ಫಸ್ಟ್ ಟೈಮ್ when the matter came, they appeared and they sought time. So to consider the interim order, it was adjourned.
Anyway, you
ಇವತ್ತು
challenge the charge sheet. If it is grantable, I'll grant.
2 suits are pending between us.
Then there is all the more a reason. We'll see. Yes.
Please, my lords.
Next page.
My lord, serial number 66, my lords, for petitioner. Date may be fixed, my lord.
For the respondent.
Date may be fixed. ಇವತ್ತೇನಾಗಿದೆ?
Illa, my lords, there is bereavement in petitioner counsel's
ಅದನ್ನ
family.
ಹೇಳಿ first. Date may be fixed.
Please,
Reason.
my apologies, my lords.
Yes.
Take me, it's an interesting case. Pune's police station proceedings is challenged in Karnataka here, my lord.
Like entry order ಇದೆಯಾ ಇಲ್ಲಿ?
Either, my lord.
ಇದೆ.
Either.
Date may be.
List the matter on, we'll have it on 18th.
Please.
18th, interim order subsisting shall continue till the next date of hearing.
Serial number 67, my lord.
67.
Petitioner in this case. Week's time may be granted.
Respondent ಯಾರು? Inform him.
Please.
Yes.
Serial
No.
interim order.
Wait. ಕರ್ಕೊಂಬನ್ನಿ.
Our appearance ಆಗ್ತಿಲ್ಲ.
ಆಗ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಡಿಸ್ಪೋಸ್ ಮಾಡೋಣ ಇರಿ. Yes. ನೀವು ಬೇರೆ ಮೂವಿಗೆ ಹೋಗ್ಬೇಕಾ? Wait.
Serial number 80, my lords. For the. Serial number 68, my lord. There for a week's time, my lord.
You are for?
Respondent number 2.
Petitioner ಯಾರು? Get him. These are all petitions which have to be disposed.
Your lordship, serial number 75. Another criminal petition number
ಅಲ್ಲಿಗೆ ಬಂದೇ ಇಲ್ಲ. Wait sir. ಏನು?
75.
75. ಕರೆದ್ರ ಮೇಡಮ್? ಏನದು?
Another criminal petition is pending. A second FIR has been lodged. That has to be tagged with these two cases.
I am for the petitioner, my lordship. In this case, no way connected. ಆ petitioner ಗೊತ್ತಕ್ಕೆ ಸಂಬಂಧ ಇಲ್ಲ. ಬೇರೆ petitioner.
Then wait. Matter will be called.
Please.
Yes.
Serial number 80, my lords. I am for the petitioner in this matter. There is no interim order. I pray for a week's time, my lords. I'd inform the respondent.
List after 2 weeks.
Grateful.
Yes. At the request of the counsel for the petitioner. ಅಷ್ಟೇ ಸರ್.
One mention.
111.
Submit.
111. Time ಬೇಕಾ?
I have intimated the other side.
I appeal for the petition.
2 weeks time may be granted for filing objections.
Interim order ಇದೆಯಾ?
I have intimated.
Interim order. At the request of the learned counsel appearing for the 4th respondent, list the matter after 3 weeks.
My lord, there are 2 other
Lordship,
matters.
kindly, my lord.
Along with this. There are 2 other matters.
The interim order subsisting shall continue till the next date of hearing. Tag this petition along with.
Writ petition bearing number 21486 of 23
ಆಮೇಲೆ
and 20341 of 23.
List them all on 20.
My lords,
22 na ಇದು? 23, 30th, 31st July.
31st
July.
July. Achha.
I request for a short.
Lordship, kindly, my lord.
Interim order ಇದೆಯಲ್ಲ?
Serial number 60, my lord.
Lords, may I make one submission?
Serial number 114.
Serial number?
114, my lord.
114.
Final hearing, my lord. There are certain documents that I would want to produce.
What in person?
Yes. I appeal
Where
for
is
the
he?
respondent number 1.
You find him and get him, I will grant.
Lord, serial number 60, my lord.
60.
For the petition. Yes, my lord. For the petitioner, my lord, we'll have to take steps, my lord. Kindly 1 week time.
60 ಆಗಿಲ್ವಾ ಮೇಡಮ್? Wait sir. Yes.
One submission. One matter for tomorrow.
ಯಾಕೆ ಇದು 2:30 ನೀವು ಮೂವ್ ಮಾಡಕ್ ಸ್ಟಾರ್ಟ್ ಮಾಡಿದೀರಾ?
Urgency is this, my lords.
ಏನು?
Third complaint, my lords, by a different agency.
So
So initially inquiry was, my lords.
day after tomorrow.
Please, day after. Grateful.
Why are you waiting?
In item 40, my lord, I failed to mention before the stay extension. my
That
lord.
will be extended, madam. Even if you don't mention, it will be extended. Yes.
Sorry for the.
My lord,
We
it was-
post immediately after service of notice upon the second respondent.
My lord,
Interim order, idea?
no interim order, my lord.
Sorry, yes, next.
It was directed, the government advocate to.
We'll see, yes, sir. Next. Same order. Same order. Same order. Interim order idre continue ಮಾಡ್ಬೇಕು madam.
My lord, 51 is for quashing, my lord.
Everything is for quashing, sir. Complainant should come.
This one.
Yes.
Lord, section 63, can I seek for a password? Which is senior is held up in.
What happened?
Senior is
My
held up
lord.
in chambers matter.
My lord, in serial number 63, I appear for the respondent BBMP, my lord. Mr. Vikram Hungal, senior advocate, appears to respond BBMP.
He's not well.
Yes, my lord, he has suffered he suffered a fracture, my lord.
I'll take it on 12th. It will be
Grateful,
all
my
right
lord.
on 12th?
Grateful, my lord. 12th is fine, my lord.
List on 12th.
Grateful, my lord.
In terms of memo. Memo, learned counsel of the petitioner seeks leave of the court to withdraw the petition. Submission, as the matter is moved for withdrawal of the petition. Disposed as withdrawn in terms of the, disposed of withdrawn on the submission. Yes, next.
Petitioner in this case, my lord.
Office objection.
Office objection is, my lord, in CC number 1885 or 2000.
Office objections overruled. List the matter on Monday in the fresh matters list. Next.
Lordship 61.
60?
1.
Yeah, 61.
Last time.
Post immediately after service of notice ಆಗಿದೆ ಮತ್ತೆ ಏನ್ ನೋಡ್ತಾ ಇದ್ದಾರೆ ನೀವು? Yes, next. Next. ಇಲ್ಲ ಇದ್ರಲ್ಲಿ ಈಗ. ಪಾಸ್ವರ್ಡ್ ಮಾಡಿ.
Here for respondent number 2, my lord.
Petitioner ಇಲ್ಲ. Mother in law and father in law.
Yes.
ಏನಿದೆ ಅವ್ರ ಮೇಲೆ?
Because idರಲ್ಲಿ your lordship could kindly take up annexure C. Wherein they have visited the complainant's house.
Where?
Complainant's parents' house.
ಎಲ್ಲಿ?
At
ವಿಸಿಟ್ ಮಾಡಿ ಏನ್ ಮಾಡಿದ್ರು?
they provoked the accused, number 1. And they pulled her hairs and she has been assaulted there.
By whom? By husband?
By the relatives and the accused and his relatives.
Where page?
But in
Which
page number
page, sir?
36, my lord, annexure C.
36, sir.
Annexure C.
Charge sheet ಹಾಕಿಲ್ವಾ?
ಇಲ್ಲ, charge sheet not filed.
Yes, sir. Where are you?
Another court.
Another court.
498.
ಅದು ಗೊತ್ತು. My interim order. ಎಲ್ಲಿದ್ರೆ ಓದಿ ಅದು?
At your honor, lordship my line 16 at page number 36C, my lord. The statement. ನಾನು
Statement ಅಲ್ಲ, complaint ಇದು.
number 544.
545 so and so.
45.
ಅತ್ತೆಯಾದ ಗಂಡನ
Some Krishna Nagar.
ಹೇಳಿ ಗಂಡ ನನ್ನ ಕೂದಲನ್ನು. Where is mother in law and father?
ಗಂಡ ಬಟ್ಟೆ ಹಿಡಿದು ಎಳೆದು ನನ್ನ ಮನೆಯಿಂದ ಹೊರಗೆ ಹಾಕಿ ಕರೆತಂದು
ಅಲ್ಲಿಯೇ ಇದ್ದ so and so. ಎಲ್ಲಿ ಗಂಡ ನನ್ನ ಕೂದಲನ್ನು ಹಿಡಿದು ಎಳೆದು ಮನೆಯಿಂದ ಆಚೆ ಹಾಕಿ. Where is mother in law and father in law?
ಇಲ್ಲಿ ನನ್ನ ಅತ್ತೆ ಶಕುಂತಲಮ್ಮ 1 2 3 4 5th ಲೈನ್ ಮೇಲೆ ನನ್ನ ಅಮ್ಮ ಶಕುಂತಲಮ್ಮ ಬಂದು ಇವಳನ್ನು ಜೀವ ಸಹಿತ ಉಳಿಸಬಾರದು ಅಂತ ಹೇಳಿ
ಆಯ್ತು,
ನೀ ಸತ್ತರೆ ಹೆಚ್ಚು
ಅಷ್ಟೇ
ವರದಕ್ಷಿಣೆ ಕೊಡು.
ಸೊ ಕೂದಲು ಎಳೆದಿದ್ದು ಮದರ್ ಇನ್ ಲಾ ಅಲ್ಲ.
ಅಲ್ಲ, ಮೊದಲನೇ
ಅಲ್ಲ ತಾನೆ?
they have provoked the accused.
Provoked. The provocation I will consider.
Provocation.
ಆಮೇಲೆ
so far as the offense has taken place in the house of the complainant.
All right.
So hence they have made the necessary parties to the complaint. So charge sheet has not been filed.
No problem.
Taking advantage of the stay order, they are not cooperating with the IO to file the charge.
Who is not cooperating?
These petitioners.
Correctly so. ಸ್ಟೇ ಇದ್ಮೇಲೆ ಕೋಆಪರೇಟ್ ಮಾಡ್ಬೇಕು ಅಂತ.
Since no charge sheet has been filed,
Yes,
offense
sir.
has been made out against them, so they are necessary parties to it. So at this stage,
ಆಲ್ ರೈಟ್. ಅದೇ ಕಂಪ್ಲೇಂಟ್ ಅಲ್ಲಿ ಓದಿದ್ ನೀವೀಗ ಕಂಪ್ಲೇಂಟ್ ತಾನೆ?
complaint.
ಎಸ್ ಕಮೆಂಟ್. ಪ್ರಚೋದನೆ. ಎಸ್ ಸರ್.
My lord, kindly peruse the page number 21, my lord.
ಏನ್ 21?
Earlier, there is already husband and the wife residing separately, my lord. He is a constable, my lord, working in a police.
Who is
department.
husband is constable?
Yes, my lord. Working in and police quarters ನಲ್ಲಿ ವಾಸ ಮಾಡ್ತಾ ಇರ್ತಾರೆ. ಮನೆ ಬಿಟ್ಟು ಇವರು ಅವರು ಯಾವತ್ತೂ ಕೂಡ ಜೊತೆ ಜೀವನನೇ ಮಾಡಿಲ್ಲ. ಗಂಡ ಹೆಂಡತಿ
What is
ಜಗಳ
this 9/11/2020 ಏನು?
ಅಲ್ಲಿ ಗಂಡ ಹೆಂಡತಿ ಜಗಳ ಮಾಡ್ಬಿಡ್ತಾರೆ, ಮನೆ ಬಿಟ್ಟು ಹೋಗ್ಬಿಡ್ತಾರೆ. ಅವಾಗ ಮದರ್ ಇನ್ ಲಾ ಆಫ್ ದಿ ಅಕ್ಯೂಸ್ ನಂಬರ್ 1 ಮಿಸ್ಸಿಂಗ್ ಕಂಪ್ಲೇಂಟ್, ಅದರಲ್ಲಿ ಕೂಡ ಚಾರ್ಜ್ ಶೀಟ್ ಆಗ್ಬಿಟ್ಟು ಅಲ್ಲಿ ಮತ್ತೆ ಜೊತೆಗೆ ಜೀವನ ಮಾಡ್ತೀವಿ ಅಂದ್ಕೊಂಡು
ವೈಫ್ ವಾಸ್ ಮಿಸ್ಸಿಂಗ್ ಅಂತನಾ?
ಎಸ್ ಮೈ ಲಾರ್ಡ್.
The case is
ಅದು ಆಲ್ರೆಡಿ ಅದು ಚಾರ್ಜ್ ಶೀಟ್ ಆಗಿ ಕ್ಲೋಸ್ ಆಗಿದೆ. ಅವ್ರು ಸಪರೇಟ್ ಆಗಿ ವಾಸ ಮಾಡ್ತಾ ಇದ್ದಾರೆ.
the husband
Correct. That is correct because ನೀವು ಅವ್ರ ಮನೆಗೆ ಹೋಗಿ ಗಲಾಟೆ ಮಾಡಿದೀರಾ ಅಂತ.
ಇಲ್ಲ, ಅದು ಏನಾಗಿದೆ
ಅಲಿಗೇಷನ್ಸ್.
but in view of the assault, she has taken medical.
ಈ 4 and 5 ಯಾರು?
4 and 5 are the relative.
4 and 5 relatives.
Relatives of the accused.
ಪಾಪ ವಯಸ್ಸಾದವ್ರನ್ನ ಯಾಕೆ ಕರ್ಕೊಂಡ್ ಬಂದ್ರಿ?
They were also present at the time of incident.
Present.
Yes. They together went to the complaint's house together.
Anything else?
Nothing.
ಏನಿಲ್ಲ ಅಲ್ಲ?
But they are required for the case. So my
They are
humble
required.
submission.
For the family also they are required. Yes. ನೀವು ಹೆಡ್ ಕಾನ್ಸ್ಟೇಬಲ್ ಜೊತೆ ಆರಾಮಾಗಿರಿ.
Because he is taking advantage of the department.
ಯಾರು ಹೆಡ್ ಕಾನ್ಸ್ಟೇಬಲ್?
Yours.
Proceed against him.
Accused one is head constable.
He is not here.
No, he is not here.
Yes.
But he is the husband of the complaint.
Correct.
Accused number 1. He is using all his influence to cover up all the lapses and latches.
Lapses and latches ಯಾವ್ದು?
Whatever the action were taken by the police station are prevented by this accused number 1, my lord.
Petitioners Mill, Bill and relatives of the accused number 1 husband are before this court calling in question the registration of a crime in crime number 81 of 2022 for the following offenses. Prayerly, madam. Heard so and so. Facts in brief germane are as follows. The complainant, the second respondent is the complainant. The petitioners are accused 2 to 5. The relationship between the complainant and the accused, the accused 2 to 5 are that they are the mill bill filler. The accused number 1 husband who is not before the court gets married to the complainant on 10/11/2010. It is an admitted fact that the accused number 1 husband who is employed as a constable in the home department, in the police department, is did reside separately with the wife. The relationship between the husband and the wife appear to have floundered. The floundering of the relationship once led the wife to leave the house of the complainant and go missing. It transpires a missing complaint was registered on 9/11/2020, which resulted in filing of a charge sheet, and later the matter is said to have been closed. The impugned complaint comes to be registered on 14/5/2022 by the second respondent complainant, alleging certain torture meted out by the husband and the other members of the family. The registration of the crime is what has driven the petitioners to this court in the subject petition. The learned counsel appearing for the petitioner, taking this court through the documents appended to the petition, demonstrates that the petitioners, who are father-in-law, mother-in-law, and relatives of the accused number 1, father-in-law, mother-in-law,
brother-in-law,
brother-in-law, yaar brother-in-law?
Second my lord.
First accused brother-in-law.
First accused, brother-in-law of first accused brother-in-law.
First of the
Family members of the accused number one husband are all dragged into the web of crime without any rhyme or reason, as these were the persons who go to the house of the complainant to settle the dispute between the husband and the wife, to bring about a truce which did not come about, but resulted in the registration of the impugned crime. He would seek quashment of the entire proceedings against, quashment of the registration of the crime against these petitioners. The learned counsel appearing for the complainant would accept that these petitioners live separately. On the date of the incident, all of them had come to the house of the complainant. In front of these petitioners, it is the husband who is said to have assaulted the complainant. The allegation against these petitioners is that they have provoked the husband for such assault. Therefore, it is a submission that these petitioners are appropriately arraigned as accused, and further proceedings must be permitted to be continued against these petitioners. I have given my source. Therefore, narrated facts are not in dispute. The issue at this juncture lies in a narrow compass. The complaint registered on 14/5/2022 has led to registration of the crime in crime number 81 of 2022. Therefore, I deem it appropriate to notice the complaint. It reads as follows, page 36, 37. A perusal at the complaint would clearly indicate that since 10/11/2010, i.e. the date of marriage between the complainant and the accused number one, the couple lived separately, as he was a constable who was posted to several places. The petitioners herein, particularly petitioners 2 and 3, did never reside with the couple, and they did reside separately, is the narration in the complaint itself. Why the complaint comes to be registered is on 10/11/2022, all these petitioners try to bring about a truce between the warring husband and wife, and for that purpose visit the house of the complainant, who by then was residing in the parent's house. It is here the incident is said to have happened. Nowhere in the complaint it is said that the petitioners have indulged in certain torture by depiction of particular overt acts by them. Vague and omnibus statements are made in the complaint against these petitioners, while the entire allegations are against the husband, accused number one, who is said to have pulled the hair of the complainant and assaulted her in the presence of these petitioners. Therefore, these petitioners are dragged into the web of crime. No foundation of whatsoever nature is laid in the complaint against these petitioners, ostensibly so, as these petitioners never did reside with the couple for 10 long years. It is the relationship between the husband and the wife that has turned sour. Therefore, these petitioners cannot be permitted to be prosecuted any further, as it would run foul of the judgment of the apex court in the case of Kashkan Kaushar versus so-and-so, 2022 SSC Online SC, page 162, para 10 to 15. So-and-so. In the light of the undisputed facts as narrated herein above, finding no ingredient of any offense that is laid against the petitioners, though the matter is at the stage of crime, I deem it appropriate to obliterate the same, as the allegations are found only against the husband, for the aforesaid reasons, failing which it would result in abuse of the process of the law and it would become an abuse of the process of the law and result in miscarriage of justice. For the aforesaid reasons, so and so, washed away these petitions. Much obliged. No represent. Basur.
petitioner in this matter, my lords. Offense under 341, my lords.
My interim orders.
Please.
I filed objection also. madam.
ಏನಿದೆ ಸರ್ 341? Your movement was curtailed that you could not move for 7 months. ತಿಂಗಳಾಗೋಯ್ತಾ?
ಇಲ್ಲ.
341 ಅವರು he has curtailed your way for 7 months.
No, madam. I have
Complaint is registered after 7 months, sir.
not after 7 months. madam.
ಮತ್ತೆ ಏನ್ ಸರ್?
Please.
ಸೊ 341 ಅಂದ್ರೆ ನಿಮ್ನ ತಡೆದು ಹಿಡಿದಿದ್ರು ಅಂತ. 7 ತಿಂಗಳು ತಡೆ ಹಿಡಿದಿರಾ?
No. I have filed complaint on the same day.
Same day? ಎಲ್ಲಿದೆ complaint?
The police have arrived at the place also.
Where is it?
They have issued endorsement, annexure R2.
Yeah,
They
okay.
have- Then I have complained to the Women Commission. madam.
BSNL office.
ಹೌದು. Harassment as against the superior officer by the
ಅದೇ ಇಂಟ್ರಿ ಮಾಡಿ ಕೊಡ್ಬೇಕಾದ್ರೆ ಹೇಳಿದೆ. You have driven him to the wall, ಏನ್ ಮಾಡಕ್ಕಾಗತ್ತೆ?
madam.
You have driven him to the wall. ಅದಕ್ಕೆ he has retaliated.
No, madam. Even if a memo is issued to him, he will not receive. That is the problem.
ಮೆಮೊ ಇಶ್ಯೂಂಗ್ ಪವರ್ ಇದೆ ಅಂತ ಇಶ್ಯೂ ಮಾಡ್ತಾನೆ ಇದ್ರೆ
ಅಲ್ಲ, ಇಶ್ಯೂ ಮಾಡ್ತಾನೆ ಇರುವುದಲ್ಲ. Kindly see R8 onwards, madam.
ಎಲ್ಲಿ ಕಂಪ್ಲೇಂಟ್ ಕೊಟ್ಟಿದ್ದು? ಇನಿಷಿಯಲ್ ಕಂಪ್ಲೇಂಟ್?
Lords, your lordships may kindly take page 15 of their objections.
Thirteen is the handwriting.
Handwritten is at 13, typed copies at 15.
ಆಯ್ತು, ಡೇಟ್ ಏನಿದೆ? ಮರ್ಡರ್ ಥ್ರೆಟ್?
Dated 3/2/2021.
ಇವ್ರು ಮರ್ಡರ್ ಥ್ರೆಟ್ ಕೊಟ್ರ ನಿಮ್ಗೆ?
ಹೌದು.
ಹೌದಾ?
ಹೌದು. ರೈಟಿಂಗ್ ಎಲ್ಲ ಕೊಟ್ಟಿದ್ದೀನಿ ಪೊಲೀಸರಿಗೆ.
ಇದೇನಾಯ್ತು ಕಂಪ್ಲೇಂಟ್?
R2, NCR has been issued by the police. That is why I have approached the Women's Commission. National Commission.
NCR ಯಾಕೆ? ಮೊಬೈಲ್ ಫೋನ್ ಹೊಡೆದಾಕಿದ್ರ?
ಹೌದು, ಫೋನ್ ಹೊಡೆದಾಕಿದ್ದಾರೆ.
Anger issues.
I have produced the CD also, what had happened. It was in my phone. He smashed it. Thereafter, some days onwards, that has been found. That is why they have registered the complaint. FIR has been filed. On the basis of this contents in my phone itself, that is recorded. I have produced the disc also.
Entry ಮಾಡಿರ್ತಾರೆ.
My lords may kindly compare the complaint that is given on 3/2/2021 and the complaint or the information, my lords, that has led to the FIR. My lords may kindly take.
It will be at variance. Improved version.
Exactly the improved version. There she says in the initial complaint, which is at page 15, my lords may kindly take.
Murder threat.
Murder threat on the last few lines, my lords, from the middle, if I may read. While I was continuing recording with my mobile phone without talking back to his shoutings, but kept calling others that he is coming close to me, he immediately grabbed my phone from my hand, broke it, stamped on it with his foot. He continued threatening me with murder one day or other. I will kill you. 3 people's staff, Vikramjit Singh, Akash Kumar Gupta and Shri N. Suresh were holding GV Raman Reddy to prevent him from coming close to me, despite which he was raising his foot to kick me. I immediately ran down the stairs from 2nd floor to BSNL ground floor, BSNL office ground floor to take shelter. My lords, I'll stop here. My lords may kindly come to page 19 of my petition. That is the information that leads to the complaint. My lords, verbatim, it is the same thing. While I was continuing recording with my mobile phone, without talking back to his shoutings, but kept
But that was registered on the same day?
with the
First, page 15?
page 15 on the same day.
Same day.
This is on 15/9/2021, after 7 months.
That's all right. It's verbatim similar.
But there is one small improvement. While I was continuing recording with my mobile phone without talking back to his shoutings, but he kept telling others that he is coming close to me. He immediately grabbed the phone from my hand, broke it, stamped it with his foot. He continued threatening me with murder one day or other. I will kill you. He wrongfully obstructed me and did not allow me to move anywhere. My lords, this sentence was lacking in this. That is the reason it became an NCR. Now, what they do is they sit before the Women's Commission. They say that my complaint has resulted in an NCR. Women's Commission would say there are no ingredients, rightly so it has become an NCR. So you include ingredients. They include the ingredients. They give another complaint only to this extent and it becomes an FIR.
341 may not be there, but others.
All are non-cognizable.
So what? Trial ನಡಿಬಾರ್ದು ಅಂತೀವಿ.
ಅಲ್ಲ.
ಮತ್ತೆ?
My lords, the FIR itself could not have been registered.
Why?
My lords,
I will permit continuance.
Your lordships definitely can, but what my submission is this. Once, my lords, an NCR is registered on a particular incident, an FIR on the same incident, my lords, cannot be registered. My lords, in order to, my lords...
So police first ಏನು ತಗೊಳ್ಳೋದೇ ಇಲ್ಲ, ಬೇಕಂತ NCR register ಮಾಡ್ತಾರೆ, ಇನ್ನೊಂದು crime ಮಾಡಕ್ಕೆ ಆಗಲ್ಲ.
If my lords, it was the same complaint, my lords, I would have accepted. But my lords, it is an improvement. In fact, my lords, on
341 I will set it aside, but not the others. You can't be left off the hook or just walk scot-free. You have done these things.
She was working in a government office.
ಅದು ಗೊತ್ತು. 353 ಯಾಕೆ ಮಾಡಿ?
Even I was working in a government office.
ಇವು ಅದೇನೆ.
Maybe he is colleague, but
ಇಲ್ಲ ತುಂಬಾ ಕೋಪ ಬರ್ಸಿದಾರೆ ಅವರು, ಬೇರೆ ಮಾತು.
My lords, may kindly take the memo list of citation, my lords, 7/9/2022 I have filed.
Yes.
Lords have, your lordships would certainly have read it, Krishnalal Chawla. Adರಲ್ಲಿ
ಏನು? Krishnalal Chawla is multiple crimes.
ಇಲ್ಲ, on this very aspect.
ಒಂದ್ಸರಿ NCR ಆದ್ಮೇಲೆ ಇನ್ನೊಂದ್ಸರಿ there should be strong reason.
Strong reason, my lords, also para 7, it specifically says, it is incumbent upon this court to preserve the delicate balance between the power to investigate offences under the Code of Criminal Procedure and the fundamental right of an individual to be free from frivolous and repetitive criminal prosecution forced upon him by the might of the state. If the respondent number 2 was aggrieved by the lack of speedy investigation in the earlier case filed by him, the appropriate remedy would have been to apply to the magistrate under section 155(2) of the Code of Criminal Procedure for directions to the police in this regard. Filing a private complaint without any prelude after a gap of 6 months from the date of giving information to the police smacks malified on the part of the respondent number 2. My lords, their remedy, my lords, if at all the NCR was not investigated, was under 155(2). My lords, they have completely bypassed 155(2). And now, my lords, 156(3) or rather directly an FIR is registered.
Then private complaint ಹಾಕಿದಾರೆ.
ಅಲ್ಲ, ಇಲ್ಲಿ FIR. ಅಲ್ಲಿ private complaint.
No, ಅದ್ರಲ್ಲ. ಇಲ್ಲೇನು?
ಇಲ್ಲಿ direct FIR.
Oh, it's not a private complaint.
No. It is complete bypass of 155(2).
But you can't walk scot-free on these technicalities.
Allah, Lord, this is bypass of procedure, my lord.
That we'll see.
They ought to have.
I'll write, take it to the Supreme Court. Let it be set it right.
He's not that.
It's all right. Yes.
No, he'll.
341, yes.
341, yes, my lords, but all other matters
is
also,
not there. That I will.
FIR could not have been registered at all. My lords, again, it would be covered, my lords, by Mohatta's case, where they say if the FIR itself is wrong, charge sheet, my lords.
Anand Kumar Mohatta. Yes.
It would be travesty of justice, my lords. Now, though I have not brought it before the court today, but lords, the FIR itself could not have been registered.
ನಿಮಗೆ ಬಿಟ್ರೆ then ಇದನ್ನೇ ಮಾಡ್ತೀರಾ ಆಮೇಲೆ?
ಇಲ್ಲ.
ಫೋನ್ ಹೊಡೆದಾಕೋದು. Threatening someone.
No, I can ask him to apologize, my lords, but nonetheless, my lords.
ಆಯ್ತು, ಅವ್ರ ಹತ್ರ ಹೋಗಿ ಕುತ್ಕೊಂಡು ಅಪಾಲಜಿ ಕೇಳಿ. Written
He's already left.
Where?
No, what had happened was she had
already left where?
The organization.
When?
Long back is what I've said. Yakendre, she had tiff with many people in the organization. So most of them requested and she is, I think, transferred or voluntary retirement. No, she was of ripe age already.
ಬೇರೆ ಯಾವುದು ಕಂಪ್ಲೇಂಟ್? Yes, retired now.
Retired.
ಕಂಪ್ಲೇಂಟ್ ಇಲ್ಲ, ಇದು ಒಂದೇ ಕಂಪ್ಲೇಂಟ್ ಇರೋದು.
ಹಾಗಾದ್ರೆ ನೀವು ಒಂದ್ ಕೆಲಸ ಮಾಡಿ, ಅವ್ರು ಎಲ್ಲಿದ್ದಾರೆ ಹುಡ್ಕೊಂಡು ಹೋಗಿ. No. If you want stay to be continued, to search her. You go in search of her, give apologies and come back.
My lords, procedure is not followed.
That we will see. You follow this procedure first. Go in search of her, give an apology and come back to the court. By the time 1 2 years ಆಗುತ್ತೆ. ಅಲ್ಲಿಗೆ ಸಾಕು. ಎಲ್ಲಿದ್ದಾರೆ? They'll be receiving pension. Address ಗೊತ್ತಿದೆ.
His promotions, my lords, are
Rightly so, sir. No problem. Yes. First go and seek apologies and come. There, nobody's phone is safe.
My lords,
You will start breaking everybody's phone.
date may be fixed.
You appear to have anger issues.
That to place it on record, my lords, might be prejudicial to my interests.
Place it on what?
Place the apology on record.
No problem. Give it in sealed cover. Yes. Apology ಕೇಳಿ.
I can ask him to come to the court, my lords.
Who?
The petitioner. I'll have to
I don't want to see him.
put it on record, my lords.
Anyway, I
it
don't carry my phone, but it's all right.
Put it on record, it might.
No, I'm not putting anything on record.
Allala, for me to put the apology on record,
ಏನಾಗಲ್ಲ. I will take care of it.
I'll ask him to. Date may be fixed.
We'll fix. When is your DPC meeting? Promotion.
I have to seek instruction.
ಇನ್ನೂ ಗೊತ್ತಿಲ್ಲ ಅಲ್ಲ. ಆಯ್ತು 19ಕ್ಕೆ ತಗೊಂತೀನಿ.
Great.
ಅಷ್ಟರಲ್ಲಿ search and
I'll send it to the same address in the cost.
send. Meet her, sir. Meet her. Don't look at the phone. Just meet her and come. Yes. She's retired now. Let bygones be bygones ಅಂತ ಹೇಳಿ ಒಂದು apology.
I will advise.
Yes. 19th. Interim order ಹೆಂಗೂ ಇದೆ. List on 19th. Interim order subsisting shall continue till the next date of hearing.
Grateful.
ರಾಮಕೃಷ್ಣ ಎಲ್ಲ ಹಾಕ್ತಾರೆ ಕೇಟಿಲ್ಲದಲ್ಲ. ನಾಳೆ
The petitioner in this case, my lord. This is a case, my lords, where.
Pay you.
Pay you.
Pay you. So you pay.
Yes, my lords.
Yes.
We're being made to pay for no
That's
fault of ours. What
You're
he has done, my lord.
transacted through pay you. Problem is now you pay. Yes.
So, my lords, he says, his case is this. He says, my lords, I engaged in gambling services. I did not know that gambling activities are illegal. I paid all my money, I lost my money. Then I realized that gambling is illegal.
That's why I've granted an interim order.
Interim order, and my lords, they had frozen the accounts. Your lordships have unfrozen those accounts.
Yes.
My lord, this is a case, my lords, where there are no allegations whatsoever that are made against directors of the company. Not a whisper in the complaint. My lords, the complaint is at page 23. My lords,
BONS ಯಾವುದು? Bonds.com.
my lord, that is the website.
Gambling website.
That is the website. My lords, no action is taken against the website.
Gaming company.
Against the gaming company. No action
You
whatsoever.
are the complainant.
I am the complainant.
How much did you lose, sir?
My lord, 27,000.
27,000.
7,000.
ಅದಕ್ಕೆ ಇವ್ರ ಅಕೌಂಟ್ ಫ್ರೀಸ್ ಮಾಡಿಸಿದ್ರಲ್ಲ.
That has been.
That's defrozen, all right.
Yes, madam.
But ಎಷ್ಟಿದೆ ಅಕೌಂಟ್ ಅಲ್ಲಿ?
Several
hundred crores.
Perhaps.
27,000 ಸೋತಿದ್ದಕ್ಕೆ 100 crores account is frozen by the
My
investigating
intention was not that it should be entire account should be frozen.
27,000 ಲೀನ್ ಮಾರ್ಕ್ ಮಾಡಕ್ ಹೇಳಿದ್ರ?
My complaint was as against bonds and as well as the PU platform.
You have paid through PU, is a payment gateway.
Correct.
What can be done if you are
Lord, my
indulging in
complaint, if
gaming or gambling?
My lord, if my lord would kindly see the complaint that I have filed. My lord, my complaint is specifically against bonds.com, the PU, and as well as I have named the directors also.
Why? What role do they have to play?
My lord, since the company is made as they have to be represented by somebody. The
Where is
directors
the
are
company is an accused?
Company has not been made as an accused by
Then
the state. But
how
it
can
has
you
to
make
be
the directors an accused?
Company should have been made as an accused, my lord.
Now you can't cure the illegality, so don't worry.
My lord, at the time of filing the charge sheet, my lord, the state can
No,
always
sir.
include.
Will not permit all this. What, Sharath Gote? ಏನಿದೆ ಇದೆಲ್ಲ ಮಾಡಿದ್ರೆ ಹೆಂಗೆ? Yes.
Just one judgment which you're relying on. Paragraph 21, last sentence. My lords, I'll just read it out very quickly. Paragraph 21, my lord, at page 204. I'll just
No vicarious liability.
no vicarious liability, and my lord, the last sentence.
SK Alag Maqsood Syed.
Yes, and they have to make specific allegations
Against the directors if there are independent role that they have played. It's not.
Nothing of the sort. No allegations.
That he knows very well.
Insofar as directors are concerned, my
Because he every day appears on this side, he knows it, yes.
insofar as directors are concerned, my lord, I have not specifically stated, but insofar as
There
PU
is no role that they would play, sir. Payment gateway, what comes in or what comes out, do you think they sit and monitor? No, sir. 27,000 ನಿಮ್ದು ಹೋಗಿದೆ ಅದಕ್ಕೆ ಮಾಡ್ಕೊಳ್ಳಿ 27,000. Yes. The petitioners are before this court calling in question registration of a crime in crime number 145 of 2022. Charge sheet agilla la?
No.
145 of 2022 registered for offences punishable under. Charge sheet ಆಗಿದೆಯಾ?
Illa, under investigation, stay was granted insofar as the first petitioner is concerned. My information is, my lord, there was
Other
no,
petitioners here.
there is no interim order granted. So the state may have to say what has
They are
happened.
not cooperating with the investigation.
Because one of the directors had retired before the complaint was filed. He was no longer a director.
No,
There is a
only
first
accused
petitioner.
number 2, I think, stays granted.
That is the first
Manish
petitioner,
Goyal.
my lord. First petitioner. Because he had resigned from the company,
Who had resigned?
the first petitioner. By the
Others
time
were-
the complaint was lodged, he had retired from the company, resigned from the company, therefore stay was granted insofar as. he is
This is not my order. Yes.
Yes.
Hmm.
The lordships had looked at this matter on the writ petition side, my lord. Wherein your lordships
Somewhere
had.
I pay you.
Yes, pay you.
Order ಯಾವ್ದು?
My lords, we produced it, my lords, at page 37. That interim order is produced, my lord.
Pay you and phone pay, 2 have written.
Yes, ma'am. Phone page family.
Page 37 is it?
Page 37 is your lordship's interim order. At page 39.
This Pari match. Same petitioner, huh? Pay you payment investments, yes. Same, nimde 27,000.
Same matter. It arises out of the same matter. The matter
Personal
insofar
accounts
as,
of the directors were frozen.
my lord, I never called upon the investigating authorities to freeze it.
No,
My
no,
lord,
if you give them some, they
but
will
insofar as the other petitioners are
blow it
concerned,
out of proportion.
insofar as other petitioners are concerned, my lord, there was a specific observation by this court that the investigation should go ahead.
For investigation. also
What has
they-
happened, my lord, the state may have to clarify.
Liberty to proceed with investigation against other accused persons.
Yes, now it's for the state to say, my lord, what is the.
Even they are also not cooperating with the investigation, my lord.
No,
They
it's-
are not
it's,
coming.
In fact, my lords, we have filed a document, my lords, a detailed memo explaining what has happened. My lord, we asked them for details of the transaction number. My lords, without a transaction number, my lords, millions of transactions happen. They don't give us. They issue 5 notices to us. First 4 notices, they don't give the transaction number. 5th notice, my lords, they give us the transaction number. Within a few hours, we tell them who is the recipient. We take immediate steps to blacklist them. My lords, all that has been mentioned, my lords, in this.
Did they take action against that man, recipient?
My lords, we immediately,
No. Did you take action against the recipient, bonds.com?
nothing at all.
No.
What have you done?
But in the synopsis, my lord, we have filed
Where is the synopsis?
7th September 2023. My lords, we produced all the subsequent developments also.
Additional document, you have filed something, 10th November.
7th September, my lord.
There is nothing concerned. Yes, what has happened to other?
Collected the documents regarding, with respect to the bonds and the bonds company, my lord.
You get instructions as what the, yes, comment.
Yes, my lord.
I cannot now stay against the other accused because there is already an order of the coordinate bench permitting investigation.
There other accused also not cooperating with the investigation.
Other accused not cooperate.
Not cooperate.
We'll ask them to cooperate
Please.
after quashing these proceedings. Yes. 27,000 ನಿಮ್ಗೆ ಬೇಕಾ?
My lord,
ವಾಪಸ್ ಬಂದಿದ್ಯಾ?
no.
Bonds.com recipient
But in
ಕೊಡ್ತಾರೆ.
so-
We'll direct the investigating officer to recover that amount.
Please.
You should be satisfied. 100 crore company account freeze
Okay.
ಮಾಡಿಸ್ಬಿಟ್ರೆ.
True, madam.
27,000. Yes. We'll have it on Tuesday. Get
Please,
the investigation details.
Grateful.
Heard the learned senior counsel Pramod Nair appearing for the petitioner. The learned senior counsel would take this court through the documents to demonstrate that the petitioners have no role to play. The second accused has long before the initiation of the proceeding itself retired from resigned from the post of director. The other directors who are arrayed as accused are not attributed with any independent role in the complaint. The issue relates to loss of 27,000 by the complainant while he was putting his money through the payment gateway -PayU for the purpose of a gaming activity of a gaming company by name bonds.com. Bonds.com. The learned senior counsel would submit that the recipient of the amount was also indicated to the investigating officer and no further steps are taken. List this matter on Tuesday in the for admission, the learned HCGP to secure the investigation papers and place it before the court. Interim order as it is subsisting shall continue till the next date of hearing.
Obliged.
Tuesday, that is, what date? Second.
Grateful.
The 498 proceedings. Case is registered against the husband, and also aged mother and also uncle and auntie. They are the
Uncle and auntie?
senior citizens. They're all accused number 2, 3 and all senior citizens. They're all suffering from various diseases.
Suffering from various diseases.
So ತುಂಬಾ ಡಾಕ್ಟರ್ ಇದೆ ಸ್ವಾಮಿ, ಏನೋ ಕಾಯಿಲೆ ಇದೆ ಅವ್ರ
ಬೇಲ್ ಕೊಟ್ಟಿಲ್ವಾ? ಬೇಲ್ ಕೊಟ್ಟಿಲ್ವಾ?
ಬೇಲ್ ಆಗಿದೆ.
ಆ ಗ್ರೌಂಡ್ ಮೇಲೆ ಬೇಲ್ ತಗೊಂಡು ಕಾಶಿಂಗ್ ಅದೇ ಗ್ರೌಂಡ್ ಹೇಳಿದ್ರೆ ಹೆಂಗೆ?
ಬೇಲ್ ಆಗಿದೆ. ಅದರಲ್ಲಿ marriage taken place in the year 2016. So then after in the 2022, that
yes, charge sheet challenge ಮಾಡೋದಲ್ಲ.
Charge sheet is challenged, my lord.
PCR contains with no allegation against that accused number.
The petitioners are father-in-law, mother-in-law, father-in-law ಇದಾರಾ?
ಇಲ್ಲ, father-in-law ಇಲ್ಲ.
Mother-in-law. First petitioner ಯಾರು?
Husband. First petitioner is mother.
Mother-in-law. Second petitioner ಯಾರು?
Uncle. Accused
ಅಂಕಲ್ ಅಲ್ಲ, ಶ್ರೀಮತಿ ಖುರ್ಷಿದ್ ಅಂತ ಇದೆ. ಅಂಕಲ್
ಅವರು sister and sister husband.
ಸರಿ.
Petitioner first petition
number 1, mother, sister, husband. So and so. A perusal at the summary of the ಯಾವಾಗಿಂದಿದು? 2000 CC of 22. So and so. A perusal at the summary of the charge sheet would not indicate any offense against these petitioners, as all the offenses are against the husband. Finding no allegation that would touch upon the offenses, further proceedings shall remain stayed till the appearance of the second respondent complainant, 1 HCGP 2 emergent notice, returnable by 31st, 22, 30th July. Yes.
Petitioners before lords are in-laws, in-laws, father-in-law, mother-in-law, and the brother-in-law. 498 and 5.
Yes, sir. ಅವ್ರನ್ನ 2 ಸರಿ ಕೇಳಿದ್ದೀನಿ, ನೀವೇ ಇರ್ಲಿಲ್ಲ.
The complaint may kindly be taken, your lordship. Page number 23. Next year C.
Yes.
In the complaint, respondent number 2 makes reference to 3 family meetings where they tried to reconcile the relationship between the accused number 1 and respondent number 2. In those meetings, I make a reference saying that the petitioners here before your lordships were present and they harassed the respondent number 2 herein. But per se, I have to admit it that in the complaint, that particular pleadings as against the petitioners is not there, your lordship.
Charge sheet ಹಾಕಿದಾರಾ?
Charge sheet ಹಾಕಿದ್ದಾರೆ.
ಅದರಲ್ಲಿ
The statement, your lordship.
ಅದರಲ್ಲಿ ಇದೆಯಾ?
ಅದರಲ್ಲಿ ಇದೆ.
ಎಲ್ಲಿದೆ?
Lordships may kindly take page number 74.
Type to
74 ಬೇಡ, 49 ಗೆ ಬನ್ನಿ.
Please, your lordship. I don't have the typed copy.
Typed copy I filed.
Typed copy ಇಲ್ಲ ನಾನು ಅದನ್ನೇ ನೋಡ್ತಾ ಇದ್ದೀನಿ. It's legible, sir.
Please.
Legible. I'll read. In para number 4.
It is completely legible.
2020 release.
Typed copy I filed separately on 20th of
2019 ರಲ್ಲಿ A2 ರಿಂದ A4 ಆರೋಪಿಗಳು ಸಾಕ್ಷಿ ನಾಕುರವರನ್ನು ಮೈಸೂರಿಗೆ ಕರೆದು ವರದಕ್ಷಿಣೆ ಕೊಡುವಂತೆ ಒತ್ತಾಯಿಸಿದ್ದು ಸಾಕ್ಷಿ ನಾಕುರವರು ಇದಕ್ಕೆ ನಿರಾಕರಿಸಿ ನನ್ನ ಮಗಳಿಗೆ ಮಾಡಿಸಿರುವ ಚಿನ್ನದ ಆಭರಣಗಳನ್ನು ನನ್ನ ಮನೆಯಲ್ಲಿಯೇ ಕೊಂಡಿರುತ್ತೇನೆ. ನನ್ನ ಮಗಳು ಯಾವಾಗ ನನಗೆ ಆಕೆಯ ಚಿನ್ನ ಕೇಳುತ್ತಾಳೋ ಅವತ್ತು ನಾನು ಆಕೆಗೆ ನೀಡುತ್ತೇನೆಂದು A2 ರಿಂದ A4 ಆರೋಪಿಗಳಿಗೆ ತಿಳಿಸಿರುತ್ತಾರೆ.
So what? ಏನಿದೆ?
That is the reference, Your Lordship. Even in his statement, he makes the same reference in his statement before the police authorities during investigation.
Yes, madam. Why have you made all these statements?
My lords, the allegation as per that is only that of there being three
Accused
meetings
number
held.
2, 3, 4. Yeah, who are they?
Accused
Lord's
number
father-in-law, first petitioner is the father-in-law, second
Ah.
petitioner is the mother-in-law, third petitioner is the brother-in-law.
Anything else, Varun?
My only submission would be this subject matter of trial, whether they were residing together or whatever transpired between accused number
Even
one.
if they're residing together, what is there against them?
Please, I'll leave it to Your Lordship.
You take care of the husband.
Please.
ಅಲ್ಲ ಅಂದ್ರೆ in the crime.
The crime.
Yes. Yes, sir.
That's all.
The petitioners Phil Mill Bill are before this of the second respondent complainant are before this court calling in question proceedings in CC 4897 of 2023 registered for offences punishable under section 498A 506 read with 34 and section 4 of the Dowry Prohibition Act. The second respondent heard the learned counsel so and so respondent. The second respondent is the complainant. Gets married to accused number 1. Yavaga, madam?
Lord 16/5/2020.
On 16/5/2020.
16 laws.
2016, and then began to reside at Qatar for the reason that the accused number 1 was in employment at Qatar. Relationship between the husband and the wife appear to have turned sour in Doha, and later on, after coming back to India, registers a complaint on 2/12/2022 for the aforequoted offences. The complaint then becomes a crime in crime number, what's that? 205 of 2022. The police conduct investigation and file a charge sheet against these petitioners. Filing of the charge sheet is what has driven these petitioners to this court in the subject petition. Learned counsel appearing for the petitioner, Srimati Sridevi Vosley, would submit that either the complaint or the findings in the charge sheet or even the statements given at the time of investigation nowhere points at any overt act performed by the petitioners. The couple, after marriage, flew to Qatar and were residing there. It appears the relationship turned sour there. Therefore, finding no allegation that would touch upon the ingredients, the learned counsel would seek quashment of the proceedings against the petitioner. The learned counsel appearing for the complainant, Varun Patil, would vehemently refute the submission to contend that the police have filed the charge sheet and the petitioners will have to come out clean in a full-blown trial, as the allegations are found against them both in the complaint and in the charge sheet. The learned HCGP would toe the lines of the learned counsel appearing for the complainant, seeking dismissal of the petition on the score that a charge sheet is filed. I have given my so-and-so. The afore narrated facts are not in dispute. It is an admitted fact that the petitioner and the complainant and the accused number 1, after marriage, were residing at Qatar. The all the happenings between the husband and the wife appears to have happened at Qatar. At Doha. At Doha. After coming back to India, it transpires the complainant registers the subject complaint against all the members of the family, including the husband, who is arraigned as accused number 1, who is not before the court. Since the issue has sprung from the complaint, I deem it appropriate to notice the complaint. It reads as follows, page 35 to 37, 38. The narration in the complaint is an amalgam of what has happened in various places, including in various places, Qatar or Chennai or Bangalore, as the case would be. Nowhere it points at harassment meted out or torture meted out by these petitioners who are Phil Mill Bill. The allegations are omnibus and vague in the complaint. The police conduct investigation and file a charge sheet. The summary of the charge sheet as obtaining in column number 17 reads as follows, page 79. A perusal at this 79. What page was that?
Charge sheet starts
Starting, Allah sir. Column
49.
49.
49, yes, page 49. A perusal of it would also indicate omnibus and vague statements made against these petitioners of demand of dowry and harassment on such demand. Else, the allegation is that they have provoked the husband, accused number 1, to behave in the manner which has become the ingredient of the offense. Therefore, finding no allegation that would touch upon the ingredients against these petitioners, if further proceedings are permitted to continue, as observed by the apex court in the case of Kashkan Kaushar, it would become an abuse of the process of the law and result in miscarriage of justice. The apex court holds as follows at court mandiment. Dismissed. Yes.
In this case, my lord. 494 and 498, my lord. Against in-laws, sister-in-laws.
Bigamy.
Bigamy is against my lord A1.
Where complainant?
I'm for the
Yes,
second
madam.
respond.
Really?
Lord, if the lordship sees the
Photographs.
charge, photographs are there. Moreover, the statement of Mohita, the daughter,
Oh, daughter.
Yes.
Ah.
She had left the mother and had gone to the house of the father.
Hmm.
And she was residing with the father at the relevant point of time when the second marriage took place. She describes how the marriage took place, how the relatives instigated the husband, her father, to go through the marriage ceremony. She has recorded the marriage ceremony and has the whole thing has happened because she was getting ill-treated after the second marriage.
You accused number 4. Who is accused number 4?
The elder sister
Of
the accused number 1 husband. And this lady resides in the same house. She says, I am a stranger, I do not know anything. That is her statement in the quashing petition.
No problem. You should catch hold of the husband and the alleged second wife.
Second wife is not made a party, my lord.
Not
We are
necessary.
not,
ಈಗ ಅವ್ರನ್ನ
we are
ಮಾಡಕ್ ಹೋಗ್ಬೇಡಿ.
accused. But the daughter's statement is very clear, my lord, where she says that
Whose daughter?
the husband and wife,
Daughter.
yes,
What statement?
she has given a statement to the police. ನನ್ನ ತಂದೆ ತಾಯಿ 35/12 ಸಂಪ್ರದಾಯದಂತೆ ಮದುವೆ ಆಗಿತ್ತು. ಮದುವೆ ಆದ ನಂತರ ನನ್ನ ತಂದೆ ಪ್ರತಿದಿನ ಕುಡಿದು ಮನೆಗೆ ಬಂದು ನನ್ನ ತಾಯಿ ಜೊತೆ ಜಗಳ ಮಾಡಿ ಹಿಂಸೆ ಮಾಡ್ತಿದ್ದರು. ನನ್ನ ತಂದೆಯ ಕಿರುಕುಳ ತಾಳಲಾರದೆ ನನ್ನ ತಾಯಿ 6/12/18 ಉತ್ತರಹಳ್ಳಿಯಲ್ಲಿ ಬಾಡಿಗೆ ಮನೆಯನ್ನು ಮಾಡಿ ನನ್ನನ್ನು ಕರೆದುಕೊಂಡು ಹೋಗಿರುತ್ತಾರೆ. ನಂತರ ನಾನು ನನ್ನ ತಾಯಿ ವಾಸವಾಗಿರೋ ಮನೆಗೆ ನನ್ನ ತಂದೆ ಬಂದು ಗಲಾಟೆ ಮಾಡಿದ್ದರಿಂದ ನಾನು ಮತ್ತು ನನ್ನ ತಾಯಿ PGಯಲ್ಲಿ ಸುಮಾರು 8 ತಿಂಗಳಿಂದ ವಾಸವಾಗಿರ್ತೇವೆ. ನಂತರ COVID-19 ಲಾಕ್ಡೌನ್ ಆಗಿದ್ದರಿಂದ 2020
ಹಸ್ಬೆಂಡ್ ಇನ್ನೊಂದು ಮದುವೆ ಆಗಿ ಅವ್ರ ಪ್ರಾಬ್ಲಮ್ ಆಗಿದ್ರೆ ಇವ್ರೇನ್ ಮಾಡ್ತಾರೆ?
ಇಮಿಡಿಯೇಟ್ಲಿ ಲೇಟರ್ ಬರುತ್ತೆ. 2020 ಡಿಸೆಂಬರ್ ಅಲ್ಲಿ ನಾನು ಬೆಂಗಳೂರಿಗೆ ಬಂದು ನನ್ನ ತಾಯಿ ಜೊತೆ ವಾಸವಾಗಿದ್ದು 1 ವಾರದ ನಂತರ ನಾನು ನನ್ನ ತಂದೆಯ ಮನೆಗೆ ವಾಪಸ್ಸು ನಿಮ್ಮ ಜೊತೆ ಬರುತ್ತೇನೆ ಎಂದು ಮೆಸೇಜ್ ಮಾಡಿ ತಾಯಿಗೆ ಹೇಳದೆ ಹೋದೆ ಅಂತ ಹೇಳ್ತಾರೆ. ಅದಾದ್ಮೇಲೆ ನೆಕ್ಸ್ಟ್ ಪೇಜ್ ಮಿಲಾಡ್. ಆದ್ದರಿಂದ ನಾನು ನನ್ನ ತಂದೆಯ ಜೊತೆಗೆ ವಾಸವಾಗಿರುತ್ತೇನೆ. 2021 ಅಕ್ಟೋಬರ್ನಲ್ಲಿ ನನ್ನ ತಂದೆ ಇನ್ನೊಂದು ಮದುವೆ ಆಗಲು ನನ್ನನ್ನು ಒಪ್ಪಿಸಿ ಹುಡುಗಿಯನ್ನು ನೋಡಲು ನನ್ನನ್ನು ಕರೆದುಕೊಂಡು ದಾವಣಗೆರೆಗೆ ಹೋಗಿ-
ಡಾಕ್ಟರ್ ಹೇಳ್ತಾರೆ ಇದು.
ಹೌದು, ಡಾಕ್ಟರ್ ಹೇಳ್ತಾ ಇರೋದು. ದಾವಣಗೆರೆಗೆ ಹೋಗಿದ್ದು ನಮ್ಮ ಜೊತೆಗೆ.
How old is the daughter?
ಮೋಹಿತ್.
How old is-
She is just major now. Just a major now. At that time she was a minor, 17 years. 17 ವರ್ಷ ಆಗಿದೆ. ನಮ್ಮ ಜೊತೆಗೆ ಮೂರ್ತಿ ತಾತರವರು ಬಂದಿರುತ್ತಾರೆ, ದಿ ಅಂಕಲ್ ವಿಲ್. ನಂತರ ನವೆಂಬರ್ 21ರಲ್ಲಿ ನನ್ನ ತಂದೆಯ ಮನೆಯಾದ ನಂಬರ್ 40 so and so ಈ ಮನೆಯಲ್ಲಿ ನನ್ನ ತಂದೆ ನಾಗವೇಣಿಯವರನ್ನು ಮದುವೆ ಆಗಿರುತ್ತಾರೆ. ಮದುವೆಯನ್ನು ನಾಗವೇಣಿಯವರ ತಂದೆ ತಾಯಿ, ಚಿಕ್ಕಪ್ಪ ಚಿಕ್ಕಮ್ಮ ಮತ್ತು ಅವರ ಸಂಬಂಧಿಗಳು ಮತ್ತು ನಮ್ಮ ಕಡೆಗೆ ನಮ್ಮ ಅಜ್ಜಿ ತಾತ, ಅತ್ತೆ ಮಾವ, ಬಾಬು ಹಾಗೂ ಮೂರ್ತಿಯವರು.
What prima facie evidence you have about the marriage?
The photographs taken by the daughter that is produced before the police. I have produced with my objection statement 1 or 2 photographs. ಅರಸಿನ ಶಾಸ್ತ್ರ, ತಾಳಿ ಕಟ್ಟೋದು ಎಲ್ಲ ಕೊಟ್ಟಿದ್ದೀನಿ. ನನ್ನ objection statement ಜೊತೆ ಹಾಕಿದ್ದೀನಿ.
ಇವ್ದು ಸೆಕೆಂಡ್ ವೈಫ್ ನಿಮ್ ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕಿರೋದು ಸೆಕೆಂಡ್ ವೈಫ್
ಅಲ್ಲ, ವೈಫ್ ಕಂಪ್ಲೇಂಟ್.
ಕಂಪ್ಲೇನೆಂಟ್ ಆಯ್ತು, ನೀವು ಮದುವೆ ಆಗಿದ್ದೀರಾ, ನೋ ಪ್ರಾಬ್ಲಮ್. ಬಟ್ ವಿಚ್ ಇಸ್ ಬೈಗಮಿಗೆ ಹೂ ಇಸ್ ದ ಸೆಕೆಂಡ್ ವೈಫ್?
ಸೆಕೆಂಡ್ ವೈಫ್ ಇದರಲ್ಲಿ ಅಕ್ಯೂಸ್ಡ್ ಅಲ್ಲ, ಅಕ್ಯೂಸ್ಡ್ ಮಾಡಿಲ್ಲ.
ಅಕ್ಯೂಸ್ಡ್ ಇಲ್ಲ, ಬಟ್
ನಾಗವೇಣಿ ಅಂತ.
ಅಲಿಗೇಷನ್ ಇಸ್ ಬೈಗಮಿ.
ನಾಗವೇಣಿ
ಅಲ್ಲ, ಅದು ಹೆಸರು ಕೇಳಿಲ್ಲ, ಐ ಡೋಂಟ್ ನೋ, ವಾಟ್ ಎವರ್ ಇಟ್ ಇಸ್. ಬಟ್ ಐ ಸೆಡ್ ವಾಟ್ prima facie evidence you have to show.
Milord, the photographs taken by the daughter of the marriage ceremony itself.
That is what I'm asking, which is that?
Page number 37.
Milord, I have
36,
not been given the
37.
document, just petition ಕೊಟ್ಟಿದ್ದಾರೆ, ಬಟ್ ನಾನ್ ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡಿದ್ದೀನಿ ನನ್ನ objection
ಓ, ಇವರು ಸೇಮ್ ಫೋಟೋಗ್ರಾಫ್ಸ್ ಅವ್ರು ಹಾಕಿರೋದು.
2ನೇ ಆರೋಪ
37 ಯಾರು?
37ರಲ್ಲಿರೋದು
1ನೇ ಆರೋಪಿ 2ನೇ ಮದುವೆ ಆಗಿರುವ ಬಗ್ಗೆ ಸಂಬಂಧಿಸಿದ ಭಾವಚಿತ್ರಗಳ ಅಸಲು.
ಸೆಕೆಂಡ್.
ಸರಿ, ಅದು ನೀವು ಯು ಹ್ಯಾವ್ ಟು ಫೈಟ್ ಅಬೌಟ್ ದಟ್. ವಾಟ್ ಈಸ್ ದಿಸ್ ಲೇಡಿ ಗೋಯಿಂಗ್ ಟು ಡೂ?
Milord,
all are
she has
instigated.
instigated this marriage. I have stated, ಅವ್ರಿಗೆ ಕಂಪ್ಲೇಂಟ್ ಅಲ್ಲಿ ಕ್ಲಿಯರ್ ಆಗಿ ಹೇಳಿದೀನಿ. The complaint of the complainant, she clearly says that this lady is responsible. ಅವರೆಲ್ಲರೂ ಸೇರಿ ಮದುವೆ ಮಾಡಿದ್ದಾರೆ ಅಂತ ಮಗಳು ಹೇಳ್ತಾಳೆ. ಅದರ ಫೋಟೋಗ್ರಾಫ್ಸ್ ಇದೆ, ಲೇಡಿ ಅರಸಿನ ಶಾಸ್ತ್ರ ಮಾಡೋ ಫೋಟೋಗ್ರಾಫ್ ಇದೆ. ನಾಟ್ ದಟ್ ಜಸ್ಟ್ ಪಾರ್ಟಿಸಿಪೇಟ್ ಮಾಡಿದ್ರಿಂದ ಅವ್ರನ್ನ ನಾವು ಮಾಡಿದ್ದು ಅಂತಲ್ಲ. ದೇ ವರ್ ದ ಮೇನ್ ಪಾರ್ಟೀಸ್ ಹೂ ಆರ್ ರೆಸ್ಪಾನ್ಸಿಬಲ್ ಫಾರ್ ದ ಮ್ಯಾರೇಜ್. ಎಲ್ಲರೂ ಸೇರಿ ಆಗಿರೋ ಮದುವೆ ಇದು. They are all residing together. The very false statements she has made saying that I am a state stranger, I am residing elsewhere since 2.5 decades. I am
Residing elsewhere, my lord. That Aadhaar card which is produced is an old one. I have new Aadhaar card, my lord. It is, my lord, shows that, and she is having, my lord, the major sons. 25 ಇವ್ರು ದಿಸ್ ಪೆಟಿಷನರ್ ಇವ್ರು 25 ವರ್ಷದಿಂದ ಬೇರೆ ಇದ್ದಾರೆ. ಅವ್ರ ಗಂಡ ಕೂಡ ತೀರ್ಕೊಂಡಿದ್ದಾರೆ, ಬೇರೆ ಕಡೆ ಇದ್ದಾರೆ. ಶಿ ಇಸ್ ಗವರ್ಮೆಂಟ್
ಗಂಡ ತಿಳ್ಕೊಂಡಿದ್ದಾರೆ.
ಪ್ರೆಸೆಂಟ್ ಪೆಟಿಷನರ್ ಅವ್ರ ಮಕ್ಕಳ ಜೊತೆ ಬೇರೆ ಇದ್ದಾರೆ. ಮತ್ತೆ ಅವರು ಶಿ ಇಸ್ ಎನ್ ಗವರ್ಮೆಂಟ್ ಎಂಪ್ಲಾಯಿ. ಅವ್ರ ಇಂಟೆನ್ಷನ್, ಯುವರ್ ಲಾರ್ಡ್ಶಿಪ್ ಮೇ ಕೈಂಡ್ಲಿ ಸಿ ದಿ ಕಂಪ್ಲೇಂಟ್ ಫಾರ್ ಎ ಮೂಮೆಂಟ್.
ಯು ಆರ್ ಅ ಗವರ್ಮೆಂಟ್ ಸರ್ವೆಂಟ್.
ಪ್ಲೀಸ್, ದಟ್ ಈಸ್ ದ ಓನ್ಲಿ, ಯುವರ್ ಲಾರ್ಡ್ಶಿಪ್ ಮೇ ಕೈಂಡ್ಲಿ ಸಿ ದಿ ಕಂಪ್ಲೇಂಟ್ ಫಾರ್ ಎ ಮೂಮೆಂಟ್. ಐ ರೀಡ್ ಓನ್ಲಿ 2 lines.
Page
16 second paragraph. ಸದ್ಯ ಸದ್ಯ 2018 ಡಿಸೆಂಬರ್ ತಿಂಗಳಿಂದ ನಾನು ನನ್ನ ಪತಿಯಿಂದ ಪ್ರತ್ಯೇಕವಾಗಿ ವಾಸಿಸುತ್ತಿದ್ದೇನೆ. ಇಟ್ ಇಸ್ ವೆರಿ ಕ್ಲಿಯರ್, ಮಿಲಾಡ್, ಸಿನ್ಸ್ ಫ್ರಮ್ 2018, ಮಿಲಾಡ್, ದೇ ಆರ್ ಡಿಪಾರ್ಟಿಂಗ್. ನೆಕ್ಸ್ಟ್ ಪೇಜ್, ಮಿಲಾಡ್, 17, ಮಿಲಾಡ್, ಲಾಸ್ಟ್ ಪೇರಾ. ಈ ರೀತಿ ಇವರೆಲ್ಲರೂ ಸೇರಿ ನನಗೆ ಮೋಸ ಮಾಡಿರ್ತಾರೆ. ನನ್ನ ಪತಿ ಅಕ್ಕ ಬೆಂಗಳೂರಿನಲ್ಲಿ ಡೆಪ್ಯೂಟಿ ತಹಶೀಲ್ದಾರ್ ಆಗಿದ್ದು, ಸೋದರ ಮಾವ ಮೂರ್ತಿ ರಿಟೈರ್ಡ್ ರೆವಿನ್ಯೂ ಇನ್ಸ್ಪೆಕ್ಟರ್ ಆಗಿ ತಮ್ಮ ಅಧಿಕಾರವನ್ನು ದುರುಪಯೋಗ ಮಾಡಿಕೊಂಡು ನನ್ನ ಪತಿಗೆ ಕುಮ್ಮಕ್ಕು ಕೊಟ್ಟು ಈ ರೀತಿ ಮೋಸ ಮಾಡಿ. ದಿಸ್ ಇಸ್ ದ ಓನ್ಲಿ ಎಲಿಗೇಷನ್. ದಿಸ್ ಇಸ್ ದ ರೀಸನ್, ಮಿಲಾಡ್, ದೇ ಹ್ಯಾವ್ ಇನ್ಕಾರ್ಪೊರೇಟ್ ಮೈ ನೇಮ್.
ಅಲ್ಲ, ಅದ್ರ ಮೊದಲು ಇದೆ ಅವರ ಕುಮ್ಮಕ್ಕಿಂದ. ಅಲ್ಲ, ಆತನು ಈ ಅಪರಾಧವನ್ನು ಮಾಡಲು ಪ್ರೋತ್ಸಾಹಿಸಿ
2018 ಇವರಿಬ್ರು ಬೇರೆನೇ ಇದ್ದಾರೆ. 498 2020 ನಲ್ಲಿ ಕಂಪ್ಲೇಂಟ್ ಕೊಡ್ತಾರೆ ನನ್ನ ಮೇಲೆ.
ಅಲ್ಲ, ಕುಡಿತ ಎಲ್ಲ ಮಾಡಿದ್ರೆ ಇನ್ನೇನ್ ಮಾಡಕ್ಕಾಗುತ್ತೆ?
ಕುಡಿತ ಮಾಡ್ತಾ ಇರೋದು ಇವರಲ್ಲಿ ಕುಡಿತ ಮಾಡ್ತಾ ಇದ್ದಾರೆ.
ಇವರಲ್ಲ, ಅವ್ರನ್ನ ಹೇಳ್ತಾ ಇದಾರೆ ಅವರು.
ಅವರು ಮಾಡಿದ್ರೆ ಏನ್ ಮಾಡಕ?
Milord, I will tell one more fact. She has married again.
Who?
His client, the petitioner.
So what? Why are you worried?
ಮತ್ತೆ ಮದುವೆ ಆಗಿದ್ದಾರೆ.
She'll marry thrice. Why are you worried?
ಹಸ್ಬೆಂಡ್ ಇದ್ದಾಗಲೇ ಮದುವೆ ಆಗಿದೆ.
ಅರೆ ಇರ್ಲಿ ಬಿಡಿ, ನೀವೊಂದು ಬೈಗಮಿ ಕೇಸ್ ಹಾಕಿ ಅವ್ರ ಮೇಲೆ.
ಇಲ್ಲ, ನಾನು ಹಾಕಿಲ್ಲ, ಬಟ್ ಐ ಆಮ್ ಟೆಲ್ಲಿಂಗ್.
ಮತ್ತೆ ಯಾಕೆ ಬೈ? ನೀವೇನೋ ಫ್ಯಾಕ್ಟ್ ಹೇಳ್ತೀನಿ ಅಂತ
ಆಲ್ ಆಫ್ ದೆಮ್ ಹ್ಯಾವ್
ಡಿಫೆನ್ಸ್ ಸೀಕ್ರೆಟ್ ಹೇಳ್ತಾ ಇದ್ದೀರಾ.
of them have joined together to see that he is married again. ಹಾಗೆ ಈ ಹುಡ್ಗಿನ ಓಡಿಸ್ಬಿಟ್ಟಿದ್ದಾರೆ ಅಲ್ಲಿಂದ ಈಗ.
ಅಲ್ಲ
ಮಗಳು
ಅವ್ರು ಬಿಡಿ,
ಇಲ್ಲ ಅಲ್ಲಿ.
if she is in the habit of getting married once or twice, don't worry about it.
ಅವರು
Let it,
husband has married ಅಲ್ವಾ?
ಅಲ್ಲ, let her,
With the guy.
let her marry, husband will face fight you.
Abet ಯಾರು abet ಮಾಡಿದ್ದಾರೆ ಅವರನ್ನ we have joined. Whoever has abetted this marriage and have actively participated and encouraged the husband to marry, we have joined. ಅದು even ಈ recent
ಕೊಡಿ madam, yes, judgment ಕೊಡಿ.
ಅದರಲ್ಲಿ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ನು ಸೈಟ್ ಮಾಡಿ the court says that even Supreme Court in 1966 1966 Supreme Court 1966 Supreme Court ಕೋರ್ಟ್ ಮಾಡ್ತಾರೆ. ಅದರಲ್ಲಿ ಅಬೇಟ್ಮೆಂಟ್ ಇದ್ರೆ they are liable ಅಂತ ಹೇಳ್ತಾರೆ. I had marked in the citation.
ಇದು ಬೈಗಮಿನ?
ಹೌದು. ಅಲ್ಲಿ ಅವರು ಅದನ್ನ they have acquitted the others because there was no allegation. But ಇಲ್ಲಿ ಕ್ಲಿಯರ್ ಎಲಿಗೇಷನ್ ಇದೆ, ಫೋಟೋಗ್ರಾಫ್ಸ್ ಇದೆ. ಡಾಟರ್ ಹೇಳ್ತಾ ಇದ್ದಾಳೆ who was present at the time of the marriage. The daughter is telling.
This is against you, madam.
ಇಲ್ಲ ಇಲ್ಲ.
ಇಲ್ವಾ?
They have
ಎಲ್ಲ
acquitted.
ಕಾಸ್ಟ್ ಮಾಡಿದಾರಲ್ಲ.
ವಾಶ್ ಮಾಡಿದ್ದು ಯಾಕೆಂದ್ರೆ ಅದರಲ್ಲಿ
ಯಾಕಾರು ಇರ್ಲಿ, ಕಾಸ್ಟ್ ಮಾಡಿದ್ದಾರೆ.
ಯಾವುದೇ ಎಲಿಗೇಷನ್ ಇಲ್ಲ ಅಂತ.
Correct.
ಇಲ್ಲಿ ಹಾಗಲ್ಲ. We have made clear allegations.
ಅಲ್ಲ,
We have given.
I was shocked, surprised in 2024, bigamy, others are, it is correctly written.
ಇಲ್ಲ, ಅದು
Bigamy can only be between spouses and within the realm of marriage. It thus makes it clear the offense of bigamy can be sustained only of the bigamous spouse and not against a third party.
Your lordship may kindly see paragraph 16 below.
Yes, 1966 court.
Further in how?
Yes.
Further in a recent decision, para 15.
Yes.
The apex court in the case of Kanwal Ram and others versus Himachal Pradesh administration held that offences under section 494 and 109 IPC is permissible when it is shown that the relatives of the offenders had also instigated or abated bigamy. ಇಲ್ಲಿ ಅವ್ರು ಎಕ್ವಿಟ್ ಮಾಡಿದ್ದೆ ಯಾಕೆ ಅಂದ್ರೆ
1966 ಅಲ್ಲಿ ಅಬೆಟ್ ಮಾಡ್ತಾ ಇದ್ರು. ಎಲ್ಲ ಆನ್ ದೇರ್ ಓನ್ ವೊಲ್ಯೂಷನ್ ಮಾಡ್ತಾರೆ.
ಎಲ್ಲ ಲೇಟರ್ ಡಿಸಿಷನ್ಸ್ ಅಲ್ಲಿ ಹೇಗಿದೆ ಅಂದ್ರೆ there is no allegation, there is no proof also. But ಇಲ್ಲಿ ಹಾಗಲ್ಲ, at this stage itself we have given the proof of the photographs, we have given the daughter has given the evidence. So at least the daughter is an eyewitness whose evidence must be given some relevance.
Does the daughter say that this lady was there?
Yes. ಹೇಳಿದಾರಲ್ಲ,
Where?
ಮತ್ತೆ ಮಾವ ಚಿಕ್ಕಮ್ಮ ಚಿಕ್ಕಪ್ಪ ಎಲ್ಲ ಹೇಳಿದ್ರು. ಈಗ ಓದಿ
Their presence will not amount to instigation.
ಅಲ್ಲ, ಅವರಿಂದಾಗಿ ಆಗಿತ್ತು ಅಂತ ಹೇಳ್ತಾರೆ. Rest she has to support herself in the evidence.
Let's see
At the
if
trial.
if that is the evidence, you can be recalled under 319. We'll close it.
Observation ತಗೋದು ಮಾಡಿ.
That is always there. Yes.
Again, it will give a
The petitioner, accused number 4, is before this court, calling in question proceedings in CC 293631 of 2022, registered for offences punishable under section 494, 498A and 34 of the IPC. Facts in brief germane are as heard so and so. Facts in brief germane are as follows. The accused number 1, brother of the petitioner, gets married to the complainant on 30th May 2004. A complaint then comes to be registered on 2/7/2022 by the second respondent, alleging that the petitioner along with others have indulged in instigation of the husband accused number 1 to get married to accused number 2, both of whom are not before the court. The petitioner is arrayed into the crime on the score that she is the sister and a garment servant. Misusing the position, has instigated the brother to get married for the second time during the subsistence of the first marriage. And therefore, the offense of section 494 is laid against against all the accused. The police conduct investigation and file a charge sheet. The filing of the charge sheet is what has driven the petitioner to this court in the subject petition. The learned counsel appearing for the petitioner submits that the petitioner is a government servant and is living a life of her own elsewhere and does not reside at any point with the brother or his wife. He would contend that if the brother has married for the second time, it is for him to answer the charge and not the petitioner for instigation. Merely because the petitioner is a government servant, she has been dragged into these proceedings. The learned counsel appearing for the respondent complainant would refute the submission, contending that the petitioner was also present in the alleged event of marriage of the second marriage of the accused number 1. She would take this court through the statement of the daughter of the complainant, who was at that point in time 17 years, and to contend that the marriage did take place and the petitioner has instigated such marriage. Therefore, all the accused should face the trial and come out clean in the same. The learned HCGP would toe the lines of the learned counsel appearing for the second respondent. I have given my source. The four narrated facts are not in dispute. The offences alleged are the ones punishable under section 494, 498A and 34 of the IPC. The issue gets triggered from the registration of the complaint against the petitioners and others. The complaint reads as follows, page 16 and 17. The police conduct investigation and file a charge sheet. Summary of the charge sheet as obtaining in column number 17 reads as follows, page 26. A perusal at the complaint or the summary of the charge sheet would only demonstrate or indicate instigation on the part of the petitioner for either offense punishable under 494 against the husband accused number 1 or the second accused number 2 who is alleged to have second wife is accused number 2 na
No, my lord.
yaru matte
Father-in-law.
Father-in-law 3 yaru
Father-in-law and mother-in-law.
second wife made ilva
ಇಲ್ಲ.
so sad baribedi so the learned perusal at the complaint or the summary of the charge sheet would not indicate any offense ingredient of an offense that would be necessary to be driven home under section 494 or 498A of the IPC. Omnibus statement is made in the summary of the charge sheet where accused number 1 to 5 have together coaxed the accused number 1 husband to get married again. Much emphasis is placed upon the statement of the daughter, which also points at the act of the father accused number 1, and also presence of the mother in the presence of the mother on the alleged event of the second marriage. The evidence is taken, the submission is sought to be buttressed upon the photographs that are appended to the petition or the statement of objections as the case would be. Section 494, is trite, is a triangle between the husband, the first wife, and the alleged second wife. All others would have nothing to do with the incident. The complaint of this kind makes the triangle to turn into a circle where all the members of the family are wanting to be dragged into the web of the crime. One such is the present petitioner, the sister of the accused number 1 husband. For an offense under 498A, there is not even a titter of allegation that would touch upon the ingredients of the offense. Insofar as the offense under 494A is concerned, what is alleged is instigation. As is settled that it is between the bigamist and the spouse who indulges in bigamy and not against others, sisters or brothers or whoever have allegedly attended the marriage to be brought into the web of crime, brought into the web of crime. In the event the role of the petitioner is found somewhere at the time of tendering of evidence of other accused, it is always open to take action in accordance with law. Till such time, if further proceedings are permitted to continue, it would become an abuse of the process of the law and result in miscarriage of justice. For the aforesaid reasons, so it's allowed question.
Only against A4, my lord.
Huh?
Against A4.
Acquire the petitioner only. It is made clear and will not be applicable to any other accused case.
Lordship, I represent the respondent number 2. The petition number 2 has filed second FIR against the respondent number 2, producing the copy of the same, your lordship. This criminal petition 956 of 24 has to be tagged with these 2 cases, your lordship. I may be permitted to read only one sentence. One sentence, how it is related, read only one sentence.
Submission, my lord.
Illa, bhaya.
May I make a submission, my lord?
Subramania sir, yarige?
Lords, I appear for
First
the
matter.
petition of lords in
Devaraj matter.
yes, 3002 of 2000.
Mahesh.
I appeal
ಏನು?
for the petitioner in criminal petition 2221 of 2023, my lord.
ಆಯ್ತು. Subramania ಅವರು start ಮಾಡಿ.
Before my learned friends say, I would like to make a submission before the court that, my lord, all the petitioner and respondent in all these cases are advocates by profession. Therefore, the issue between.
I should not hear them.
No, no, my lord, I'm not saying. It can be solved. Therefore, I'm requesting my lords to kindly
Settlement.
refer this matter to mediation where it can be settled. Because both the petitioner as well as the respondents are practicing advocates. It cannot be.
Cannot be adjudicated here.
No, no, my lord. What I'm saying is I don't want to mention their name. That's the reason, my lord.
Lordship, in this case.
ನಾನೇ ನೋಡ್ಬಿಡ್ತೀನಿ ಬಿಡಿ. Second petition ಕೊಡಿ ಮೇಡಮ್. ಅದು ಯಾರು ನೋಡಿ.
Please, my lord. It is my case. Page number 11 is the complaint, my lord. Offense are section 384 and 506 of IPC.
One submission. Second petition ಅಲ್ಲಿ objection ಹಾಕ್ಬೇಕು, objection ಹಾಕಿಲ್ಲ ಅದ್ರಲ್ಲಿ.
ಇಲ್ಲ, ಹಾಕಿದೀನಿ ಸ್ವಾಮಿ. I filed it.
Petition ಅಲ್ಲಿ ನಾನು ಹಾಕಿಲ್ಲ.
ಇವ್ರು ನಂಗೆ
Second petition time ಬೇಕು, ನಾನು first petition ಮಾತ್ರ ಪ್ಲೇಸ್ ಮಾಡ್ತೇನೆ.
ಆಯ್ತು, ಈಗ ಯಾವ್ದು ಥರ್ಡ್ ಪೆಟಿಷನ್ ಹೇಳಿದ್ರಲ್ಲ ಅದು?
ಅಲ್ಲ, ಕೊಡ್ತಾ ಇದ್ದೀನಿ ಸ್ವಾಮಿ. Only one sentence I will read. Only one sentence. How it is connected, I am just
ಸರಿ
demonstrating.
ಸರಿ ಕೊಡಿ.
ಕೊಡಿ.
ಎರಡು ಕ್ರೈಮ್ ಯಾರು ಹಾಕಿರೋದು?
ಅಲ್ಲ, ಎರಡು ಪೆಟಿಷನರ್ ಬಂದು ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 2 ಮೇಲೆ 2 FIR ರಿಜಿಸ್ಟರ್ ಆಗಿದೆ ಸ್ವಾಮಿ. One is in 3002, your lordship. Sorry, 2221. Your lordship may kindly read a page number 10, your lordship. Page number 10 ಅಲ್ಲಿ 3rd line ಸ್ವಾಮಿ. ಫಿರ್ಯಾದಿದಾರರಿಗೆ ಮಂಜುಳಾ ದೇವಿ TS ಡಾಟರ್ ಆಫ್ ಸದಾಶಿವಯ್ಯ ಎಂಬುವವರು ಫಿರ್ಯಾದಿದಾರರಿಗೆ ಮತ್ತು ಅವರ
ಹೇಳ್ಬೇಡಿ ಅಂತಾರೆ.
ಮಹಿಳಾ ಠಾಣೆಯಲ್ಲಿ ದೂರನ್ನು ನೀಡಿರ್ತಾರೆ. They are referring to the first FIR, your lordship. That's
saying I can't take the names. You are reading all the names.
ಅಲ್ಲ, 956 of 24 has to be tagged in this case, your lordship. That is what my humble submission is. All the 3 crime are connected, your lordship.
My lordship, one
ಆಯ್ತು, all the advocates are connected.
The issue only regarding to discard the embryo. That's the only issue in all these 3 cases.
ಏನು?
ಅಲ್ಲ, ಇದರಲ್ಲಿ I will narrate, your lordship.
ನಿಮಿಷ ಸರ್. ಇರಿ ಸರ್.
ಒಂದು ಎಂಬಾರಿಯೋನು ಡಿಸ್ಕಾರ್ಡ್ ಮಾಡ್ಬೇಕಂತ
ಡಿಸ್ಕಾರ್ಡ್ ಮಾಡಕ
ಎಂಬ್ರಿಯೋ
in
fact, petition number 23-921 listed before your lordship, and stay has been granted by your lordship only, and that same is pending before
what embryo, sir?
My lordship, one submission. In this case, first petition is concerned for 498 petition. My Subramania sir argued, my lordship.
Submission ಮಾಡ್ತಾ ಇದ್ದಾರೆ, ಮಾಡಿ.
498 ಅಟ್ರಾಕ್ಟ್ ಆಗಿಲ್ಲ. ಸೆಕೆಂಡ್ ವೈಫ್ ಅಂತ ಕ್ಲೈಮ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ. ಸೆಕೆಂಡ್ ವೈಫ್ ಅಲ್ಲ, ದಟ್ಸ್ ಮೈ ಕಂಟೆಂಟ್, ದಟ್ಸ್ ಮೈ ಕೇಸ್.
ನೀವು ಸುಬ್ರಹ್ಮಣ್ಯ ಅವ್ರು ಎಂಗೇಜ್ ಮಾಡಿದಿರ ತಾನೆ? ನೀವು ಕೂತ್ಕೊಳ್ಳಿ, ಅವ್ರು ಕೂತ್ಕೊಂತ ಇದ್ದಾರೆ.
All the 3 petitions, my lords, will have to be heard separately. Lords, it is no way connected to each other. Lords, merely because the parties are same, lords. I personally, my lords.
What embryo is involved in this?
Lords, that is a case where, my lords.
I am the junior under the respondent. That's the only issue.
Yeah, new petitioner.
Petitioner is the junior under the respondent. Both are working in the same office. They have built their physical relation.
Oh.
Due to a age issue, she cannot be pregnant. Therefore, they went to the Tamra IVF center, where the later stage it has been developed like this one.
ಆಯ್ತು, ಇದು ಸಪರೇಟ್ ಆಗಕ್ಕೆ
ಆಗು ಮಾಡ್ಬೋದು. ಇಲ್ಲ, ಸಪರೇಟ್ ಅನ್ನೋಕ್ಕಿಂತ ಮಾಲಾಡ್
ನೀವು you are who this
I am the respondent number 2 in criminal petition 3002 of 23. 3002 of 23.
You are this ಮಂಜುಳಾ ದೇವಿ.
Yes, please do.
ಎಲ್ಲಾದ್ರಲ್ಲೂ ನೀವೇ ಕಂಪ್ಲೇಂಟಾ?
ಇಲ್ಲ, ನಾನು ಒಂದರಲ್ಲಿ criminal petition 956 of 24, I am the complainant in that case. Sorry, I am the accused in that case. Adralli FIR, they have filed PCR. Based on that PCR complaint, FIR came to last. That is second FIR, Lordship. In the third line of the FIR, it is clearly stated that ಮುಂಚೆ ಒಂದು FIR ಮಹಿಳಾ ಪೊಲೀಸ್ ಸ್ಟೇಷನ್ ತುಮಕೂರಲ್ಲಿ ಪೆಂಡಿಂಗ್ ಇರಕರೆ ಈ FIR ರಿಜಿಸ್ಟರ್ ಆಗಿದೆ ಅಂತ ಅಲ್ಲಿ ಉಲ್ಲೇಖ ಇದೆ ಸರ್. So all are connected. That's the reason I'm stating that criminal petition 956 of 24 has to be tagged with this case.
ಆಯ್ತು, ಎಲ್ಲ ಒಟ್ಟಿಗೆ ಕೇಳೋಣ.
Maybe had separately.
One by one.
Separately ಅಲ್ಲ, clear ಆಗಿ mention ಇದೆ. Kindly.
It is my discretion to tag or not, sir.
Please do.
Lawyers shall not attach to notes.
All of you are advocates here. It is better we hear it separately. Separately ಅಂದ್ರೆ separate ದಿನ ಅಲ್ಲ, ಒಂದೇ ದಿನ separate ಆಗಿ ಕೇಳೋಣ ಬೇಕಾದ್ರೆ. ಅಂಡ್ ನೀವು ಅವ್ರ ನೇಮ್ ತಗೋಬೇಡಿ ಅಂದ್ರೆ ಎಲ್ಲಾರ ನೇಮು ಹೇಳ್ತಾನೆ ಇದ್ದೀರಾ. ಎಸ್, ಸೆನ್ಸಿಟಿವ್ ಮ್ಯಾಟರ್ ಸರ್. ಎಸ್, ವಿಲ್ I'll post it on 23rd.
Please.
List the matter on 23rd. De-tag them, post them in seriatim along with
Criminal petition 956 of 24.
so and so. Barkondra madam. So and so.
Interim order, my lords.
Interim order subsisting shall continue till the next date of hearing.
Very well.
ನೀವು ಅವ್ರನ್ನ ಎಂಗೇಜ್ ಮಾಡಿದ್ಮೇಲೆ ಸುಮ್ಮನೆ ಇರಿ. ಎಸ್. ಸೆಟಲ್ಮೆಂಟ್ ಇದೆಯಾ? ಟೈಮಿಂಗ್ಸ್ ಇದೆಯಾ ಯಾವ್ದಾರು ಮ್ಯಾಟ್ರ್? 3 o'clock, 4 o'clock, 4 PM ಯಾವುದೋ ಇದೆ, 3:30 ಯಾವುದೋ ಇದೆಯಲ್ಲ ಮೇಡಮ್? ಏನಾದ್ರು ಮೇಡಮ್? 2:30 ಆಫೀಸ್.
3:30 on NDPS.
Huh?
3:30 on NDPS.
ಅದೇ 3:30 ಒಂದಿದೆ ಅದಕ್ಕೆ. Call those timing matters. 7 ಇದೆಯಾ? ಸೆಟಲ್ಮೆಂಟ್ ಕರೆದ್ಬಿಡಿ, ಕರೆದ್ಬಿಟ್ಟ.
My lord, this for the settlement matrimonial case, the decree of divorce has been granted. A joint memo will be filed, my lord. Parties are present before the court.
498.
498.
Mediation agreement. Page 82. Clause 8 to 11. Yes.
Much.
Next. Signature ಮಾಡಕ್ಕೆ. ಇಲ್ವಾ? ಇಲ್ವಾ? ಆಯ್ತು ಸರಿ. ಇಲ್ಲ ಅಂದ್ರೆ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಹಾಕ್ಬಿಡಿ. ಇಫ್ ದೇ ಆರ್ ನಾಟ್ ದೇರ್ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಹಾಕಿ. ಫಸ್ಟ್ ಓವರ್ ಎಷ್ಟಿದೆ? ಪಾಸ್ ಓವರ್ ಮಾಡಿ. ಕೌನ್ಸಿಲ್ ಇರ್ಲಿಲ್ವಾ? ನೋಡಿ. ಇರ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಅಲ್ಲಿ ಸೆಟ್ಲ್ ಆಗಿದೆ ಬಿಡಿ. ನೆಕ್ಸ್ಟ್. ಅದೇ ಅದಕ್ಕೆ ಅದು ಕರೀರಿ, ಬರ್ತಿದ್ದೀನಿ, ಕಾಲ್ ಮಾಡಿ.
There is one more matter, my lord, which is required to be connected.
By the same petitioner, my lord, in criminal petition 8594 of 20.
Yes, Madhukar,
My lord, that is 52A non-compliance, my lord. Like same petitioner
ಇನ್ನೊಂದು
has
ನೆನ್ನೆ
filed one more
ಇತ್ತಲ್ಲ?
petition, ಹೌದು.
Yesterday there was one, I've granted stay in this. 52A non-compliance. Madam, ನೆನ್ನೆ lady ಯಾರೋ ಮಾಡಿದ್ರಲ್ಲ.
ಅದು ನಾಳೆಗೆ ಹಾಕೊಂಡಿದೆ.
ಅದು ನಾಳೆಗೆ ಹಾಕಿದ್ದೀನಿ. ಅಲ್ಲ, which is that matter? ನೆನ್ನೆ list ಕೊಡಿ. There is one more matter.
Yes.
We'll hear the two together.
Yes, there only one fact, one submission, my lord. In 2000.
Sampling is not before the magistrate.
Yes, my lord.
Yes.
Now the 2022, my lord. Of course, this particular case is prior to 2022, my lord. The rules have been notified, my lord. Exercising power under section 52A and 76 of NDPS Act. That rules explains, my lord, how it has to be disposed of, how the sampling has to be drawn and all those things, my lord. I will just place that particular
Call with this matter. ಅದು ಕೊಡಿ.
Yes.
Serial number 19 yesterday.
Yes. That particular rules, my lord.
52A.
52A. Now there is a rules. After Mohanlal, my lord. In Mohanlal, there was an observation. So appropriate notification has to be issued and it has been issued. But even today, these rules are not being followed. Or even it is not circulated also.
Yes, this we wanted to lay down some guidelines.
Yes, yes.
ಅದು ನಾಡಿದ್ದು ತಗೊಂತೇನೆ ಎರಡು ಸೇರಿ.
Yes.
We'll have
Yes.
both on Friday.
Yes.
Tag this petition along with so and so, list them both on Friday ಅಂತ.
My lord, there is one more criminal petition, my lord, 8594 of
ಅದು
22.
52 ನಾ?
By the same petitioner, ಇವ್ರದ್ದು ಇನ್ನೊಂದಿದೆ. By the
ಯಾವ್ದು
same
Madhukar?
petitioner has filed this. By the different advocate has filed. Different advocate.
Criminal petition?
8594 of 22.
8594 of,
22, my lord.
shall we tag that also?
Please, my lord, because.
Yes, Madhukar.
Yes, if it is relating to some other crime, may not be necessary, but if it is respect to the same crime by the same petitioner.
We'll post them in seriatim.
Please.
List this petition along with ನೆನ್ನೆ serial number 19, ಅದೊಂದು 898594 on Friday in the fresh matters list, not tagging but in seriatim. Entry order ಇದೆಯಾ ಇಲ್ಲಲ್ಲ?
We have not insisting
sought
for, because he is already in judicial custody. Will do.
Yes.
Petitioners, please.
Documents which are required to be filed, my lords, require a short accommodation.
My lords, already 2-3 times they have taken time. Please.
What is the issue?
My lords, this is a case, please, my lords, where a complaint comes to be filed after a lapse of about 7 years, please, my lords. The petitioner, please, my lords, is only.
7 years.
Please, my lords. My lords, the petitioner, please, my lords, is CEO of the accused 4 company, please, my lords. Accused 2 company, please, my lords. He is based out of US, please, my lords. My lords, first this, if I invite your lordship's attention to page number 1.
You are A4.
I'm A4, please.
What happened to A1, 2 and 3?
Please, my lords.
A1, 2 and 3 ಯಾರು?
A1, 2 and 3, please, my lords. 2 of them are the employees of DRDO. And A2 is the company, please, my lords.
Yes, how much more time you want?
Week, my lords, with next date of hearing.
Finally, next date. Otherwise, I'll grant an interim order stay.
Definitely, assess.
Heard so and so. The learned counsel Rahul Krishna Reddy seeks a week's time to produce certain documents. As a last chance, a week's time is granted. List the matter on 5th. In the event the respondent would not produce any documents as time is sought for, the order would be passed on the petition averments. Yes.
Grateful.
Yes, next. Yes, government. Rahul. Prashant, ನಿಮ್ಗೆ ಹೇಳಿದ್ದೆ. Senior is here today. Yes. No, in all the cases, 50% is released. I asked him to seek instructions whether withholding some amount, 40% can be, 40 or 50% can be released.
In this case, we have already paid more than 64%.
No, that is true. 536 crores ಇನ್ನು ಪೆಂಡಿಂಗ್ ಇದೆ ಅಂತಾರೆ. 250 crores ಇಟ್ಕೊಳ್ಳಿ, 250 crores ಕೊಡಿ.
Maybe one submission, only 2 submissions. Only they have in other cases comparison is.
Mike.
Compared to other cases. Compared to other cases, in this case, they have not submitted quality control certificates.
ಅದು ಕೊಟ್ಟಿದ್ದೀವಿ ಅಂತ ಹೇಳಿದ್ರಲ್ಲ.
We have not received.
No, I
That's the
produced
instruction.
it in annexure L and.
That is only for.
Last time I told you, what is the problem in giving another certificate, quality control certificate? Kashna
They
nimge.
have to issue certificate, madam. Their competent authority has to issue the certificate.
May this one point. Another is some rectification is done.
Certificate issued by.
Wait.
Another point, some rectification has been done. This is second point. Third point, some inquiry also been last year, some inquiries also pending.
No, that inquiry is not going to go any further. Yenu ಮಾಡ್ತಾ ಇಲ್ಲ ಅಲ್ಲಿ.
Therefore, my humble submission.
ಅದಕ್ಕೆ Advocate General in all the other cases has said 75% is paid and another 25% also will be paid is what he has said. Time is granted.
May make one submission. 75% in this case will come to Milord about 140 or 150 crores. Milord, that will come to 75% will come.
And that you pay now, that's all.
Not to me person order, not.
I'll pass an order, not on you, not on concession. The petitioner is before this court seeking the following prayer. The learned counsel for the respondent, Prashant BR, learned senior counsel, MRC Ravi, appearing for the petitioner, respondent Kaveri Niravari Nigam.
Sorry,
KBJNL would take this court through the statement of objections to contend that most of the bills of the petitioner are cleared. What remains even according to the second
Bill ಅವರೇ pay ಹೇಳ್ತಾರೆ. What is not paid ಅಂತ para 23.
Madam, the objections ಕೊಡಿ. One ನಿಮಿಷ, I'll get back to that. All cleared and what remains is for 536 crores. In all identical, the learned counsel for the petitioner submits that in all identical matters, where the matters have been referred to the committee, one-man committee of Justice H.N. Nagmohan Das, the bills are cleared to up to 75%. And 75%, which the learned Advocate General in identical matters has accepted such submissions. The learned senior counsel for the respondent submits that the 75% bill clearance would amount to another 156 or 160 crores to be paid to the petitioner. What is wanting from the hands of the petitioner, what is wanting in the case in favor of the petitioner is a quality control certificate to be issued by the petitioners. The learned counsel for the petitioner submits that quality control certificate is already issued by them, which is also appended to
Annexure M, page number 223.
Annexure M?
Page number 223.
Page 223. Date ಹೇಳಿ.
Date 25/8/2023.
223. Yeah. 25/8/2023. The learned senior counsel would clarify that this quality control certificate was issued only on RA7, the running account 7, which pertains to 47 crores and not the entire 536 crores. The learned counsel for the petitioner would seek to clarify that.
That is last bill, madam.
1 minute. Clarify that this is the last bill that was pending and it is for the said with the quality control being issued to this, all the bills are now quality control complaint and therefore would submit that the entire amount cannot be withheld and the amount will have to be released. This is disputed by the learned senior counsel by the petitioner contending that the petitioner has already been paid 69% of the total. Pending, sir?
What are the
Bills would submit that bills to the tune of 69% is paid and for package 1 there is still quality control certificate to be submitted by the petitioner. Therefore, to strike a balance between the right of the petitioner to get the amount and the right of the respondent to withhold the amount, I deem it appropriate to direct the respondent KBJNL to release 160 crores to release an amount of rupees 160 crores, which would come to a total of 75%, as is done in all the cases by the state where the contractor's bills are pending. pending further orders, the same shall be released within 4 weeks from the date of receipt of the copy of this order. Yes. ಅಷ್ಟು ತಗೊಳ್ಳಿ ಈಗ, ಮತ್ತೆ ಆಮೇಲೆ ಡೈರೆಕ್ಟ್ ಮಾಡೋಣ.
50% ಆಗಲ್ಲ, ಯಾಕಂದ್ರೆ 657 ಕೋಟಿ.
536 crores ಇರೋದು ಬಾಕಿ.
ಇಲ್ಲ 657 ಕೋಟಿ.
ಅವ್ರ ಬಿಲ್ ಅಲ್ಲೇ ಇದೆ 536 crores. ನಿಮ್ ಪ್ರಕಾರ ನೀವು ಕೇಳಿರೋದು ಅದು.
130 crores.
ಹಾ,
After receipt of the quality control.
ಹಂಗಾದ್ರೆ ಬರೋದೇ ಇಲ್ಲ ಅದು. ಅದಕ್ಕೇನೆ 300 ಕೋಟಿ ಇಟ್ಕೊಳಕ್ ಹೇಳ್ತಾ ಇರೋದು. Still 300 crores you have with you. It's 6 weeks. 8 weeks if not earlier. Yes.
630,
ಇನ್ ಮಿಕ್ಕಿದ್ ಆಮೇಲೆ ಮಾಡುವ. ಫಸ್ಟ್ ಇದು ತಗೊಳ್ಳಿ. You have taken 69%. This will amount to 80%.
69% 1,008 crores ಅಲ್ಲಿ.
ಹೌದು ಸರ್, ಅದರಲ್ಲೇ 69% ಕೊಟ್ಟಿದ್ದಾರೆ.
ಅದ್ರಲ್ಲಿ ಕೊಟ್ಟಿದ್ದಾರೆ. ಈಗ ಬಿಲ್ ಡ್ಯೂ ಇರೋದ್ರಲ್ಲೇನೆ 536 undisputed
536 ಪೆಂಡಿಂಗ್ ಇದೆ ಗೊತ್ತು.
ಅಲ್ಲ, ಟೋಟಲ್ 657
Now you take this 160 crores. I have quoted the figure also. The rest of the things we will release later.
75% ಆಗಲ್ಲ ಅಂತ.
75% ಅದರದಲ್ಲ, ಟೋಟಲ್ ಅಮೌಂಟ್. ಟೋಟಲ್ ಅಮೌಂಟ್ 75% ಆಗದದು. Yes.
650.
Next.
Lord's permission, with my Lord's permission, may.
One minute. 75% is not of 650 crores that you have claimed. 75% is what the total claim was and what the others have been granted to be given, directed to be given in other cases. Remaining will direct. Ella onde sari yake. Yes.
With my Lord's permission, may I mention serial number 92? The display board was not refreshed.
I am not
serial
rising
number
for the. I am not rising for the day. Wait, madam.
Okay, yes.
Yes.
Petitioners. The petitioners are accused before the trial court, accused number 2 and 3 before the trial court. Kindly see the allegation, my lord. There is a case and counter case between the complainant and the accused number 1.
Charge sheet challenge ಮಾಡಿದೀರಾ?
Please, charge sheet. Kindly see page number 23, my lord.
Allegation ಏನು?
Allegation column number
Counter
7.
case ಯಾವುದು?
Counter case, there is a case between the accused number 1 and the complaint, not between us. The fighting between that day on 5/6/2022, my lord, the fighting between the complainant and the accused number 1. The allegation is, my lord, the accused number 2 and 3 is not to intervene the incident. Column number 7 of the charge sheet, my lord. Charge sheet is page number 28.
I am there only.
Page number 23, annexure D.
First time ಬರ್ತಾ ಇರೋದಾ ಇದು?
The last time when there is an objections.
List on Monday in the fresh matters list. Yes, next.
$420 read with 34 of IPC.
Enter material ಎಲ್ಲ ಹೇಳಿ madam. ಇಲ್ವಾ? Charge sheet material and the role of the petitioner.
Please, madam.
ತರಿಸಿದ್ದೀರಾ? Tuesday in the fresh matters list. Yes. Next.
For petition. 447 and 34.
Respondent ಇದ್ದಾರೆ ಚಂದ್ರಹಾಸ. ನೀವೇನಾ? You are in possession. Suit is pending.
RFA is pending.
RFA is pending. Decree is in your favor.
Injunction, suit for injunction came to be dismissed. I filed our RFA, which is pending.
Who is in possession?
I am in possession. NTI Society, Housing Society.
NTI Society. I will hear it.
Charge sheet is filed, my lord.
17/4 ಗೆ
There's a crime
interim order.
Charge sheet file ಆಗಿದೆಯಾ?
Crime, yes, charge sheet is
Interim
filed.
order.
Amend it.
Interim order ಇತ್ತು.
ಅರೆ amend ಮಾಡಿ ಅದಕ್ಕೇನಂತೆ?
Okay, please.
The learned HCGP on instructions would submit charge sheet is filed. In the light of the interim order subsisting in the case at hand, I grant leave to the counsel for the petitioner to amend the petition by raising a challenge to the charge sheet. List the matter after 2 weeks. Interim order subsisting shall continue till the next date of hearing. Yes.
For petition, SCS. 19/6, a detail order has been passed.
19/6. ಇವತ್ತು ಇಲ್ಲ. Government.
In this also, my lord, charge sheet is filed.
ಇದ್ರಲ್ಲಿ ಎಂಟ್ರಿ ಮಾಡಿದ್ಯಾ? ಸೇಮ್ ಮಾಡಿ. 2 weeks ಅದು ಸೇಮ್ ಡೇಟ್ ಕೊಡಿ ಮೇಡಮ್. ಅದು ಯಾವತ್ತಿತ್ತು? We'll take it on 25th ಎಲ್ಲ. Please 25th. Yes. Entry order subsisting shall continue till the next date. ಅಲ್ಲಿ ಬರ್ಕೊಳ್ಳಿ. This court had passed the following order on 19/6. Even today there is no representation by the respondent. The learned HCGP would now submit that charge sheet is filed before the concerned court. In the light of the interim order subsisting, the petitioner is at liberty to file an liberty to challenge the charge sheet by way of an amendment. Interim order ಇಲ್ಲ ಅಂದಿದ್ರೆ fresh petition ಹಾಕಕ್ಕೆ ಹೇಳ್ತಾ ಇದ್ದೆ. Yes. What is this?
Rejection of the B report, my lords, and taking of cognizance. And
Ravi Kumar.
no, my lords, I'm not on that ground now. I'm on the merits of the matter, my lords. It is of a case which is of civil in nature, my lords.
ಇಲ್ವಲ್ಲ. No representation on behalf of the respondent. Awaiting his appearance list on 9th ಅಲ್ಲ 10th July. Interim order subsisting shall continue till the next date of hearing. Same 10th July. ಇದೀರಾ ಬನ್ನಿ.
The last date of hearing also, respondent number 2 counsel was not present. Breach of promise of marriage.
Madam is appearing.
Madam is not appearing.
Respondent 2 ಗೆ. Yes.
376, 420, 417, 109 read with the 34 IPC. Madam.
ಎಷ್ಟು ವರ್ಷ?
The petitioner number 1.
ಅರೆ ಎಷ್ಟು ವರ್ಷ ಅಂದ್ರೆ petition number 1 ಏಜ್ ಅಲ್ಲ. ರಿಲೇಶನ್ಶಿಪ್ ಎಷ್ಟು ವರ್ಷ?
More than 1 year, my lord.
ಒಂದೇ ವರ್ಷನಾ? ಹಾಗಾದ್ರೆ ಕಷ್ಟ. Yes.
And the respondent 2 now already married, my lord.
Already married?
Yes, yes.
You are also married?
Not yet, not yet.
Not yet. Yes, government.
Concession.
Huh?
Concession.
Concession. ಒಂದು ವರ್ಷನಾ?
The petitioner has got acquainted with the respondent 2 on 9/12/2021, my lord. To Instagram.
Instagram?
Yes.
Huh.
Then, my lord, engagement ceremony was performed on 12/5/2022, my lord. Then it is alleged that
Engagement with the same girl?
Yes, my lord.
Engagement ಆಯ್ತಾ?
Yes, yes.
But promise of marriage ಎಲ್ಲಿ ಬರುತ್ತೆ? Breach of promise of marriage ಎಲ್ಲ ಆಯ್ತು. Why did the engagement break? ಏನು?
There is some
Why are you stoic silence?
there is some dispute arose between the petition number 1 and the respondent number 2, my lord.
ಆಯ್ತು, ಏನ್ dispute?
Yes.
So why are you silent, sir? ಹೇಳಕ್ ಆಗಲ್ವಾ? ಅಲ್ಲ ಎಲ್ಲಿದೆ ಹೇಳಿ.
ಅಲ್ಲ, dispute ಅಂದ್ರೆ the petition number 1 has suspected the
ಆಯ್ತಾಯ್ತು ಸರ್.
extramarital affairs. Respondent 2, my lord.
Of the complainant,
Of the complainant.
Yes.
Then complaint filed on 31/7/2022, my lord.
Yes.
My lord, in this matter, it was heard, my lord, for some time and was adjourned. Respondent number 2 was present.
Present?
They were there, my lord, on the last occasion.
For close to 3 years ಅಂತ ಹೇಳಿದ್ದೀರಾ?
Not close to 3 years, my lord.
Yes, my lord.
Got acquainted on 9/12/2021.
List on Wednesday.
And petition number 2 and 3 are the parents.
In the fresh matters list, yes. Thursday. Yes.
lords, appearing
To the
for
remote matter.
petitioner, my lords. 2 weeks time maybe.
Why Mohan Kumar?
Senior is unwell.
बताए surgery.
Spondylosis.
Spondylitis. What's the matter?
It's advocate cheating, my lords. Advocate had made a
Petitioner is an
notice.
advocate.
Yes, my lords. Legal notice ಕೊಟ್ಟಿದ್ದಕ್ಕೆ ನಮ್ಮ ಮೇಲೆ complaint ಕೊಟ್ಟಿದ್ದಾರೆ. We also filed written arguments.
Senior ಬರ್ಲಾ? Spondylitis ಕಮ್ಮಿ ಆಗ್ಲಿ. At the request of the learned counsel appearing for the petitioner, list the matter on 24th. Interim order subsisting shall continue till the next date of hearing.
Got a short matter, my lord. 498, 306 is the charge sheet.
306 also.
306 also there, my lord.
Wife dies.
Lord, the marriage, my lord, was of 2002. My lord, she committed suicide, my lord, in 2017 after 15 years of marriage. My lord, she lived for 15 years. A daughter was there, my lord. My lord, 6 months prior to the date of committing suicide, my lord, because of some difference, my lord, she went to her parents' house. 6 months, my lord, she lived there. My lord, then, my lord, the elders intervened. My lord, they advised her to join the family of husband. She came to husband's house, my lord, on 29th. My lord, 30th, my lord, she went back to bring all her belongings. 30th, my lord, evening, my lord, husband, daughter, and this deceased wife, my lord, they had been to movie. My lord, they returned back. They were well off. My lord, my lord, 1st October, it was a Sunday. These accused, my lord, they had gone out to see a flat, a new flat, my lord, to purchase. Well, she was alone. This daughter, my lord, had gone down, my lord, to play. When she was alone, my lord, she had hanged herself. My lord, here, she has left a death note. The death note, my lord, clearly that she is continuously under depression, that I am not in a position to live hereafter. I don't want to give trouble to anyone. I want to quit my life, my lord. That is, my lord, she has put a death note, my lord, in Hindi. My lord, she had not blamed anyone in the death note. She did not implicate any allegation of cruelty, anything. Your lordship gets, my lord, death note at page 174, your lordship. The translated copy, your lordship gets at page 177. Lord, मैं बहुत डिप्रेशन में हूँ, बहुत कोशिश की खुश रहने की.
174.
174 में लॉर्ड, 177
मैं बहुत डिप्रेशन में हूँ, बहुत कोशिश की
खुश रहने की, मन पर मेरा कंट्रोल नहीं है. मैं
आप सभी को दुखी नहीं करना चाहती. Yes.
इसलिए मैं जा रही हूँ. This is, my lord, that this was the death note. My lord, this is got verified during investigation. Her sample handwriting, my lord, S1, S2 was compared. My lord, it is the authorship, my lord, is proved that it is the deceased. Now, my lord, in the charge sheet, my lord, during investigation, the allegation, my lord, that father, brother statement is recorded, stating, my lord, that after the birth of first child, my lord, that was in the year 2005, my lord, the husband was insisting, my lord, these accused were insisting her to undergo further treatment under IVF method to create a male baby. My lord, this was the allegation, my lord, that except this allegation, my lord, this was in the year 2005, my lord, after 2005. But thereafter, my lord, for more than 10 years, she lived it in the house of the accused. My lord, in between, my lord, she suffered, her health was affected, she could not live at all. There were differences, my lord, in between them. My lord advised that she should live in her parents' house for some time so that she can console herself. My lord, this was the understanding. She was sent to her parents' house. She lived, my lord, for 6 months. Came only one day before. My lord, there is no act of proximity to abet her to commit suicide. In the absence of proximate act to abet her to commit suicide, section 306, my lord, do not apply. Now, my lord, umpteen number of decisions, my lord, your lordship has
rendered and Supreme Court also recently. Well, it is not a case of either dowry demand, harassment for dowry. Well, both the families are well off. Well, there is no instance of any specific allegation of cruelty being caused to that woman. And that lady herself has put it in writing in the death note. Well, she was the best, my lord, to put any allegation against the husband or in-laws. And particularly, my lord, that the in-laws, my lord, that mother-in-law and father-in-law, they are age old. Well, no specific allegation against them. Well, they have been roped, my lord. This is matter, my lord, she committed suicide in 2017. Now, this matter is pending since 7 to 8 years. This court is, my lord, is pending huge pendency, not even a position to go for trial also. There is portal number 46, my lord, in City Civil Court. These kind of cases, my lord, are ripe so much, my lord, it takes another 5 years. My lord, the circumstance of the case, my lord, it is totally a case initiated, my lord, only for oppression and harassment of these petitioners. Genuinely, my lord, it is a case where the deceased was under depression, and my lord, she ended her life. My lord, for such an act, my lord, either the act of abetment to commit suicide or cruelty also under 498 do not attract. My lord, I stress more in respect of this mother-in-law and father-in-law. They are age old, my lord, 70 years, 75. One is suffering from blood cancer.
Interim order is there?
Interim order, my lord, that 3-4 occasions, my lord, it had come before your lordship.
No, today I'm deciding it. Don't have to worry. No adjournment, we'll decide it.
Well, this, my lord, except this allegation, my lord, that she was insisted and troubled to undergo for IVF treatment for the male baby. And this is the allegation, my lord, that was of a old one, allegation of 2005 or 2006 it was. Well, the daughter's statement was also recorded under 164. That my father was very strict to my mother. Except this word, my lord, there is no allegation. Particularly on the date of incident, my lord, they were happy that this lady had returned back to the family. They went, my lord, that we have the photographs. They went to buy a new flat for them so that they can be kept separately. My lord, when they were away from the house, my lord, she closed the door and committed suicide.
Page 77 of their petition.
Ready?
Please, page 77 of their petition.
Yes.
Hazard and seizure, your lordship may kindly see.
77 is some witness state. Page. Mazar and L.
On the top, your lordship, para 18, column 18.
One minute, madam.
This is how they've served us.
Lordships, in the list of witnesses, your lordships, CW 18.
Madam.
Witnesses.
Page 77.
Charge sheet. Page number.
Page 77. List of witnesses, yes.
List of witnesses, Panchanama.
18, your lordship may kindly see.
Column 18.
Please, on the right hand side.
25/11/2017.
Yes.
Lordship may kindly see what they state is that the father has handed over the death note and the diary written by her. One is the father-in-law has handed over the death note. Father is not going to go and hand over a death note. And the father has given the diary what she has written. That conveniently doesn't find its way anywhere in the charge sheet, which I'm also producing the She writes only in English, your lordship. Her thoughts, her whatever she's penned down her torture that she's endured for all of these years. She's penned it down only in English. Thought processes in English. This question of writing in Hindi, that to a death note, would not arise. This conveniently doesn't find its way at all, despite the fact that there is a mention of it over here. So your lordship may kindly
Now,
see.
two things. ಬರೆದ ಬರವಣಿಗೆಯ 2 ಚೀಟಿಗಳು ಹಾಗೂ ನೋಟ್ಬುಕ್ ಅನ್ನು ಹಾಜರುಪಡಿಸಿದ್ದು ಇವುಗಳು ಅಮಾನತು ಪಡಿಸಿಕೊಳ್ಳುವಾಗ ಪಂಚರ್ ಆಗಿ ವೇರ್ ಇಸ್ ದಿಸ್ ನಾಟ್ ದೇರ್ ಎಟ್ ಆಲ್?
It is not there, your lordship, which I have produced before your lordship may kindly see.
These are all sample writings.
No, sample writing. Your lordship may kindly see.
Produce the father of
one more sample we shall produce at page 13.
That's her handwriting.
This is her handwriting, not just her handwriting. The entire torture she has endured is all written down in all of these pages up to page 32. And it unfortunately does not continue after that because she was killed. There would probably be a requirement, Your Lordship, that an additional charge should be framed. Reason being, Your Lordship, what has transpired is the CCTV cameras, what the footage they've got, also the police does not take it. That also we want to produce, where the parents are very much there at the time that she dies. They call her parents and her brother saying, something's wrong, come immediately. They rush there. They have to bring her down from the bed. And Your Lordship, post-mortem report, I'll show Your Lordship. It says physical assault. Then it says, of course, the language is faulty. Then they say due to hanging, but then there is blood also. Your Lordship, the blood is at certain places, which even if as a result of hanging, it could not have dropped in all of those places. Parents immediately ask, why didn't you take her immediately to the hospital? They say, we did not want to do anything. We wanted you to come. They immediately rush her there. Post-mortem report is also not very clear, doesn't give him a go-by. Now he's trying to state that this is the forensic report. Since there is no mention of anybody, therefore give me a clean chit. Your Lordship, even assuming the worst case scenario that Hindi writing was hers, it is not. And even if they assume that it is hers, Your Lordship, this was done much prior, long ago by her mother-in-law under duress. She would follow no matter what instructions were given, she would pen them down. This was all planned entirely. The CCTV footage show them in that particular room, and they get out a little later. There are frantic movements around as to what they have to do. Lot of things have even been eliminated and Your Lordship, wiped out. Therefore, Your Lordship, this is a matter for trial. And his daughter, Your Lordship, he's not taken care of her one single day after that. He got remarried, and then they have a divorce. He gives her 1.25 crores just to silence her. And that lady, her divorce
What
petition.
divorce? Whose divorce?
His second marriage, he gets remarried, and then there is a divorce. He pays her 1.25 crores so that nothing else comes out of it. And therefore, that also I have filed in, Your Lordship. Child has not been paid a penny till date, even for her education. The grandfather is even till date taking care. So for them at this point of time to say that this would not require a trial, Your Lordship, that would not. Your Lordship may kindly see the post-mortem report, which is at page 168 of the petition. Death is due to as physical assault of hanging, however.
That's my lord, this typing error, Your Lordship. Kindly see original postmortem at page 164.
One?
Typing error, my lord.
1 minute, sir.
Yes, page 164. Death is due to asphyxia, result of hanging. However, blood and viscera sent for chemical analysis. Our typist, my lord, yes. Then a blunder. That's astonishing it was.
Allah, it is your translation.
Yes, my lord. It's not a correct typing. I also saw that it is like that. Originally, it is, my lord, that death is due to asphyxia as the result of hanging. However, blood and viscera sent for chemical assault and the
We'll see. We'll go by the original.
It is not just the what she's endured, Your Lordship. She's been made to go through 7 IVFs. The first IVF after she conceived, it was a girl. They said, we want a boy, and they insisted. She went through the most painful processes of 6 more IVF treatments. Finally, the doctor had to say she will die if you ask her to go through even one more. And then the doctor
Where have you said all that?
All of that is in her diary. And the police have conveniently not produced that, despite that having a mention there. That is why I pointed that out to Your Lordship. Lordship, even series of judgments, Your Lordship, may I produce. It's very clear that this would be a matter of trial. And even assuming that, even if they have to assume that handwriting and that he's given a go-by with respect to her statement, Your Lordship, that itself cannot give him a clean sheet. Lordship, page 3, paragraph 7. There's a prima facie case on
Paragraph Sakidira.
Chief, Your Lordship.
Where? Ask him to indicate the paragraphs and give.
We shall mark it.
No, it is his job. He should do it.
I have.
Yes.
No, sometimes they don't know whether when they hand out, they can mark it or not.
No, please do it. I don't mind at all. It makes my job easier. Gone are those days where you marked the judgment and given.
And
yet gets influenced by that. No.
So that's why they're a little doubtful.
All different judiciary. Man.
Might I pass this on, Your Lordship? This is
Please.
marked.
Whatever is marked, you can give. ನೀವು ಏನ್ ಬೇಕಾದ್ರೆ mark ಮಾಡ್ಕೊಡ್ಬೋದು sir. ತೊಂದ್ರೆ ಇಲ್ಲ.
I know, my lord, your lordship is very liberal. But earlier days, my lord, they used to
Earlier
push-
days, you marked this. I have also faced, sir.
Yes, yes.
You have highlighted and given, so it is
Who are
influenced.
to undermine my mind, and that's all because.
It makes our job easier, sir.
Page 3.
What we have to write, we will write. Yes.
Para 7, page 3. Whether a pregnancy case under 30234 is made out or not is the point of consideration in this case. No doubt it's recorded in the postmortem report that the cause of hanging.
Adaralli, you are Gautam, right? What's your name? Gautam, mark the paragraphs of what madam is reading. No, in that only you mark and give. No, mark in the sense, don't have to highlight. You just mention the paragraph numbers in the beginning and give
Talk
it.
of the each.
That's all.
That should be.
Sir, name the object.
Your lordship may kindly see, today, my lord, the documents along with objections written produced, my lord, said to be of her is not the part of charge sheet.
Not a part of the charge
Not
sheet.
the
That's
part
what,
of charge sheet, my
that
lord,
is the
unless-
allegation.
Lord, this is, my lord, your lordship may kindly see, not signed by anyone. Not signed, it is not signed by deceased.
Correct. This should have
No
also.
one is signed, it is.
forensic
My lord,
analysis
this
on-
authenticity, my lord, is not examined at all, not verified. This kind of document, my lord, unsigned letter, my lord, that said to be of deceased, my lord, how to, my lord, believe this kind of. My lord, they had ample opportunity, my lord, during investigation. My lord, they were monitoring the investigation. This document was not present.
Did you give this
They have not
document to the
checked-
investigating officer?
That is why mentioned saying her diary, your lordship. That is why.
Oh, this does not find charge sheet.
Correct.
This is the diary.
This is the diary.
My lord, this diary was not produced before the investigation officer.
Then
Aಲ್ಲ, ಇದು
My lord,
what is that column number 18 ಅಲ್ಲಿ the seizure
not that your lordship, that has been subject.
notebook ಅಂತ ಇದೆಯಲ್ಲ.
ಇಲ್ಲ, this is
ನೋಡಿ.
your lordship, kindly see, my lord, page.
ಅಲ್ಲ notebook ಅಂತ ಇದೆ.
77.
Notebook is, my lord, is specimen writing that has been sent to FSL for comparison.
Which notebook
This
is,
is not any
notebook is sent for
it is not
special?
this notebook, your lordship.
Secure my instruction.
My lord, ಫಿರ್ಯಾದಿದಾರರಾದ ಮೋಹನ್ ರಾಲ್ ಭಂಡಾರಿ ತನ್ನ ಮಗಳಾದ ಭೂಮಿಕಾ ಬೋರ್ ಅವರು ಬರೆದ ಬರವಣಿಗೆ 2 ಚೀಟಿಗಳು.
ಎರಡು ಚೀಟಿ.
ಹೌದು.
That is Hindi.
Yes, very those cheaties. These are all
Notebook.
S1, S2, my lord, those are all, my lord, compared and now opinion is
No.
given.
Notebook is already there.
Notebook also, your lordship may kindly see here, the expert's opinion, my lord, is those are all S1, S2.
Your lordship, first of all, the father will not go and give the death note. Therefore.
That we'll see.
Question of death note was taken to custody by the police officer in the presence of daughter, that is CW 11
What
Magni.
stage is the trial at now?
Not even is ripe for hearing before charge also, your lordship.
No,
Third,
there's no interim order here, right?
interim order is
There
there.
is-
Interim order is
Stay
there?
order is there.
Stays there.
Look, this is a case, my lord, that in respect of
My interim
mother-in-law and
order.
father-in-law, there is no material. And
Not
my
your
lord,
lordship,
one
not-
statement, my lord, that, my lord, one statement, your lordship, of a security guard who opened the door. Lordship may kindly see, it's a part of charge sheet. My lord, it is not that, my lord, no material is there in this case. Kindly go to page 129, my lord. Page 129, your lordship. Lord, if allegation is there, if death note is not there, they are not disputing. It is the police, my lord, who collected this death note. It is now verified. Handwriting expert has found it. It is belong to deceased. They say that it is concocted. How can that? In my lord, complainant, everyone, it is concocted. Now, what is the document now they have produced, my lord? It is not investigated by the investigation officer, not signed by anyone. Well, such kind of unconnected document is now try to be introduced here, my lord, before this court for the first time. Well, there is no opportunity for the police to verify this. Now, kindly see, my lord, page 129, my lord.
129.
129, my lord, this was a flat, my lord, an apartment where he was appointed as a security guard. My lord, his conduct, your lordship may kindly see.
Suresh.
My lord, ನಾನು ಈ ವಿಳಾಸದಲ್ಲಿ ಕಳೆದ 5 ವರ್ಷಗಳಿಂದ ಸೆಕ್ಯೂರಿಟಿ ಗಾರ್ಡ್ ಆಗಿ ಕೆಲಸ ಮಾಡಿಕೊಂಡು ಸ್ವಂತ ಊರು ನೇಪಾಳದಲ್ಲಾಗಿದ್ದು ಕಳೆದ 5 ವರ್ಷ ಹಿಂದೆ ಹೆಂಡತಿ ಕರೆದುಕೊಂಡು ಬಂದು ಇದೇ ಅಪಾರ್ಟ್ಮೆಂಟ್ ಅಲ್ಲಿ ನನಗೆ ಇದ್ದುಕೊಳ್ಳಲು ಒಂದು ಮನೆಯನ್ನು ನೀಡಿರುತ್ತಾರೆ. ನೆಕ್ಸ್ಟ್ ಪ್ಯಾರಾಮಿಲಾಟ್ ದಿನಾಂಕ 1/10 ಆನ್ ದಿ ಡೇಟ್ 1/10/17 ಸಂಜೆ 4:15 ಗಂಟೆಯಲ್ಲಿ ಊಟ ಮಾಡಿ ಸದರಿ ಅಪಾರ್ಟ್ಮೆಂಟ್ನ ಬೇಸ್ಮೆಂಟ್ನಲ್ಲಿ ಇರುವಾಗ ನಮ್ಮ ರೂಮ್ನಲ್ಲಿ ಇರುವಾಗ ಹೊರಗಿನಿಂದ ಕೂಗಾಟ ಕೇಳಿಸಿತು. ನಾನು ಕೂಡಲೇ ಹೊರಗೆ ಬಂದು ನೋಡಿದಾಗ ಹಲವಾರು ಜನರು ಅಪಾರ್ಟ್ಮೆಂಟ್ನ ಹೊರಗೆ ನಿಂತುಕೊಂಡಿದ್ದರು. ಸದರಿ ಅಪಾರ್ಟ್ಮೆಂಟ್ ಪಕ್ಕದ ಸ್ಟೇರ್ ಕೇಸ್ ಹತ್ತಿರ ಹುಡುಗಿ ಜೋರಾಗಿ ಅಳುತ್ತಿದ್ದಳು. ನಾನು ಹೊರಗೆ ಹೋಗಿ ನೋಡಿದ್ದು 1ನೇ ಮಹಡಿಯಲ್ಲಿ ವಾಸವಿದ್ದ ಧೀರಜ್ ಬೋರಾರವರು ಕಬ್ಬಿಣದ ಆಂಗಲ್ ಮೇಲೆ ನಿಂತುಕೊಂಡು ಮನೆಯ ಬೆಡ್ರೂಮ್ನ ಕಿಟಕಿ ಡೋರ್ ಕಡೆಗೆ ನೋಡಿಕೊಂಡು ಅಳುತ್ತಿದ್ದರು. ಏನಾಯ್ತು ಎಂದು ಕೇಳಿದಕ್ಕೆ ತನ್ನ ಹೆಂಡತಿ ನೇಣು ಹಾಕಿಕೊಂಡಿದ್ದಾಳೆಂದು ಹೇಳಿದನು. ನಾನು ನಿಧಾನವಾಗಿ ಮೇಲಿನಿಂದ ಕೆಳಗೆ ಇಳಿದುಕೊಂಡು ಆಗ ಬಿಲ್ಡಿಂಗ್ನ ಮಾಲೀಕರಾದ ಶ್ರೀ ನರೇಂದ್ರ ಜೈನ್ ರವರು ನನ್ನನ್ನು ಕರೆದು, ಧೀರಜ್ ಮನೆಯ ಮುಂದಿನ ಬಾಗಿಲು ಒಳಗಿನಿಂದ ಬಾಗಿಲು ಹಾಕಿಕೊಂಡಿರುತ್ತಾರೆ, ಬಾಗಿಲು ತೆಗೆಯಲು ಕೀ ಇಲ್ಲ, ಒಂದು ಕೆಲಸ ಮಾಡು, ಹೊರಗಿನಿಂದ ಅವರ ಮನೆಯ ಬಾಲ್ಕನಿಗೆ ಹತ್ತಿ ಹೋಗಿ ಹಿಂದಿನ ಬಾಗಿಲನ್ನು ಓಪನ್ ಮಾಡಿ ನೋಡುವಂತೆ ಹೇಳಿದರು. ನಾನು ಅಪಾರ್ಟ್ಮೆಂಟ್ ಮುಂದಿನ ಗೇಟ್ನ ಧೀರಜ್ ಮನೆಯ ಬಾಲ್ಕನಿ ಕಡೆ ಇದ್ದ ಕಬ್ಬಿಣದ ಕಂಬಿಗಳ ಮೂಲಕ ಬಾಲ್ಕನಿಗೆ ಹೋಗಿ ಬಾಗಿಲು ಹ್ಯಾಂಡಲ್ ಅನ್ನು ತಿರುವು ನೋಡಿದಾಗ ಬಾಗಿಲು ಓಪನ್ ಆಯಿತು. ಆಗ ಶ್ರೀ ನರೇಂದ್ರ ಜೈನ್ ರವರಿಗೆ ಬಾಗಿಲು ಓಪನ್ ಆಯಿತು ಎಂದು ಹೇಳಿದಕ್ಕೆ ಅವರು ಹಾಗೆಯೇ ಸದರಿ ಬಾಗಿಲು ಮೂಲಕ ಒಳಗೆ ಹೋಗಿ ಮುಂದಿನ ಡೋರ್ ಓಪನ್ ಮಾಡುವಂತೆ ಹೇಳಿದ್ದರು. ನಾನು ಸದರಿ ಬಾಗಿಲನ್ನು ಹೋದಾಗ ಮನೆಯ ಮಧ್ಯದ ಬೆಡ್ರೂಮ್ನ ಬಾಗಿಲು ಓಪನ್ ಇತ್ತು. ಒಬ್ಬ ಹೆಂಗಸು ರೂಮ್ನ ಫ್ಯಾನ್ಗೆ ತುಪ್ಪಟದಿಂದ ನೇಣು ಹಾಕಿಕೊಂಡಿದ್ದು ಮುಖ ಕಾಣಿಸುತ್ತಿರಲಿಲ್ಲ. ನನಗೆ ಗಾಬರಿಯಾಗಿ ಮನೆಯ ಡೋರನ್ನು ನೋಡಲಾಗಿ ಸೆಂಟ್ರಲ್ ಆಗಿತ್ತು. ಲಾಕು ಹೊಡೆದಿದ್ದನು. ಆಗ ಅಲ್ಲಿದ್ದ ಎಲ್ಲರೂ
Which apartment is this? Andre, whose house was this?
Accused house, my lord.
Accused house.
My lord, she came only previous day. My lord, she was there for 6 months in her house. That is their case, my lord, in the complaint itself.
No, for six
6 months she was in her parents' house.
Prior to 6 months, she was in this house only.
Prior to 6 months, she was in that house only.
This security says 5 years in the Kalsa Matadane. Doesn't recognize that lady?
My lord,
Doesn't recognize that lady who was hanging 5 years that is working.
no, not.
So he says, Yavdo hengsu, ನೇಣಾಕೊಂಡಿದ್ದಾರೆ ಅಂತ ಹೇಳ್ತಾರೆ.
Appreciate what the contest is.
No, the problem is
That
he
it's not that way.
glorifies the man
No, not.
and
No.
tells about this lady he doesn't know at all.
Not to understand in that manner. You
So what else?
Illa, when he went through the window, one woman was hanging, was able to be seen. Well,
No,
it was
he's-
from the back portion.
1 minute. He says on the railing, he sees this husband weeping
Yes.
and he says the lock is not there. So you come from that side. When he asks, so he recognizes the husband completely. When he comes and sees inside, he sees some body hanging. He doesn't know who it is.
Only that much was
So
visible.
doesn't know who it is.
No, not visible. Well, only
And he
back
says
portion.
he is for the last 5 years he is working there.
These are all the statements, my lord. The language
this
of
is-
police, they prepare it. But it cannot be outrightly said that that she was killed. My lord, FIR was
We'll
that
see.
as if it is.
No, not based upon these witnesses either who are postpaid or prepaid.
Submission, my lord, here, Lakshmi kindly,
Hmm.
my lord, upon reading the charge sheet material,
That will see,
Well, not
not
yet.
this witness. This other,
what I want to show from this witness statement, my lord, at the time when the deceased hanged herself in her room, she closed the door from inside, the main door.
true, no
These
problem.
accused had no access at all. They were away. They came. In fact, the daughter also was not there at home. She was also, my lord, crying when these persons they came. My lord, by then, my lord, she alone in the home, she committed suicide. There is no question of cruelty or anything in this
That
case, my
we'll
lord,
consider,
that
we'll consider.
if there is no proximity of causing cruelty, my lord, she
107
has
will not be proved.
107 will not be proved, and our death note is consonant with the facts and circumstances observed. My lord, on the basis of material collected itself, my lord, some allegation they make it because they say that they are all blood relatives. Not even a single neighbor has supported that this lady was subjected for cruelty. And there is no specific allegation against mother-in-law and father-in-law. They are age of 65 and 70 years. And my lord, this accused number 1, my lord, he married it and lived for 15 years. And she was under depression. Last date of hearing is submitted. She used to go for meditation in some spiritual institution. And my lord, today they are inserting, my lord, this was not known at all. This letter, my lord, that now this requires further investigation. Now this, it has to hang for.
That's what
ever
she's
and all these
asking.
things. My lord, if it is.
That's what madam is asking.
My lord, it is not the question of further investigation. My lord, first they have to prove that this is written by deceased. My lord, there nothing prevented them, my lord, producing this before the investigation officer. Well, it is they who lodged it. There is no allegation here challenging, my lord, the final report filed by the police. So far, they have not.
Further
done-
investigation is not done, 173.
My lord, nothing, no, they have accepted the final report. Everything, my lord, was ready, settlement was made. My lord, 2.5 crore to be amount to be paid to the daughter. We have drafted the compromise petition, everything was ready. All jewels, everything should be returned to them. This was the understanding. Someone instigated, now they have come that with this story and all.
Now you have paid the amount to the daughter?
We are ready to pay, my lord. We are ready to pay. That is what it is. We are not, my lord, bargaining anything. Daughter's share, my lord, whatever of deceased, my lord, and daughter's share from the family, my lord, they are ready to.
So now you will pay.
They are, even now, my lord, even now, they are ready to take back her.
Take
And
back whom?
That girl, my lord, the daughter.
Daughter.
Yes.
After she's
She is
attained,
CW 13, my lord, now she is 19 years. My lord, if she is not willing, now she has attained majority. If she is not willing, my lord, we are not forcing it. But my lord, petitioners are ready to contribute for her marriage, for her education. My lord, they have lot of affection towards her. She was the only child in the home. My lord, this is a case where, my lord, they are ready to contribute whatever for her. They have, my lord, they have not, my lord, they agreed everything, all elders intervened, settled the matter, but settlement memo to be filed at this stage, this development. Now this has come that, how to know that this is movement? This bardiರೋ one signature illa, one initial illa.
Your lordship,
No, this is now that she has written detailed written. Now what should happen to this authenticated and verified handwriting expert has confirmed that it is the handwriting in her. Now oral say of somebody to say that it is not the disease. Well, the comparative material, your lordship may kindly see what material is there. Well, kindly see.
We'll send this also to the FSL.
Well,
We'll send this also to the FSL, keeping this petition pending.
your lordship,
Anyway, interim order is there.
well, interim order is there, my lord, that let that letter, my lord, whatever they are saying, my lord, that.
These letters what are now produced, I'll direct the prosecution to send it to the FSL.
My lord, appropriate admitted handwriting is required for comparison.
Admitted handwriting is there.
LIC, your lordship at page.
Where is the appropriate admitted handwriting?
Your lordship at annexure R1, page 12. This is the LIC form of nomination where she signs as Bhumika.
No, not only the signature, the handwriting.
Not is their signature.
It is also there, your lordship, which is produced, your lordship, at page 13 onwards. We give the
Allah, this is 13 onwards is a disputed writing now.
This,
we shall give
no,
one.
where is it?
Please,
You
your lordship.
give the handwriting of the wife.
We'll give that, your lordship. The reason I had produced that LIC nomination is she signs it in English. Bhumika.
No, not
Her,
the signature. Signature is not enough.
Signature is not there in this.
Now,
that signature, your lordship,
you have to produce some other handwriting of
I shall hand it over.
to
your
mark it as a foundation and send it to FSL.
We shall do that, your lordship.
We'll do
The
it.
reason this was given was, in Hindi, it is written Bhumika in the end. Even if she had written it supposedly in Hindi, normally the signature would be what signature? It is in Hindi, it is written Bhumika. Whereas her signature in any other LIC form or others are all in English is Bhumika. I shall produce one more to compare the note.
If you
that
send
is
it,
written.
we will send it to
Please.
My lord,
the FSL.
here, my lord, death note left which was found at the scene of occurrence where she was hanging.
No,
was taken to custody by the police. My lord, it is in Hindi language.
All right, let's see why.
Comparison, my lord,
See,
comparison is done
instead
with
of permitting a whole hog further investigation, I will just get the FSL done in this. What is the
Now-
hitch?
Now they are producing this letter which is not signed by deceased. My lord, authentication, my lord, directly without knowing this, my lord, will ask me kindly, my lord, let this petition be pending. First of all, it should be verified whether this letter written in English is of deceased or not.
That is why.
Then,
You
my lord,
give me a
sitting-
comparison handwriting,
then-
comparative handwriting.
Not your lordship, kindly see. My lord, the authentication of this letter is to be verified by investigation. My lord, thereafter, my lord, sending it to the
Then
comparison purpose.
I'll have to direct further investigation.
My lord, further investigation is to be directed means, my lord, the report, final report, what is there, it may be stayed, my lord, and direct.
It
my lord.
is already stayed, sir.
Please. My
There is
lord,
already an interim order.
your lordship may kindly keep pending, my lord.
I will keep this pending and direct
That
further
we have
investigation.
investigation on this letter.
Yes.
And if required, my lord, the investigation officer, let him refer it, my lord, by collecting admitted writing for
We'll see.
handwriting expert.
It is up to the investigating officer
Yes, sir, to
to
decide it.
investigate, and whatever is to be done, he will refer it to the FSL.
Yes, sir.
I will keep this petition pending,
Yes, sir.
and the interim charge sheet is already stayed. So further trial is not on.
Yes.
We will permit the trial only after this.
Please.
Tomorrow morning I will pass the order. or on Friday morning?
Friday, by then I'll get the other.
Friday morning I'll pass.
No, that should be produced before the investigation.
No, you produce
Ah,
everything
that-
before the, not before this court. Yes. We'll keep this petition pending and from time to time see what the investigating officer is doing. 4 weeks sakala,
I'll secure.
further
the-
investigation.
I'll secure the report first, your lordships, and then I'll.
Secure that column 18 ಅಲ್ಲಿ ಇದ್ದಿದ್ದು ಯಾಕೆ ತಗೊಂಡಿಲ್ಲ ಅಂತ ಕೇಳಿ. And what is that? Senior counsel says, both the senior counsels have contradictory statements to make, so you just clear it. I'll take it on, I'll pass an order on Friday morning, sir.
The death note, my lord, which is part of the charge sheet, we have produced it, confirmed by handwriting expert that it is belong to deceased. No one can say that it is not belong to deceased. Otherwise, they have to challenge the
No problem, sir.
handwriting opinion it is.
No, I am not entering into that.
Now the new document is inserted, my lord, which is to say that it is written by deceased, which is unsigned. My lord, under what course, my lord, it is written,
No,
my lord,
but
it is
what,
investigated.
now this is produced. The court has power to direct further investigation in the matter. So I will direct further investigation to be, this will be stayed. No problem, but let me see. Ultimately, it is the expedition to discover the truth. We will see.
That's
Yes.
right.
It's ಸಾಕು madam. In terms of memo. 5 ಗಂಟೆ ಆಯ್ತು. I have a meeting at 5:15. Yes. 1 minute, page wise ಕರ್ದ್ಬಿಡಿ madam. 85 to ಎಲ್ಲೆಲ್ಲಿ interim order ಇದೆ, they will come only after 3 weeks.
87, my lord.
Interim order ಎಲ್ಲಿದೆ continue ಆಗುತ್ತೆ, they will come after 3 weeks. That is on 1 minute, on 24th. Yes, ಯಾವ್ದು interim order ಇಲ್ಲ, ಯಾವತ್ತಿದೆ madam?
Serial number 53,
1 minute. ಅಲ್ಲ interim order ಯಾವತ್ತು ಹಾಕ್ತೀರಿ? Interim order ಯಾವ್ದಿಲ್ಲ, they'll come on 9th.
My lords,
9th ಅಲ್ಲ 10th.
serial number 99, my lords. Interim order is not there. Next date is my lord 2nd. My lords 376, 11 years of my lord's relationship. My lord, last time my lordship has heard.
Serial number
99. Respondent to counsel also present, my lords. Last time my lords lives.
Second respondent, my lord.
Against respondent petition number 1, my lords, we are not pressing. He is also, my lords, agreed. For other accused.
ಬರ್ಲಿ ಅಲ್ಲಿ you take an adjournment. I'll take it on 10th.
Second, my lord, second.
ಯಾವ್ದು ರೀಚ್ ಆಗಿಲ್ಲ ಅದು interim order 4 ಅಲ್ಲ ಮೇಡಮ್, interim order ಇಲ್ಲದೆ ಇರೋದು only 4 matters. Interim order ಇಲ್ಲದೆ ಇರೋದು ಎಷ್ಟು ಮ್ಯಾಟರ್? ಸೆಕೆಂಡ್ ಹಾಕ್ಬೋದಾ?
With my lord's.
Monday.
1 minute, Leela madam. 1 minute. Appearing on the VC, have some patience.
My lords, it may be
Yes,
Monday.
yes,
my lords. Monday, my lords. Or is very short point, my lords.
Monday ಅಲ್ಲ, Tuesday, second.
In the fresh list, my lords. My lords,
Second ಬೇಡವಾ? 9th ಬೇಕಾ?
ಅಲ್ಲ ಬೇಡ. Second ಇಲ್ಲಿ fresh list ಅಲ್ಲಿ. Lords only short.
Early, yes.
110, my lord. Vehicle release, my lord. 110, this honorable court is directed to file an application for release of the vehicle, my lord. I
ಅದು
filed it.
second fresh matter ಹಾಕಿ.
Serial number 53.
110, 3, my lord.
Serial number 53.
87, my lord.
Interim order ಇದೆಯಾ? 85.
Serial number 109, your lordship.
Interim order ಯಾವ್ದಿದೆ? ಅದು 24th. Interim order ಇಲ್ಲದೆ ಇರೋದು divided bit ಇಲ್ಲ. Post them all on second itself.
Serial number 50. Serial number.
Interim order ಇಲ್ವಾ?
109.
Second, sir. Tuesday.
Serial number 53, my lord. Poxo matter, 75 years old man, my lord. Last occasion the matter.
Interim order ಇಲ್ವಾ?
ಇಲ್ಲ, ಅದು next ಹೋಗ್ಬಿಟ್ಟು ಬರ್ಲಿ.
Second ಬರುತ್ತೆ.
ಆಗ್ಲಿ.
Serial number 95, my lord.
ಎರಡೇ ಪ್ಯಾರಾಮೀಟರ್ ಸರ್. ಇಂಟ್ರಿ ಮಾಡ್ರಿ ಇರೋದು 24, ಇಲ್ಲದೆ ಇರೋದು 2. ಬೇರೆ ಏನು ಕ್ಲಾರಿಫಿಕೇಶನ್? ನಾಯಕ್ ಸರ್ ಏನು?
Serial number 94.
1 minute sir.
Serial number 94, my lord. There are 6 petitions.
94.
94. My lord, my learned friend.
Please, my lord.
He appears. My lord, we have almost reached a settlement in this matter. We have deposited 10 crores of amount, rupees, and they have withdrawn it also. 94, my lord.
It's only where the interim order is to be clarified also to a certain extent, my lord.
1 minute, sir.
Please.
1 minute. 94.
Yeah, 94.
6 matters. Yes, what is that, sir?
There are 3 main matters, and the other 3 matters, my lord, we have filed a petition for defreezing our bank accounts have been frozen by the investigation officer.
ಇಲ್ಲ,
The learned magistrate.
it can't wait till Tuesday.
Tuesday, this Tuesday, my lord.
No, this Tuesday, coming Tuesday. Sir.
Yes.
This is
There
today's
there
Wednesday.
there is an order, interim order is there.
Interim order ಮತ್ತೇನ್ urgency? Defreeze ಆಗ್ಬೇಕಾ?
ಅದು defreeze ಮಾಡ್ಬೇಕು.
ಹಾಗಾದ್ರೆ Tuesday ಹಾಕಿ ಮೇಡಮ್.
Serial number 109, my lord, Tuesday.
ಬೇರೆ ಎಲ್ಲ
With my lord's-
order ಇದ್ರೆ 24th ಬರ್ಲಿ.
I have filed the serious objection in
With
this
my-
matter. Taking the advantage of interim model. may not
Represent,
comply the office-
respondent ಈಗ?
Yes, my
Saturday
lord.
ಅಲ್ಲ?
Who is the petitioner?
Friday.
He is interested.
ಯಾರು?
Sir. 109.
Serial number?
With my lord's permission.
Madam and the VC, please wait.
Yes, sir.
109, my lordship.
106 may I take convention. 109 ಏನು?
Yes, ma'am. I have filed the objection, my lord. Taking the advantage of interim order is not complied even office objections also. Since the
What is that, sir?
the
Petitioner ಯಾರು? Yes, sir.
This is a matter wherein interim
Use the mic.
Lord, this is a matter. Joint memo was filed before the learned
Why
magistrate.
office objections is not complied?
My lord, there was a minor objection which
Whatever it is, I'll vacate the interim order now.
was, objections under, my lord, that is not, because earlier that had come and court has kept it in abeyance. There was an earlier order. Court has kept it in abeyance.
ಈಗ ಏನೀಗ? Compromise ಏನಾಗಿದೆ?
A compromise petition was filed. My lord, 138 proceedings. My lord, there are certain allegations. Court has also, my lord.
You are the accused.
Yes, my lord.
Compromise ಅಲ್ಲಿ ಏನ್ ಮಾಡಿದ್ರಿ?
Compromise ಅಲ್ಲಿ one.
Yes, sorry, my lord.
My lord, in compromise, what has happened is, my lord, the complainant advocate.
Sir, without your permission has signed it, is it?
Yes.
That is your allegation.
Yes.
We'll see. Yes.
Date may-
Serial number
24th, sir.
95,
Yes.
my lord.
Interim order may kindly be extended.
ಯಾವ್ದು interim order extension ಕೇಳ್ತೀರಾ ಅದ್ ಮಾಡಲ್ಲ. ಇಲ್ದೇ ಆಗಿರುತ್ತೆ.
I am sorry.
ಎಸ್ ಪಾರ್ಥ ಸರ್ ನಿಮ್ದೇನು?
Serial number 95, my lord.
95.
Your
Yes.
Lordship,
ಏನಿದೆ?
Interim order is there, my lord.
My lord, I appear for respondent. There are serious allegations there in the complaint.
Serious allegation. What allegation, madam?
Yes, my lord, this is the matter under the SCST Act,
SCST Act.
Yes, ma'am.
Atrocities Act.
Hmm.
So charges have been framed and 160.
Charges are framed.
Yes, your lord, charges have been framed. And
ಮತ್ತೆ
one,
why it is not brought to my notice?
No, it is earlier, it was
No, if
paid.
charges are framed, then I will not post this matter on Tuesday in the fresh matters list. Interim order subsisting shall continue till the next date of hearing.
106,
my lord. Yes.
106. Not on Tuesday, some other day, my lord.
Wednesday. Yes.
Serial number 106.
Hmm.
Some urgency, one of our colleagues' car is seized, not this is an excise act.
ಯಾರು ಅಡ್ವೊಕೇಟಾ? ಏನ್ ತಗೊಂಡ್ ಹೋಗ್ತಾ ಇದ್ರಿ ಕಾರ್ಲಿ?
ಇಲ್ಲ ಅದು
ಫೈಲ್ಸ್ ತಗೊಂಡ್ ಹೋಗೋ ಕಡೆ ಬೇರೆ ಏನಾದ್ರು ತಗೊಂಡ್ ಹೋದ್ರೆ ಮತ್ತೆ ಇನ್ನೇನಾಗಿದೆ?
election code of conduct, but he was completing his marriage.
ಎಷ್ಟು ಬಾಟ್ಲ್ ಇತ್ತು?
12.
12 bottles.
That was gifted articles. He was carrying it to home from the marriage pendant. That is the
12 bottles of what?
black and white.
Black and white.
That was given.
ಏನು ಯೂನಿಫಾರ್ಮ್ ಅಲ್ಲ ಕೇಳಿದ್ ನಾನು.
ಅದಕ್ಕೆ ವಿಧಾನ್ humility I am submitting.
12 bottles of what? Whiskey. Whiskey. Then I told you, case is very risky.
Yes, there was covered by judgment, two judgment.
Whiskey judgment ಇದೆ.
Okay, similar. Therefore,
We'll see. Yes, government ಎಲ್ಲಿದ್ದಾರೆ? ಯಾರು ಇಲ್ಲ? ಇಲ್ಲೇ ಇದ್ದೀರಲ್ಲ.
If compliance ಆಗಿದೆ, state permission is not obtained.
It should go then. ಆಯ್ತು, advocate ಕಾರದ್.
Serial number 109.
That also Wednesday fresh matters.
Serial number 91.
Hmm.
Serial number 91, my lord. Lord, no interim order. Lord,
Tuesday.
almost 5 times, Lord.
Tuesday, sir, fresh matters.
Serial
Yes.
number 104.
Interim order ಯಾವ್ದಿಲ್ಲ Tuesday ಬರುತ್ತೆ. Don't make a mention. Interim order ಇದೆಯಲ್ಲ ಸರ್? 24 ತಗೊಂತೀವಿ.
24, some inconvenience is there for me, that's why.
ಅದು ನೆಕ್ಸ್ಟ್ ವೀಕ್ ತಗೊಳ್ಳ?
Next week, ಅದಕ್ಕಿಂತ ಮುಂಚೆನೆ ತಗೊಂಡ್ರೆ.
ಮುಂಚೆ ಯಾಕೆ ವಾಯ್ಸ್ ಏನಾಯ್ತು ಸಡನ್ ಆಗಿ?
Not well.
Not well. All right, we will take it, don't worry.
Serial number
On
104.
the third bed, second yearly, third I am not in stage.
Second ಪರವಾಗಿಲ್ಲ. Yes.
Serial number 104. Kindly direct the office to show the name of Learned Council BB part.
109.
104.
ಏನಾಗಿದೆ ಈಗ?
Some HCGP ಗೆ notice ಅಂತ ಮಾಡಿದ್ದಾರೆ.
Learned the registry to delete the name of HCGP and print the name of BB Patil as appearing for the respondent ಲೋಕಾಯುಕ್ತ.
Kindly post it on second.
Second by ಏನು 7 ಏನೋ 13?
13. Exoneration of charges. Exoneration departmental enquiry.
Departmental enquiry. Let it come on 11th.
My lord, sir, interim IA ಹಾಕಿಲ್ಲ.
IA ಹಾಕಿಲ್ವಾ?
IA
ಏನು ಸ್ಟೇ ಕೊಟ್ಟಿಲ್ಲ.
Last time stay to
11th held, yes.
No, serial number 25 was reserved. The filing coordinate bench judgment in
ಯಾವ್ದು ಸರ್ ಅದು?
GMCPC. Serial
ಹಾ,
number
ಏನಾಯ್ತು
25.
ಅದು?
There is a status quo order.
ಗೊತ್ತು, ಈಗ ಇವತ್ತೇನಾಯ್ತು?
They've adjourned it in the morning.
ಆಯ್ತು ಕೊಡಿ. Yes, take
Photograph
that.
ಮಾಡಿದೆ.
May I please, Your Lordship? Your Lordship, I beg to mention for IA for the listing of an IA, Your Lordship.
Listing of IA?
Yes, Your Lordship.
Which bench?
5, Your Lordship. Day after tomorrow, Your Lordship. Obliged.
I
pray for a listing of a bench 5 motion matter tomorrow.
What is the subject matter?
There's an auction by the PF authority.
All right.
May it please, Your Lordship, I pray for listing of a bench 5 matter, Your Lordship, tomorrow, Your Lordship.
What is the urgency?
They might open the price bid, Your Lordship.
All right.
May I pray? May I please, Your Lordship? May I pray for listing of matters, my lord? Motion matters tomorrow, my lord.
Friday.
Tomorrow, similar matters are already
All
listed.
right.
Highly obliged.
May I please, Your Lordship? Lordship, I beg to mention item number 46. Lordship, in this matter, I may request to kindly fix it after vacation, Lordship.
40?
46.
My Lord, I appear for the petitioners in this matter. Yes. If the date will fix in the first week after the reopening. As prayed for by Mr.
S. Doctor on behalf of R. Bora.
Mr. S. Doctor on behalf of
R. Bora.
R. Bora,
Mrs.
Learned
R.
Counsel for the
Agriculture Department.
For the respondent agricultural department, which is not opposed by the other side, list this matter on such and such date. Yes.
Yes, please, Your Lordship. Well, I beg to mention item number 35 and 36. I'm led by Mr. K.N. Chaudhary.
All right, all right.
I'm appearing for All India Limited as a respondent. I am also led by Mr. M.K. Chaudhary.
No problem, I'm adjourning it. 35 and
Same
36.
problem, both sides.
Yes, contesting parties.
Contesting parties.
Both in court and outside. As prayed for by Mr. B. Kaushik, Learned Counsel for the petitioner, which is not opposed by Mr. A. Sharma, Learned Counsel for the respondent oil.
Yes,
Respondent,
Oil India Limited.
Standing Counsel, Oil
Standing
India
Counsel, Oil
Limited.
India
List this matter when?
After vacation.
Your Lordship, I am respondent number 3 in item 35.
Give a date.
July.
All right.
May it please, Your Lordship, I pray for the listing of 3 motion matters, my lord, tomorrow, GST matters, my lord. Obliged.
Lordship, item number 61, Lordship, we have filed affidavit in reply, recording me for
61,
Lordship.
What do you want in 61?
Lordship, we have filed affidavit in reply in IA, Lordship.
All right.
That may be called.
May it please, Your Lordship. Lordship, I beg to mention item number 52, Lordship. Conducting counsel, Mr. R.S. Mishra is out of station, Lordship.
52?
52, yes, Lordship.
Your name?
M. Nirola, Lordship.
M. Nirula, MSN Nirula, Learned Counsel for respondent number?
Lordship, I'm for the petitioner.
Respondent, my lord.
Consent has been taken from the respondent.
Learned Counsel for the petitioner, as prayed for by MS so-and-so, Learned Counsel for the petitioner, comma, which is not opposed by the other side, list this matter after 3 weeks on a date to be fixed by the registry.
Lordship,
Yes.
there's an interim order, Lordship.
Interim, if any, shall continue till the next date of listing. Yes.
May I please, Your Lordship? I beg to mention item number 26, Lordship. It can be kindly adjourned list after 2 weeks, sir, after vacation.
26?
Yes, sir.
26 is the land acquisition
Yes,
compensation.
yes,
I think status.
Instruction is awaited, sir.
Huh?
Instruction from the petitioner is
Who is
awaited.
appearing for the other side?
SHRI Revenue and Government.
You wait. 26 you wait. I think this is a 2019 matter where on the last occasion some instructions were sought. I shall accommodate, but let me have a look at the file once.
And
Yes.
another prayer in respect of item number 64 also. Today my senior has some difficulty, Lordship.
64? All right. As prayed for by Mr.
A. Borwa.
A. Borwa, Learned Counsel for the petitioner, on the ground that the leading counsel, Mr. T.J. Mahanta,
Yes.
has some personal difficulty today, stop, comma, which is not opposed by the other side, list this matter on such and such date.
Obliged.
May please, Your Lordship. I beg to mention item number 53, my lord.
50?
53, my lord.
Yes.
My lord, the matter has become infructuous. My lord, contempt petition.
Your name?
W. Rahman.
Heard Mr.
W. Rahman.
W. Rahman.
Yes, my lord.
Learned counsel for the petitioner.
My lord.
Stop. Also heard yes, Mr. S. Borwa or MS Borwa. Government. MS S. Borwa, learned government advocate. You're additional senior government advocate.
Contempt petition.
55.
53, my lord.
53.
53, my lord.
Okay, okay.
Contempt petition has not complied with, my lord.
Any respondent there?
Lordship, I can appear on behalf of Mr. Bhattacharya, Lordship.
And also heard MS?
G. Hazarika.
G. Hazarika for respondent. Stop. Mr. W. Raman, learned counsel for the petitioner, submits that during the pendency of the contempt proceedings, the order of this court has been complied,
yes,
and accordingly nothing survives, and accordingly the instant petition can be closed. Stop. Prayer allowed. Contempt petition stands closed for being complied.
My lord, another prayer, my lord. 54, my
Disposed
lord.
of.
My lord, item number 54, service report may kindly be awaited, my lord. As per the office note, the notice.
It's an order matter. Wait.
My lord.
Yes.
May I please, therefore listing a motion matter Friday.
Tomorrow.
Friday.
Urgency.
Friday, Lord.
Friday. Oh.
May I please, Lordship? Item number 14 and 15, my lord.
Yes.
My kindly pass over for the day. Due to demise of my father, I was not able to prepare the case, and I have also to file.
You are for the petitioner.
In 15, I am petitioner. In 14, respondent.
No, but in 14, who is for the petitioner? Because this has been listed today for dismissal.
Yes, sir.
All right. In item 14, you say that since on the last occasion there was no representation on behalf of the petitioner, this matter has been listed today with the remark for dismissal in the cause list. Stop. However, today Mr. M. Sharma, learned counsel for the petitioner, is present. Stop. List this matter after 3 weeks on a date to be fixed by the registry. In item 15, you say, as prayed for by Mr.
S. U. Ahmed.
S.
U. Ahmed.
S. U.
Ahmed.
Ahmed, learned counsel for the petitioner. Petitioner?
Yes, yes.
Comma. List this matter after 3 weeks on a date to be fixed by the registry.
Obligement.
May I please, Your Lordship?
Along with also you can say or whatever.
May I
Yes.
please, Your Lordship? Lordship, I beg to mention item number 8, Lordship. Kindly
Item
pass-
number?
8,
8.
Lordship. Kindly
Yes,
pass-
what do you want?
Lordship, kindly pass over the matter for the day.
As prayed for, list this matter after 1 week on a date to be fixed by the registry. As prayed for by the petitioner. Your name?
D. Datta.
MSD Datta, learned counsel for the petitioner. Yes.
May it please, Your Lordship, with due consent of the other side, I beg to mention item number 2 of the daily list, my lord.
2.
2, my lord.
Yes, what do you want?
We are awaiting of instructions in this matter, my lord.
You are for?
I am for the respondent, finance and
Petitioner?
taxation.
This item 2 will just be called. Why are you making a mention? Yes. Any more mention?
Yes, please, Lordship. Lordship, I beg to mention, Lordship, I'm praying for a listing, Lordship.
Listing?
When? Listing. It's a part-head matter, Lordship. Supposed to come on 18/4, but it has not been listed. I submitted an application before the registry, but it's not.
Part-head matter?
Part-head matter, Lordship.
What was the subject matter?
It is a criminal appeal, Lordship.
That quashing? No.
No.
Appeal.
Suspension. Yes.
Right. Then after the vacation?
16 on maybe.
We are reopening kitya hoya sir?
It's Monday, Lordship. Sorry, Tuesday.
All right.
Probably.
May I please, Your Lordship, I beg to mention item number 34. Kindly the matter may be fixed after vacation.
34?
Yes, Lordship.
Yes. 34 you are for?
I am for the petitioner. Lordship,
On the last occasion you were absent.
Lordship, in this case, I am appearing for revenue department. Lordship, that case budget has been already sanctioned.
All right,
Lordship.
you wait for your turn.
Yes, Lordship. That can be disposed of, Lordship.
You wait for your turn. We may pass a favorable order on.
Your Lordship, the respondent side had filed the affidavit, but we need some time to file the affidavit. No, Lordship, their prayer has been already
Miss
complied,
Counsel, please don't come like a puppet before the court and say what you are being asked to say. Also be attentive of what the respondent counsel is saying. Have you heard what she said? That there is some progress in the matter and the matter can be disposed in your favor. So in that case, why do you want unnecessarily another date if something in your favor is going to be given? Yes, Mr. Mondal?
Yes, may I please? Not one matter, my lord, the main petition is posted for my lord, motion hearing tomorrow, my lord. One IA has been filed today for implementing party respondent. Now new party has come.
What do you want?
Let it be, my lord, listed tomorrow, my lord. That must
Along with that?
Along with that. Oblige.
Okay. Yes, call the list. Mr. R. Dekal, Learned Counsel for the petition. Mr. S.I. Akan, Learned Counsel for the petitioner, heard so and so, and also heard Mr. A. Bhattacharya, Learned Standing Counsel Revenue, Mr. M.S. S. Borwa, Learned Government Advocate for the State Respondent, and Finance. Anyone from the Finance? And Mr.
H. Borwa.
H. Borwa, Learned Standing Counsel, Finance.
And on behalf of B. Gogoi, madam.
On behalf, then I'm giving B. Gogoi's name. B. Gogoi, Learned Standing Counsel, Finance. Stop. Mr. S.I. Akan, Learned Counsel for the petitioner, submits that he has received instructions from his client, the petitioner, not to press the instant petition. Stop. Accordingly,
Matter has been infructuous.
As the matter has become infructuous. Dismissed for for withdrawal. Disposed of.
May I please?
Yes.
Lordship, instruction was sought for regarding the representation filed by the petitioner before
Yes,
the register
Corporation
of
Department.
My lord, I have not received. Lordship may issue notice, my lord, short notice, my lord, after the petition.
Notice not yet issued. All right, issuing the notice so that things can move. Heard Mr.
S.H. Raman.
H.H.
Raman.
H.S. Raman, Learned Counsel for the petitioner. Stop. Also heard Mr. S.K. Talukdar, Learned Standing Counsel, Corporation Department.
1, 2, and 3, my lord.
Within bracket, respondent number 1,
2, 3, my lord.
1, 2, 3. Anybody else?
There are other respondents, my lord, Cooperative Apex Bank.
So that has to go by steps by my registered post.
Well, I think there are standing counsel.
Anyone appearing? No. All right. Issue notice. Returnable 2 weeks. Mr. So-and-so accepts notice for respondent number 1, 2, 3. Steps by registered court, respondent number 4 and 5.
Well, there are other respondents also, 6,
4,
7,
5,
and 8.
6, 7, 8. Within a period of 2 days from today. Extra copies during the course of the day. Okay. List after return. I have given 2 weeks. List after 2 weeks on a date to be fixed by the registry. Yes. What were you submitting in item 2?
My lord, our instructions are being awaited, my lord. I'm praying for 3 weeks time to file our affidavit, my lord.
Then I'll issue notice.
Yes, my lord.
Heard M.S. N. Gogoi.
Yes.
Learned Counsel for the petitioner. Stop. Also heard Mr.
H. Borwa.
H. Borwa, Learned Counsel for Mr. B. Gogoi, Learned Standing Counsel, Finance and Taxation Department for the respondent numbers 3 to 6. All right. B. Gogoi. Just put B. Gogoi's name. You don't have to put. I'm recording your name, Mr. Gogoi. Anyone else? Anybody from GST?
Yes.
And Dr. B. N. Gogoi, Learned Counsel.
1 and 2.
Learned Standing Counsel GST for the respondent numbers 1 and 2. Stop. Issue notice, returnable 2 weeks. I think extra copy already been served.
Yes, sir.
Isn't it? Since the respondents are represented and have already received the extra copies of the petitioner, no formal notice is required to be issued. Stop. Let affidavits be filed by before the returnable dates. List after 2 weeks on a date to be fixed by the registry.
Obliged.
Obliged, my lord.
May I please, Lord? My senior is on leg, my lord. Matter will be taken after some time.
Instruction has received, Lordship. Investigation going on. I have received the report.
You file an affidavit then?
Then
Investigation is going on.
going on.
MSS Purva Learned Government Advocate submits.
Lordship, alternative remedy also available under CRPC 156. Sakri Basu said if proceedings are not going on, then they claim every person can apply before the SP.
Alright, then let his senior be there.
Yes.
At all of the piece of matter. Keep that provision ready. And Sakiri Basu?
Yes.
Prosecution instructions sought for my lord. Some demarcation is directed to be two DUG numbers, 202, 205.
Yes.
Yes, I have received telephonic instruction. A demarcation has proceeding has already completed, and demarcated land was demarcated on the presence of.
So that means the relief sought for has been met with.
Yes, but I have not written instruction.
Then you do one thing. You file an affidavit. You get the complete instructions.
Yes.
In the meantime, let me issue notice.
Yes, sir.
Right.
Yes, my lord. Another direction is there to record correction, my lord. Page 72, 71, 72. But I don't know that was done or not. So logical end, and that way logical end should be reached. So they will ensure that until then notice is issued.
No, let me issue notice and let them file their return.
Yes, but my lord, why I filed this requisition? Because they started construction in disputed land, and page 82P, DC has says only 205 you restrain, 202 not restrain. That is my anxiety, my lord, and that nature.
What was page 82?
Yes, because there is two DUG numbers, your lordship. One is 202, 205. They mentioned only 205. We said that our 205, then 202 is, they are owner of 202, but they encroach 205. That is why demarcation is. So here.
So here the stop ongoing construction is relating to 05. Oh.
But 202 is not mentioned.
202? So there were two DUG numbers involved.
Yes, that should be mentioned. That is why.
202.
Yes.
Alright, then we will mention 202 and say that
yes,
even in 202 there should not be any construction because your own order is there 82. Yes, yes. See page 82.
Yes, on the last occasion when these the petitioners approached the Honorable Court, page 40, page 70, it starts from page 65.
Yes.
Page 66 is the petition filed by them.
This is another petition.
7184.
This is another petition.
Earlier petition. There is a question of title involved. There is a dispute between two parties regarding 202
Alright, then we are not going into all this. Rising out of DUG number 202
and 205. There is
205.
Yes. Now the difficulty what this Honorable Court find that in a 226 proceeding that declaration cannot be done. Therefore, they were relegated to civil court. Now, if they approach the civil court and finds an injunction, that can be done, whether they have filed a civil suit or not. Pursuant to order of the Honorable Court, because they are coming in again and again, my lord.
Before that, the demarcation should be there, and we know
that's
who is
a different issue,
my lord. Who is
in terms of the order dated 19/6/2024, MSS Borwa, Learned Government Advocate for the respondent numbers 2 and 3, submits that she has received verbal instructions to the effect that the demarcation proceedings have been completed. Stop. Let written instructions in this regard be placed on the next date of listing. List again on such and such date. After vacation, did you? Nothing. Next. What is this?
Lordship, her petition of purchase a plot of land from his father by executing registered deed, Lordship. And thereafter, Lordship, in the year 2022, that purchase.
In the year 2022.
And thereafter, Lordship, in 2024, he intends to sell the property, Lordship. And accordingly, he intends to apply for NOC, Lordship, in the online system. and there he found there is an objection filed by someone.
All right, I'm issuing notice.
Yes.
Heard Mr.
AZ
Ahmed, Learned Counsel for the petitioner. Stop. Also heard MSS Borwa, Learned Government Advocate for the state respondent. Respondent number 1, 2, 3. Stop.
1, 2, 3.
I think one.
I am one.
Respondent number, you will be for 2 and 3?
2 and 3.
Respondent number 2 and 3. And Mr. A. Bhattacharya, Learned Standing Counsel, Revenue Department for respondent number 1. By filing the instant petition under Article 226 of the Constitution of India, the petitioner is seeking is assailing the order dated 17/5/2024 passed in objection case number 15/2024 by the respondent number 3, whereby NOC for sale / gift / transfer of the subject land was denied to the petitioner. Stop. Let notice be issued, returnable 4 weeks. Mr. A. Bhattacharya, Learned Standing Counsel, Revenue, accepts notice on behalf of respondent number 1, and MS S. Borwa, Learned Government Advocate, Assam, accepts notice on behalf of respondent number 2 and 3. Registered post AD in respect of respondent number 4 and 5. Steps as indicated above shall be taken within a period of 2 days from today. List after 4 weeks on a date to be fixed by the registry. Yes, Mr. Kataki.
Yes, ma'am.
Land
regarding
settlement.
the rejection of my prayer for Basundhara, my lord, 20.
Prayer?
My prayer for settlement, my lord, under Basundhara scheme, my lord, that was rejected on the ground that I have not been residing continuously for 3 generations. But the fact remains that way back in 98, my lord, I purchased the petitioner and the sons while residing for 3 generations.
All right, issuing notice
Notice.
at this stage.
And we apprehend that there is a possibility that we may be evicted, my lord. That, so, in terms of no eviction may be done without due process of law, my lord.
Eviction order was not passed.
Not possible. We are apprehending because...
All right. Heard Mr. P. Kotoki, Learned Counsel for the respondent, for the petitioner. Stop. Also heard Revenue is not there.
Yes, one.
For also heard Mr. A. Bhattacharya, Learned Standing Counsel, Revenue, and MSS Borwa, Learned Government Advocate for respondent numbers 2 and 3. Stop. By filing the instant petition under Article 226 of the Constitution of India, the petitioner is assailing the orders of rejection dated 21/9/2023 issued by Mission.
Circle officer, my lord.
Issued. What is of Mission Basundhara?
That's a scheme, my lord. There's a scheme for
orders of rejection dated so and so in relation to the Mission Basundhara 2.0 scheme of the petitioner.
No petitioners. Separate orders were passed, my lord. 1, 2, and 3. 31, 32, 33. The petitioner and the sons, my lord, they filed their petition.
Really pertaining to the petitioner and his family.
Family.
By the respondent number 3. Stop. Issue notice. Let notice be issued. Returnable 4 weeks. Mr. A. Bhattacharya accepts notice on behalf of respondent number 1, and MSS Borwa accepts notice on behalf of respondent numbers 2 and 3. Extra copies within a period of 2 days from today. In view of the apprehension projected by the petitioner as regards eviction from the subject land.
Yes, ma'am.
From the subject land, let no coercive steps be taken till the returnable date. All right?
Yes, ma'am.
let no coercive steps be taken in this regard till the next date of listing. List after 4 weeks on a date to be fixed by the registry. Yes, illegal sealing of your shop.
Milord.
Why was your shop sealed?
Because, Milord, the Lordship will find at page number 16, Milord, Annexure 3, because somebody lost an FIR, Milord, and subsequent to that, Milord, the petitioner was arrested on the allegation that, Milord, some of the stolen properties, Milord, was recovered from the shop of the petitioner. I was arrested, I was in jail, Milord. And
alright, and then?
Then, Milord, when I came back from the jail, Milord, I went, Milord, because the impugn order directed me to produce documents.
Alright, I'll issue notice, nothing more at this stage.
But subject to, my lord, subject to the concurrence from the other side. Since my shop is, my lord, deceived, my lord. So therefore, my lord, if your lordship is pleased to dispose of the representation that was submitted therein, on perusal of the documents, if that those are found.
Where is the representation?
Yes, my lord, I have connected.
Mr. Nayak?
Yes, one representation is there, but in the meantime, his trade license has also expired. Lordship, one representation is pending. Lordship may direct the authority to dispose of them.
Yes. Which page is the representation?
It is page number 28, Milord.
13.3.
20?
28, Milord, last page.
So this direction for disposal has to be issued to the GMC?
Yes, Commissioner GMC.
Respondent number?
Respondent number 2.
2, Milord.
2
Alright. This is item number?
7, Milord.
7 for disposal, huh? Heard Mr. A. Ali, Learned Counsel for the petitioner. Stop. Also heard Mr. P. Nayak, Learned Standing Counsel, GMC.
All the 3 respondents, Lordship, GDD plus GMC, Lord. 1, 2 and 3.
For respondent number 1, 2 and 3. Anybody else? No.
No.
By filing the instant petition under article, this is under 227.
26, Milord.
Please be mindful when you draft the petitions. It is mentioned 227. By filing this petition under article 226 of the Constitution of India, the petitioner is assailing the order dated 22/1/2024 within bracket annexure 1, whereby his shop within quotes Krishna Guru Jewellery at Sharmakata Biharbari has been sealed by the respondent number 3. Stop. The brief facts of the case is that pursuant to an FIR being lodged before the Bokhista police station, after the petitioner was arrested in connection with Bokhista PS case number 823/2023 registered under section 457/380 IPC. Stop. It is alleged in the said FIR that on the base no, don't say you say like this.
Lordship, may kindly say page 25.
Page?
25.
25.
Lordship. In the same case, Lordship, a search was conducted at his shop, Lordship, and following metals were recovered.
25.
Page 25.
No, where is the FIR? I was trying to
FIR
find out.
Annexure 2, Milord.
What is the allegation in the FIR?
The allegation is that, Milord, one.
Page?
Page number, Milord, 16. annexure.
In the FIR you are named.
No, my lord.
Can you read that sentence? No, before that. Wait. No, person, just delete that. I'm going to give you once again. Brief. An FIR was filed being Bokista PS case number 823 of 2023, registered under section 457/380 IPC, wherein it has been alleged by the informant that the accused mentioned therein has taken some jewellery ornaments worth rupees 5 lakhs and a cash amount of rupees 50,000. Stop. Thereafter, it appears that on the basis of the statement of one Tej Bahadur Chetri, comma, raid, the petitioner's shop was raided. Where from?
Is number 25.
Where from the stolen gold and the cash of rupees 50,000 and of rupees 18,000 was recovered. Stop. The petitioner was accordingly arrested on, were also arrested. Stop. In the meantime, respondent number 3 issued notice dated 22/1/2024 asking the petitioner to produce requisite documents pertaining to his shop within 3 days. Stop. However, since the petitioner was in custody, he could not submit the aforesaid documents, whereupon the respondent number 3 sealed his shop. Stop. The petitioner, after being released on bail, submitted application dated 13/3/2024 before the respondent number 3. However, the same was not accepted. Stop. It is submitted at the bar that the aforesaid application dated 13/3/2024 Annexure 7 being pending, this writ petition can be disposed of with a direction to the respondent number 2 to dispose of the aforesaid application in accordance with law. Stop. As such, this court is of the considered view that this writ petition can be this court disposes of this writ petition with the direction to respondent number 2 to dispose of the application dated 13/3/2024 filed by the petitioner within a period of 1 month from the date or receipt of the certified copy of the order in accordance with law. Stop. Disposed of.
Obliged.
Lordship,
yes.
This matter may be fixed along with writ petition number 1229/2000.
More writ petitions are pending.
Yes, my lord. Similar issue, my lord. Writ petitions are pending, and my lord, there is already interim orders are passed, my lord. This is one of the order, my lord.
You are aware?
Yes, my lord. No coercive action.
So I can issue notice and pass a similar order?
Yes, my lord.
Other cases are fixed on 22nd.
Notices have been issued then?
Yes, my lord. And my lord, there is interim order also.
Alright, then I shall also issue notice here. Okay. Heard Mr.
A.K. Gupta.
A.K. Gupta, learned counsel for the petitioner. Stop. Also heard
M. Deka.
MS N. Deka, learned.
Lordships for CGST Lordship.
Learned learned standing for learned standing counsel CGC.
Representing CGST on behalf of SC Kyle Lordship.
Learned counsel on behalf of SC Kyle and Mr. SC Kyle, learned. What is the designation? Learned
CGST Lordship.
DYSDI.
Yes, Lordship.
DYSDI and Mr.
Lordship, it will be CGST.
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 Learned standing counsel.
Yes,
SC CGST. And Mr. B. Chaudhary.
For 4 and 5.
Learned standing counsel. Finance and taxation for respondent number 4 and 5. Anybody else?
No.
By filing this writ petition under Article 226 of the Constitution of India, the petitioner have assailed the notification number 9/2023 central text dated 31/3/2023 issued by the respondent number 2 extending the period for issuance of order under section 73 within bracket 10 of the CGST Act 2017. Stop. Assailing inter alia, huh? Issue notice returnable on 10/5/20. 10/5 is already gone.
22/7 is the next date, madam.
The next date is 22/7. The other matters.
Returnable 2 weeks. Stop. Mr. MS, your name?
M. Deka.
MS M. Deka for Mr. S.E. Kyle accepts notice on behalf of respondent numbers
2 and 3.
2 and 3. Stop. Mr. B. Chaudhary, learned standing counsel for the state GST,
4 and 5.
accepts notice for respondent number 4 and 5. So, who is for 1?
One lordship CGST will apply.
So she will apply 1, 2 and 3 then?
No lordship.
Or CGSE? Anybody there? No. As MS S. Borwa for respondent number 1. And what the 4, 5? It is submitted at the bar that the issue involved in this writ petition is also that it is submitted at the bar that similar writ petition where the same issue is involved is pending adjudicating before this honorable court, being WPC 1845 of 2024, wherein interim measures to the effect that the recovery of the amount assessed against the petitioner shall not be enforced. Stop. In view of the above, it is directed that as final order has already been passed and taking note of the fact that in view of the above, let the recovery of the amount assessed against the petitioner not be enforced as an interim measure. Stop. List along with WPC so and so on
22/7/2024.
22/7/2024.
Obliged. My lord, item number 10 and 13 are also same, my lord.
Item number
10
10
and 13.
and 13. Okay,
Also
same order in item 10 and 13.
I'm for Union of India, my lord.
You are for the petitioner?
Union of India.
Union of India.
That's one.
I've already, S. Borwa was there. All right. Naam to Lulu. All right.
I'm here as a social worker. I have preferred an application through RTI, and the RTI replies at page 19, where I got some information where somebody has acquired the land, which is a government land. Let's see, with reference to the cited, it is page 19. Let's see, next time. It is an RTI reply. So,
yes,
Mary. So and so, with reference to the above
government municipality.
Yes, Lucy.
Okay.
The horizon community because
yes.
So somebody has acquired the land, then I have preferred application to evict the land from the.
Let notice go first. Heard Mr.
H.
Chetri, learned counsel for the petitioner. Stop. Also heard MSS Borwa, learned government advocate for the state respondent. Stop. By filing this petition under Article 226 of the Constitution of India, the writ petitioner is seeking inter alia directions to the respondent authorities to take appropriate action against the respondent number 5 so as to recover the government land measuring 14 lecha covered by duct number 1580 and 1581, which has been wherein illegal construction, wherein they have illegally constructed a pakka structure.
Yes.
Correct?
Yes.
Stop. Let notice be issued, returnable 4 weeks. MSS Borwa, learned government advocate, accepts notice on behalf of respondent number 1, municipal 1, 2, 3 and 4. Steps by registered post AD in respect of R5 within the period of 2 days from today. Extra copies also within the during the course. 2 days.
Tomorrow.
During 2 days. 2 days. List this matter after 4 weeks on a date to be fixed by the registry.
Obliged, highly obliged.
Regarding illegal eviction passed by the conducted by the this application has been filed for the illegal eviction has been conducted by the respondent number 456 on 8/6/2024, Your Lordships, this month, Your Lordships, without producing any prior notice to the without prior issuing any notice or intimations to the writ petitioners, though they have been bona fide possessor of the land.
What documents have you annexed to show that you are a bona fide?
Yes, land revenue receipts, Annex 1. The
land revenue is not.
And the Jamamondi.
That shows your possession.
And Jamamondi, Your Lordships, wherein the Jamamondi, wherein my father's name has been appeared, and the land has been settled in way back in 1985.
You've been in possession since when?
1985, Your Lordships. But the thing is that
which is the order that you are challenging?
No, order is not.
There is no order of eviction.
That is why
already been evicted, Your Lordship. Evicted.
We have already evicted.
Without prying any notice, Your Lordship.
And similar matter came up yesterday. It's fixed on 15, Your Lordship.
On 15.
Similar, 15 of July.
What order has been passed?
Notice only issued.
No, there is a direction to furnish the instructions on 15. Till then, no coercive action will be taken against the.
So I'll pass the same order.
On 15.
Where is that order?
Lordship?
Where is that order?
The order has not been uploaded yet. That is this one of the decisions.
Okay. Anyway, this is item number 12.
Lordship.
Heard Mr. H. Borwa, learned counsel for the petitioner. Stop. Also heard Mr.
R.R. Gogoi.
R.R. Gogoi, learned
Forest Department.
Standing Counsel Forest. Mr. A. Bhattacharya, learned Standing Counsel Revenue, and MSS Borwa, learned Government Advocate for the state respondent. By filing this petition under Article 226 of the Constitution of India, the writ petitioner is challenging the alleged illegal action of the respondent authorities in evicting them from the land where they have been residing since 1985. Stop. Let notice be issued, returnable 4 weeks. Mr. R.R. Gogoi, Learned Standing Counsel, Forest, accepts notice on behalf of respondent numbers
1, 2, 3, 4, 5 and 6.
1, 2, 3, 4, 5 and 6. M.S. Borwa for respondent number 7 and 8 and 9. So revenue is not there. 7, 8, 9. You remove Mr. Bhattacharya's name on top. Actually, in the cause list, it was mentioned. Okay. Till the returnable, till the next date,
15
comma, let no coercive steps be taken in respect against the petitioners as regards the subject land. Stop. List this matter on 15/7/2024 along with WPC number
3211/24 and
2024
and
WPC
322
of
24.
222.
Obliged, Lord.
Obliged.
Lordship, there is a direction by this Honorable Court, page 11, madam. On 31/7/2023, there is
Is a contempt case. It's a contempt case.
Yes, ma'am.
Direction is where?
My Lord, page 11, madam. There is a direction to complete the demarcation process within a month of 2, my Lord. Till that nothing has been done, my Lord.
All right, I'm issuing notice.
Yes, ma'am.
In item number 66. Heard Mr. S. Amaria, Learned Counsel for the petitioner. Stop. By filing the instant contempt petition, the petitioner is drawing notice of this court of the alleged willful violation of the directions contained in the order dated 31/7/2023 passed in WPC number 4284 of 2023 by the respondents. Stop. Let notice be issued, returnable 4 weeks, steps by registered post AD within a period of 2 days from today. List this matter after 4 weeks on a date to be fixed by the registry. Yes.
May I please, Your Lordship? The petitioner before Your Lordship, they are members of a board of directors of a cooperative society. My Lord, their board was dissolved during the COVID period. And after dissolution, the board approached this Honorable Court. And this Honorable Court granted some time, 3 months time, liberty was given to them to hold the election. But that election actually could not be held because of lack of quorum. Then, my Lord, the one-man committee has been appointed. In the meantime, the period already expired. The one-man committee was appointed. Then, my Lord, the meeting was scheduled to be held, and that was not also not done. SGM could not be held. Now, my Lord, they are going to hold the SGM on 7th of July. Tomorrow is the last date for applying for the nomination, my Lord. My Lord, our limited...
Who are you?
I am the board of earlier member of the board of directors.
Now, what is? How can you be?
My Lord, that is
at your instance, we delay this process.
My Lord, in earlier occasion, my Lord, I approached. We are given time, but we could not hold the election. Actually, disqualified.
See, I can issue notice, but I am not inclined to stay this election.
No, I am not praying for stay of the. I may be allowed to participate in the election, my Lord, subject to, my Lord, the result of this writ petition, my Lord.
My Lord, in fact, there is a statutory bar. The embargo created by the statute cannot be lifted by judicial order. And there are some orders, my Lord, annexed. My Lord,
I can simply issue notice and also say That's all, nothing else. I'm not inclined to pass an interim.
tomorrow
And if you want, I
I
can issue notice in the interim prayer as well, and keep the interim part open.
That is correct.
If you want, I can do that, or otherwise, I will hear you on the interim and decide it right away.
Just tomorrow is the last date for filing nomination.
I'm not inclined to do it. You had your chances.
And your Lordship will see order is of 8-11.
You had your
after 8
chances.
months.
That 8-11, my lord, subsequently, my lord, another.
Sorry.
And similar secretary.
If you sit silently and don't do anything, later
That
on
is
now.
not our
Yes, that
fault
is a
of the-
lectures on your part, and
No,
this
no,
is a
that is correct.
discretionary relief that you are ultimately seeking. Correct?
Only to participate.
Only because of that, this court is not inclined to grant you the interim.
Only to participate in the election, my lord. And I may be allowed to, my lord,
No,
file
sorry.
nomination, my lord.
Where is that embargo?
Yes, my lord.
Section 40.
40, my lord.
That is correct.
Then I'm deciding the interim. Or if you wanted, I could have kept it open. But
44A and E, my lord. Unless there is an expiry of 5 years, they are debarred from participating in the election, my lord.
40?
40 subsection 4, A and E.
A and E?
E, A and E. Both are two, my lord. A is related to AGM, E related to election, my lord. These are settled positions, my lord. These are mandatory provisions, my lord.
So after 5 years, he
Yes,
can
after 5
participate.
years, they can participate.
And if there is an automatic dissolution under subsection 4 of 41.
Yes, my lord, yes.
Heard Mr. Heard Mr. N. Hawk, learned counsel for the petitioner. Stop. Also heard Mr. A. Talukdar.
S.K. Talukdar.
S.K. Talukdar, learned standing counsel, Corporation Department. Stop. By filing the petition, the instant petition under Article 226 of the Constitution of India, the writ petitioner is challenging the order dated 8/11/2023 within bracket annexure 5 issued by the respondent number 3, whereby the prayers of the petitioner to submit nomination papers for participating in the ensuing AGM/election for the year 2024-25 of Rangapani number 1 SS Limited scheduled to be held on 7/7/2024 was rejected. Stop.
Tomorrow is the date of nomination, Lordship will mention it.
Issue notice returnable 4 weeks. Mr. S.K. Talukdar, learned standing counsel, Corporation Department, accepts notice on behalf of respondent number 1, 2, 3, 4, 5 and 6. Stop. Registered post AD in respect of respondent number 7. Stop. Heard the parties on interim prayer. Stop. The petitioner, who is the ex-board director, the petitioners who are the ex-board directors of Rangapani number 1 SS Limited, they were of the previous, no?
Previous.
Former ex-board, then I'll say, ex-board directors of the previous, what is it called? Previous board.
Well, in fact, the language is not correct. They were members of the earlier board.
That is what I thought.
Exactly, well.
That the petitioners were the members of the earlier
Board of
Directors of the
Rangapani number 1 SS Limited.
Of the Rangapani number 1 SS Limited.
Well.
In view of the fact that the election is scheduled to be held on 7/7/2024, that is tomorrow, 7/7/2024, the petitioner is seeking an interim direction that that the petitioners be allowed to participate in the ensuing election scheduled on 7/7/2024. Stop.
Nomination date tomorrow.
Tomorrow nomination.
It is also submitted that the nomination date is scheduled for tomorrow, i.e. 27/6/2024. Stop. Mr. S.K. Talukder, Learned Standing Council Corporation Department, submits that Section 40 of the Assam Cooperative Societies Act 2007 cast an embargo for participating in the election by the ex-members of the board unless a period of 5 years has elapsed from the date of such member ceased to be a director for the reasons mentioned in subsection 4 of section 40. Stop. Admittedly, in the instant case, the period of 5 years has not been elapsed. Correct?
My lord, correct.
Elapsed. And therefore, the interim prayer sought prima facie cannot be allowed.
But we will add only one thing, 5 years from the date of their default.
5 years from the date of the default. Admittedly, from the default. As such, the interim prayer sought for is rejected. List after 4 weeks on a date to be fixed by the registry. Yes.
68.
Yes.
This is regarding non-payment of area, my lord, against the land acquired for the purpose of national highway, my lord.
When land was acquired when?
In the year 2021, my lord.
2021?
Yes, my lord. Part payment has been made, my lord.
Some payment has been made. How much left?
66 lessons, my lord. 3 katha 6 lessons.
How much payment is, how much is the outstanding?
Outstanding amount has not been informed to me.
But some amount you have received.
Yes, my lord. Page
Yes.
19 will reflect, my lord. Page 19 will reflect, my lord.
Page?
19, my lord.
Alright, you take instruction.
My lord, Lordship may look into it, my lord. 3 and 3D notification under ANS Act is issued by the Ministry of Road Transport and Highways. Ministry of Road Transport and Highways not made a party. Work is executed by the NSIDCL. NSIDCL is not made a party. Land acquisition is made by the Kala.
Then how, if you do not make the appropriate
My lord.
authorities a read respondent
My lord, Karbi
whose
Autonomous Council
presence
also
is
made a
necessary
party.
for the
My lord,
effective
I have made the-
adjudication.
I have made the principal secretary National Highway Mandal Party.
No, National Highway itself has to be made a party.
My lord, I have made party. my lord.
Where have you made them party?
One, my lord. National Highway is 2, my lord.
That is National Highway Authority of India.
Yes, my lord.
Ministry of Road and Transport should be made.
No, he has made NHAI a party.
NSIDCL, my lord. National Highway Authority.
NHIDCL.
Road is constructed by
Mr. Council, it is
I will
for
make them party,
it
my
is for your benefit that the proper respondents are irate, correct? Otherwise, any order passed by this court will have no meaning if the concerned departments are not before this court. So you make the appropriate correction. You file an application. Now you have to file an application, and after that, we'll issue notice. There's no point of issuing notice at this stage.
Another Karbi Autonomous Council is also not by the represented by the principal secretary, by the chief executive member. So he should correct it also.
Just hear out the order. Please tell me the authorities that you think is necessary. It is submitted by Mr. J. Chutia, Learned Standing Council, KAC.
My lord. And also Kala, my lord. Kala
Here,
is not by the party.
In this, you are appearing as Standing
That's
Council.
for number 6, my lord.
SCKAC for respondent number 6. For respondent number?
6.
6 only?
Yeah.
For respondent number 6. That. Yes, now tell me one by one.
My lord, the Ministry of Road Transport and
Ministry
Highways.
of Road Transport and Highways.
Government of India issued
Government
the
of India. Government of India.
Issued notification under section.
No, just tell me the
my
names.
lord. One. Second is the National.
National.
NSIDCL Highway Infrastructure Development Corporation.
Karbi Anglong.
No, National Highway Infrastructure Development Corporation.
Pala. National Highway Infrastructure Corporation Department.
My lord, third by the Kala, Competent Authority for Land Acquisition appointed under National Highway Act. There is Joint Secretary, Department of Revenue, KAC.
Please, Mr. Chutia, can you ask one of your junior to just give the names? Otherwise, they'll be confused.
And the Karbi Autonomous Council represented by should be represented by Principal Secretary.
Represented by the
Principal Secretary.
Principal Secretary are the necessary parties in order to effectively decide the issue in hand. However, the said authorities have not been arrayed as party respondent in the instant writ petition. Stop. Let petitioner obtain instruction in this regard and do the needful within a period of 3 weeks from today. List on a date after 3 weeks fixed by the registry. Please give those. Yes, Mr. Bora.
May I plead the Lordship?
What is this?
Petitioners all are residents of a particular residential area, my Lord, before your Lordship, against the setting up of a IMFL offshore within the in violation of the, my Lord, provisions of the Assam excise rules, my Lord. My Lord, the violations we have stated at paragraph 5, my Lord.
I can issue notice, but at this stage,
my Lord,
stay will be difficult because...
no, my Lord, what I pray that, my Lord, because the allegation, that is specific. Because as per the provisions of the rules, my Lord, if there is a temple or a temple which has a structure, a pakka structure of more than 200 square feet, here specifically I have stated that within 71 meters from the wine shop, that particular...
Mr. Bora, what is the status now? What is happening?
My Lord, they are...
you must have filed a representation.
Yes, but that has not been considered.
Correct. And till now they have not issued the trade license?
Trade license issued, my Lord.
Trade license issued?
Yeah, after filing of this writ petition, they have issued the trade license,
no, because one of your interim is
yes,
not to issue. So that they have.
They have
now,
issued...
you don't want it to be started.
Yes,
that is what you are saying.
Yes, ma'am. Status quo as on today, they are preparing.
If we dispose of this petition with the direction to the authorities to look into the grievances of the...
and only thereafter they can start.
Yes. Are you satisfied with that?
Submit one thing, Your Lordship. There was an inquiry conducted against which I have received the copy. If I may submit, Your Lordship.
And my
this
Lord,
is an inquiry as regards
as
the
regards the shop of
grievances.
the, yes, the shop of the petitioner, because the excise department always conducts an inquiry before opening of the shop or issuing license. In fact, surprisingly, there is another IMFL offshore which is only 800 meters away from the present shop, Your Lordship, and there have been no objection in that.
800 meters. That is not 800 meters. That is
just
not
near
in
800.
See, this inquiry otherwise has been done by the inquiry officer,
and
where the petitioner has not got any chance, correct?
Yes, sir.
Now, since the petitioners are the, you all are the residents of that locality.
Yes, my Lord.
In fact, we have the NOCs from the local residents, Your Lordship.
Hear me out, Mr. Gogot. What I am thinking is, why don't you give them an opportunity of hearing,
very well,
and thereafter you pass your whatever order you want to
we'll
pass. Until you do not complete that exercise, you don't start that shop. It is up to you how soon you want to complete that hearing, provided they cooperate. I think that would be fair enough.
Yes, my Lord.
Because otherwise, no point in keeping this matter or grant a stay order. That will also go against you.
Yes,
correct?
Yes, my Lord.
Mr. Bora, you are okay with that?
Yeah.
Where is the representation?
Representation at Annexer...
Page 24, Your Lordship.
Annexer 2, page 20. It starts from page 20. There are 3 representations filed before...
Do you want to file a fresh representation?
Yes, my Lord. Fresh representation.
So I will say that you file a fresh representation within a period of 1 week from today.
Yes, my Lord.
And after receiving within a period of 2 weeks.
2 weeks, Your Lordship.
2 weeks, you dispose of that representation in accordance with law by giving them opportunity.
Yes, my Lord. And till such disposal? Yes, my Lord.
Item 69, at a disposal of. Heard Mr. D.P. Bora, learned counsel for the petitioner. Stop. Also heard Mr. K.K. Mr. R.R. Gogoi, learned standing counsel.
Yes, Your Lordship.
Learned standing counsel, excise department, and M.S. Bora, learned government advocate for the state respondent. Stop. By filing the instant petition, under Article 226 of the Constitution of India, the petitioners are seeking directions inter alia to the effect directing the respondent authorities to consider the objections, representations submitted by the petitioners, praying for not allowing the respondent number 7 to set up his within quote IMFL OFF. This whole thing should be within double quotes, right?
Within double quotes, yeah.
Within double quotes, huh? Shop at NSCB Road, Krishna Nagar, Municipal Holding Number 36, Ward Number 9, Hojai Town. Stop. The brief facts of the case is that the petitioners who are, where have you described, the petitioners are about 25 numbers, no? Where have you described them?
My lord, the side.
The petitioners, where have you described, yes, alright. The petitioners who are residents of Krishna Nagar, Hojai, within a radius of 75 meters from the site proposed to be set up for the IMFL off shop of the respondent number 7. Stop. It is the specific case of the petitioners that the said IMFL off shop is being set up in the aforesaid location in violations of the provisions of the Assam excise rules. Stop. Paragraph 5 of the petition is reproduced hereunder for ready reference. Paragraph 5, correct?
Yes, my lord.
Mr. D.P. Bora heard the parties at length and perused the materials available on record. It appears that the petitioners have filed an application, have filed a representation to the respondent authorities for reconsidering the issuance of IMFL shop to the respondent number 7.
Yes, ma'am.
To the respondent number 7, however, no response whatsoever has been received till date. Stop. Mr. R.R. Gogoi, Learned Standing Counsel, submits that an inquiry has been conducted by the Inspector Excise, Hosai Excise Circle, whereby it is seen that the grant of IMFL of license to the respondent number 7 is justified. Stop. Next. Be that as it may, next paragraph. Be that as it may, this court is of the considered view that since the residents of the locality has certain grievances as regards the setting up of the IMFL off shop in the proposed location, comma, to which representations has also been filed, which has not been considered till date, comma, deems appropriate to dispose of this writ petition at the motion stage itself, directing the respondent number.
That would be your lordship.
Respondent number so and so
Three, Your Lordship.
Respondent number 3, to dispose of the application which shall be filed by the petitioners within the period of 1 week, after receipt thereof in accordance with law within a period of
2 weeks.
2 weeks from therein. Stop. Alright, I think it is sufficient. Till needless to clarify that till the respondent number 3 disposes of the application filed by the petitioners in this regard, it is respondent number 7, but he is not here, no?
He's not here,
R7.
Your Lordship. Respondent number 7 is not present, Your Lordship.
The proposed IMFL off shop shall not be started. Stop. It is further made clear that that all the stakeholders involved in the matter shall be duly heard before considering the application filed by the petitioner.
And they were speaking out of the past, Your Lordship, that will be better.
No, because you see R7 also has a right.
Yes, Your Lordship. After hearing both the parties speaking out of the
Alright. It is made clear that after hearing the parties involved in the writ petition, a speaking order shall be passed. I'll edit this later.
Yes.
Highly obliged, Lordship.
Deeply obliged.
May I please, Your Lordship? My Lord, it's eviction matter, my Lord. Impugned notice, Lordship will find page 35.
Page?
35, my Lord. Annexure 7, my Lord.
Yes.
My Lord, may I read, my Lord?
Yes.
It is observed that you are encroaching government land measuring 0 visa.
This is eviction?
My Lord, eviction. Covered by Doc number 119, Revenue Village, Bongaigaon, Town Part 1, under Bongaigaon Revenue Sub-Board. As per directions of District Commissioner Bongaigaon, so and so, you are hereby directed to vacate the aforesaid plot of land and remove your structure and establishment with immediate effect. Further failures. Now, Lordship will find, I have annexed the my Lord Sita copy, that Lordship will find at page 26.
Page?
26. Annexure 2, my Lord. In the, my Lord, impugned notice, it is mentioned as Doc number 119, my Lord. Now, Lordship will find Doc number 119 is a, my Lord, railway land, my Lord. That in vernacular, Lordship, I have also annexed that vernacular Sita copy, my Lord. It's a remarks column, it is railway land, my Lord. And now, Lordship will find page 29. 29, my Lord.
RR Gogo Didigo. 29 is what?
This is, my Lord, certificate issued by the, my Lord, authorized officer, my Lord, NF Railway, my Lord. That Lordship will find that may I read, my Lord. This is the certified that the...
What is your prayer?
My Lord.
What is your prayer?
Prayer is, my Lord, I am challenging that impugned notice because, my Lord, the circle officer has no jurisdiction and authority, my Lord, because it is the, my Lord, railway land, my Lord. So, my Lord, the circle officers cannot, my Lord, issue that notice, my Lord.
Yes.
And
the first thing is that whether the petitioner has been able to make out a case for interference by this court. He has already admitted it is a government land. The Sita, the Jamabandi very clearly shows that it is a Sarkari land. So the meaning of Sarkari land is the government land. So he is saying that he has been allowed to be in possession by the railway authority. I don't know what kind of right he has accrued by way of such certificate being issued by officer. I don't know whether they are authorized officers of the railway.
As of now, he is in possession.
Yes, that is what he is claiming. But that apart, these are the certificates that is...
Mr. Borwa,
yes.
You obtain the an issue notice, and till that next date, you don't. If he is in possession, let status quo.
Because
if he's in possession, why to? Because he's been there since.
No, the possession doesn't
Page
give
30
him the right to be
I'm
there.
not declaring his right, correct?
Yes.
But instead
Page
of
30 is the-
depossessing him right now,
Yes.
I'm not even staying this order. I simply say that you don't take. Let status quo be maintained till the next date. Simple order.
Page 30 is the certificate issued in the
Page,
year
page.
30, my lord. 2017, my lord, wherein the circle officer himself admitted
See,
that.
because this is otherwise he's staying there only because of that. On the next occasion, you file your affidavits, and if something is there, this court will not extend the stay. Status quo only till the next date.
Page 30 is the, my lord.
This notice
This
is only
certificate is what? Issued by
circle
the
officer himself,
revenue
my lord.
circle officer.
Yes, my lord. Wherein, my
Has
lord, it is
possessed a plot of railway land.
my lord.
Now, how have you you have to prove your possession, because Mr. Borwa has raised a very pertaining question of how did the railway settle this land on your
Railway allotment has been
with
given,
you?
my lord.
Huh?
Railways, my lord, the government has allotted because the Sita copy itself says that it is allotted to
All
the
right.
railway, my lord.
Anyway, today is for motion. So, heard Mr. R. Sharma, learned counsel for the petitioner. Stop. Also heard Mr. S. Borwa, learned government advocate for the state respondent, and Mr. A. Bhattacharya, learned standing counsel, revenue. Stop. By filing this petition under Article 226 of the Constitution of India, the petitioner is assailing the impugned notice issued under memo number capital BNGC-14/2012/448 within bracket A, dated 14/6/2024, issued by the Circle Officer Bongaigaon, Revenue Circle Bongaigaon, within bracket Annexure 7. That is the Annexure 7 is that eviction, no?
Yes.
Stop. Let notice be issued, returnable 4 weeks.
15 days.
Mr. S. Borwa, learned government advocate, accepts notice on behalf of respondent number 2, 3 and 4, and A. Bhattacharya accepts notice on behalf of respondent number 1. Correct? Extra copies within the period of 2 days from today. It appears from that certificate is at page 30.
My lord.
That certificate is page 30.
Certificate of circle officer?
Yes.
Yes, my lord.
It appears from the certificate dated 22/11/2017 and enclosed as Annexure 4 to the writ petition that the petitioner is possessing the subject plot of railway land prior to 1997.
My lord.
Prior to 1997. Stop. In the interest of justice, let status quo as regards the subject land be maintained till the next date of listing. Stop. List after 4 weeks on a date to be fixed by the registry.
One thing, they have made 5 petitioners. Who are these petitioners? We do not know. Yes, because if it is a registered Sangha, the Sangha is registered in a different name. Krihi Bikah Sangha, not Bongaigaon, and the petitioner's name is Ahom Krihi Bikah Sangha. If I take it to be the same, then who are these 4 other
So
petitioners?
I'll say the subject.
Secondly, the entire case is based on
the certificate talks about this Assam Christi Bikah Sangha, right?
Yes.
So I will say status.
Certificate of registration is different, man.
Yes.
Little different.
Page 11, my lord, I have specifically stated that.
All right, on that returnable date, you file your returns and bring everything.
And I pray the railway may be paid party because their entire claim is based on the railways.
I have
make them a party. Why to unnecessarily
I have
get
no
into
any
all that?
grievance against the railway.
But
That's
if
why.
there, you see, the railway has at Korea, it appears that the presence of the railway is essential for effective adjudication of the matter, as the lend, as the subject lend has been alleged to have been given to the petitioner by railway.
Yes.
Correct?
Yes.
Stop. Let petitioner obtain instruction and do the needful in this regard.
Obliged.
Before the next date of listing.
Obliged.
Item number 3.
Yes, Mr.
My
Mahmood.
husband was brutally killed by the private respondents. My husband was killed by the private respondents.
Your husband was
killed
killed
by the private respondents, and they kept his dead body in a pit, and my lord, in that dig they kept a cow, so that people may consider it as a case of accident. Later on, I went to one local outpost, Boribazar police outpost, in the district of Borigaon. But police told that it is a matter of accident, so he compromised take rupees 2 lakhs. So it appears that the police is very much interested with them. So under compelling situation, I approached the SP. Learned SP sent the FIR to the police station, and police station thereafter, Wikivita police station thereafter registered the case and asked the police to investigate. But after some time also, we didn't know about the police
They will
officers.
issue notice.
No, they were asked to take instruction by the last order. And if
Yes, Mr. Borwa, you have the instructions. I think Miss Borwa in the morning
yes,
was there.
Unfortunately, I don't have the file, so that's it.
I
Just
think
give
she
me-
has it. She was mentioning something has come.
If I rightly remember, is it something relating to the non-registration of taking appropriate actions against the FIR?
Yes.
So in that case, the petitioner has an alternative remedy.
That's
to,
right. That is what she was submitting.
Sudhi Bhaskar Tambe and Sakira Basu.
Alternative remedy,
Alternative remedy is very much available.
Section 1.
But Mr. Borwa, you see on 12/6/24.
In many such cases, this honourable court also have dismissed those cases,
Yes,
asking
but,
them to approach the appropriate.
That is one thing. Dated 12/6/2024, whereby the government was directed to obtain instruction as regards the status of investigation.
There she comes.
Ms. Borua, in view of the judicial order that was passed on the last occasion, whereby you were asked to obtain instructions as regards to the status, have you got it?
Yes.
Yes. Investigation appears to be going on, Mr. Mahmood.
Investigation is going on. The
Statements have been recorded.
accused person regularly coming to police station. Gandhi page 22 man.
No, but you see, in such a situation,
Page 22.
there is nothing otherwise. Which is the decision you were referring to?
Yes, that's it.
Some photos I have annexed of the dead body.
Which
Page
is
20.
Sakiri Basu.
Sakiri Basu is one, and there is another one you said. Show me.
Wait. On my photo.
I have also so many judgments. Lolita Kumari. Then, my lord, I have also studied
One
here.
second, Mr. Mahmood, just 1 second. You do one thing, Ms. Borwa.
Yes, sir.
You file an affidavit.
Yes.
You give chance to the other side to rebut and say whatever they want to do. After that, this court can always pass. This matter is still at the motion stage. Notice has not been issued. So I am issuing formal notice and let them file the
A short date may fix, otherwise
Yes, yes. All right.
they will vanish the witnesses.
I will bring this
Yes.
report on record.
MS S. Bora, learned government advocate, in terms of the order dated 12/6/2024, has placed the status report in connection with
With Mikrivita PS case number
in connection
70
with JRG.
Mikrivita PS.
Yes, I got it. In connection with Mikrivita PS case number 70/2024, registered under section 302/34 IPC. Stop. Issue notice returnable on given date after vacation on such and such date. Let the aforesaid instructions be placed by way of an affidavit before the next date of listing. List this matter on such and such date. Return the instructions.
Kindly last week of July, Lordship.
All right. Because there is vacation in between, Mr. Mahmood. I'm returning these to you.
Yes,
huh?
Lordship. Always.
Item number
16.
Item 16.
You want some accommodation?
No, my lord. I am basically, I have a simple prayer, my lord. At page 50, your lordship will find an order passed by the department.
Page?
50.
Yes.
There is an order of demolition issued against the respondent number 5 herein, my lord. It says, my lord, whereas Honorable Guwahati High Court, by its order dated 18/1/2018, in connection with review petition number so-and-so, clearly held that building permission issued by NOC number so-and-so dated 14/11/2002, granted to Sheikh Nur Alam based on a false affidavit submitted by him was not a valid permission, and the building constructed by Sheikh Nur Alam on the strength of NOC dated 14/11/2002 is invalid in law and unauthorized. Whereas all the petitions submitted by Sheikh Nur Alam were disposed of, and a notice under section 88 of GMDA Act was already served to Sheikh Nur Alam, directing him to demolish the building of height number so-and-so dated 30/6/2015. Therefore, I so-and-so, Chief Executive Officer, Guwahati Metropolitan Development Authority, to hereby direct Sheikh Nur Alam, Ulugadi Bazar near so-and-so, Ashram Road, Guwahati 7, to demolish the unauthorized construction which is in violation of provision of GMDA Act 1985 zoning regulations and building bylaws made there under in pursuant to order of Honorable Guwahati High Court within 5 days from the date of receipt of this order. Failing which GMDA will be free to proceed with the demolition or sealing. Well, this is the order issued against the respondent number 5. Well, I am the petitioner herein residing in the adjoining land, my lord. Well, basically, respondent number 5 and the petitioner are brothers, my lord. They have a joint property out there. Well, there are long civil suits are pending before the court, my lord, regarding their partition. In the meantime, he obtained, respondent number 5 obtained a NOC by forging the signatures of various brothers and obtained that NOC hiding, my lord, all the facts which has led to the various cases in various courts, my lord. After all, my lord, the GMDA, after perusing all the records, issued a revocation order by which the NOC issued in favor of him.
Your prayer in the writ petition is to demolish the illegal construction of R5.
Yes, my lord. And this is the order, my lord.
But there is a dispute pending.
Well, there is no dispute pending with regard to this, my lord. The NOC obtained by the respondent number 5 is a forged one.
You are challenging that NOC.
My lord, that NOC, they have challenged, my lord. The petition, the respondent number 5 filed a writ petition challenging the revocation order issued by GMDA. Well, the writ petition, in the writ petition, your lordship will find.
No, in the writ petition, your prayer appears to be directing the respondent authorities to demolish the illegal
to comply the order, basically. The order they have issued, my lord, after
order
considering.
At page 50.
Yes, my lord.
Yes, Mr. Bora.
But I need to get instruction. There is a provision of section 71 of the GMDA Act, my lord.
Section?
There is a provision 71.
You have not filed your
I have
affidavit.
not filed, my lord. That instruction I will get it, my lord. If there is appeal is pending, because against that order there is a provision of section 71 appeal. The appeal will be before the district judge.
71 is, my lord, is on a different footing, my lord. 71 is an order passed against a person who is...
My lord, I am not holding the GMC Act, my lord.
All right, we are posting it after vacation.
Because I will get the instruction.
In the meantime, you get your instruction.
Lordship.
Mr. S. Bora, Learned Standing Counsel, GMC, seeks some accommodation in the matter to obtain instruction as regard whether any appeal
under section 71 of the GMDA, 71 of the GMDA Act 1985
is pending.
There is no appeal pending, my lord.
Mr. Your name?
S. Biswas, my lord.
Mr. S. Biswas, Learned Counsel for the petitioner, however, submits that no such appeal is pending. Stop. He is saying no appeal is pending, then?
And the appeal will be before the district judge, my lord.
No, my lord. This is an order, my lord.
The petitioner, if appeal would have been filed, who would file?
The person against whom this order has been issued. He will file an appeal under section 71.
Respondent number 5.
Respondent number 5.
Well, he already filed a writ petition. Writ petition was dismissed. Then they filed a review petition. Review petition was also dismissed.
Be that as it may, 2 weeks' time is granted to the parties to apprise the court as regard if any such appeal is pending. Stop. List this matter after 2 weeks on a date to be fixed by the registry. You have it. If you can also file your affidavit saying that it is not there. Yes. I shall resume in 5 minutes.
As per order dated 22/5/2024.
One WPC is also, few WPC has already been disposed of.
This case was also earlier disposed of, Lordship. But again,
yes, Mr. Purva?
That WPC has been reviewed and that has been restored. So now thing is that in this particular case, we are already prepared the affidavit which will be filed within this week. So let it be listed.
As per order dated, complaint is required, Lordship. One complaint has been filed, Lordship. As per order dated 22/5.
All right, he has said he has received
we will file
instructions. Let him file his affidavit.
We will file the detailed.
Why are you apprehending that he will not bring the complaint on record?
We will file a detailed.
Mr. S. Borwa, Learned Government Advocate for the state respondent, submits that in view of the order passed on 22/5/2024, comma, he has received instructions and the same shall be brought on record by way of affidavit. Stop. Prayer allowed. List after date of the DDB. After the vacation. End of July.
End of July, Lordship. File.
Right. You were. This is that matter on that day, Mr. Bora.
Yes,
you had come here. All right. This matter has been listed today with the remark for dismissal in the cause list in view of the fact that there was no representation on behalf of the petitioner when the matter was called on the last date, 19/6/2024. Stop. Today when the matter is called, comma, Mr. N. Bora, Learned Counsel for the petitioner, is present. Accordingly, as such, list this matter. When do you want it? Date?
Any date, man.
List this matter after August. On 26th July, so and so. For admission. Admission, right?
Mine.
Tag matter is asylum. 25 or later. Yes.
Lordship, in this case, mention was made in the morning on my behalf, Lordship. So Lordship, in this case, the instruction I have sought for from my client is awaited. They have claimed that certain amount has been deposited in my account.
So it was the status of payment is you were supposed to intimate.
Yes,
so do you have it?
No, Lordship.
You want some more time for that?
Some more time, Lordship.
All right. Actually, this was mentioned in the morning,
Yes,
but
sir.
I thought it is from the state government that the status report has to come. So
No,
there was a confusion. Anyway,
amount has been deposited and
Yes.
to the
that is
deposited, general manager.
See, he
So
wants to
there is only
take
for disbursal.
he wants to obtain instruction from his client, but if it is deposited, it is deposited.
It is in their record, Lordship. Marks at X.
It's already in the record in the last occasion.
Last occasion, Lordship.
It has been flag marked.
Mr.
P.P. Datta.
P.P. Datta, learned counsel for the petitioner, submits that he may be given further time to obtain instruction from his client as whether the payment has been received by his by the petitioner or not. That is the only thing.
That's the only thing.
Needless to clarify that if the sought, if the information, if the aforesaid information is not placed before this court on the next date of listing, this court shall take cognizance of the, which is that 2110, the communication dated 21/10/2021, marked as X, showing that the subject payments have already been deposited to the account of the petitioner. Correct, Mr. Borwa?
Yes.
Yes, sir.
So last chance we are giving. If he doesn't give, we'll close it.
List after, Lordship?
List after reopening date. List on such and such date.
Lordship, on the last week of July, Lordship.
VIVEK Pavone.
Lord, I am extremely sorry, my lord, on the last.
All right.
My lord.
It appears that this matter has been listed today with the remark for dismissal in the cause list, as on the last occasion, I-19/6/2024, there was no representation on behalf of the petitioner. Stop. However, today when the matter has been called, Mr.
A.R. Bhuyan, my lord.
A.R.
Bhuyan.
Bhuyan, learned counsel for the petitioner, is present for the petitioner. Stop. This is an eviction matter. Anything to do?
My lord,
Pleadings are completed?
No, my lord, the issues are live, my lord.
All right, I'll post it after vacation.
Is a shop has been established in the Vijaya land.
List this
Inspection has been done.
matter after vacation date, did you, for admission?
My lord.
Is that the admission stage?
Yes, yes.
For admission.
Obliged.
Anything, Mr. Borwa?
No.
Actually, these for dismissal, it should have come in the column of orders.
Yes, that's what I was wondering.
Because otherwise,
ultimately, otherwise the matter could have been heard.
Yeah. Yes.
But so later matter be taken after some time.
No, 28th.
Yes, sometime. Why?
Mr. Esbora is on legs.
What is? Huh?
Mr. Esbora is on legs court too.
No, Lordship, in this matter, we, on behalf of the Deputy Commissioner, we have obtained our instructions, so we would like to place it on record by way.
What is your what is the instruction?
Instruction says, as regard the land, the dogs which are in possession of which petitioner. So there are Gulab Boro and another Binoy Boro. So the dogs under which Gulab Boro and Binoy Boro are in possession has been clearly specified here. The field verification report of the Lat Mandal is also been narrated.
Gulab Bora and Sikan Boro. Yes. But you filed this by way of an affidavit.
That's what I will file it.
Mr. S. Borwa, learned government advocate for the state respondent, submits that he has received parawise comment and accordingly seeks time to file the same by way of an affidavit. Prayer is not opposed. List this matter after 3 weeks on a date to be fixed by the registrar. So 21 matter, let the affidavit be filed. It will return to anybody. Yes. None appears for the petitioner when the matter is called. Stop. It appears that Mr. K. Gogoi, learned Standing Counsel, learned CGC
For railways.
For railway.
Railways.
For railways is present. For the respondent railways. It appears that this matter was. It appears that this matter has been listed today with the remark for dismissal in the cause list, as on the last occasion, i.e. 21/6/2024, there was no representation on behalf of the petitioner. Stop. Today also, there has been no representation on behalf of the petitioner. As such, in view of the consecutive non-appearance on behalf of the petitioner, this petition stands for non-prosecution.
Otherwise, the work is completed, that's why they are lawsuit. And 30 also same lawsuit.
30 also same, disposed of, 29 and 30.
Habla Julus.
Disposed of, okay. Yes, Mr. Goswami. What is the instruction?
They need some more time, Lordship. They could not press.
Instruction for time?
No. They seek some more time, Lordship, for instruction, Lordship.
That's right. Your instruction is seeking more time.
Lordship, no more time may be granted. No more time may be granted, Lordship. India, the situation is such, and all the petitioners are sort of they are starving, and they are living on an embankment after being evicted from their.
What is a prayer?
Prayer is for compensation.
Compensation for? Compensation for?
Acquisition of land.
For acquisition of land?
Yes, ma'am.
When was the land acquired?
Land was acquired in 2007.
2007? By state government?
Railways.
You are appearing for?
Government. He is for railways.
2007 by railways. Who is to give the compensation?
Compensation will be paid by the district commissioner.
Railway Lordship.
The deputy commissioner has to assess and send it to us, Malad. We will make the final payment, Malad. But Malad will produce the order dated 24/4.
Before perusing those orders, let me understand one thing. In this case, the factum of acquisition is not disputed. It is admitted, and it is also admitted that till date they have not got compensation, correct? This much is admitted. Now the question remains, by when they can be compensated? Because you see that basic human right is at stake.
Yes,
this cannot go on like this. The Constitution, human rights are at stake. He has been deprived of his property since 2007 without a penny. How can this be done?
And they have also been evicted. In last November,
So
they have been
therefore,
evicted.
either you come up with some action right now, or otherwise I am saying that whoever has to do will complete the exercise and within the period of 2 months from today, and I'll dispose of this writ petition. Because the factums of acquisition is admitted. Now, this court is not really concerned with how your internal organs are functioning, why the district administration has not sent it to railway, the assessment. This court is not going to go into all this. Otherwise, this court will ask everyone to be present in this court and explain who is doing what. So instead of going into all this, I think a simple disposal would be better.
According to Railway Lordship, that plot of land is government land, Lordship.
That is mentioned in the order. That is why a clarification was asked
Not
from
government
the
land, my lord.
deputy commissioner.
No, you see, you said that a clarification has been called from the office of the DC. What is the office of DC doing till today? You invite me to go into all these matters? This court has no difficulty. This court will go into it.
If I may interrupt, Lordship. Lordship would see Page 22, Annex 4.
Page
22 of the writ petition.
See, Mr. Goswami, Mr. Gupta, you are understanding, right?
Yes, sir.
It is at the end of the day, since 2007, he has been evicted out of his land. And it appears it has been done without following the due procedure of law because he has not been compensated.
Okay. Because we could not get that original land acquisition record, Lordship. That was sent to the district judge.
This court has been giving you time. You are not coming up with anything. Today you are giving me an instructions whereby the additional district commissioner is seeking for more time. He must, time should not be sought so casually in these matters, where the constitutional, statutory and human rights are at stake. Isn't it?
Can you next page of my instruction, Lordship?
Alright, I'm doing one thing. I'm posting this matter on the reopening day. Positively on that day you come up with whatever instructions you want. Whatever positive instructions in favor. Basically this court is only interested within which, how much time you can complete the exercise. I'm going to indicate that in the order.
My Lord, one small prayer. If they fail to do so,
no, Mr. Counsel,
the circle officer and ADC to be present in this court.
You hear out the order. Heard Mr. Your name?
A.K. Das.
Heard Mr. A.K. Das, learned counsel for the petitioner. Stop. Also heard Mr. N. Goswami, learned government advocate for the state respondent, and Mr. H. Gupta, right? Mr. H. Gupta, learned. You are appearing as learned CGC for the central government, and A. Bhattacharya, learned standing counsel, revenue. Stop. It appears that the petitioner has been evicted way back in 2007 and not a single penny has been paid till date. Stop. It further appears that time and again instructions were called from the state respondents in this regard, and in fact on 14/6/2024, this court, by way of a last chance, granted the state respondents to bring on record the information sought. Stop. Regrettably, today when the matter has been called, a letter dated 24/6/2024 received from the office of the Additional District Commissioner Kamrup Amingao has been placed before this court, whereby more time has been sought for submitting the requisite instruction. Stop. This court depreciates the casual approach of the state respondents in dealing with matters where the constitutional, statutory and human rights are at stake. Stop. However, before passing any adverse orders, this court, at the assurance of Mr. N. Goswami, learned government advocate for the state respondent, provides further time to bring on record the instructions sought earlier, and also to all the respondents to apprise this court as regards the time frame within which the entire exercise of releasing the compensation to the petitioner can be released. Stop. List this matter again on
17.
Needless to clarify that failing any response, any positive response from the respondents, comma, this court shall consider, this court shall proceed in the writ petition in accordance with law. I am returning this back. You want to say something? But I have said at the end all the respondents. So therefore you all find out, make your own plans. If something has to go from the Office of District Administration, you do it. If they are not entitled, you come up. I am not saying that you give something if somebody is not entitled. But you cannot be sitting silently in the matter. Do whatever is to be done and take back this instruction. Yes, Mr. Sharma.
Myself, Vikash Bucha, Lordship, petitioner.
Vikash
Bucha, petitioner in person.
B. Bucha.
Yes, Lordship.
Right.
Lordship, the last order passed by the Honorable Court on 19th June may kindly be seen.
Yes. Affidavits were required to be filed. Mr. Nath, you were required to apprise the court the progress, if any, in the complaint filed by the petitioners under the PC Act, in which the Home Department has now filed an affidavit stating no sanction is required. Yes, what is the status?
From the SP Vigilance, I have received a communication. They have sought for some time to apprise the position. I pray for taking up the matter after the
Nath, this is a very simple information that has been asked for.
That's true. No,
you are just supposed to inform the court what is the progress. Why further time has been sought in such a matter?
They have said that the position is this. Earlier the complaint, after receipt of the complaint, the vigilance has sought for a sanction from the government. Government has rejected.
This is already mentioned in the last order that sanction is not required.
Yes,
in terms of Surinder Kumar Bansal versus State of Punjab.
That is the subsequent affidavit filed with the government. Now I have already communicated, but the SP Vigilance, they have said that in view because they were not aware of the affidavit filed with the government. We have handed over a copy to them, and after that, they said that some office memorandums are there. They are examining the matter. They have said that some time may be given to us so that we can apply the honorable court.
Lordship, the affidavit has.
One sec, Mr. Bucha. See, Mr. Bucha,
please may seek
Mr. Bucha,
186.
You see, since some time is sought,
no, Lordship,
a last chance.
That is the problem. That is the problem,
Mr. Bucha, please hear
since
the
last
court.
3.5 years,
Mr. Bucha, please hear the court.
Lordship.
There is a judicial order of 19/6/2024, right? And as per that judicial order, they were supposed to give us some instructions. However, some time is sought. This court will not give them the 4 weeks time that they have sought. This court will fix this matter on the reopening. As a last chance, they will be provided. If they don't give anything on that day, this court shall proceed.
Lordship, before you
save your energy for the next date.
Lordship, I have already submitted the copy of the affidavit which they have submitted, and they are saying that if they are not in the knowledge. So this is the letter which I have already submitted to this court on 186 page number.
Mr. D. Nath, learned senior government advocate, produces a copy of the communication dated 25/6/2024 issued by the Office of the Superintendent of Police Directorate of V&AC Assam, whereby further 4 weeks time has been requested to submit the instructions as sought earlier by this court by order dated 19/6/2024. Stop. Since the instruction sought pertains to the status and progress in relation to the complaint filed by the petitioners, this court fixes this matter again on reopening date, on such and such date, by when the requisite by which the requisite instruction shall be positively placed by the state respondent in the matter, failing which the petition shall be proceeded in accordance with law. I'll keep this on record. A copy of the correspondence dated 25th June, but it is actually not required. You have submitted it.
As a logic.
It returned back.
One thing, if I may just point out, the last order,
Mr. Bucha and Rupak, please take all their names. Please give all the names appear in an appearance slip. Yes. What, Mr. Dekka, you are appearing in this matter?
Yes, I appear for respondent number 5, my lord. We were also supposed to file their affidavit. We had trouble serving the copy. We've done that today, my lord.
You have received?
Just right now.
You have received?
Yes.
If you want to file anything, you file it by the next date. So shall I record that?
My lord may do that. My lord, I was just drawing your lordship's attention to the last para of the last order, my lord. Petitioner 1 was represented by a counsel, and he had remained unrepresented. My friend here appears in person for petitioner number 2, my lord. Last paragraph says, if none represents the petitioner number 1 by the next day, the court will proceed to pass orders striking.
Who is for petitioner 1? Nobody is appearing.
No, Lordship, one counsel was there. He is out of station for his personal works, and Hemant is in Guwahati today, but he is suffering from fever. When I am entering this court, I have called him, but he was fever. That's why I have told him, don't need. I will replace the court, Lordship.
But let me mention this. Mr. B.D. Dekka, learned counsel for respondent number 5, submits that the necessary affidavit, that he has filed the affidavit as required in terms of the last court's order, has been filed today. Has been filed?
Filed today.
Today. With copy to the petitioner. Stop. It further appears that since there was no representation on behalf of the petitioner number 1, this court observed that in case there is no representation on behalf of petitioner number 1, but petitioners, how 2 persons will represent petitioners?
Which is that was
We are the joint complainants. We are the joint complainants.
I'm not getting into all this. Where is the one has to appear? How can we, if we start entertaining such requests where 2-3 set of people comes and represent it, there will be no end to hearings.
In fact, that was a concern raised earlier also.
No, there can't be. One has to you decide who will argue the case among yourselves.
It has been decided that I will argue the case.
Very well. Then.
But he cannot represent one. That's the difficulty.
Why he cannot represent? Because he doesn't have a power in his name.
My lord.
So then obtain. You obtain a.
He's not a pleader.
So should I bring in a power of attorney or?
Why are you not engaging a counsel?
Lordship, last time we have engaged in counsel, and the court has dismissed the petition.
See, Mr.
Lordship, let me
just hear this out, because you see, you both are otherwise there, and now in person you will not be able to represent the other person.
Yes, Lordship.
And unless the other person is here, there shall be always some difficulty. The respondents are entitled to object to all this, correct? Right. Now, you think over. I am not suggesting. I am only asking you to think about it. To avoid all this, you may come up engaging a person, lawyer. So think about it. Last partner.
This is, my lord, covert matter. My lord, first several orders, my lord. The matter pertains to ex gratia due to road accident.
Ex gratia?
My lord. My lord already passed several orders. My lord.
Yes. Is the case of the petitioner covered?
Yes, otherwise we have filed on affidavit laws. We have categorically mentioned case 39 laws.
Page?
39 of our affidavit laws. Filed by respondent number 4.
39. Yes.
There is a case which was filed also.
My lord. In this line, my lord may pass out.
In a motor accident.
Yes, my lord.
Dead. FIR was filed.
Yes.
Yes. Is he entitled?
We will consider Lordship.
Under which?
After verification, Lordship.
Which OM? Is there a OM?
Yes, Lordship.
Huh?
18.
Page?
18, my lord. 18.
Column 3. Serial number 3.
Page 15.
18, my lord.
18. Accident in public places or in public carriers. So
Serial
here
number-
it will be accident in public place, correct?
My lord.
Okay.
Serial number 3, Lordship.
Yes, I've seen.
Yes.
Disposal of animal. Heard Mr. S. Hawk?
M.R. Khandakar.
Huh?
M.R. Khandakar.
This is item 37.
33.
33. Heard Mr. M.R. Khandakar, learned counsel for the petitioner. Also heard Mr. N. Goswami, learned government advocate for the state respondent, and M.S. G. Hajorika, learned standing counsel, revenue for respondent number 1. B. Gogoi is there, finance. Mr. Borthakur, are you there in finance? And Mr. B. Gogoi, learned standing counsel, finance. Stop. By way of this petition, the petitioner is seeking ex gratia grant of rupees 2 lakh in terms of the notification dated 15/11/2014 on the ground that the petitioner's son, on the ground that the petitioner's son expired due to a road accident. Stop. The case of the petitioner is that on 10/3/2023 at around 7:30 p.m. while the petitioner's son was coming towards Kukurmara from Shiagaon, sitting behind in a bullet motorcycle bearing registration number AS-225 T-8392, and while they reached at Nuapara on 17th number National Highway, the rider of the motorcycle, due to high speed and negligent, having lost his control, injured the two persons seriously, and in such accident, the petitioner's son sustained serious injuries for which he ultimately died. Stop. Is there a police report here?
Yes, my lord.
Which is that?
Page 31.
The police report dated, dated
24/4/2023.
24/4/2023
2023
also reveals that the petitioner's son died due to a road accident on 10/3/2023. On a public road accident. It's a public road.
And we have filed charge sheet also.
It further appears from the affidavit in opposition filed by the
number 4.
Respondent number 4, that based on the FIR, a case has been registered at Chagaon Police Station, Videjaigaon PS case number 169/2023, registered under section 279-338-304 capital A IPC, and after completion of investigation, charge sheet Videjaigaon PS CS number 123 has been submitted on 29/4/2024. Stop. I have heard the learned counsels. No, then you say. As such, the petitioner, being the father, is entitled. Being the wife, being the mother, is entitled for getting the ex gratia grant of rupees 2 lakhs as per the government notification dated 15/11/2014. But since the same has not been paid till date, the instant writ petition has been filed. Stop. I have heard the next paragraph. I have heard the learned counsels for the parties at length and peruse the materials available on record. Stop. Next paragraph. Mr. M.R. Khandekar learned. Mr. N. Goswami, the learned government advocate, fairly submits that the instant case is covered by the notification.
This will consider a lot. This will verify all the facts.
Is covered by the notification dated 15/11/2014 for granting ex gratia compensation to the petitioner whose son was died due to an accident in the public area. Stop. The relevant portion of the notification dated 15/11/2014 reads as a chart similar order. Next, a perusal of serial number 3 of the aforesaid notification abundantly reveals that the petitioner's son, who was knocked by a vehicle to death in the public road, is entitled to the compensation of rupees 2 lakhs. Stop. Next paragraph. Further, the decision of this court in the case of Lakhidas versus Gyanendra De Tripathi, reported in 2023 volume 2 GLT at page 850, clearly covers the issue in hand. Paragraph numbers 10, 15, 19, 20, 21 of the aforesaid judgment is extracted hereunder for ready reference, which is as follows. A decision to para 9 not a Next paragraph. In view of the above, it appears that the petitioner has made out a case for grant of ex gratia compensation. Stop. Accordingly, in the interest of justice, this court directs the respondents to pay the ex gratia amount of rupees 2 lakh upon proper verification in terms of the notification dated 15/11/2014 to the petitioner within a period of 2 months from the date of receipt of the certified copy of this order. Stop. Next paragraph. With the aforesaid observation and direction, this writ petition stands disposed of. Sharmila?
My lord, may I say one thing? I can 75 also say. 75.
1 second. This is right now I've passed in 33.
33, my lord.
And
75.
33 disposed of. And 70?
5.
75.
My lord, same, my lord.
No, but what is the relation?
Relation
Mr. Goswami?
is 75, my lord. He is the
wife.
When you say same, it becomes very difficult because the dates, the incident, everything is different. And then later on, I and my steno have to dig the file to find out all these details.
Let them
Let them you have the file? 77?
75.
75 to the answer.
Here, petitioner is the wife, husband.
75 to petitioner's. They are petitioner's husband.
Husband died.
Petitioner's husband. So and the petitioner is the wife. And date of death? 4/1/2020. And where is the narration? The facts? Which page is the facts?
Facts, my lord, paragraph 9, page 10.
A paragraph to my dictate kori di. My facts je ko. On 4/1/2020 at about 2:45 p.m. the petitioner's husband and 5 other persons, while was standing at the nearby PWD road at Moirabari Bazaar, a truck bearing registration number AS-02 capital E-6266 came speeding from Loharigat to Moirabari direction and knocked down the husband of the petitioner, for which he sustained serious injury and finally died on 4/1/2020. Stop. Accordingly, an FIR being Moirabari PS case number 10 of 2020 registered under section 279-338-304 IPC was registered. Stop. Police reporter date to hobo 29/1/2020.
We have filed affidavit also.
And respondent number 4 affidavit. Which paragraph?
Paragraph 4, page 30-31.
Here also charge sheet, paragraph 4. Affidavit charge sheet to underline korisu. Charge sheet date to pai jabo pink flag eta lagai disu. Thik ase? Running page 31 hoy. All right.
Deeply obliged.
You are appearing. It appears that this matter was listed today with the remark for dismissal in the cause list, since there was no representation on behalf of the petitioner when the matter was last called on 19/6/2024. Stop. Today, when the matter is called, MS
A. Parasar.
A.
Parasar.
A. Parasar appears on behalf of the petitioner. Stop. You want to say something?
Lordship, actually the budget has been already released, Lordship. Lordship, may peruse.
MS, your name?
G. Hazarika.
MSD. G. Hazarika, Leonard, Standing Council, Revenue and Disaster Management, and Mr. N. Goswami, Leonard Government Advocate for the State Respondent, and MS Sharma, B. Sharma, Leonard, CGC are present.
This is a letter from the Joint Secretary of Government Revenue Department, Lordship, to the District Commissioner.
So now rupees 5 lakhs has been sanctioned for payment of the petitioner.
Lordship.
Huh?
Lordship.
Within how much time this will be done?
This will be done by Deputy District Commissioner, Lordship.
So I say you release this within a period of 1 month or 2 months? 1 month?
2 months.
2 months from today. Money has already been sanctioned. Okay? Do you still want to take time in this matter, which you wanted in the morning?
District Commissioner the District Commissioner is a disbursing authority, Lordship. He will disburse this amount. Lordship.
Yesterday they have sent the letter to the Deputy Commissioner.
So right now the direction has to be to the District Commissioner. Respondent number. Check and tell me, okay? MS S Bhattacharjee, right? No.
And I am G. Hazarika.
Sorry, I'm getting very confused. Sorry. MS G. Hazarika, Leonard Steering Council Revenue submits that the ex gratia payment of rupees 5 lakh sought as sought for in the instant writ petition has already been sanctioned by the sanctioning authority, i.e. Revenue and Disaster Management Department. Stop. She further produces a communication dated 25/6/2024, which is kept on record and marked as X, which indicates that budget allotment of rupees 5 lakh for making payment of ex gratia grant in respect of petitioners who, how is it petitioner related?
It's an NOK of
Son.
Lordship.
In respect of late Nil Bahadur Khanal, within bracket, petitioner's son, has been released with a online budget number 05-HAM/001-2024-25 within bracket 1-11 dated 25/6/2024 in connection with the instant writ petition. Stop. Mr. N. Goswami, learned government advocate appearing for respondent number 6, submits that the office of the district administration, that the concerned office of the district administration has received the aforesaid communication, has received the sanction. You said received yesterday, right? Has received the sanction, the said sanction letter yesterday.
Yesterday they have sent us.
Oh, they have sent it.
Yes.
Submits that the aforesaid sanction order has been sent to the office of the district administration only yesterday. Stop. In view of the aforesaid sanction, next paragraph, this court is of the considered view that this writ petition can be disposed of by directing the respondent number 6 to release the sanction amount of sanction payment, release the sanction payment of ex gratia grant to the petitioner within a period of 1 month from within a period of 2 months from receipt of the sanction order, sanction letter, right? Sanction letter. Stop. Let certified copy of this court's order be also furnished to the concerned respondent authorities by the petitioner. Stop. Disposed of. You give a copy. Within 2 months from the date of receipt of sanction order and or receipt of certified copy of the court's order, whichever is earlier.
Lordship,
yes.
Lordship, with regards to item number 61, Lordship, we have filed for an affidavit in opposition.
Item number
61, Lordship.
Yes.
We have filed for an affidavit in opposition, Lordship. The same may be called for. We have checked the records. It's not in the records.
Ms. Counsel, you are making a mention out of turn. You should have checked in the morning. Yes. Yes. There is one matter, that bar. We'll relist that matter after you choose a date after the reopening. When do you want it? Thursday? First Thursday? Thursday? Item number 63.
15.
63, na? In item number 63, due to paucity of time, this matter could not be taken up for hearing today. List again on Thursday date today, on so and so for further hearing. Yes.
Lordship, I have an unusual prayer, Lordship. Lordship, what happened today at 10:30, Lordship? I have mentioned before the Honorable Court, Lordship, for
court number 4, Lordship, for listing of an unlisted matter, Lordship. And accordingly, the
Bench 5 matter.
Yes, Lordship. It is already numbered. Now, from the registry, informed me that actually.
When do you want it?
Lordship, at 2 p.m. Lordship. Already it is numbered. There is an urgency.
Tomorrow,
Lordship.
tomorrow.
Disconnection of my water supply pipe, Lordship.
Tomorrow.
Since 2020.
You should have been more careful, Mr. Counsel. Tomorrow. This court can accommodate you for tomorrow.
On 23rd, Lordship, it is disconnected, Lordship.
Tomorrow.
Because water supply, Lordship. Already it is numbered, Lordship. At 2.
All right.
Lordship, kindly allow my prayer.
Yes, what is your prayer now?
Lordship, we have filed for an affidavit in opposition.
In item number?
In item number 61, Lordship.
61?
Yes, Lordship. The same may be called for, Lordship. It is not in report. We'll give a requisition, Lordship.
All right.
So deeply obliged, Lordship.
My private secretary has not come till now.
Actually, distribution of machinery. Machinery particular machinery particular factory.
What is this matter?
What the matter is the Lordship. The petition is a licensed timber shop holder, Lordship.
Huh?
Timber shop holder, Lordship. Timber shop.
Timber shop?
Yes, Lordship. Is the licensed Lordship. At the time, it is a licensed Lordship. It is licensed. Lordship, my shop, Lordship, has been sealed by them, Lordship. Sealed means just lock is put, Lordship. Without giving any opportunity, Lordship. And Lordship, prior to that, Lordship, only one simple incident has happened, Lordship. One person of my village, Lordship, he, Lordship, brought one piece of, 2-3 pieces of timber, Lordship, of his own parcel and tree, Lordship. That was not connected to the forest land, Lordship. And only for that reason, Lordship, one day, Lordship, they, Lordship, brought my machine, Lordship, which is a part of my shop, Lordship. It was in a separate place, Lordship. And thereafter, Lordship, after Lordship, some days, Lordship, they suddenly, Lordship, one day came and put the lock, Lordship. Without, Lordship, hearing me, without giving any opportunity, Lordship, to that aspect, Lordship. So, Lordship, it is the totally violation of law, Lordship. And this shop, Lordship, it was only my earning source, Lordship. I have taken the shop, Lordship, I have running the shop, Lordship, with taken a shop with a dental house, Lordship, dental room, Lordship. The rent
Yes, Mr. Wadakar?
Lordship, in our affidavit, we have written that the petitioner had actually violated his license conditions, which is why a criminal case was also registered, Lordship.
This matter perhaps will need some...
It will need some
hearing. So I'll
no, Lordship,
admit and post it for hearing.
Lordship, my means of livelihood.
Yes, I am admitting this petition. It's a 23 petition.
Lordship, may take
and I'll fix it for hearing after the reopening. It will need some amount of hearing, right?
Maybe tell admission hearing, Lordship, for disposal, Lordship.
Is that you are interested in a hearing, correct? This
Yes,
court is going to give you a hearing. But in terms of the procedure that is normally followed, your matter is for admission. It appears it needs a full-fledged hearing. We'll admit and post it for hearing on a date after reopening. Is there any difficulty? Yes.
নহলে চিন্ময় বৰুৱা আৰু মধুচিন্তা বাইদেউ দুজনক একেলগে মাতিম
My only humble prayer of Lordship, on that Lordship, we have given authorization to try to dispose of the matter, Lordship. Otherwise, my whole thing is taken by
Understood.
Yes, Lordship.
Very difficult to function like this when the infrastructures are not available. This court is now waiting because there is no stenographer. The 3 stenographers were there in the morning are already burdened with all the dictations that have happened. They are still typing. The 4th one has not come till now. It's very difficult. It obstructs the administration of justice if the basic infrastructures are not provided to the judges. Madhu Bedok Matok. They don't get nine. They don't have in charge nine. Chinmay Dagmadi, Chinmay Bro. Why you are not here at 2 o'clock? Nobody has informed you. Alright, sit down. This is item number 37. Heard Mr. M.
S. Hawk. S. Hawk.
S. Hawk.
Yes.
Learned Counsel for the petitioner. Stop. Also heard Mr. I. Borthakur, Learned Standing Counsel, Forest. Stop. This matter requires a full-fledged hearing. Stop. Admit list on reopening day first week.
Lordship, may I pray that matter may be listed after 20th?
Why? You have some personal difficulty? Mr. Gogoi will be there if you have a difficulty. You have a battery of lawyers appearing for Forest. Yes, one date on 19th July, 19/7/2024. If you are not them, make alternative arrangements. তাত লিখি দিবা since parties are no formal admission মোক খুদি লবা লাগিলে. Alright, that since they are respondents are all represented, comma, no formal notices.
May I please, Lordship?
Yes, you are appearing for the petitioner?
Yes, Lordship. Lordship.
1 second. Now for item 38. This matter has been listed today with the remark within quotes for dismissal in the cause list due to no representation on behalf of the petitioner when the matter was last called, i.e. 19/6/2024. Stop. Next para. Today when the matter has been called, comma, MS
S. Devi, Lordship.
as Devi, Learned Counsel for the petitioner is present. Stop. In view of the said, list this matter on such and such date for admission. 26 July. Yes, Mr. Ganguly. Government advocates were required to obtain instructions. Status of complaint.
Yes,
Yes. Is Mr. Majumdar appearing in this matter?
No, Your Lordship, I'll be appealing.
You are for?
Respondent number 4.
R4?
Private respondent.
For private respondent. Yes, Ms. Das?
My love, I'm awaiting instruction, my love.
How much more time?
My love, after dictation, my love.
what I pray is that the status of the complaints is all right, but the issue here is a question fell from the court. It was listed before Justice Sakia on the other day. The question arose principally as to whether for the second time physical position could be taken under Section 40. That was the principal issue that the court had put to me. I have taken there are decisions to support that.
Anyway, let them first come up with
the private respondent has also not filed any affidavit.
Yes, are you intending, or otherwise I'll say you are not interested to file affidavits?
Your Lordship, we have apprehension that the writ petition is not maintainable. So,
Mr. Counsel, whatever be your...
Your Lordship, in due course, if it is required,
the moment if some time may be granted?
You see, you have to choose. You can't be first trying your luck and then take time to file affidavit.
So we need some time.
You may file a detailed affidavit where you may take the ground of preliminary objection, ground of maintainability as a preliminary objection. This court will do what this court wants to do, but you can't be waiting for the preliminary issue to be decided first, and then thereafter again file. These things will only delay and prolong the matter further. You are filing an affidavit or you are not filing an affidavit?
Your Lordship, I need some time to take it.
Very well.
I'll take instant.
On the next occasion, affidavits, if not filed, this court will proceed with the writ petition in accordance with law. Am I making this very clear? Heard Mr. A.K. Ganguly, learned counsel for the petitioner. Stop. Also heard Mr. J.R. Datta, learned counsel for respondent number 4, and M.S. U. Das, learned additional senior government advocate for respondent numbers 1, 2, and 3. Stop. M.S. U. Das, learned additional senior government advocate, assures the court that the instructions as sought for by this court by order dated 5/6/2024 shall positively be placed by the next date of listing. Stop. In the meantime, Mr. J.R. Datta, learned counsel for the private respondent, also seeks time for filing affidavit in opposition in the matter. Stop. In view of the aforesaid comma, let this matter be listed after 2 weeks. 2 or 3 weeks, you guys want? 3 weeks. After 3 weeks, to enable the respondents to file their respective return in the matter. Stop. Needless to clarify, if the returns are not filed as assured, comma, this writ petition shall be proceeded in accordance with law. Stop. List on at the date of taking this going on again. Yeah.
Production list item number 1. May to your Lordship.
What your name to keep? Yes.
The petitioner before Lordship is a registered society Lordship under the Registration Act Lordship, and as per recommendation of the chief engineer of the PHC department Lordship, they have handed over the charge of the Navajyoti Nagar pipe water supply scheme. That Lordship will find Annexure 5, page 24. Annexure 5, page 24. This is to certify that and this is the handing over certificate Lordship to our registered society. This was done on 6th of
Mr.
March.
Counsel, what was handed over to you all?
The pipe water supply scheme that is run from that.
So basically for maintenance.
Lordship.
So the Navajyoti Nagar piped water supply scheme, not the scheme, it must be the Navajyoti Nagar pipe. The water pipe must have been handed over to you under this scheme for maintenance, correct?
Yes, Lordship.
Is it correct?
And supply water, Lordship.
And supply water.
So thereafter, Lordship, the list of different units has also been handed over, Annexure 6, page 25, and we are operating the scheme. And water have been supplied to the consumers. There are altogether 160 to 170 numbers of consumers, and there are Lordship.
How many consumers?
160 to 170
160 to 170.
Lordship.
Yes.
So thereafter, Lordship, we have operated a joint bank account with the Assistant Executive Engineer PHC, Mamuni Madam, along with the Petitioner Society. And after collection of the money, the monthly fees for water supply, we have deposited the said amount in the the said bank account. It is a joint account, Lordship. That is Annexure 12. I have given the deposition slip in the bank account, Lordship. And accordingly, we are continuing. But suddenly, Lordship, an unauthorized body, Lordship, they using the...
You said some water is going to be disconnected.
Yes.
What, not supply of water to you. You are only maintaining the pipeline.
Pipeline and supply water from that.
Supplying water to whom?
To the consumers, Lordship.
To the 170 consumers?
Yes, Lordship.
Yes.
Then suddenly, Lordship, that at page 40, notice has been served from an unauthorized society. These are the office bearers, Lordship.
Page 40?
Page 40.
Where is the translated copy?
A translated copy, Lordship, page 39.
Yes.
They have served a so-called notice to one of the consumers that since they have not paid the monthly fees amount, Lordship, they are going to disconnect the water connection. But our submission is that, Lordship, our contention is that these people, the three people, they are the respondent number 7 to 9. They are the self-styled office bearers, Lordship.
Mr. Counsel, please read this notice.
Yes. Kindly accept my greetings. Height resolution dated 2/6/2024, passed in general meeting of Navajyoti Nagar Khopani Jugan Asoni Porichalona Committee. It is hereby requested to the customer whose monthly payment.
So basically, some payments are due,
Yes,
because of which the Samiti has served this notice.
Yes, they have seen also because of receiving monthly water supply. They have
Who
to
is anybody representing the Samiti?
No, Lordship.
They have made a
It's
party.
it's a private body. Yes, yes.
They made a party.
Unauthorized body, yes, Lordship.
Yes.
9 to Lordship.
No, unauthorized, authorized, this will come later on.
Lordship.
But it appears there is some allegation that monthly payments are not made.
Yes. So ultimately, Lordship, pursuant to this letter, Lordship 15/6, we have replied that Lordship will find at page 40. 45. Page Annexure 17. We replied with reference to the above.
Yes, please.
With reference to the above cited subject matter, it is informed you that the aforesaid notice with regard to the dispute for default of area amount is baseless. Under what authority you have issued the notice for disconnection? We are regularly depositing the monthly fees in the joint bank account maintained with Assistant Executive Engineer PHC at 6 Mile Branch. Copy of the same is enclosed herewith.
Have you enclosed these monthly payments?
Yes, at Annexure. One of the deposition slip at Annexure 12, page 34.
Page 34?
Page 34, Annexure 12.
Alright, if I have understood you correctly, your case is that as per the appointment you have been maintaining and supplying water to the 170 customers under that scheme, and suddenly you have been issued notice by a committee which whose competence you are questioning. That is your thing, despite the fact that all the payments have been deposited in the bank. This is your case?
Yes, this is joint.
Yes.
And we approach the authority, Lordship.
You are PHE?
Yes, I'm representing.
So this is not your order.
Lordship, the issue is that I have taken a verbal instruction. This dispute is between two committees, Your Lordship. The first, presented by the petitioner, and the prior respondent. As per my instruction, Lordship, the prior respondent...
Mr. Gogoi, now the issue is their water to these 170 consumers cannot be suddenly stopped if the payments are being made. On the body of the petition, there are receipts which indicates that the payments are being made. Now, of course, you will take instruction, they will appear, these things will go on. But right now, this court, while issuing at the notice stage, is also thinking if any interim protection has to be granted, because at the end of the day, somebody's water cannot be just disconnected. That is the moot issue, right?
Lordship, true.
Now, it appears that it is not you whose order is under challenge.
Yes, Lordship.
Isn't it?
And the connection is stopped on basis of only this petition.
So what? Let me issue notice, and in the until the next date, no coercive steps in terms of that notice be taken. Let them appear. That Samiti whose orders are under challenge.
They have disconnected the water connection.
If it is disconnected, they will reconnect.
If I may submit one
So
thing.
in that case, I will stay this order. If I stay this order, any steps taken prior to this order then has to be restored.
Yes.
If I may submit
Yes,
one thing,
Mr.
Your
Gogoi.
Lordship. The site in charge has already informed me that they're going to be the meeting is going to be held between these two committees, and to resolve this matter, who will be in charge in maintaining this water supply. In that view, my Lordship, if my learned counsel agrees, Your Lordship, let the water be restored, let the meeting be held, and in case the petitioners are given this authority to maintain this water supply scheme, the payment which they have made in that, which they have stayed in their account, that will be stayed, or otherwise in
That will be?
That will be with them, Your Lordship, the payment which they have made. And in case the meeting decides that the prior respondents are the main authority who will handle these situations, the payment have to be given back to
Mr.
them.
Gogoi, how can this court pass such an order at this stage? What you are saying is absolutely correct. Instead of keeping this matter pending, if this is done, then whatever is the outcome. But in a way, then this court is going to give sanction to that meeting. Now we don't know what is going to happen in that meeting.
Exactly.
Why should we stretch it so far? If suppose today we simply issue a notice and stay this order, and in case in the event, since it has already been submitted, that in the meantime the water has been disconnected, we will say in the meantime it will be restored. And tomorrow when they come and it appears that in the minutes this way or that way something has
Yes,
happened,
Your
then whatever will follow. True. Isn't it?
Perfect.
On 23rd of June, Lordship, they have disconnected. Lordship.
On
23rd of June.
Mr. Gogoi, you want to say something?
Which is instructing my colleague, my lord. My lord, this is a kind of private dispute, my lord. Let us not go into that.
Exactly.
Let us take over the plan.
Exactly.
Restore water, my lord.
Exactly. This
Let
is
them
what
fight
I am
over them
thinking.
what they want,
Because you are a government, you
Yes,
pay
my lord. Yes, my lord.
and
We'll
the
take over
dispute
the-
appears to be in that. However, what should be of your interest as well as of this court is about those consumers.
Yes, my lord.
Their water should not be disrupted.
The
If
consumers,
the water, huh?
the consumers should not be suffered.
Exactly. That is why this court is saying let them do what they want to do.
Let the water connection be restored.
Yes. And keeping in mind that they have paid.
Yes, Your Lordship.
You see, the annexures are there, which shows that the necessary money has been paid. Right?
So the restoration that is only given to the PHC. For restoration, it is the PHC. Lordship.
They will restore.
Yes.
We'll take control of the plan, we'll restore the connection, Lordship.
Heard Mr. Edeka,
Lordship.
Learned Counsel for the petitioner, stopped. Also heard Mr. R.R. Gogoi, Learned Standing Counsel, PHE, and Mr. S.S. Roy, Learned Government Advocate, for the state respondent number 6, 7, and 8. By this petition, under Article 226 of the Constitution of India, the petitioner is seeking inter alia directions to the respondent numbers 1 to 5 to hand over the key of the piped water supply scheme Navajyoti Nagar Panjabari Guwahati to the petitioner's society, and also direct the respondents to restore the disconnected water supply connection of the consumers under the petitioner's society. Stop. Issue notice returnable 4 weeks. Mr. R.R. Gogoi, Learned Counsel, accepts notice on behalf of respondent number 1, 2, 3, 4 and 5. Stop. 5 you will take? Yes.
I will take a look.
Mr. S.S. Roy, Learned Government Advocate, accepts notice on behalf of respondent number 6, 7, and 8. Extra copies within the course of the day, within a period of 2 days from today. Steps by registered post AD in respect of respondent number 9, 10, and 11. Mr. A. Deka, Learned Counsel for the petitioner, submits that on 6/3/2023, as per recommendation by the Honorable MLA Dispur LAC and the Chief Engineer within bracket PHE, Water Assam Hengerabari, comma. What is the name of the committee?
Committee Lordship Navajyoti
Khuapani.
Navajyoti Nagar Khuapani.
Navajyoti Khuapani Yogan
Asoni Porisalana Hamiti.
Please give that name, Mr. Talukdar.
Yes.
So and so committee was handed over to the petitioner for operation and maintenance under the Navajyoti Nagar Pipe Water Supply Scheme. Stop. He further submits that thereafter the petitioner has been supplying water to almost 160 to 170 consumers of the concerned locality. Stop. He further submits that on 15/6/2024, one Navajyoti Nagar Khuapani Jugan Asana Porisalana Samiti, whose authority is under challenge by him, informed the petitioner that there is monthly fees from April 2023 to June 2024 due, and as such, unless the aforesaid payment of arrear is cleared, the supply of water shall be disconnected.
Yes.
Stop. Pursuant to the aforesaid notice, on 23
June
6/2024, the water supply has been disconnected. Stop. He further submits that no payment of water supply is due, as the aforesaid payment has already been paid, receipt of which is enclosed as Annexure 12 to the writ petition.
Yes.
Stop. Next one.
And next are 11 is the photograph of disconnection. Page 33.
Mr. R.R. Gogoi, Learned Standing Counsel, PHE, submits that it appears that there is a dispute as regards the constitution of the subject committee and operation and maintenance thereof of the pipeline under the subject scheme. Stop. Next one. Be that as it may, as it appears that since payment appears to have been made by the consumers, disconnection of water, which is an utility service, perhaps is not justified at this point. Stop. Accordingly, as an interim measure, this court directs the respondent numbers
1 to 5
to restore the subject water connection to the premises of the aforesaid consumers.
Yes, Sir Lordship.
Forthwith.
Sir Lordship.
Forthwith. Stop. List this matter. Returnable given this 4 weeks. After 4 weeks, on a date to be fixed by the registrar.
Very well.
I think that is all right.
Yes, sir.
Deployment.
Obliged, Lord.
Item
Greetings, Your Lordship.
Yes.
Lordship, a very short point involved over here is that, my Lord, on the application filed for cancellation of the GST registration.
Affidavit's not filed?
Not
My Lord, we have received about specific instructions in this matter. May I produce before?
What is the instruction?
My Lord, the petitioner's firm was registered under the central jurisdiction, my Lord. So the cancellation authority, my Lord, they are entitled, my Lord. The central, he's entitled under.
He's entitled.
Yes.
So your instruction in his favor.
No, my Lord. Just he's entitled, not entitled, my Lord.
Mr. Counsel, whenever you receive a copy of instruction, please go through it before you decide to hand it over to the judge.
My Lord.
Have a look at it. You file it. He is entitled to know whatever instructions you have. Since your instruction is adverse to him, you file it by way of an affidavit. Mr. Kayal?
In this case, the issue is this: their registration was cancelled on their prayer. There was a mistake in dates, and that registration was cancelled by the state GST authorities. They filed accordingly. Now they have received instruction that it is not the state, it is with the central government. But the documents reflect that everything was done by the state authorities.
So how can they say that it is central?
Yes, my Lord, that is the confusion lies over. And otherwise, my Lord, the law is silent on this aspect. And
that is why let the affidavit be filed, and you please furnish a copy also to
my Lord. The case of the petitioner falls under the jurisdiction of central authority, my Lord, not the state authority, as his license was cancelled under the central authority, my Lord.
Is there any difficulty for you to file any affidavit?
No, my Lord.
You file an affidavit, they will get an opportunity to defend,
my Lord.
And Mr. Kayal will also get an opportunity. If you are not agreeing with the submission, then you file an independent affidavit clearing the stand. Let the stand be cleared.
Yes,
right. That is important.
My Lord.
Your name?
H. Purva, my Lord.
Mr. H. Purva, learned government advocate?
No, my Lord. On behalf of B. Chaudhary.
On behalf of Mr. B. Chaudhary, learned
Standing Counsel, Finance and Taxation
Standing
Department.
Counsel, Finance and Taxation
My
Department, submits that he has received instructions and he has received instructions in the matter. Stop. Stop. Let the same be filed by way of an affidavit within a period of 2 weeks from today. List this matter after 2 weeks on a date to be fixed by the registry.
So I am agreeing for respondent number 2.
Appearance slip. Cover appearance.
Highly obliged.
Obliged, my Lord.
Yes.
This matter relates to
affidavits not filed.
Affidavits you have filed, but that is not on record. Yesterday.
Government affidavits.
They have not filed.
Exactly. Not required.
Probably not required. Yeah, my whole case is that, Lordship. That
you have filed an affidavit yesterday. What affidavit? Additional affidavit?
Additional affidavit.
Mr. A. Ahmed, Mr. A. Ahmed, Learned Counsel for the petitioner submits that an affidavit has been filed yesterday, i.e. 25/6/2024.
On 24th.
Or 24 day, not yesterday. On 24 6/2024. However, the same is not on record. Stop. Let registry verify and place the same on record. List after reopening date.
Lordship, may I pay for a fixed date? Because here whole...
Mr. Counsel, you start speaking without hearing the court. I have asked for a date.
Lordship. I'm sorry. Obliged, Lordship.
Why don't you all have patience?
I'm sorry.
Yes.
Obliged, Lordship.
My Lordship.
42 also, Mr. Ahmed, you appear.
My Lord.
Oh, achha, you are appearing. Yes.
My petitioner purchased a plot of land, my Lord. 4 kata something.
Ms. Das, no affidavits, nothing.
My lord, my friend has written letter, my lord. We are waiting instruction, my lord.
How much time?
My lord, last first week of August, my lord.
My Lord, we have filed the case in the month of December, my Lord.
You are lucky. This is a 2023 matters. I have been dealing matters of 2017 and 18, where till date nothing has been filed. Anyway, we will ensure that you don't have to wait that long. Ms. Das?
My lord, maybe first week of August, my lord. I'm for the 2, my lord.
Who is it now?
My Lord, last occasion, Honorable Court of Bill Observation, my Lord, consider interim prayer, my Lord.
This is an NIT matter.
My Lord, my Lord, Lordship, can you see last order, my Lord?
No, which is this?
10-6, my Lord.
What is the writ petition number?
My Lord.
Writ petition number?
Lordship, 7553, my Lord.
7553. Kumud Gwala.
My Lord. And he purchased a plot of land, my Lord. Thereafter, Lordship, NOC obtained from the...
Alright, yes, we are giving you another chance. Huh?
I am for 2, my lord.
And who is appearing for other respondent?
Other, my lord, may it pleases your lordship. Lordship, I am appearing on behalf of Mr. S.P. Chaudhary for respondent number 4. Presently, he is on legs in court number 17. Lordship, can it be taken after some time, lordship?
Are you appearing? The government wants time for filing affidavit.
Affidavit is otherwise not required, lordship. Kindly see the prayer in the writ petition. It's basically a declaratory suit. Prayer for this declaration and injunction. How this writ petition is maintainable? There is no impugn order, nothing of that sort. Restraining the respondent number 4, not to make any disturbance. Kindly see the prayer at page number 13. Directing, commanding the respondent authorities, more specifically the respondent number 4, not to obstruct. This is a matter of injunction from construction of his building. Further, direct respondent authority not to disturb peaceful
You file your objection.
Yes, lordship. This is basically a civil suit.
Mr.
S.P. Chaudhary.
S.P. Chaudhary, learned counsel for
the
respondent number
4,
submits that the petition is not maintainable as it is nothing but a declaratory suit.
With a prayer for injunction.
Stop. Let the returns be filed
immediately after vacation
by the respondents within a period of 2 weeks from today. Stop. List this matter after 2 weeks on a date to be fixed.
Can a date be fixed, lordship, immediately?
All right.
Oblige.
पानी गिलास को चेंज कर दो ना. Yes. Arbitration petition?
Yes. Your Lordship, in the last hearing, I have given the letter.
No, this is for appointment of an arbitrator.
Yeah.
Rupak, arbitration or bench আছে তো. আবার check করে লোছে. Actually, probably this has to come before the designated judge under the Arbitration Act. It's wrongly listed before this bench. Documents? Check. Just wait for some time. Let him check with the bench. Ever immediately call kori the arbitration petition. And yate could yarn that. Mr. Ghosh, you are appearing?
I'm sorry, Lord.
No problem, Mr. Ghosh. As long as you appear, there is no difficulty.
My Lord. My Lord, there is two writ petition, my Lord.
It appears that this matter has been listed today with the remark within quotes for dismissal in the cause list, as there was no representation on the last occasion, i.e. 19/6/2024, on behalf of the petitioner. Stop. However, today when the matter is called, Mr. B.J. Ghosh, learned counsel for the petitioner, is present. Stop. Let this matter be listed for admission.
After 4 weeks, lordship, because in one case we have to file our affidavit. One we have filed. In the first 319 we have to file.
Mr. S.S. Roy, learned government counsel, submits that pleadings in which one?
6053 of 23.
Pleadings in where it is not complete.
319.
Pleadings in WPC 319 of 2024 is yet to be completed. Stop. Accordingly, he seeks
4 weeks time.
4 weeks time to file the necessary return in the aforesaid writ petition. Stop. Prayer is not opposed. List this matter after
4 weeks.
My lord, there is a
3
further-
weeks.
My lord, there is a further direction to quote a requisition that relevant record.
We have received the records.
My lord, then
Further list this matter after 3 weeks on a date to be fixed by the registrar. Stop. In the meantime, Mr. S.S. Roy further submits that the necessary records have been received by the office of the state government. Stop. Let these said records be retained till final disposal of the case.
my lord, there is an interim order.
Interim, if any, shall continue till the next date of listing. Okay. Call. Yes.
We have received pair-wise comments.
Are you objecting?
Yes, my.
So you want to file an affidavit?
Yes, my.
They want to file an affidavit objecting to the prayer for appointment of an arbitrator. They have a right to file the reply. Let them file.
Your Lordship, I want to say I have submitted Supreme Court judgment.
That's all right, Mr. Counsel. They being the other side, they have a right to file the reply. It's a 24 matter. The last chance will be given. If you do not file it by the next date of listing, the arbitration petition shall be taken on its own merit. Item 43. Heard, your name please?
Sanjay Sharma.
Mr. Sanjay Sharma, petitioner in person. Stop. Also heard MS?
K Deka.
MS?
K Deka.
K Deka. Learned counsel for respondent?
CGC.
For respondent CGC. Stop. She seeks how much time?
After vacation.
She seeks 2 weeks time to file
Your
file
Lordship,
objection.
take it 25th July. I will be out of this
Objection
session.
in the matter. Stop. Prayer is allowed. List this matter after 25th of the day. When do you want it?
On 25th July.
On
itself.
25/7/2024. Stop. Needless to clarify that if the objection is not filed by then, comma, the arbitration petition shall be proceeded in accordance with law.
Obliged.
47.
Yes, Mr. Islam.
Yes, my lord, this matter was,
Mr. Gupta.
in fact, we already heard and was fixed for orders, my lord.
Then I'll say list before appropriate bench.
My lord.
It is submitted at the bar that this matter has already been heard by another coordinate bench of this court. Stop. Let registry verify and place the matter before the appropriate bench.
Right.
List the matter before the appropriate.
Interim order will continue.
Interim orders, if any, shall continue till the next date of listing.
Obliged.
In this case, Your Lordships, last occasion, the applicants file an IA, which has been disposed of, Your Lordships, and the Honorable Court has directed the petitioners to amend the cost title in view of the notification passed by this Honorable Court. But till that this cost title has not been amended. It has been specifically directed.
You are appearing for the petitioner.
I am for the writ petitioners. The applicants as petitioners have preferred an IA.
Applicants, where are the applicants? Who are the applicants? Ms. Das, you had filed?
Now don't think আমি আছে আমি কেন আমি গভর্নমেন্টে কেউ
Government.
5-6
It's a private respondent.
Where are they? They are not before this court today. They are not appearing.
As because of the cost, their name, their cost title has not been corrected.
Understood, but for us to direct them, their counsel should have been here. No one is there. Who's appearing?
Lordships.
Who's appearing for them?
who are there
See, the name is not shown.
GK Deka.
His name is not shown on the cost list.
probably they missed it.
In item 48, list this matter after the reopening of the ensuing holidays on a date to be fixed by the registry, reflecting the name of Mr.
GK Deka.
GK Deka, Learned Counsel for respondent number
5, 6 and 7.
5, 6 and 7.
And necessary correction to be made in the cost title, Your Lordship.
You see, they are not before this court.
Lordship.
How can I direct?
Lordship.
The name is also not shown.
Lordship.
If you are so much urgency, you should have called them up, told them the matter is listed. You could have always expedite. Anyway, next matter please.
the last order.
Yes.
The respondent has filed affidavit yesterday.
You want to file a rejoinder, Mr. Chaudhary? Mr. H.I. Chaudhary, learned counsel for the petitioner, seeks 3 weeks time to file rejoinder to the affidavit in opposition filed by the respondent number 6. Respondent number 6. Stop. Prayer is allowed. List this matter after 3 weeks on a date to be fixed by the registry. Sibu, follow korbo pariছে না? Too fast. Tomar change korbo like kore diba, but they are all not finished. Eta to korbe pariছে na?
May I please Lordship, in this case, the petitioner purchased an insurance policy, Lordship, for an amount of 19,70,500, Lordship, on 29/7/2016, Lordship. As per policy, Lordship, terms and condition, Lordship, he shows the benefit option, Lordship, lifetime income with cashback, Lordship. As per the...
Alright, pleadings are complete.
Yes,
I'll admit and fix it for hearing.
Lordship, the petitioner is suffering from heart disease, Lordship.
I will give you a short date. Heard Mr.
S. Alam, Lordship.
S. Alam, learned counsel for the petitioner. Stop. Also heard Mr.
S. Das.
S. Das for the
Respondent number 2.
Learned counsel for the respondent number 2. And anybody else? Stop. This matter requires a full-fledged hearing. Admit, list after vacation at the date job.
Lordship, my entry may be considered, Lordship. His condition
List
is not
on
good,
so and so date for hearing.
Lordship, I have an interim prayer, Lordship.
30th July hearing.
Lordship,
Yes.
I have an interim prayer.
What is your interim prayer?
Yes, Lordship. Page 17, Lordship. His condition is not good, Lordship. He is
No, what
suffering
is
from
the
heart
interim
disease.
prayer?
Page 17, Lordship. 17. At least 50% for medical treatment, Lordship. Page 17.
You should have insisted it on the day of issuing notice. Yes. Next.
Lordship, then
Next.
immediately after vacation.
First week of Digya.
Lordship, on 16, Lordship.
I'm giving you that.
18.
18. Yes, Mr. Chaudhary. Mr. Bora, no affidavits.
My lord, the parawise comments that was furnished, my lord, that was not sufficient, my lord, because the core issue that, my
Alright,
lord,
how much time?
my lord,
Let them file their return.
yes, my
How
lord.
much time?
My lord, 3 weeks time may be gone.
Mr. D.P. Bora, Learned Standing Counsel, Health submits that the parawise comments received in the matter was not sufficient and accordingly instructions have been sought for. Stop. He accordingly seeks 3 weeks, further 3 weeks time to file the necessary return in the matter. Prayer is not opposed by Mr. D. Chaudhary, Learned Counsel for the petitioner who is present in Learned Counsel for the petitioner who is present in the court. Stop. List after 3 weeks on a date to be fixed by the registry.
Obliged, my lord. Much.
Yes, Mr. Sharma, you've come this side.
Yes, not this side.
Yes.
See, here in this case, I have yesterday filed an implement petition, and against a old matter, and I needed time to also to go through it.
You had filed what?
It's an old matter.
No, you filed yesterday.
An implement petition. Actually, implement petition.
All right, that implement I don't think is listed before this court today.
No.
It is not listed.
Only yesterday.
Mr. P. Sharma, Learned Counsel for the petitioner, submits that an interlocutory application for implement has been filed in the matter yesterday, i.e. 25/6/2024. However, the same is not on record. Let registry verify and place the same on record. Stop. List this matter.
19th of July. No, 19th of 19th July. 19th. Around 20 meters fixed, Lordship, in court number.
No, tell me after.
Any date after
let it
25.
be fixed after 2 weeks on any date. 20. On any day after 2 weeks fixed by the registry.
Objection.
Yes, next matter. 71, 74 there. Yes, Mr. Gogoi.
My lord, may I please for instruction, my lord? Here, my lord, the respondent 4 has now intimated that, my lord, that no construction work will be undertaken from their side in the Doboka municipal market, my lord. The petitioners are of the apprehension that, my lord, the vita that they are holding,
yes,
that building will be, my lord, demolished and new construction will be made, whereby they will be displaced. Now, my instruction says that, my lord, no construction will be held. So, they are already protected. In fact, my lord,
have you shared the instruction with your
my lord,
counterpart?
They have been already been intimated by the authorities.
So I can close this petition with his undertaking?
Yes, yes. Well, Lordship may record my instruction, whatever is there.
I shall record the undertaking of Mr. B. Gogoi and take this instruction on record and
Yes.
thereafter close the writ petition.
My lord, only the notice of eviction is now infected.
Yeah,
Right.
that may be
recorded and my lord.
Court.
Rupak. All right. Likha. This is item 73.
Well, the respondent number 4 has placed the instruction. They have been implemented as respondent 4.
They are not, the council is not.
I am appearing.
You are appearing for R4. Heard Mr. J. Sharma.
A.J. Attia.
MD A.J. Attia.
Yes.
Learned Counsel for the petitioner. Also heard Mr. B. Gogoi, Learned Counsel for respondent number 4, and M.S. U. Das, Learned Government Advocate for the state respondent. Stop. By filing this petition under Article 226 of the Constitution of India, the petitioner.
Lordship may kindly record this part. One page of instruction. This will be more precise. The second para. Only one page.
Notice issued by the municipality, Doboka Municipal Market. My lord, they have not representation. After receiving notice.
Challenging inter alia the notice issued under number WB/2021-22/295 dated 12/1/2022, signed by the executive officer Doboka Municipal Board, Doboka within bracket annexure.
Annexure, my lord.
67 to 100.
Yes, my lord.
Annexure 67 to 100 to the writ petition.
Individual notices.
Okay.
But it is, my lord, page 90. Starts from page
That's all
90.
right. I am only saying the annexure number.
Annexure number 67, yes, sir.
Now, Mr. Gogoi, you want the instruction dated, this instruction?
Yes, this one, no, like it is more precise.
Today, when the matter was called, Mr. B. Gogoi, Learned Counsel for the respondent number 4, produces a letter dated 15 June 2024 issued by the Office of the Chief Engineer, PWR Department, PWRD, PWRD, wherein it is categorically mentioned that all activities under the APART project are scheduled to conclude by 30/9/2024, in alignment with the current project closing date, and that the contract for the Doboka market was formally closed with a letter dated 13/2/2023, and therefore it is It is further informed in the aforesaid letter that no construction activities will be undertaken within the Doboka municipal market premises under the APART project, ensuring that the vitas and livelihoods of the petitioners are not disturbed. A copy of the aforesaid letter dated 15 June 2024 is kept on record and marked as X. Since the issue involved in this writ petition is primarily as regards the construction.
Yes, well.
Primarily
construction of a new market.
Primarily construction of the new market, yes. In view of the specific instructions that no construction activities will be undertaken, this court is of the considered view that there is no life issue involved in the writ proceedings for adjudication. Accordingly, this court, in view of the categorical information as placed before this court, the notice dated 12/1/2002.
2022.
Huh?
Well, dated 12/01/2022.
12/1/2022. Annexure 67 to 100 stands set aside.
104.
104, huh? Stands set aside and becomes infraction. Actually, it becomes obsolete. Automatically stands set aside and obsolete. Stop. In view of the above, the writ petition stands dismissed on being infractious. Disposed of. Please ascertain that the annexure numbers.
Yes. It's 67 to annexure 67 to
100.
It's
notices.
Those are under challenge, isn't it?
Yes, ma'am.
All notices.
That is till annexure 100.
100, my lord. Annexure
67.
Annexure 100.
101
is the representation.
Because it is mentioned 100 in the prayer, that's why I said 100. All right.
My lord, it's a copy of this.
You want this instruction?
Yes, ma'am.
You request your friend.
Yes, my lord. I will provide.
Mr. Gogoi,
copy, my lord. I have
photocopy kori lobo diok. You make photocopies.
Yes,
and you also give it to the petitioner.
Yes. The impugn, my lord, notice is from page 67 onwards.
I'm not saying page, annexure. Annexure number.
Annexure number 67 to
100.
100, yes, page 100. These are all, my lord, notices.
I have said 67 to 100, no?
Yes.
All right. Okay.
My lord, one small prayer, my lord. After the notice, my lord, they have not taken our revenue, my lord, for the land, my lord.
Next matter. All right.
Well, here is one communication I have got, my lord. The petitioner, my lord, termination order of the work, my lord, has been now in, my lord, cancelled, and he has been allotted the work. So this matter is also effective. In fact, my lord, this communication was made to the petitioner's counsel. We have been served with a copy by the petitioner.
Matters become infractious, Mr. Sharma.
Not infractious.
Lordship, you see the last part.
What will remain then?
Nothing.
Yes.
Surviving.
So, if nothing is surviving, I will. All right. 74. Heard Mr. P. Heard Mr. P. Sharma, Learned Counsel for the petitioner. Stop. Also heard Mr. B. Gogoi, Learned Standing Counsel, PWD Roads. Yes, this is the same. I think it's the same. Same. The contents appears to be same. Then I will say. I'll simply say it is.
Nothing.
Yes. Mr. P. Sharma, Learned Counsel for the petitioner, submits that the matter has in the meantime become infructuous. Stop. In view of the aforesaid endorsement, this writ petition stands dismissed for infructious. For being infructuous. I have already recorded.
Lordship, kindly repeat the letter dated.
You want me to refer the letter?
Lordship.
Alright.
Termination order has been withdrawn, Lordship.
In view, has in the become infructuous. In view of the letter dated 4/8/2023 issued by the Chief Engineer PWD Border Roads Assam Chanmari, whereby it is being informed that the termination letter of PMG-SY work under package number AS01211 issued earlier by the Executive Engineer Borpeta Bagbar Chenga TR Division Borpeta dated 9/11/2022, which is under challenge in the instant writ petition, has been withdrawn, and you are Muslim Ali, and the same work and the said work is re-allotted to the petitioner. Stop. Copy. In fact,
Lordship will keep this copy, my lord, 4/8/2023 as part of the record. That will suffice.
A copy of the communication dated 4/8/2023 as produced by, I will say Bigogo, as produced by the
parties,
as produced by the parties is kept on record and marked as X.
Not such. Obliging.
Disposed of. Yes, government. No affidavit, nothing was filed.
My lord, one instruction
Yes.
has been received on 31st of May, my lord. So it's on record. Here, my lord, record. Can
You file it?
My lord.
MS Udas, government advocate for the state respondent, submits that instructions in the meantime has been received, and accordingly she seeks 3 weeks time to file the same by way of an affidavit. Prayer is not opposed. List this matter after 3 weeks on a date to be fixed by the registry. You want to file? File. Yes. What happened to the affidavit in opposition?
Immediate after. My lord.
Mr. Mahmood, it looks like interim order is there. So you enjoy it till the vacation.
But they have obtained the interim order fraudulently. By dint of a fake deed, madam.
No. You are for whom?
I am for private restaurant number 7, madam.
Why are you that side then? Where is the petitioner?
Sorry.
Where is the petitioner? Yes, you are for the petitioner. And who are you? BTC. You want time for filing affidavit?
Yes, my lord.
Mr. Mahmood, have your private respondents' affidavits have been filed?
You have filed a vacation petition.
Huh?
Vacation petition.
Vacation petition has been filed.
It is 1/6/4/24.
Alright, let them file their affidavit and then together we will take it up.
My land friend wrote instruction that with BTC's power and that power they have exercised, but by the end of a
fact cell
All
date.
right, let us hear, let the affidavit be
My
filed.
lord, a short date may can leave this. May I expect a pardon, my lord, because pardon.
No, where have I heard you?
Actually, my lord, what thing?
All right, please do not
I
embarrass
have
the
got
court,
permission
Mr.
for
Mahmood.
sale of the land. Time is expiring.
Your
I have
name,
got-
Mr. R.K. Mushari.
R.K. Mushari.
Mr. R.K. Mushari, Learned Counsel for the respondent numbers 3, 4 and 6 seeks 3 weeks time to file necessary return in the matter. Stop. Prayer is not opposed. List this matter after 3 weeks on a date detail. List this matter on such and such date. Stop. Interim order passed earlier shall continue till the next date of listing. Needless to clarify that if the return is not filed by the next date of hearing, the interlocutory application for stay vacation shall be taken up on its merit.
Hello,
May it please, Your Lordship. In this case, my lord, proposal has been sent
My
today.
lord, government has filed affidavit, my lord. There we have already sent the proposal to my lord, Revenue and Disaster Management, my lord. We have filed the affidavit. In that we have annexed that, my lord,
Proposal
for sanction of the amount, my lord, 2 lakhs rupees, my lord.
But your affidavit is only not here.
My lord,
No, it has
respondent
come.
filed
It has
respondent
come.
number 3.
R3?
Lordship.
Which para?
Para, your lordship will find at page for 28, para 4.
You have
We
sent.
Stated, my lord.
So we can
And
dispose it
annexures,
off.
I have annexed the letter also, my lord. It's annexer A. Page
What
30.
instruction?
Regarding the budget, availability of fund, Lordship. Lordship may allow me to
Availability of fund cannot be a ground. Non-availability cannot be a ground for keeping the sanction matter pending. Anyway, you take it. I'm fixing it in the next week. In
My lord,
view,
within a time frame, my lord, payment may be made, my lord, and the deduction within a specified time, my lord.
in view of the affidavit in opposition filed by the respondent number 3 on 21/5/2024 to the effect that the ex gratia amount of rupees 2 lakhs has been sanctioned to the next of kin in favor of the petitioner,
Not
comma, MS G. Hajorika, Learned Standing Counsel, Revenue, Revenue submits that she may be allowed some accommodation in the matter to obtain instruction as regards
regarding the sanction letter, Lordship. Regarding the sanction letter, Lordship.
sanction to they have saying they have done
No, Lordship.
We have
This is the
sent.
Only for
regarding
sanction. This is
provisional.
sanction only, Lordship.
So I got provisional one to the effect of provisional sanction, and then say regards the status of the said provisional sanction forwarded from the office of the district administration.
Lordship.
List on such and such date after reopening.
My lord, in
This
this
is an
case,
order matter. Order matter.
My lord, we have filed our affidavit, my lord.
You have
My lord,
filed?
I am a CRPF personnel.
No, but this matter. Why is this matter for
Whether
orders?
is this, my lord, as per the provision of section 9 of the Muslim Shariat Act 1935, there is a provision that when a
Mr.
Muslim
Mahmood, why is this matter for orders?
orders from my lord, the other friend was asked to file their reply.
So they have
The
filed.
Qazi has filed. The government has not filed.
Affidavit, respondent number 3 has filed, my lord. I open government affidavit.
My lord, their claim is that the act has been repealed, but the act has been repealed after 9 months, and there is no retrospective effect.
It appears that the state respondent has filed their affidavit in opposition on 25/4/2024. Stop. Are you going to file any rejoinder?
On the basis of law, my lord. Law point is only here.
Mr. M. Mahmood, learned counsel for the MU Mahmood, learned counsel for the petitioner, submits that the petitioner is not going to file any rejoinder to the affidavit in opposition filed by respondent number 3. Stop. List this matter. This matter is admitted.
My lord, problem, my lord. Because it had come in the order, my lord. They are not admitted.
List this matter for admission after 3 weeks on a date to be fixed by the registry. All right. Yes. Yes. Contempt matter. Yes. Respondents affidavits have been submitted. Await service report. List this matter after 3 weeks on a date to be fixed by the registry.
Date may kindly be fixed, which is
Yes.
contempt matter, my lord.
Yes.
After
Next.
May I please, Lordship?
Yes.
Lordship, in item 56, the respondent bank is yet to file their affidavit. And in item number 57, I am the private respondent. I am to file my affidavit.
All right. One by one, then this matter is orders today.
Lordship.
In item 56, who is to file?
The respondent bank, Lordship.
Are you filing or you're not filing?
Your Lordship,
Simple question, because the matter is for orders.
Your Lordship,
In order matters, you should not unnecessarily waste time of the court. You want to file, you don't want to file. I'll record it and I'll close it.
No, Your Lordship, we will not file.
You will not file. Mr. Your name?
M. Sharma.
Mr. M. Sharma, learned counsel for respondent number 1, submits that he has instructions not to file any affidavit in opposition in the matter. Stop. Any other respondents?
My lord, I am appearing
One
for
more
the
submission.
private respondent number 3, my lord.
You will file anything?
No, my lord, this, I have objection regarding the maintainability of
So
the
are you going to file that or not?
My lord,
Because you
I have already filed it.
You have
Is there,
filed?
my lord. My lord.
You are for?
For respondent number 3, my lord.
Yes,
Item
you
number
have filed.
56, my lord.
Mr. Batra, you are appearing?
I am appearing for respondent 1, item number 56.
Not in this. Okay. It appears that respondent number 3 has already filed their affidavit in opposition on 19/6/2024. Stop. Wherein the maintainability of the writ petition has been raised by the said respondent. Stop. You want to submit something?
Lordship. I will file a rejoinder.
Mr. Your name is Dr. Saraf? D. Saraf?
Saraf.
Mr. D. Saraf, learned counsel for the petitioner, seeks 2 weeks' time to file rejoinder to the affidavit in opposition filed on behalf of respondent number 3. Prayer is allowed. List this matter after 3 weeks on a date to be fixed by the registry. Now, next matter.
Well, in item number 57, I am the writ petitioner, my lord.
Yes.
Here, my lord, I may be allowed to withdraw this writ petition to approach before the appropriate before.
All right. Heard, Mr.
S. Hazarika.
S. Hajorika, learned counsel for the petitioner. Stop. Also heard Mr. K.K. Batra, learned counsel for respondent number 1. Mr. Who's for R2?
D. Saraf.
Mr. D. Saraf for respondent number 2. And anybody else?
Yes, Your Lordship, for bank, Mr.
I've said R1.
Yes.
So R1 and 2. Stop.
And
Mr. S. Hajorika, learned counsel for the petitioner, submits that he has received instructions from his client, from the petitioner, not to press the instant writ petition, and accordingly seeks withdrawal thereof. Stop. Prayer is allowed. Writ petition stand dismissed on withdrawal.
My lord, liberty may be so because my surfacing.
Mr. Counsel,
my lord.
if you wanted liberty, when you said you have received instructions to withdraw, you should have asked, what is this? You wait for the orders to be passed and then you want the court to just add the word liberty? Liberty is not granted as a matter of right. You will have to ask for it. Did you ask for it?
My lord, I have submitted, my lord, maybe.
Where did you submit about liberty? You said you want to withdraw.
With a liberty, my
With
lord,
liberty,
because
cordial or allowed cordial?
I am deeply obliged.
All right.
Obliged.
Wanted to approach the appropriate authority.
Because surfacing matter, DRT, we have to file before the DRT, my lord. That's why, my lord.
with the liberty to apply approach before the appellate authority. I'll edit that. So basically, you're withdrawing with the liberty to approach before the appellate. Why can't you be clear when you make submissions? Yes. 57 is disposed of. Yes, please.
As per order dated 19/6/2024, my lord, already submitting.
Yes, Mr. Das. Huh?
Already submitting amendment cost title to the registry, my lord. Permit me to take.
Newly implemented has been.
Notice is yet to be issued, Your Lordship. Only implement has been done, Your Lordship.
Who is the newly implemented?
The first one, the President Chief Secretary.
No, respondent number.
Respondent number 6, my lord.
6, Your Lordship.
6 and 7.
6 and 7.
Respondent number 6, Robi.
Respondent number 6.
Yes, my lord.
But the cost title of the court's copy is not corrected. Have you submitted the amended cost title?
Yes, my lord, submitting.
MS D. Sonawal?
Yes, my lord.
Sonawal Learned Counsel for the petitioner submits that the necessary amended cost title has already been submitted before the registry for doing the needful in terms of the order dated 19/6/2024 passed in IAC number 1801 of 2024. Stop. However, However, the cost title in the court's file appears to have not been corrected till date. Stop. Let registry verify and do the needful. List after 2 weeks on a date to be fixed by the registry.
Oblige, Your Lordship.
May I please, Your Lordship? Also, this is contempt petition, Your Lordship. In this case, Your Lordship, service has
Who is
been...
appearing? Yes, Ms. Bodler.
Lordship, I am appearing for respondent number 1.
Sole respondent.
Matter, Your Lordship. Actually, what has happened, Your Lordship, this matter is an ex gratia matter, Your Lordship. They have not made the Deputy Commissioner as a party. Your Lordship, the Deputy Commissioner sends the proposal to the government. All the verification is done by the DC office.
DC is not a party in the writ petition.
He was a party in the writ petition, not in the contempt case.
As because, Your Lordship, in order, Honorable Court directed to consider the claim of the petitioner by the respondent number 1.
Who is 1?
One is the Revenue Department. Definitely, it will be sanctioned by the Revenue Department, but the proposal needs to be...
You see, now if that is what you are contending, why don't you put it by way of an affidavit? See, what is contempt? Contempt, the element of willful has to be there.
Yes.
Now, if suppose the district administration is not sending you the concerned file, or they are not doing what they are supposed to do, how can you perform your part, right?
Yes, Your
but
Lordship.
nonetheless, since you are aware that such and such order has been passed, simply saying that is not sufficient.
Lordship, as
You
per
will
the-
have to also enclose letters showing that from your side you have already communicated to the district administration to provide.
Yes, Your
And
Lordship,
thereafter,
in this
if they are
regard-
not providing, that is not your problem.
Lordship, in
Correct?
this regard, the Revenue Department has given me a instruction, Your Lordship. There it is stated that the department has already requested to the Deputy Commissioner.
You see, if you file this affidavit, this court can close this contempt, because if the petitioner does not array the respondents, this court will not go on telling the petitioner to array the respondents. Correct? Since the operating part was to respondent so and so, it appears the DC has not done.
Lordship,
But you file it.
The department has sent a letter to the DC Kamrup Metro on 1st of
I'm
March
understood, Ms.
2024,
Bordeler.
Lordship.
There are two ways about it. One, we can right away ask add the DC.
Lordship.
You want that? I think it would be better.
It's for his convenience, Your Lordship.
Lordship can implement.
Just give me that instruction, please.
Otherwise, Your Lordship, we have submit the certified copy of order before the DC also.
The first page can also be perused, Your Lordship. second last
MS
paragraph.
N. Bordeloi, Learned Counsel for respondent number?
And for the sole respondent.
For the respondent, places copy of the instructions received in the matter, which indicates that despite of communications being sent from the office of the Revenue Department to the concerned jurisdictional deputy commissioner, comma,
Lordship can put
necessary proposal stroke sanction order for ex gratia grant in respect of the petitioner has not been received from their end. Stop.
the second page date can be put in the order, Your Lordship. 1st of March.
Dated 1/3/24. Huh? Instruction dated, sir. It appears that though the district commissioner Kamrup Metro,
Not Morigaon.
though the district
It's a typographical error.
District Commissioner Morigaon.
Yes, Lord.
Morigaon was a party respondent in the original writ proceedings, comma. However, the said authority has not been arraigned as a contender in the present contempt petition. Stop. It appears that unless and until the said authority forwards the proposal stroke sanction order to the office of the Revenue Department, comma, there cannot be any effective compliance of this court's order dated
Order dated 01/09/2023.
01/09/2023, passed in WPC number 5024 of 2023. Stop. In view of the above, let the petitioner file necessary application for impleading the district commissioner Morigaon in the present contempt proceedings. Stop. Okay, you file it.
Okay, amendment cost title will file.
Yes, no. You first file an application,
Implementation.
and in that application you annex this order, the order of this court's today's order,
Yes.
and first get him implemented. Okay.
Lawsuit can also implement. We will file.
No, it
amendment
is
cost title.
nowadays. It has to be done on by an
amended
application.
clause title needs to be filed.
You have to do it by way of an application, so you file it by way of an application.
Lawsuit. Deeply.
You take back.
I'm deeply obliged. Your Lordship.
Have you filed the amended cost title?
Yes, my lordship. Filing my amendment cost title.
Yes, you have placed it.
Yes, my lordship.
Now the newly respondent is.
Respondent number 7, my lordship. Yes.
Notice has been issued.
Yes, notice, no, my lordship. We are not yet. Today is the day after amendment.
Who is the newly implemented respondent?
notice-
Respondent number?
What, my lordship?
Who is the newly implemented respondent?
Respondent number 7, my lordship. Pallavi Mandal.
What does the amended cost title do?
May I, my praying, my lordship, maybe an interim order, my lordship, for custody of child, for natural justice, my lordship. To the
Is anyone appearing for R7?
My lord, no. It's a private response.
Because notice has not gone.
Pallavi Mandal is a natural mother.
Let notice first go. You are not for Pallavi. You are the petitioner. You are for whom?
Here is an interim order,
This
my
does,
lordship.
I
From
cannot
Supreme Court.
understand anything.
From Supreme Court, there is an interim order.
The Supreme Court will
Supreme
go
Court's order,
later.
my lord, on the first date.
First of all, who are you? You are for the husband. You are the petitioner.
Yes, my lordship.
And but you see, you have implemented the mother, but she is not before this court because notice has not been issued.
Already, after custody, after
This
rescue,
council, it is very
taking
difficult when
baby.
councils do not address to the queries put by the court. please answer what the court is asking. If you do not clarify the court, then how shall this court pass an order in your favor? I'm asking a very simple question. Has notice been issued to respondent number 7?
Yes, my lordship.
Notice has been issued.
Yes, no, not yet.
Then that is what I'm saying. Let notice first be issued.
She is the natural mother as per her contention. This is the natural mother.
Natural mother.
Notice has to go first.
Actually, my lordship, natural mother after
Your name.
baby.
Heard MS.
Yes, my lordship.
Your name.
M. Burman.
Heard as MSM Burma.
Yes, my lordship.
Burman, learned counsel for the petitioner. Stop. Also heard Ms. Udas, learned additional senior government advocate for the state respondent. Stop. It appears that in terms of the order dated 26/4/2024, comma, the petitioner has not taken, it appears from the office note dated 27/5/2024 that the petitioner has not taken any steps for issuance of notice upon the newly impleaded respondent number 7. Stop. Ms. Das, there must be some order then, because the office note says.
Yes, my lord, but
I can't find.
my lord, I'm sorry, my lord, we have no record, so I have taken the court's, my lord, second file. Ms. Counsel, kindly take the steps. Unless you take steps, nothing can be done. How much time do you want for taking steps?
According to order, 15 March 2024.
Ms. Das, please assist her.
তাৰমানে কি কৈছে জানে নতুন যে দিছে প্ৰাইভেট ৰেসপন্ডেন্ট তেওঁ মোৰ স্টেপস পঠিয়াব
I am waiting for a court order, my lord.
Court's order is already there. It's very unfortunate that the petitioners, that the counsel is appearing for the petitioners do not assist this court at all. There is already an order issuing notice. This is dated 26/4/2024. After completion of impleading process, the petitioner shall take. Ms. Counsel, please pay attention to the court.
Oh, yes, my lord.
There is a judicial order dated 26/4/2024, whereby it is mentioned the petitioners shall take steps for service of notice on the newly impleaded respondent number 7 by registered post with AD as well as by usual process.
Yes, my lord.
Correct?
Yes, my lord.
You have not done anything till now. There is an office note
Yes, my lord.
dated
already order আছে
14/6/2024, where it is categorically mentioned. That the learned counsel for the petitioner has not taken any steps for issuance of notice upon the newly impleaded respondent number 7. You are not taking steps. You don't even know whether notice issued, not issued. You come appear before this court and you want to place an order of the Supreme Court?
Yes, my lordship. Actually, I
Steps
cannot
listen, private
find.
respect.
I have get the order.
সেইটোৱে কোৰ্টে পঢ়িলে এতিয়া সুধিছে আপুনি কিমান দিন লাগিব প্ৰাইভেট
List this matter after 3 weeks on a date to be fixed by the registrar. All right, next matter, please. I have given sufficient time to this court. This matter. You cannot be taking court's process as a matter of such casually. Yes, Mr. Sharma. Yes, Mr. Sharma.
Yes, Madam. I filed an application for vacating the interim order, Madam.
You filed an application for
vacating the interim order passed
vacating.
on 31/5/2024. In fact, Madam, this issue, entire issue involved in the petition, can be disposed of by a covered judgment of this court, as well as a single judge, which is upheld in the division bench, Madam. Entire issue. Here, whatever, Madam. Notice of no confidence was given.
Notice of?
No confidence was first given in December. Then, my lord, the chairman didn't call the meeting. On the ground that we addressed the letter to the deputy commissioner and he simply forwarded it. But they challenged it. On their challenge, my lord, this court held that deputy commissioner has no role in the scheme of the municipal act regarding no confidence. So we are given liberty to file second notice. We filed it. The chairman first gave the date of 24, cancelled it, there was a holiday. Again gave 26, there was a holiday, cancelled intentionally. And ultimately she didn't call the meeting. On 27, after expiry of 20 days, on section 43, we called the meeting. And on 29, meeting was held and she was ousted by majority of the votes. And also, in the second half, my lord, is recently passed, electing my lord Jitendra Kutum to be the chairman of the
Where is the
board.
interim order?
Interim order, my lord.
Mr. Biswas, you are appearing for
I am
the
the
private
read petitioner.
respondent.
I am the read petitioner.
Read
Read the
petitioner.
petitioner. Yes, my lord. 27 it starts.
Miss Counsel, please continue this conversation outside the courtroom, please. You are disturbing the court proceedings. Yes.
Page 27, my lord, of the IA.
Yes.
Yes, my lord. Relevant paragraph, my lord.
What happened, Mr. Biswas?
No, this page is not there in the IA, the copy which has been served on me. But still, my lord, let them argue. I'm not taking all this.
All right.
Now, my lord.
You don't want to file any objection or anything in this matter?
No, my lord, because on those flimsy ground, my lord,
That is also in the record also. Then, my
You
lord,
cannot dismiss the grounds brought by Mr. Sharma as flimsy. If there are flimsy, you wouldn't have come up.
No. I am saying I will not object to those grounds. Because
he
inadvertently,
because there is also in the record of the court.
Yeah, because there is the record of the court, so I said I will not object.
All right. Yes, which paragraph?
Paragraph 11, my lord, page 32.
Yes.
Of the IA. Until further orders, the resolution adopted insofar as the termination of the petitioner as chairperson will not be implemented without leave of this court. It is also made clear that notwithstanding the order passed as directed above, the petitioner will not assume the office of the chairperson to take any such policy decision in any meeting or in any financial matter, save and except where the participant of the petitioner is necessary as a joint signatory along with the executive officer of the chairperson. This was the order.
Petitioner will not assume the office of the chairman.
Yes.
To take any such policy decision in any matter or so and so.
Yes.
You are aggrieved by this?
Yes.
Why? You are not the petitioner.
I am not there. I am agreeing, my lord, because I have been elected as chairperson after her ouster. So that is here.
It says until further orders, the resolution adopted insofar as the termination of the petitioner as chairman will not be implemented without the leave of the court.
Yes.
This is the first part.
Yes,
That means he will continue acting as a chairman.
Yes.
Correct?
Yes.
However, it is made clear that he shall not assume the office of the chairman to take any such policy decision in any meeting or in any financial meeting, save and except where the participation of the petitioner is necessary as a joint signature. So basically, power is not given to him, but he is allowed to continue in the office as such. If I have understood this order correctly, correct, Mr. Sharma, Mr. Biswas? Yes.
My lord, I agree.
Now, who are you?
I am the ward member, my lord. We have put the notice of no compliance, majority 7 members.
But that itself is under challenge, no, Mr. Sharma, in this writ proceedings.
Yes. But
now,
this matter exactly, my lord,
because you see, today you are before this court only to vacate vacating this order, right?
The main case is fixed today.
Is it?
Yes.
It has come for orders.
No,
they have filed this IA.
Mr. Sharma, today it is in the order column. If you are saying that the entire matter can be disposed, we can fix it after the vacation and make an endeavor to dispose the entire writ petition.
Absolutely.
But as regards the...
Actually, my lord, what happened here, this second resolution which was passed on the same day, both are together.
Second?
And the same day on 29
I'm sorry, I didn't understand you.
There are 2 resolutions. One is removing her
resolution.
Yes. And another was electing one of us.
Yes.
Jitendra Kutum.
Yes.
As the chairperson.
Yes.
This resolution was not annexed with the repetition, my lord. On the basis of that, since
I've understood that, Mr. Sharma, but what I am trying to tell you is that it appears there is nothing wrong as far as this interim order is concerned. So, but however, since you have come for stay vacating, I am saying that I can. It appears that in order to dispose of your IA, the entire contentions of the writ petition also has to be looked into. So, the suggestion from the court is I can fix this matter after the reopening on a date you both agree. And in the meantime, if anyone wants to file any affidavits, can file.
It is complete.
And we can take it up for final hearing. The writ petition.
Buildings are complete.
So therefore,
Buildings are not complete.
no, if it is not completed, you've completed. But I am proposing to finally dispose of the writ petition. If you agree.
In fact, my lord, this court has already decided on the same. It appears
That's all right. That's all right, Mr.
same
Sharma. That is why I am saying final disposal. When do you want for final disposal? You make those submissions on that date. When do you want for final disposal?
Matter was urgent, my lord, because
after vacation, final disposal.
What do you want to submit?
Right now, there will not be time for finally hearing this
No,
matter.
no, I am not at it.
Otherwise, I will disallow the
one sentence
IA.
I will submit, my lord.
Yes.
Because once the resolution is passed, my lord, she is not entitled at all to hold the office as held by this court.
That's all right.
Yes.
I have understood, but what I am saying, that itself is under challenge. Now,
okay, my lord. Then
since I am having an interim in my favor, so
yes, but before that date, if anybody has to file anything, please file it.
The government
because the
needs to-
whole idea is to finish, is to dispose of the matter on the next date.
Government probably needs to file an
Government's affidavit is required.
Yes. Yes.
No, I don't think.
No,
Mr.
I don't think
Biswas.
it is.
My lord, may I submit one line why government affidavit is required?
Yes.
The entire challenge in the IA is that on that day when I was ousted from the post of chairman, 2 resolutions were taken. One ousted, removing me, and the second resolution at 2:30. One was taken at 10:30, removing me, and at 2:30 one resolution was taken, electing somebody else, my senior counsel's client, as the chairman. Now, while we challenged the resolution which was taken at 10:30, we did not annex the resolution which was taken at 2:30. That is appointing him as a. That is their entire challenge, and that is how we got it. Well, I will demonstrate.
All right. In IA 1851. It appears that in order to dispose of the interlocutory application seeking vacation of the stay granted by this court by order dated 31/5/2024, the entire writ petition would require to be heard. Stop. Accordingly, this court directs that this writ petition be listed on such and such date, on which date an endeavour shall be made to finally dispose of the entire writ petition along with any pending IA if.
Or can it be 16 months?
16 is the, I think, immediate reopening.
Immediate
Take it after 1 or 2 days. Because you see,
18 Malur?
18.
18.
Needless to clarify that in the meantime, parties are at liberty to file affidavit if any. None appears for the petitioner when the matter is called. None appears for the parties courier when the matter is called. List after 2 weeks on a date to be fixed by the registry.
Wait. Let it reach. We'll see. Implemented maybe. Let's see what happened to this order.
The court has been already complied.
Complied with. Then what is left?
That's why.
Some instruction. Why some instruction? Am I not received? Am I instructions not received?
No, madam.
Received.
No, madam.
Financial dealings left Baki.
Yes, madam. I do not communicate from my client.
Forget it. That is between me and him. He will satisfy me. Be here when the matter is called up. If you have not received MI, tell me. I'll adjourn the matter. Next.
I could not communicate.
Forget it. Something Baki. Yes.
Personal problem, personal problem,
You go. Contempt is between he and me. We will deal with it. Yes.
May I please, Your Lordship? Lordship, I beg to mention an item for listing, Lordship.
Not here. Before the senior judge. There is a senior bench. You will have to mention that.
Number 10, 11, madam. After the occasions, I have some difficulties with
That PWD matters.
only for today.
Okay. We'll have it. Mr. Chaudhary is busy. But is there anything left here?
Perhaps no. Perhaps
Then we'll have it on Friday.
Friday.
10 and 11 on Friday. We will not keep it pending. There is nothing. That notification was subsequently also in one of the cases considered. It was upheld. Now, by this time, new people may have also traveled. What can we do now?
None of us might be present here, my lord.
You go. Today we don't want you.
Friday. And 50.
You, Mr. Ken Chaudhary, Mr. Mohanto, we don't want them today. We will not want them here today. You please go.
58 also.
58. 10, 11, 58. 58 year go idea. Oh, they have filed a why?
Review, Lordship.
Why?
Correction is there, Lordship. A little bit.
Some date.
Some date, Lordship.
We'll correct that. Oh, okay. List this matters. 10 and 11 Friday go idea. 58 to Friday go idea.
Obliged.
On the prayer be parties will go do.
Please, Your Lordship, I beg to mention item number 24 and the matter may be passed over for the day. Lordship, can it be fixed on Friday?
Sachindra Day. This was an issue pertaining to
Challenging the order of the allowing of maintenance regarding passed by the airport station.
So, it's in. I'll do. Give me a minute. Let me find. Yes.
This matter I am appearing for the respondent on behalf of Mr. S.
Divorce happened? No. Okay, fine.
On Friday.
List this, on the prayer of the parties, list this matter immediately after the vacations. It can wait.
Okay. Please, Lordship. Lordship, I beg to mention item number 48. Lordship, in my humble submission, this matter needs to be listed before another bench because the order regarding which we are saying that it has been not complied, in that particular writ petition, your Lordship was appearing for the private respondent.
On the prayer of the Learned Council, Dr. P. Agarwal. No, list this matter before any other bench without me.
May it please, your Lordship. Lordship, I beg to mention item 9, Lordship. My senior is having some difficulty.
Rangan Kumar Nath. This is with regard to. Let it be called. Wait.
Yeah, please, Your Lordship. I beg to
You are for the petitioner?
No, your Lordship, for the respondent. I am appearing on behalf of GPEG, your Lordship.
Oh, wait.
Yeah, please, Your Lordship. I beg to mention item number 51, Lordship. Contempt this matter, Lordship, respondent authority have complied this order.
Mr.
PJ
Dr. Learned Council for the petitioner submits that the order, violation of which has been alleged in the present proceedings, has been complied with by the respondents. Full stop. Accordingly, in view of the above, the contempt petition stands closed.
Obliged.
Madam, wait. We'll see. We'll see. Wait. Just wait.
Lordship, I beg to mention.
If I have to pass any adverse order against you, I'll adjourn it. Don't worry.
Lordship, I beg to mention item number 46 and 47 of today's daily list. Maybe adjourn for 2 weeks, your Lordship.
Wait.
So my senior colleague has some personal difficulties, your Lordship, and I am on behalf of Harris Johan.
On the prayer made on behalf of Mr. R.S. Chauhan, who is stated to have some personal difficulty. Have you informed the other side? No, forget it. Let the matter be called. Don't make mentions without informing. No, they'll come and wait here for the whole day. Wait. When the matter reaches, renew your prayer. Yes.
With regard to item number 55,
Huh.
can it be consent? Can it be after 3 weeks? The
Wait.
appeal is pending a lot. Then regarding the completion appointment, minimum 3
Oh,
years.
that case. Registry on the prayer of the Learned Council for the parties, registry to
55.
Registry to list this matter after 4 weeks.
And also, your Lordship will pass a direction to the petitioner to implement the new chief secretary at party, your Lordship.
If they want, they'll do it. Now, anyway, this matter cannot be done.
Yes, sir.
Why? By the time there will be another one. By this, so we'll not do it.
After 3 weeks.
This impleading business, this court finds it very difficult. Found it difficult that side.
I understand.
Carrying that this side.
Yes, sir. That's correct. Much obliged. 3 weeks. Much obliged.
4 weeks.
4 weeks.
May I please, Madam Lordship? I'd like to mention item number 49 to list the case to adjourn today and list the case after summer of the case.
You are 40?
I'm 40 as petitioner.
Wait.
Because my senior counsel, Sukumar sir, he left to abroad in lockdown.
You be here. Be here with the file. We'll see what we can do. Contempt matter. We'll see. Yes. Yes.
We've received instructions. However, my lord, the additional advocate general is under the weather, and there's a prayer to be taken up on Friday.
This matters. We'll
Lordship.
finish it up today.
Lordship.
Just give me your instructions. Are these villages included or not?
No, my lord.
No.
Page 27 is the first notification. Annexion. Village is included in the Radha.
So have you checked up this repetition villages are not there?
That has to be, my lord. Individually, my lord, I have to check.
You check up. Check up and tell me.
Some of the briefs are with the AG, my lord. I have only one.
Give them the briefs. Whatever briefs are there. You can take the High Court copies.
Yes, my lord, the first brief.
Oh. We'll have it in the second half. It will be okay. That's the only point we want. If it is included, they are in. If they're not, out. Finished. We'll not trouble Mr. Majumdar. We'll record his name. Hope he is not that much of a problem. It's normal.
My lord, he is down.
Viral. I was
From yesterday.
It'll take another week.
No, my lord, my lord, has given me instruction to place it before the court, my lord. That Friday, my lord, he can to make a request before the court, my lord. He wanted to address, my lord.
Okay. Friday.
Deeply obliged.
My lord.
She is very happy, seems to be. You take this back. Hey, yaar twiddle hol. I'm not a twiddle. Yeah, twiddle. Sleep out pothari. On the prayer of the parties, list this matter again on Friday. 8 number, 1 to 8. Yes, who is appearing for an item number 9?
So 1 to 11.
1 to 9, 1 to 8. Rangannat is something different. Yes. Yes, madam. Where is the instruction? Where is the instruction whether the petitioner was forwarded to the Departmental Rehabilitation Board? That much only I want. For that, Mr. Pegu need not take the trouble. You can give it to me.
Sorry, Your Lordship, but I do not have the file, Your Lordship.
Where is Mr. Pegu?
He's having some personal problem, personal work, Your Lordship.
Girin Pegu?
Yes, Your Lordship.
He is contesting election.
Yes.
Oh. On the prayer made on behalf of Mr. G. Pegu, list this matter again after the vacation. You should tell me that earlier. Today he is having his fundamental rights there. How can we stop him? Let him.
Apply, Your Lordship.
Lordship, as per Lajima order, we were supposed to take steps on respondent 3 to 7. Lordship, we have contacted the petitioner. So they failed to provide us the new address. So Lordship, they're in process.
What is left here? What is there in this matter? We'll dismiss it.
One last time.
No.
It's been long time. That is true.
All these things are pertaining to a selection process of 14. Then, and you don't take steps till 2024. 10 years, no steps.
Last occasion when it has come before before that it has not been listed, Lordship.
Forget it. Whether listing or non-listing is not a question, but the question is whether there was an order from this court. There were repeated orders from the Lazima court.
Steps, Lordship.
But the latest order.
That's the new address of the respondents.
Who are these respondents?
Respondent, private respondent, Lordship.
They are appointed. They are working.
Working, yes.
Get a standing council of Forest Department.
Forest.
You are 40?
Wife. The first.
Where is the petitioner?
The petitioner who needs to be implemented for nomination to the
Madam,
pension.
you are not the petitioner. You are the applicant.
Petitioner, we are the
Runumi Das. You are for Runumi Das.
Das.
Where is the petitioner?
The petitioner.
He may not have a grievance now. He has got his pensions.
Yes, but we still are not nominated.
You come back with a writ petition.
But it's not fair because when we filed this IA, he was not given everything. And we were assured
Madam,
order.
Madam, In his writ petition, how can I pass directions in your favor?
But
They have said that we have not done it because there was no nominee made.
But
You come back with a writ petition, madam.
Mandatory law.
Show me the law.
136,
Hmm.
my lord.
Okay.
And we have enclosed it in the petition as well.
Family. Family means the wife and all this. You get hold of the petitioner. We will resolve it today itself. You get hold of the counsel for the petitioner. Who is that?
For the petitioner.
Mr. Yeah, get it.
Yes, and he was meant to file objection in the last.
Forget
order,
it.
as per the
No
last
need.
order.
Mr. Bhuya, you are appearing for Mr. Bhuya. Yes, what is your case? Get it. We'll finish it off today.
I'll do it.
After some time.
After some time. And madam, I'm not very sanguine until and unless you satisfy me. How can I force him, madam, how can I force him in his writ petition to act on your behalf? You file a writ petition, we will pass orders.
But it was filed while the matter was still pending, and we were meant to be impleaded because the pension was held up for a single reason that he had not nominated.
Madam, I am with you.
Held up because it's a mandatory law.
Madam, I am with you. I am with you, but come back. No, come back in a proper forum, proper manner. File a writ, we will pass orders.
But this is fair enough. We filed it while it was still pending.
Okay, I'll pass orders. You come back.
Obviously.
See, madam, one more thing.
Yes.
If he comes, they are not here, I'm telling you. If they come up and say that we have got our relief, we want to withdraw the writ petition, you are gone for a 6. That is why I am saying you, madam, that is why I am saying,
Close that order.
Madam, you don't understand. How long have you been in practice?
For a pretty long time, but outside the country.
Okay. That's why you have left, you have not got the roots. Madam, file a writ petition. We will keep this matter pending. File a small writ petition, exercising your right. We connect it with this writ petition, we'll pass orders.
That's well taken.
By impleading you are not going to get a relief, madam. I'm sorry. That is the position. Because today I fear that they will come up and say that we have got our relief, we want to withdraw it. If they are intelligent enough, they will do that. They are not here. That's why I'm making that openly then. But if they do that, I am bound to close the writ petition. You will be going for a 6. I'll not do that. I'll keep the matters pending. You file it by Friday, bring it before me. I'll pass orders.
And there's one more additional prayer here, because the son is mentally
ill. I got it.
So he needs to be impleaded as well, actually. But we have not.
Madam, you are there. He is mentally ill. You represent.
That is where the writ comes in, actually. The next writ comes in.
You have to bring in a writ petition, these grounds, and take the order. Not in an interlocutory application.
Much obliged, deeply obliged.
Get them, we'll pass. We'll keep this pending, you file. That I'm not passing an order. You do it, bring it by Friday, I'll pass the orders.
Okay.
But get them. Get them here. We are keeping it for time being. Yes, madam, what is this?
We have filed our affidavit.
Forget your affidavit. Forget your affidavit. We are not worried. There were 3 cases against him, 2 suspension orders. All the 3 cases acquitted. You have not drawn up corresponding departmental proceedings. Now, he was deprived of his promotions only because of those cases. 1. 2, period of suspension not regularized. How can you do this?
Lordship, we have filed the affidavit.
Well, forget your affidavit. Tell me what is here.
I can give my copy, Lordship.
No. Tell me what is to the things I told you. What is your answer? That much only is this case.
May I hand over my copy of the
You tell me, madam. You tell me openly what is this. Why was his period of suspension not regularized?
Lordship, may I call my senior, Lordship?
Fair enough. That is your case?
Yes.
Nothing more, nothing less? Come back. 16.
May it please your lordship, kindly adjourn the matter for a time being, conducting counsel conference.
Respondent number 2, he has already filed the affidavit, lordship.
Who is there? Who is the petitioner counsel? Who is appearing for a petitioner?
ST Hussain.
Huh?
ST Hussain.
Gola.
Much obliged.
Yes, madam. Give me a clarification. Come to page 16. Madam, but second file today.
Second copy to you.
Second file 98. Come to page 16.
Yes, Lordship.
This is the dispute. Approval is hereby accorded to so-and-so, 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 annual increment, so-and-so. He is regularized. Why? Director of Medical Education letter dated 26/2000, right?
Yeah.
But in your affidavit, the superintendent, not the director, superintendent has filed an affidavit saying that he was not regularized.
regularized.
Get me a copy of this letter, 26/2000. Tomorrow.
Tomorrow,
What should we-
after vacation,
No, no,
Lordship.
no.
So the petitioner is
No, no, no.
not here.
Forget, we can dismiss it for default. We will not do it. We want that. Only that one letter. If he is regularized, your action goes. If he is not regularized, dismiss. That's all. Get it on WhatsApp. That will do. Give it to me. She'll take out a copy.
On this ground, Lordship may pass order.
Why should I? I'll pass orders that he is regularized. Take him back with
Yes,
full
Lordship.
benefits. Shall I do that?
Yes,
With in your, I'll record your submission. Okay, done.
After vacation,
No,
Lordship?
today. I'll record your submission, madam.
No, Lordship, tomorrow.
No, today. You have said you pass orders, I'll pass orders. Lekha, none appears for the petition.
As per our affidavit, Lordship, he has.
Your affidavit is by
not
an
regularized
authority
him.
not even competent to do that.
So
Just get that
I will
letter,
take
madam.
Instructions as per your Lordship's order.
That's it. Tomorrow. Only that letter I want. That's all. And you have put in an affidavit, that letter you have not brought on record. Kali, as prayed for Miss D. Bora, Learned Counsel for the petitioner, for the respondents, shall produce before this court a copy of the communication dated, communication bearing number 3207/DME/327/96 PT dated 26/2000 issued by the Director of Medical Education Assam and finding mentioned in the office order dated 31/7/2006 issued by the Superintendent, Guwahati Medical College and Hospital, Guwahati.
Lordship, on last occasion had asked me about the vacancy position, Lordship. As far as written instructions, Lordship, we are seeking some time, but otherwise, Lordship, I have been informed that currently there is no vacancy for grade 2 forester. As and when, Lordship, it will arise, petitioner will.
Yes, Mr. What to do? What more can we do? Already covered by the orders.
And the rule says, my lord, after passing the training, I am entitled to.
You are entitled, but there will be others above you who have passed that training also. It's not that only Mr. Day has passed the training, others have also.
Their letter is also there, my lord, that.
They say that cannot be dehouse the rules and the seniority position, Mr. Day. And I have scanned it. You have not even made a whisper. Not even made a whisper to that effect. How can we? And it's already covered by the earlier orders, repeated orders.
Some observatory in my favor.
Okay, done. Dispose of. I bought Thakur, huh?
Okay.
We will only reiterate the early. Mr. Day said that we will only reiterate the early orders, record your statement, and say that whenever there is vacancy arising, his position as per his seniority will be considered. Right?
HON'BLE.
Because he's a very old, he's a very repeated petitioner before this court. So we can't dishearten him.
In this matter, we need some time.
Why?
We will file our affidavit also.
What affidavit? What is there in this matter? What is left?
There were-
After the page 21 order, what is left?
Pardon, Lordship.
After page 21 order, what is left, Mr. Counsel?
That's not correct.
They are not working?
They were not working. Means, Lordship, some of the appointments, we have, some other cases also have been filed. We have filed our affidavit in the same matter, Lordship.
What is your stand?
Our stand is that only eight persons were working and others were not appointed, Lordship.
Heard the learned, none appears for the petitioner on call. Heard Mr.
C. Sharma, Lordship.
C. Sharma, learned standing counsel.
Lordship, I am not the standing counsel. I am appearing on behalf of Mr. R.M. Das, Lordship.
Learned counsel appearing for the Water Resources Department. Mr. Sharma has submitted that on a scrutiny made of the workers working during the period when the petitioners herein have contended to be so serving as master roll workers, 8 of them were found eligible for being regularized and their service.
Not regularized, Lordship. They were working.
And therefore found to be working, and accordingly they were extended with the benefits of Upendas.
No, Lordship.
Then what? You have your clear instructions. Come back after some time. Since Mr. P.N. Goswami is there, his father had passed away. Raised it to list this matters again after the ensuing vacations.
This matter may be fixed on after the vacation.
Why?
We have filed a affidavit in reply on 11/6.
Nobody is appearing. You have asked them not to come. No, you have asked them not to come. Then why are they not coming? On the prayer of the learned counsel for the petition, list this matters again after the ensuing vacations. Why? Why was she replaced? What is the ground? You are appearing for respondent number
2.
Who is for the private respondent number, sir?
She is appearing for 3.
3. Yes. Why should we not interfere? 11 years she is working.
11.
Show me some documents that you have given her that your service is not satisfactory. Show me. You yourself is an ad hoc. Establishment is an ad hoc.
Lordship.
And then this is not countenanced. They are interfering. Anything more to say?
She has been warned several times verbally because.
Oh, show me that material. Your only a statement in the written statement, the affidavit will not do. Even the order. Where is the order releasing her?
Order does not reflect any results.
Then. Take her back.
But that does not violate her, my lord.
No. Ad hoc by ad hoc. How can it be permissible? 1. 2. Show me that these are the grounds we had given her notice. Still, she did not. Sweepers, poor person working.
Actually,
I have my sympathies with the private respondent also, but weighing both, I think it should go to the petitioner.
Actually, my lord, our conduct is such that, my lord, that cannot be reflected in the record, my lord. Because of that, my lord, that has happened. Actually, she used to say liquor after the in the premises of the.
No, that is a ground. You bring it on record. Why, somewhere you indicate.
Office hours, my lord. That is
After
the
office
reason why he has been removed, my lord. Actual reason is that, my lord.
Who is appearing for the petitioner? P. Borua, DCC, Fukon, T. Get somebody. We'll see. All of you, sir. Get somebody. Or I'll dismiss it for default then.
Yeah, please, Lordship. Lordship, my senior legs in another court. My senior legs in another court.
Okay, fine. Should this matter be taken to that court or
No,
it'll come here?
Pass over the time.
Ah, yes. Okay. What happened?
Lordship, with sincere apologies, Lordship, our instructions have not yet received.
21 onwards from,
Lordship,
where is your office? This PCC of office?
We have written.
No, where is your PCC of office?
It is in Punjabari.
Panjabari. It was in Panbazar when this matter, Poltam Bazar when this matter was taken up. Huh? Now it has gone to Panjabari. 2 o'clock.
At least, my lord, my provisional pension and other benefits has to be given, my lord.
Huh?
I retired, my lord, now nothing to survive, my lord.
Mr. Bhattakur. Get me the reason. 2 o'clock.
Okay.
2021 pension, you can't just sit over the matter. Will not permit. Yes. Come, we require you. Very serious allegation. Very serious allegation against you. That you sell liquor after the office hours. That is why they terminated you.
No, my lord, there is no any written notice or anything written given to me that I have not complied at their direction and I am irregular. In my 11 years of service, nothing, no notice, nothing is shown by them.
Why was you then removed?
My lord, without abruptly.
No, abruptly means what? Why? Why that abrupt action?
But I don't know, man.
You don't know.
I don't know, my lord. They have nothing. They have served any
So clean, so nice. 11 years.
My lord, after 11 years of service.
Huh?
She has continued for 11 years.
So, how can you, after 11 years, one fine morning say you go home and bring respondent number 3?
Respondent number 3 was brought in, my lord, because it is necessary to clean and sweep the office, my lord. That's why someone is required.
So,
if 3 not
so 2 is coming, petitioner is coming back. In the event she is having any dereliction of duty, remove her by following the procedure. A notice, that's all. Otherwise, nothing. She is not entitled to discipline and service rules. She'll only be entitled to a notice saying that you are doing this, says. But 11 years, she has maintained her family with this. We will not permit.
My lord, my service is temporary. And I am replaced by a temporary service, my lord.
Got it?
That is barred by honorable.
Did I say even a word against you? Then your name?
DCC Pukana.
And you, madam?
S. Boro.
S. Boro. Mr. Soikia, you are appearing for both respondent number 2 and 3.
No, well, 2, my lord, 3 that has been reflected wrongly.
Wrongly, okay. I thought you are appearing for both.
No.
Either. But Mr. DCC Fukon, learned counsel for the petitioner. And also heard Mr. U.J. Soikia, learned counsel appearing for the respondent number, Mr. C.K.S. Borua, learned counsel appearing for the government advocate, appearing for the respondent number 1, and Mr. U.J. Soikia, learned counsel appearing for the respondent number 2. Respondent number 3 is represented by Ms. S. Boruto. Full stop. The challenge in the present proceeding pertains to the issuance of an order dated 5/11/2020 issued by the member Foreigners Tribunal bracketed second Morrigan, releasing the petitioner from her engagement as a sweeper in the establishment. Full stop. As projected in the petition, the petitioner herein was initially engaged by the respondent number 2 on wage basis as a sweeper in his establishment with effect from 29/1/2009, right?
My lord. Her service was extended.
With effect from 31/3/2009. Also, the petitioner's service was thereafter extended from time to time. Also, it is to be noted that the wages of the petitioner was also being enhanced in conformity with the enhancement by the government of Assam of the wages of such category of workers. Also, it is the contention of the petitioner that without any prior notice, she was while order dated 5/11/2020 removed from her released from her services, and consequently the respondent number 3 herein was so engaged for the works being done by the petitioner, by the respondent number 2. Also, being aggrieved, the present proceedings have been instituted by the petitioner. Also, a perusal of the materials brought on record reveals that an ad hoc has been replaced by another ad hoc. However, there is no justification brought on record for the purpose of engagement of the respondent number 3 in place of the petitioner herein. In the affidavit filed by the respondent number 2, a vague statement to the effect that the petitioner was guilty of disobedience and dereliction of duty, and she had not followed the rules and regulation while in office premises. It was also highlighted that the petitioner was issued with verbal warnings. Full stop. The said position is clearly is disputed by the learned counsel for the petitioner by contending that the petitioner was never issued with any notice in this connection. Full stop. In view of the above, and this court not being satisfied with the contention made in this connection in the affidavit filed by the respondent number 2, the removal of the petitioner hearing having been so done without there being any reason assigned for the purpose, and the reason assigned subsequently in the affidavit being in the form of a development made in the matter by the respondent number 2, the same is not accepted, and accordingly the order dated 5/11/2020 stands interfered with. Full stop. The petitioner shall now be reinstated in her services in her earlier capacity and be permitted to discharge her duties in such capacities. Full stop. In view of the interference made with the order dated 5/11/2020, the engagement of the respondent number 3 in the said establishment would also come to an end. Subpara. Given the apprehension raised in the matter by Mr. U.J. Soikia with regard to the conduct of the petitioner hearing, it is provided that in the event the petitioner does not display a demeanor as mandated of an employed in the said establishment, the respondent number 2 would be within his liberty to take appropriate action in the matter against the petitioner by issuing due notices to her. So, with the above observations and directions, the writ petition stands disposed of.
My lord, obliged.
Full stop. The petitioner would, it is provided that the petitioner would not be entitled to any wages for the period with effect from the removal with while the order dated 5/11/2020 till the date of her reinstatement in terms of this order. On the principle of no perk to no pay.
My lord.
Protected Whatever salary she got, she'll get it. But don't do it in this manner. Poor people. If she is not doing, she is doing something contrary, take steps, issue a notice and finish her off. No problem.
All right.
Yes, Mr. Deka.
My lord. I thought they were supposed to bring
I have them. I just received them, my lords.
Yes.
Madhya Pradesh, the compassionate appointment and the minutes they have referred, it is in their affidavit. Where from they have extracted it, who has issued it, there is nothing in.
You tell me whether that fact is correct or wrong.
The fact is very much correct, my lord.
Mr. B.D. Deka. Finished.
My lord.
Finished. 2016, what compassion it is?
Yes, my lord. What is their ground, my lord?
Forget the ground. 2016.
My lord, it is.
Mr. Deka, 2016.
Maybe.
And paragraph 5 not disputed. What more is required?
My lord, maybe after vacation.
No.
Maybe fixed after vacation.
And a similar matter, my lords. An identically placed petitioner, my lords. His case was decided against, was dismissed by the coordinate bench of this honorable court, my lord, Sumit Wari. Same stand, same procedure, my lords, adopted. Para 5 to 7 and 10 to 14, my lords. I have the reports otherwise.
Show me where there is an order. Where did you extract this para 5 from? Anyway, he says he's not disputing it. Why should we go into that?
Yes, my lord.
We are disputing, my lord.
Para 5 of the affidavit.
They are affidavit, my lord.
That your family is getting 30,000 as family pension.
Disputing on that, but
Then-
that cannot be a ground, my lord, because
Forget it.
even after Devabrat
2006
Tiwari, my lord, there is the judge, the Honorable Supreme Court judge, one of the co-judges has decided it.
Devabrat Tiwari held to be bad law.
No,
Then
but the pension amount received by the petitioner, that cannot be a
I'll
ground
not
for
even go
rejection,
into
my
that.
lord.
I'll not even go into that. I'll not even go into that. 2016 today, you have no compassion. To be appointed on compassion. No.
Maybe after vacation, if possible.
No. We'll have to give it this matters quite as this files should not be carried around like this. 2016 dead. 8-9 years afterwards, what compassion remains? You tell me. Today, to direct that, I'll have to say that there is a compassion remain.
Yes.
Compassion is here, but it can't be in my order.
There is a compassion.
No.
Because the lady has been suffering.
There are hundreds of people like this. You are getting something.
But that cannot be discriminated, my lord.
If there is a case of discrimination,
Yes.
bring a case of
There is a
discrimination.
case of discrimination.
Show me.
My lord will get the impugn order, my lord.
Show me.
The last page, page number 45, my lord.
You have a family of 3.
My lord?
Family of 3. 3 persons.
Yes.
30,000.
Yes, my lord.
Divided by 3. Every month 10,000 per head you are getting. That is enough.
But the.
That is above the minimum.
Where the.
Yes. What do you want to show me?
My lord, page 46, my lord. Subsequently, as per recommendation of the selection committee, all the pending applications submitted under the scheme of 2014 had been considered for their disposal as a one-time exercise. And as per approval of the board of directors, so-and-so, most eligible applicants, so-and-so were considered for appointment.
Have you made them parties?
No, my lord.
Then
But
have you challenged them?
How they have
That you will get
categorized
it.
it? Most eligible person, my lord.
That you will get it.
Perhaps not my place to point out, my lord. The order that I just placed before my lords, my lords,
Has
similar
taken-
matter.
taken
My
into-
friend had appeared in the matter.
I know, I've seen it. That is why I am going against him. Do you think I have been saying all these things in air?
My lord.
I've seen his name there.
My lord.
He is trying to take a chance. Why will he not? That is his right. Dismissed.
Much of labor.
Deeply obliged. My lord, is retaining the records, my lord.
No, record. Record to be. 2016, today, what compassion? We don't have, we'll not direct. Yes, Mr. Upamanyu, what do you have to say?
Lordship, here his pension and other benefits are in active consideration, Lordship. We have treated his last day of working as his date of retirement.
Active consideration with nuclear fuel or with kerosene?
Lordship, here in this matter.
Nuclear fuel or kerosene?
Lordship, we have taken steps because there was no record.
With kerosene energy or with nuclear fuel energy? If it is nuclear fuel energy, I'll give you some time. Kerosene, 2 o'clock.
Not kerosene, Lordship.
Nuclear fuel.
Yes.
Mr. D. Upamanyu on instruction submits that the pension and pensionary benefits of the petitioner are being computed for being released, and the final proposal in this connection would be submitted to the AG within a period of 15 days from today. Post up. In that view of the matter, raised it to list this matter again on 18/7/2024. 17/7/2024. On the next date of listing, Mr. Upamanyu shall invariably place on record communications reflecting the forwarding of the proposal in this connection to the AG.
Highly obliged.
Highly obliged.
17. Here we have filed an IA for modification of one order, my lord, by which order, my lord, we were debarred from filing our affidavit.
Cost.
My lord.
Cost. How much? Cost, how much?
Affidavit filing, my lord. I can.
I'll have to review an order passed by me. Why should I? We are wasting paper. We are wasting time. How much?
We have been.
How much? Decide. We'll just interact with Mr. Avedi. Yeah, Mr. Atia. Yes, Mr. Atia. What is your case?
My case, my lord. They filed the IA, my lord.
Forget the IA. You tell
my
me.
case is my
You
lord.
tell me what is your right here. Mr. Muni, take your seat and decide the quantum.
My lord.
Whatever you say, I'll incorporate.
My lord.
What is your right here?
As per rule of Assam 34, employees service rule. my lord.
Iman kyo khami gul? AC to lagai dia. Thik hai. Now today, I can't see you.
Yes, sir.
Full day, all full day. Fan to lagai dia. Thik hai. Ene dekha na paye mo. Kari ito aru dekha nu ko. Yes, Mr. Atia, what is your right? Tell me. When did you join?
I joined, my lord. My appointment letter is 22, my lord. Is 22. It ends 2019.
19. Okay.
As per
2019 as contractual.
Contractual.
Okay.
Then I
Was it regularized?
sent for training, my lord.
Okay, fine.
And my lord,
And 2019 you were engaged as contractual. 2021 you were released.
yes,
And thereafter you are not in
Without-
service.
yes, sir. Without
Show me your right. They say they don't have.
my lord, can you
They don't have work. Yes,
My
Mr. Muni, what is your reason for releasing him?
see,
My lord.
What is the reason for releasing him?
We don't have that particular industry is not working. at
Working.
this- no-
Yes, Mr. Atia.
industry is still working, my lord.
Show me.
My lord,
Show me.
my lord, I have some photograph of the
Show me
The
from
functioning of
from your writ petition that the industry is still working. Just show me.
industry is still working, my lord. My lord, they
Where?
subsequently submitted that industry was
Your
No, no.
affidavit is ready
My lord, we'll file it
today,
tomorrow.
tomorrow. Okay. List this matter again on Friday. Writ petition, not list this matter again on Friday. Ayat likha. The present interlocutory application has been filed, praying for a review of an order dated 22/11/2023 passed by this court in the connected writ petition, that is WPC number 2733/2022, by which the right of the respondent number 125 to file an affidavit in the matter was struck off. Also, I have considered the submissions made, the contentions made in the interlocutory application, and also heard Mr. Munir, learned counsel, appearing for the said respondents in the matter. Also, accordingly, for the ends of justice, the order dated 22/11/2023 shall stand modified, and the petitioners herein are granted time till tomorrow, that is date to DDA, to bring on record their affidavit with a further direction that the petition respondents number 225 shall pay a cost of rupees.
That I'll have to pay off my pocket, my lord.
Yes. Get it tomorrow. I only want one contention, one reply. That is paragraph page 11, second paragraph.
Page 11, para 11.
Para 10, second. However, they said handmade industry is still functioning and is requirement of workers. If that be so, why they were removed? That much only you show me. List this matter again on Friday. Mr. Atia, let's see what they have to say on that. Or are they creating other problems for which you have not allowed them?
No.
Mr. Atia might be advising them in that direction also.
Nothing such, my lord. Only